Hello everyone, Net Narrator here. Before we get started, I wanted to give a brief introduction to add some context to what you're about to hear. To start, in the title I have called this a curated full narration, and I want to clarify what that means. Firstly, considering the subject matter at hand, you should not be surprised to learn that there are several sections in these files that go into some dark detail. And to comply with YouTube's terms of service, as well as common decency, I am omitting these parts from the narration, and I make it clear when I am doing so. Secondly, I have done my best to also omit personal and business information that could lead to any kind of doxing. Though these documents are in the public domain, I wish to discourage any harassment of the people involved, to the best of my ability. Thirdly, as these are legal documents, I have omitted some of the formatting to make the flow of information more smooth. As for the content, since these are a collection of legal documents, there will be several repeats, sudden stops, and rapid change of topics. There is also notation which I do my best to keep you informed about. Finally, as you can likely tell by the length, this is quite an undertaking with no text-to-speech or AI used whatsoever. While as a YouTuber I should probably be asking you to like, subscribe, leave comments, and check out my other narrations, I'm not going to do that, and instead I would ask you to be the best possible parents you can be for your children. Now, let us begin. This narration is of the widely circulated 943-page document that was publicly released on January 3rd. I was also made aware of a document with over 2,000 pages, including the 943 pages narrated here. However, when I perused this document, it contained a lot of redacted information or otherwise unreadable content. Also, I have recently seen several headlines stating that more documents either have or will be released to the public, though I've not found any PDFs yet. If there is enough interest, I will narrate that too. January 3rd, 2024. R.E. Jeffery v. Maxwell. Case number 15 CV 7433 LAP. Dear Judge Presker, pursuant to the Court's December 18th, 2023 unsealing order, and following conferral with defendant, plaintiff files this set of documents ordered unsealed. The filing of these documents ordered unsealed will be done on a rolling basis until completed. This filing also excludes documents pertaining to DOS 105, see December 28, 2023 email correspondence with Chambers, 107 and 110, see ECF number 1319, while the court's review of those documents is ongoing. Respectfully, Sigrid S. Macaulay, CC Counsel of Record, via ECF. Exhibit 4. From gmax1@lmax.com. Sent Saturday, January 10th, 2015, 9 a.m. To Philip Barden, Roscoe. I am out of my depth to understanding defamation and other legal hazards and don't want to end up in a lawsuit aimed at me from anyone if I can help it. Apparently, even saying Virginia is a liar has hazard. I have never been in a suit, criminal or civil, and want it to stay that way. The US lawyers for the Jane Does are filing additional discovery motions, and if I speak, I open myself to being part of discovery, apparently. I am trying to stay out of litigation, and not have to employ lawyers for years as I get lost in US legal nightmare. I stand no legal risk currently on these old charges and civil suits against Jeffery. We need to consult with US lawyers on any statement I make, and the complaints too. Perhaps we make a statement of the legal risk of saying anything for potential defamation or something that prevents a full and frank detailed rebuttal, and the press not being the place for that? Regardless, Philip, please call Jeffrey lawyer and see what you can understand from him, and perhaps craft something in conjunction with him. Either way, I think you need to speak to him to understand my risk, so you can help me understand it. Too many cooks in the kitchen, and I can't make good decisions. Please reach out to him today. Plus, I have already suffered such a terrible and painful loss over the last few days that I can't even see what life after press will even look like. Statements that don't address all just lead to more questions. What is my relationship to Clinton? Andrew, on and on. Let's rest till Monday. I need headspace. The Terramar Project. Facebook, Twitter, Google+, Pinterest, Instagram, Pledge, The Daily Catch. United States District Court, Southern District of New York. Virginia L. Joffrey, Plaintiff. Case number 15 CV 07433 RWS v. Ghislaine Maxwell, Defendant. Plaintiff's motion to compel defendant to answer deposition questions filed under seal. Plaintiff Virginia Joffrey, by and through her undersigned counsel, hereby files this motion to compel defendant to answer deposition questions. During her recent deposition, defendant refused to answer numerous questions about allegedly adult sexual activity related to Jeffery Epstein. Because this activity is highly relevant to this case, defendant should be ordered to answer questions about it. As the court is aware, this defamation case involves Miss Joffrey's assertions that she and other females were recruited by defendant to be sexually abused by Jeffery Epstein under the guise of being massage therapists. See complaint DE1 at 27. Joffrey described Maxwell's role as one of the main women who Epstein used to procure underage girls for sexual activities, and a primary co-conspirator and participant in his sexual abuse and sex trafficking scheme. In response to these assertions, defendant has made the sweeping claim that Miss Joffrey's assertions are entirely false and entirely untrue. Complaint DE1 at 31. Note, defendant has labelled her entire deposition transcript as confidential at this time. Counsel for the parties conferred at the deposition regarding answering questions. Yet during her deposition, defendant refused to answer any questions that she construed as having something to do with consensual adult sex. Defense counsel supported that petition that, frankly, that's none of your business and I instruct the witness not to answer. See Declaration of Sigrid S. Macaulay de Cole, at Exhibit 1, TR of Maxwell Depo. April 22nd, 2016, at 21. The result was that at a number of points throughout her deposition, defendant refused to answer questions about subjects integral to this lawsuit, including questions about what the alleged massage therapists were doing at Jeffery Epstein's house and the sexual nature of those massages. For example, defendant refused to answer questions about whether she had given Jeffery Epstein a massage. Question: have you ever given Jeffery Epstein a massage? Mr. Pagluka. Object to the form, Foundation. And I'm going to instruct you not to answer that question. I don't have any problem with you asking questions about what the subject matter of this lawsuit is, which would be, as you've termed it, sexual trafficking of Ms. Roberts. To the extent you are asking for information relating to any consensual adult interaction between my client and Mr. Epstein, I'm going to instruct her not to answer, because it's not part of this litigation, and it is her private confidential information, not subject to this deposition. Miss Macaulay: You can instruct her not to answer, that is your right. But I will bring her back for another deposition because it is part of the subject matter of this litigation. So she should be answering these questions. This is civil litigation, deposition, and she should be responsible for answering these questions. Mr. Pagluka: I disagree, and you understand the bounds that I put on it. Ms. Macaulay: No, I don't. I will continue to ask my questions and you can continue to make your objections. Question: Did you ever participate, from the time period of 1992 to 2009, did you ever participate in a massage with Jeffery Epstein and another female? Mr. Pagluka: Objection. Do not answer that question. Again, to the extent you are asking for some sort of illegal activity, as you've construed, in connection with this case, I don't have any problem with you asking that question. To the extent these questions involve consensual acts between adults, frankly, they're none of your business, and I will instruct the witness not to answer. Ms. Macaulay: This case involves sexual trafficking, sexual abuse, questions about her having interactions with other females is relevant to this case. She needs to answer these questions. Mr. Pagluka: I'm instructing her not to answer. Ms. Macaulay: Then we will be back here again. See Macaulay Decal at Exhibit 2, TR of Maxwell Depo. April 22nd, 2016 at 1922. Emphasis added. Defendant's participation in massages with Epstein is a central part of this case. Miss Joffrey has explained that during her first sexual encounter with Jeffery Epstein, it was defendant who provided instruction on how to do it, and how to turn the massage into a sexual event. Obviously, proof that defendant had previously massaged Epstein, including massages with sexual component, will provide important corroboration for Miss Joffrey's testimony at trial. And proof that defendant was involved in massages will further help prove that statements to the press that Virginia's allegations were obvious lies was itself an obvious lie. As another example, defendant refused to answer questions about her knowledge that Johanna Sjoberg was hired to work for Epstein and provided massages. In the police report, Johanna admitted that Maxwell recruited her to work for Epstein. See Macaulay Decal at Exhibit 3, Joffrey 00007677. Police report indicating that Johanna was recruited by Maxwell. Yet during defendant's deposition, she refused to answer questions regarding Johanna Sjoberg. Question: Do you know what tasks Johanna was hired to performance? Answer: She was tasked to answer telephones. Question: Did you ever ask her to rub Jeffrey's feet? Answer: I believe that I have read that, but I don't have any memory of it. Question: Did you ever tell Johanna that she would get extra money if she provided Jeffrey massages? Answer: I was always happy to give career advice to people, and I think that becoming somebody in the healthcare profession, either exercise instructor or nutritionist, or professional massage therapist, is an excellent job opportunity. Hourly wages are around $7, $8, $9, and as a professional healthcare provider, you can earn somewhere between, as we have established, $100 to $200, and to be able to travel and have a job that pays, that is a wonderful job opportunity. So in the context of advising people for opportunities for work, it is possible that I would have said that she should explore that as an option. Question: Did you tell her she would get extra money if she massaged Jeffrey? Answer: I'm just saying, I cannot recall the exact conversation. I give career advice, and I have done that. Question: Did you ever have Johanna massage you? Answer: I did. Question. How many times? Answer. I don't recall how many times. Question. Was there sex involved? Answer. No. Question. Did you ever have sexual contact with Johanna? Mr. Pagliuca. Object to the form and foundation. You need to give me an opportunity to get in between the questions. Anything that involves consensual sex on your part, I'm instructing you not to answer. Question. Did you ever have sexual contact with Johanna? Answer. Mr. Pagliuca? Again, she is an adult. Question. I'm asking you, did you ever have sexual contact with Johanna? Answer. I've just been instructed not to answer. Question. On what basis? Answer. You'll have to ask my lawyer. See Macaulay Decal at Exhibit 4, TR of Maxwell Depo, April 22nd, 2016, at 6062. Emphasis added. Here again, this information is critical to the case. Among other things, these questions are designed to show a modus operandi, MO, for Epstein and Maxwell, specifically how they recruited for a non-sexual massage, then converted the massage into sexual activities. One last illustration comes from defendant's refusal to answer about her knowledge of Epstein's sexual interests during massages. Question. Does Jeffrey like to have his nipples pinched during sexual encounters? Mr. Pagliuca. Objection to form and foundation. Answer. I'm not referring to any advice on my counsel. I'm not talking about any adult sexual things when I was with him. Question. When Jeffrey would have a massage, would he request that the masseuse pinch his nipples while he was having a massage? Answer. I'm not talking about anything with consensual adult situation. See Macaulay Decal at Exhibit 5, TR of Maxwell Depo, April 22nd, 2016, at 82. While Epstein himself might also provide answers to these questions, it appears likely that he will assert his Fifth Amendment privilege regarding his sexual activities. Accordingly, Ms. Jeffery must pursue questioning of Maxwell to obtain information on this subject. Here again, information about Epstein's sexual idiosyncrasies will provide important corroboration to Ms. Jeffery's testimony that she has sexual interactions of an identical nature with Epstein. These refusals are not an isolated instance. Instead, similar refusals to answer questions occurred repeatedly throughout the deposition. See e.g. Macaulay Decal at Composite Exhibit 6, 52-55, 64-65, 82, 92-93, 137-38, 307-09. The court should compel defendant to answer all these questions. In addition to the specific points made above, the big picture here reveals how vital such discovery is. At the core of Ms. Jeffery's allegations is the allegation that defendant lured her into a sexual situation with the offer of a job making money as a massage therapist, that Epstein always habitually tried to turn massages into sex, that was his modus operandi and plan all along, and that Maxwell recruited other females for an ostensibly proper position, such as therapeutic masseuse, with knowledge that the intent was for that person would be pressured to provide sexual gratification to Epstein. As a result, Epstein's use of massages for sexual purposes is a central part of this case. And defendant's role in those massages, and knowledge of the purpose of those massages, is a critical piece of evidence showing her state of mind when she attacked Ms. Jeffery's assertions as entirely untrue. Ms. Jeffery intends to prove at trial that defendant knew full well the sexual purpose for which she was recruiting females, including underage females like Ms. Jeffery. Ms. Jeffery is entitled to explore defendant's knowledge of the sexual activities that took place under the guise of massages. Otherwise, defendant will be able to portray to the jury an inaccurate picture of what was happening at Epstein's house, what nothing more than run-of-the-mill massage therapy. See e.g. Macaulay de Carl at Exhibit 7, TR of Maxwell Depo, April 22, 2016, at 51. Question: did the pay for massage therapists vary on what sexual acts they performed? Answer: no. It varied depending on how much time. Some massage therapists charge more, and some charge less. Defendant's refusal to answer questions about alleged adult consensual sex also blocks Ms. Jeffery from seeking legitimate discovery in this case. By refusing to answer questions about her and Epstein's sexual activities with alleged adults, defendant is essentially given the ability to refuse to answer any sexual question she does not wish to answer. Defendant simply has to deem the question as involving consensual adult sex, and no need be given. The result is to leave Miss Jeffery with no way of exploring the identity of these alleged adults, the ages of these alleged adults, and indeed whether they were adults at all. This allows defendant to claim that she is unaware of any sexual activity involving underage females because, she claims, the only sexual activity she was aware involved adults. The court should compel Ms. Maxwell to answer all questions about her knowledge relating to sexual activities with Epstein and other females while at Epstein's various homes. See Fed R. Crim P. 37, subsection A, subsection 3, subsection B, subsection 1. See, e.g., Kelly vs. Al-Tech. Number 09, Civ. 962, LAC MHD, 2010 WL 1541585 at 20. SDNY, April 12, 2010. Under the federal rules, when a party refuses to answer a question during a deposition, the questioning party may subsequently move to compel disclosure of the testimony that it sought. The court must determine the propriety of the deponent's objection to answering the questions, and can order the deponent to provide improperly withheld answers during a continued deposition, internal citations omitted. Of course, the party objecting to discovery must carry the burden of proving the validity of its objections, particularly in light of the broad and liberal construction afforded the federal discovery rules. John Wiley & Sons, Inc., v. Book Dog Books, LLC 298 FRD 184186, SDNY 2014. For purposes of a deposition, the information sought need not be admissible at the trial if the discovery appears reasonably calculated to lead to the discovery of admissible evidence. Shen Oster v. Goldman Sachs & Co. 293 FRD 557561, SDNY 2013, citing Fed R. Civ. P. 26, subsection B, subsection 1. Defendant cannot carry her burden of showing that the questions asked are not reasonably calculated to lead to the discovery of admissible evidence. This is a case in which sexual activities lie at the heart of the issues in dispute. As a result, it is highly surprising to find that discovery pertains to alleged adult sexual activities, and questions about such subjects are entirely proper. See e.g. Condit v. Dunn, 225 FRD 100 113, SDNY 2004. In defamation case, plaintiff is hereby ordered to answer questions regarding his sexual relationships insofar as they are relevant to a defense of substantial truth, mitigation of damages, or impeachment of plaintiff. Weber v. Multimedia Entertainment Inc., number 97 Civ 0682 PKL THK 1997 WL 729039 at 3, SDNY November 24, 1997. While discovery is not unlimited, and may not unnecessarily intrude into private matters, in the instant case inquiry into private matters is clearly relevant to the subject matter of the suit. Accordingly, Plaintiff Misty Weather shall respond to defendant's interrogatories concerning her sexual partners. Generally speaking, instructions from attorneys to their clients not to answer questions at a deposition should be limited to issues regarding privilege. Morales v. Zondo, Inc., 204 FRD 5054, STNY 2001. In this case, defense counsel ranged far beyond the normal parameters of objections and sought to decide for himself what issues were relevant. That was improper, and the court shall order a resumption of the defendant's deposition so that she can answer questions about her knowledge of sexual activity relating to Jeffery Epstein. Conclusion. Defendant should be ordered to sit for a follow-up deposition and directed to answer questions regarding her knowledge of alleged adult sexual activity. Dated May 5th, 2016. Respectfully submitted. Note: this daytime business address is provided for identification and correspondence purposes only, and is not intended to imply institutional endorsement by the University of Utah for this private representation. Certificate of Service. I hereby certify that on the 5th day of May 2016, I electronically filed the foregoing document with the Clerk of Court by using the CM-ECF system. I also certify that the foregoing document is being served this day on the individuals identified below via transmission of notices of electronic filing generated by CM-ECF. Signed by Sigrid S. McCauley. Exhibit 4. United States District Court, Southern District of New York. Virginia L. Joffrey, Plaintiff. Case number 15CV07433 RWS. Against Ghislaine Maxwell. Defendants. Confidential. Videotaped deposition of Ghislaine Maxwell, taken pursuant to subpoena, was held at the law offices of Boyce, Schiller, and Flexner, 595 Lexington Avenue, New York, New York, commencing April 22, 2016, 9:04 a.m., on the above date before Leslie Fagan, a court reporter and notary public in the state of New York. Magna Legal Services, 1200 Avenue of the Americas, New York, New York, 126. Appearances: Boyce, Schiller and Flexner LLP, attorneys for plaintiff. G. Maxwell, confidential. Answer: she was tasked to answer telephones. Question: did you ever ask her to rub Jeffrey's feet? Mr. Pagluka: objection to the form and foundation. Answer: I believe that I have read that, but I don't have any memory of it. Question: did you ever tell Johanna that she would get extra money if she provided Jeffrey massages? Answer: I was always happy to give career advice to people, and I think that becoming somebody in the healthcare profession, either exercise instructor or nutritionist, or professional massage therapist, is an excellent job opportunity. Hourly wages are around $7, $8, $9, and as a professional healthcare provider, you can earn somewhere between, as we have established, $100 to $200. And to be able to travel and have a job that pays, that is a wonderful job opportunity. So in the context of advising people for opportunities for work, it is possible that I would have said that she should explore that as an option. Question: did you tell her she would get extra money if she massaged Jeffrey? Answer: I'm just saying, I cannot recall the exact conversation. I give career advice, and I have done that. Question: did you ever have Johanna massage you? Answer: I did. Question: how many times? Answer: I don't recall how many times. Question: was there sex involved? Answer: no. Question. Did you ever instruct Johanna to massage Glenn Dubbin? Answer. I don't believe. I have no recollection of it. Question. Did you ever have sexual contact with Johanna? Mr. Pagluka. Object to the form and foundation. You need to give me an opportunity to get in between the questions. Anything that involves consensual sex on your part, I'm instructing you not to answer. Question. Did you ever have sexual contact with Johanna? Answer. Again, she is an adult. Question. I'm asking you. Did you ever have sexual contact with Johanna? Answer. I've just been instructed not to answer. Question. On what basis? Answer. You have to ask my lawyer. Question. Did you ever have sexual contact with Johanna that was not consensual on Johanna's part? Mr. Pagluka. You can answer non-consensual. Answer. I've never had non-consensual sex with anybody. Question. Not Annie Farmer? Mr. Pagluka. Objection. Answer. I just testified I never had non-consensual sex with anybody ever, at any time, at any place, at any time, with anybody. Exhibit 6. United States District Court, Southern District of New York. Virginia L. Joffrey, Plaintiff. Case number 15CV07433RWS. Against Ghislaine Maxwell. Defendants. Confidential. Videotaped deposition of Ghislaine Maxwell, taken pursuant to subpoena, was held at the law offices of Boyce, Schiller and Flexner, 595 Lexington Avenue, New York, New York, commencing April 22, 2016, 9:04 a.m., on the above date before Leslie Fagan, a court reporter and notary public in the state of New York. G. Maxwell, confidential. For sexual acts. Question. I'm asking if they performed sexual acts. Mr. Pagluka. Object to the form and foundation. Question. Did any of the massage therapists who were at the home perform sexual acts for Jeffery Epstein? Answer. I don't know what you mean by sexual acts. Question. Did any of the massage therapists who were working at the home perform sexual acts, including touching the breasts, touching the vaginal area, being touched while Jeffery is masturbating, having intercourse, any of those things? Mr. Pagluka. Objection, form and foundation. To the extent any of this is asking for you to acknowledge any consensual sex act that may or may not have involved you, I'm instructing you not to answer the question. Question. I'm not asking about consensual sex acts. I'm asking whether any of the massage therapists performed sexual acts for Mr. Epstein, as I have just described. Answer. I have never seen anybody have sexual intercourse with Jeffery, ever. Question. I'm not asking about sexual intercourse. I'm asking about any sexual act, touching of the breast. Did you ever see? Can you read back the question? Record read. Answer. I'm not addressing any questions about consensual adult sex. If you want to talk about what the subject matter, which is defamation and lying, Virginia Roberts, that you and Virginia Roberts are participating in perpetuating her lies, I'm happy to address those. I never saw any inappropriate underage activities with Jeffery ever. Question. I'm not talking about underage. I'm asking about whether any of the masseuses that were at the home performed sexual acts for Jeffery Epstein. Answer. I have just answered the question. Question. No, you haven't. Answer. I have. Question. No, you haven't. Answer. Yes, I have. Question. You are refusing to answer the question? Answer. Let's move on. Question. I'm in charge of the deposition. I say when we move on and when we don't. You are here to respond to my questions. If you are refusing to answer, the court will bring you back for another deposition to answer these questions. Do you understand that? Mr. Pegluka, you don't need to threaten the witness. Ms. Macaulay, I'm not threatening her. I'm making sure the record is clear. Mr. Pegluka, certainly, can you apply to have somebody come back and the court may or may not have her come back again? Again, she is not answering questions that relate to adult consent, sex acts, period. And that's the instruction, and we can take it up with the court. Question. Ms. Maxwell, are you aware of any sexual acts with masseuses and Jeffery Epstein that were non-consensual? Answer. No. Question. How do you know that? Answer. All the time that I have been in the house, I have never seen, heard, nor witnessed, nor have reported to me that any activities took place. That people were in distress, either reported to me by the staff or anyone else. I base my answer based on that. Question. Are you familiar with a person by the name of Annie Farmer? Answer. I am. Question. Has Annie Farmer given a statement to police about you performing sexual acts on her? Answer. I have not heard that. Question. Has Annie Farmer given a statement to police about Jeffery Epstein performing? Question. Did you have sex with her? Mr. Pegluka, this is the same instruction about consensual or non-consensual. Question. Was Emmy under the age of 18 when you hired her? Answer. No, I didn't hire her. As I said, Jeffrey did. Question. Did Emmy ever have sex with Jeffrey? Mr. Pegluka. Objection to the form and foundation. Answer. How would I know what somebody else did? Question. You weren't involved in the sex between Jeffrey, Emmy, and yourself? Answer. We already... Question. Were you involved with sex between Jeffrey, Emmy, and yourself? Mr. Pegluka. Everyone is talking over each other. You heard the question. Again, you know what the instruction is. If there is any consensual issue involved, I instruct you not to answer. Answer. Moving on. Question. So you are refusing to answer that question? Answer. I have been instructed by my lawyer. Question. Did you ever have sex with Jeffrey, Emmy, Virginia, and yourself when Virginia was underage? Answer. Absolutely not. Mr. Pegluka, we've been going for about an hour. I would like to take a 5-minute break, please. Ms. Macaulay, I'm almost done. Mr. Pegluka, you are not going to allow a break? Ms. Macaulay, as soon as I get through my line of questioning, which is perfectly appropriate. Question. Did Emmy Taylor travel with you and Jeffrey to Europe? Answer. I'm sure she did. Question. What is she doing today? Answer. I have no idea. Question. Did you train Virginia on how to recruit other girls to perform sexual massages? Mr. Pegluka. Objection to the form and foundation. Answer. No. And it's absurd, and her entire story is one giant tissue of lies. And furthermore, she herself has... If she says that, you have to ask her about what she did. Question. Does Jeffrey... they need to stop throwing this one at me. Question. Does Jeffrey like to have his nipples pinched during sexual encounters? Mr. Pegluka. Objection to form and foundation. Answer. I'm not referring to any advice on my counsel. I'm not talking about any adult sexual things when I was with him. Question. When Jeffrey would have a massage, would he request that the masseuse pinch his nipples While he was having a massage. Answer. I'm not talking about anything with consensual adult situation. Question. What about with underage? Answer. I am not aware of anything. Question. You are not aware of Jeffery. Question. In your responsibilities in working for Jeffery, would you book massages for him on any given day so that he would have a massage scheduled? Would you take a call, for example, and book a massage for him? Mr. Pegluka. Objection to the form and foundation. Question. You can answer. Answer. Typically, that was not my responsibility. He would either book the massage himself, or one of his other assistants would do that. Question. From time to time, you had to do that? Mr. Pegluka. Objection to the form and foundation. Answer. Like I said, typically it was somebody else's responsibility. Question. If you are unable to book a girl for a massage on a given day, would that mean that you are responsible for giving him a sexual massage? Mr. Pegluka. Objection to the form and foundation, and I instruct you not to answer any questions about any of your consensual adult sexual activity. Question. So you are not going to answer that question? Answer. You just heard my counsel. Question. Have you ever said to anybody that recruiting other girls to perform sexual massages for Jeffery Epstein takes the pressure off you? Mr. Pegluka. Objection to the form and foundation. Answer. Repeat the question and break it out. Question. Have you ever said to anybody that you recruit girls? Answer. Stop right there. I never recruited girls. Let's stop there. Now break down the question. Question. Have you ever said to anybody? Answer. By girls, we are talking about underage people. You said girls. Are you talking about underage? We are not talking about consensual acts. This is a defamation suit. The flights? Answer. I cannot recollect having a meal with them, but just so we are clear, the allegations that Clinton had a meal on Jeffrey's Island is 100% false. Question. But he may have had a meal on Jeffrey's plane. Answer. I'm sure he had a meal on Jeffrey's plane. Question. You do know how many times he flew on Jeffrey's plane? Answer. I don't. Question. Do you know who Doug Band is? Answer. I do. Question. How do you know him? Answer. He used to work or still works for Bill Clinton. Question. Have you ever had a relationship with him? Answer. We are talking about adult consensual relationships. It's off the record. Question. I'm not asking what you did with him. I'm asking if you ever had a relationship with him. Mr. Pegluka. If you understand the term relationship, certainly you can answer that. Answer. Define relationship. Question. Somebody that you would have spent time together, either seen them in a romantic relationship or... Answer. You need to be. What do you mean by romantic? I was friends with Doug, but you are suggesting something more, so I want to be clear what you are actually asking me. Question. You defined it. You said you were friends with him. If that's what you were, that's all I need to know. While you were on the trip with President Clinton, do you recall where you stayed at these locations? In other words, would you leave the jet and stay overnight at a hotel? Do you have a recollection of this trip? Answer. I recollect the trip, but if you're asking me where we stayed, you can see it's a very fast-paced trip. It was very tiring, and... Form and foundation. Answer. I don't know why the name is... I'm sorry, I can't. I have no idea. I recognize the name, but that's it. Question. Was Johanna Sjoberg a masseuse? Mr. Pegluka. Objection to the form and foundation. Answer. What are you asking me? I'm sorry. Question. When Johanna Sjoberg worked for Jeffery Epstein, did she perform massages? Answer. I've testified that when Johanna came originally, she came to answer telephones. I believe at some point she became a masseuse. I don't recollect when, and I personally had massages from Johanna. Question. What did Johanna do for Jeffery Epstein? Did she perform massages? Anything else? Mr. Pegluka. Objection to the form and foundation. Answer. When she came, she answered phones, and at some point, I believe, I don't have any firm recollection, but I believe she went to school and became a masseuse. And I had massages from her. Question. Did you ever have any sexual interaction with her? Mr. Pegluka. Object to the form and foundation, and I'm going to instruct you if we're talking about any consensual adult contact, you are not allowed to answer the question. Question. Did you have any sexual contact with her in the presence of Jeffery Epstein? Mr. Pegluka. Same instruction. Question. Did you have any sexual contact with her in the presence of anybody other than Jeffery Epstein? Mr. Pegluka. Same instruction. Question. How many massages did you receive from Johanna? Answer. I really don't recall, but a fair amount. Question. Did the massages involve sex? Mr. Pegluka. I'm going to instruct you not to answer. Question. Have you ever engaged in sex with any female? Mr. Pegluka. I'm going to instruct you not to answer. Ms. Macaulay. I want the record to reflect that Ms. Maxwell's attorney is directing her not to answer these series of questions. Mr. Pegluka. It definitely does. Question. Were you responsible for introducing Anushka to Jeffery Epstein? Mr. Pegluka. Objection to the form and foundation. Answer. I already testified that I don't really recall Anushka. Question. Were you responsible for introducing Johanna to Jeffery Epstein? Mr. Pegluka. Objection to the form and foundation. Answer. Again, I don't like the characterization of introduction. Johanna came to answer telephones. Question. When did you... Were you the person who brought or introduced or met Johanna for purposes of bringing her to Jeffery Epstein's home? Composite Exhibit A. United States District Court, Southern District of New York. Virginia L. Joffrey, Plaintiff. Case number 15 CV 07433 RWS. Against Ghislaine Maxwell. Defendants. Confidential. Videotaped deposition of Ghislaine Maxwell, taken pursuant to subpoena, was held at the law offices of Boyce, Schiller, and Flexner, 595 Lexington Avenue, New York, New York, commencing April 22, 2016, 9:04 a.m., on the above date before Leslie Fagan, a court reporter and notary public in the state of New York. Questions about people under the age of 18 at Epstein's home. Question. You can answer. Answer. I have not any idea exactly of the youngest adult employee that I hired for Jeffery. Question. When you say adult employee, did you ever hire someone that was under the age of 18? Answer. Never. Question. Did you ever bring someone who was invite someone under the age of 18 to Jeffery's home? Any of his homes? Mr. Pegluka. Object to the form foundation. Answer. Can you repeat the question? Question. Did you ever invite anybody who was under the age of 18 to Jeffery's homes? Mr. Pegluka. Same objections. Answer. I have a number of friends that have children, and friends of mine that have kids, and in the invitation of my friends and their kids, I'm sure I may have invited some of my friends' kids to come. Question. Anybody that is not a friend of yours? Questions about meeting the plaintiff and massages with plaintiff. Answer. Miss Roberts held herself out. Question. I'm not asking how she held herself out. I'm asking how she arrived at the home. Did you meet her and invite her to come to the home, or how did she arrive there? Mr. Padgluka. Object to the form and foundation. Answer. Miss Roberts held her to be a masseuse, and her mother drove her to the house. Question. When did you first meet Virginia Roberts? Answer. I don't have a recollection of the first meeting. Question. Do you recall meeting her at Mar-a-Lago? Answer. Like I said, I don't have a recollection of meeting Miss Roberts. Question. So you recall Miss Roberts being brought to the home by her mother. Is that your testimony? Answer. That is my testimony. Question. And that is the first time you met her? Answer. Like I said, I don't recall meeting her the first time. I do remember her mother bringing her to the house. Question. Are you a member at Mar-a-Lago? Answer. No. Question. Have you visited Mar-a-Lago? Answer. Yes. Question. Did you visit Mar-a-Lago in the year 2000? Answer. I'm pretty sure I did. Question. When Miss Roberts arrived at the home with her mother, what happened? Answer. I spoke to her mother outside of the house and she... What I don't recall is exactly what happened because I was talking to her mother the entire she was in the house. Question. Did you introduce Miss Roberts to Jeffery Epstein? Answer. I don't recall how she actually met Mr. Epstein. As I said, I spoke to her mother the entire time outside the house. Question. Did you walk Miss Roberts up to the upstairs location at the Palm Beach house too? Absolutely everything that took place in that first meeting. She has lied repeatedly, often, and is just an awful fantasist. So very difficult for anything to take place that she repeated because I was with her mother the entire time. Question. So, did you give a massage with Virginia Roberts and Mr. Epstein during the first time Virginia Roberts was at the West Palm Beach house? Mr. Pegluka. Object to the form and foundation. Question. Yes or no? Answer. No. Question. Have you ever given a massage with Virginia Roberts in the room and Jeffery Epstein? Mr. Pegluka. Object to the form and foundation. Answer. No. Question. Have you ever given Jeffery Epstein a massage? Mr. Pegluka. Object to the form, foundation. And I'm going to instruct. Questions about massages with minors. Questions. Mr. Pegluka. I'm instructing her not to answer. Ms. Macaulay. Then we will be back here again. Question. Have you ever given a massage to Mr. Epstein with a female that was under the age of 18? Answer. Can you repeat the question? Question. Yes. Have you ever given a massage to Mr. Epstein with a female that was under the age of 18? Answer. No. Question. Have you ever observed Mr. Epstein having a massage given by an individual, a female, who was under the age of 18? Answer. No. Question. Have you ever observed females under the age of 18 in the presence of Jeffery Epstein at his home? Mr. Pegluka. Object to the form and foundation. Answer. Again, I have friends that have children. Questions about hiring massage therapists. Just another one of Virginia's many fictitious lies and stories to make this a salacious event to get interest and press is absolute rubbish. Question: were you in charge of hiring individuals to provide massages for Jeffery Epstein? Answer: my job included hiring many people. There were 6 homes. As I sit here, I hired assistants, I hired architects, I hired decorators, I hired cooks, I hired cleaners, I hired gardeners, I hired pool people, I hired pilots, I hired all sorts of people. In the course, and a very small part of my job was, from time to find adult professional massage therapists for Jeffery. Question: when you say adult professional massage therapists, where did you find these massage therapists? Answer: from time to time I would visit professional spas. I would receive a massage, and if the massage was good, I would ask that man or woman if they did home visits. Questions about redacted. And Nadia Marsakova. Here today, I do not. Question: Ms. Maxwell, when did you first meet redacted? Mr. Pegluka, object to the Foreman Foundation. Answer: I have no idea when I met her. Question: do you know how old she was when you met her? Answer: I have no idea how old she was when I met her. Question: is it possible she was 13 years old when you first met her? Mr. Pegluka, object to the Foreman Foundation. Answer: redacted. May have been in the house when Jeffery was in the house. I have no idea how old she was. Question: I understand she was with redacted. I'm asking if redacted was 13 years old when you first met her. Answer: I have no idea. Question: was she under 18 when you first met her? Answer: I have no idea how old she was when I first met her. Question: did she look like a child when you first met her? Answer: I don't remember what she looked like at the time she was in the house. Question: how many years have you known her? Answer: I can only recall the last time I saw her. Question: when was the first time you met her? Answer: again, I just told you, I don't recall the first time I met her. Question: did redacted travel with you on Jeffrey's planes? Answer: I wouldn't remember if redacted was on the plane or not. Question: did you ever have sex with redacted? Answer: no. Question: did you ever observe Jeffery having sex with redacted? Answer: no. Question: were you aware that Jeffery was having sexual contact with redacted when she was 13 years old? Mr. Pegluka, object to the Foreman Foundation. Answer: I would be very shocked and surprised if that were true. Question: were you in the house when redacted was in the house in a private area with Jeffery Epstein? Mr. Pegluka, object to the Foreman Foundation. Answer: can you repeat the question? Question: were you ever in the Palm Beach house when Jeffery Epstein was in the house with redacted? Mr. Pegluka, object to the Foreman Foundation. Answer: I've already testified that I have met her and that she was there, redacted. I don't understand what your question is asking. Question: so you have never seen redacted? Mr. Pegluka, object to the Foreman Foundation. Question: is that your testimony? Answer: I already said I don't recall all the times I've seen her, and I have no memory of that. Question: Have you ever seen redacted in the house with Jeffery Epstein redacted? Mr. Pegluka. Object to the form and foundation. Answer. I just told you I don't recall seeing redacted. Question. Were you ever involved in an orgy with redacted? Answer. No, absolutely not. Question. Can you tell me, do you know an individual by the name of Nadia Marcinkova? Answer. I do. Question. How did you meet Nadia Marcinkova? Answer. At some point she was a friend of Jeffrey's, and I recall meeting her at some point. Question. Did Jeffrey arrange for a visa for Nadia Marcinkova? Answer. I don't know what Jeffrey did. I cannot testify what Jeffrey did. Question. Was Nadia involved in sex with Jeffrey and other girls? Mr. Pegluka. Object to the form and foundation. Question. Girls under the age of 18. Mr. Pegluka. Same objection. Answer. I have no idea. Question. Was Nadia involved with sex with Jeffrey and girls over the age of 18? Mr. Pegluka. Same objection. Answer. I have no idea. Question. Did Nadia recruit other girls for sex with Jeffrey? Mr. Pegluka. Object to the form and foundation. Answer. I have no idea. Question. Do you still talk to Nadia? Answer. No. Question. Is she a pilot? Answer. I have no idea. Questions about Mr. Epstein and sex. Acts. I'm asking whether any of the massage therapists perform sexual acts for Mr. Epstein, as I have just described. Answer. I have never seen anybody have sexual intercourse with Jeffrey ever. Question. I'm not asking about sexual intercourse. I'm asking about any sexual act. Touching of the breast. Did you ever see... Can you read back the question? Record read. Answer. I'm not addressing any questions about consensual adult sex. If you want to talk about what the subject matter, which is defamation and lying, Virginia Roberts, that you and Virginia Roberts are participating in, perpetuating her lies, I'm happy to address those. I never saw any inappropriate underage activities with Jeffrey ever. Question. I'm not asking about underage. I'm asking about whether any of the masseuses that were at the home performed sexual acts for Jeffrey Epstein. Answer. I have just answered the question. Question. No, you haven't. Questions about Sarah Kellen, Glenn Dubbin, Plaintiff, Johanna Sjoberg, Annie Farmer, and sex. Answer. I have. Question. No, you haven't. Answer. Yes, I have. Question. You are refusing to answer the question. Answer. Let's move on. Question. I'm in charge of the deposition. I say when we move on and when we don't. You are here to respond to my questions. If you are refusing to answer, the court will bring you back for another deposition to answer these questions. Do you understand that? Mr. Pegluka, you don't need to threaten the witness. Ms. Macaulay, I'm not threatening her. I'm making sure the record is clear. Mr. Pegluka, certainly. Can you apply to have someone come back, and the court may or may not have her come back again? Again, she is not answering questions that relate to adult consent, sex acts, period. And that's the instruction, and we can take it up with the court. Question. Ms. Maxwell, are you aware of any sexual acts with masseuses and Jeffrey Epstein that were non-consensual? Answer. No. Question. How do you know that? Answer. All the time that I have been in the house, I have never seen, heard, nor witnessed, nor have reported to me that any activities took place, that people were in distress, either reported to me by the staff or anyone else. I base my answer based on that. Question. Are you familiar with a person by the name of Annie Farmer? Answer. I am. Question. Has any farmer given a statement to police about you performing sexual acts on her? Answer. I have not heard that. Question. Has any farmer given a statement to police about Jeffery Epstein performing... Asked and answered already. Question. You can answer the question. Answer. I have no idea what Sarah Kellen did. Question. You never observed Sarah Kellen with girls under the age of 18 at Jeffrey's home. Mr. Pagluka. Object to the Foreman Foundation. Answer. The answer is no, I have no idea. Question. Do you know Glenn Dubbin? Answer. I do. Question. What is your relationship with Glenn Dubbin? Mr. Pagluka. Object to the form. Answer. What do you mean, what is my relationship? Question. Are you friendly with him? How do you know him? Answer. He is the husband of Eva Dubbin. Question. Is Eva Dubbin one of your friends? Answer. Yes. Question. Did you ever send Virginia to Glenn's condo at the Breakers to give him a massage? Mr. Pagluka. Objection to the Foreman Foundation. Answer. No. Question. Did you ever instruct Virginia Roberts to have sex with Glenn? Mr. Pagluka. Objection to the Foreman Foundation. Answer. I have never instructed Virginia to have sex with anybody else. Question. How old was Eva Anderson when she met Jeffrey? Mr. Pagluka. Objection to the Foreman Foundation. Answer. I have no idea. Question. What, she under the age of 18? Mr. Pagluka. Objection to the Foreman Foundation. Answer. I just testified I have idea how old she was. Question. You testified she was your friend. You don't know how old she was when she met Jeffrey? Answer. That happened sometime in the 70s. How would I know? Or 80s? I have no idea. Can you testify to what your friends did 30 years ago? Question. You don't ask the questions here, Miss Maxwell. What about Johanna Sjoberg? When did you first meet Johanna? Answer. I don't recall the exact date. Question. Did you hire Johanna? Answer. I don't hire people. She came to work at the house to answer phones. Question. Where did you meet her? Answer. I just testified I don't recall exactly when I met her. Question. Was one of your job responsibilities to interview people that would then be hired by Jeffrey? Answer. That was one of my responsibilities. Question. Do you recall interviewing Johanna? Answer. I don't recall the exact interview, no. Question. Do you know what tasks Johanna was hired to performance? Answer. She was tasked to answer telephones. Question. Did you ever ask her to rub Jeffrey's feet? Mr. Pagluka. Objection to the Foreman Foundation. Answer. I believe that I have read that, but I don't have any memory of it. Question. Did you ever tell Johanna that she would get extra money if she provided Jeffrey massages? Answer. I was always happy to give career advice to people, and I think that becoming somebody in the healthcare profession, either exercise instructor or nutritionist, or professional massage therapist, is an excellent job opportunity. Hourly wages are around $7, $8, $9, and as a professional healthcare provider, you can earn somewhere between, as we have established, $100 to $200, and to be able to travel and have a job that pays, that is a wonderful job opportunity. So in the context of advising people for opportunities for work, it is possible that I would have said that she should explore that as an option. Question. Did you tell her she would get extra money if she massaged Jeffrey? Answer. I'm just saying, I cannot recall the exact conversation. I give career advice, and I have done that. Question. Did you ever have Johanna massage you? Answer: I did. Question: How many times? Answer: I don't recall how many times. Question: Was there sex involved? Answer: No. Question: Did you ever instruct Johanna to massage Glenn Dubbin? Answer: I don't believe. I have no recollection of it. Question: Did you ever have sexual contact with Johanna? Mr. Pegluka, object to the Foreman Foundation. You need to give me an opportunity to get in between the questions. Anything that involves consensual sex on your part, I'm instructing you not to answer. Question: Did you ever have sexual contact with Johanna? Answer: Again, she is an adult. Question: I'm asking you, did you ever have sexual contact with Johanna? Answer: I've just been instructed not to answer. Question: On what basis? Answer: You'll have to ask my lawyer. Question: Did you ever have sexual contact with Johanna that was not consensual on Johanna's part? Mr. Pegluka, you can answer non-consensual. Answer: I've never had non-consensual sex with anybody. Question: Not Annie Farmer? Mr. Pegluka, objection. Answer: I just testified I never had non-consensual sex with anybody else, at any time, at any place, at any time, with anybody. Question: So if Johanna were to testify that she did not consent to a sexual act that you participated in? Answer: I just told you I have never, ever, under any circumstances, with anybody, at any time, in any place, in any form, had non-consensual relations with anybody. Question: Did you introduce Johanna to Prince Andrew? Mr. Pegluka, objection to the Foreman Foundation. Answer: I've again read that Johanna claimed that she met, or that she said she met Prince Andrew. I don't know if I was the one who made the introduction or not. Question: Do you know a female by the name of Emmy Taylor? Answer: I do. Question: How do you know her? Answer: Emmy was my assistant. Question: So she worked for you? Answer: Yes. Question: Did you hire her? Answer: Again, Jeffrey hired people. Questions about Emmy, Virginia, and Miss Maxwell regarding sex. Consensual issue involved. I instruct you not to answer. Answer: Moving on. Question: So you are refusing to answer that question? Answer: I've been instructed by my lawyer. Question: Did you ever have sex with Jeffrey, Emmy, Virginia, and yourself when Virginia was underage? Answer: Absolutely not. Mr. Pegluka, we've been going for about an hour. I would like to take a 5-minute break, please. Ms. Macaulay, I'm almost done. Mr. Pegluka, you are not going to allow a break? Ms. Macaulay, as soon as I get through my line of questioning, which is perfectly appropriate. Question: Did Emmy Taylor travel with you and Jeffrey to Europe? Answer: I'm sure she did. Question: What is she doing today? Answer: I have no idea. Questions about outfits and sex toys. About. Question: So you didn't provide her with that? Answer: As I just testified, I have no idea what you are talking about. Question: I was trying to interpret whether you didn't understand what a schoolgirl outfit was, or if you are saying that didn't happen. Answer: I clearly know what a schoolgirl outfit is. I have no recollection of providing anybody with a schoolgirl outfit. Question: Did you have a set of outfits used by the massage therapists that would include things like a schoolgirl outfit or a black patent leather outfit, or anything of that nature? Mr. Pegluka, object to the Foreman Foundation. Answer: That would be just another one of Virginia's lies. Question. You didn't have anything like that. Answer. I did not. Question. Did you have a basket of sex toys that you kept in the Palm Beach house? Mr. Pegluka. Objection to the form and foundation. Answer. First of all, what do you mean? Question. A laundry basket that contains sex toys in it. Mr. Pegluka. Objection to the form and foundation. Answer. Can you ask the question again? Question. Did you have a laundry basket that contains sex toys in it in the Palm Beach house? Mr. Pegluka. Objection to the form and foundation. Question. Did you have a laundry basket of sex toys in the Palm Beach house? Mr. Pegluka. Same objection. Question. You can answer. Answer. I don't recollect anything about a laundry basket of sex toys. Question. Do you recollect having sex toys at the Palm Beach house? Answer. You have to define what you are talking about. Questions about plaintiff and Epstein and sex. Question. Do you recall having a basket full of sex toys? Answer. I already told you I did not. Question. We were talking a moment ago about Ms. Roberts and her position as a masseuse. Do you know what she was paid for working as a masseuse for Jeffery Epstein? Answer. I do not. Question. Did you ever pay her? Answer. I don't ever recall paying her. Question. Do you know what happened during the massage appointments with Jeffery Epstein and Virginia Roberts? Mr. Pegluka. Objection to the form and foundation. Answer. No. Question. Were you ever present to view a massage between Jeffery Epstein and Virginia Roberts? Answer. I don't recollect ever seeing Virginia and Jeffery in a massage situation. Question. Do you ever recollect seeing them in a sexual situation? Answer. I never saw them in a sexual situation. Question. Did you ever participate in sex with Virginia Roberts and Jeffery Epstein? Answer. I never ever, at any single time, at any point, ever at all participated in anything with Virginia and Jeffery. And for the record, she is an absolute total liar. And you all know she lied on multiple things, and there is just one other disgusting thing she added. Question. Did you help her obtain an apartment in Palm Beach to live in? Mr. Pegluka. Objection to the form and foundation. Question. Was that part of your responsibilities for Jeffery? Answer. First of all, I didn't know she had an apartment in Palm Beach. I only learned that from the many times you guys have gone to the press to sell stories. So no. Question. Did you help her get a cell phone? Was that one of your responsibilities for Jeffery? To get her a cell phone as part of her masseuse obligations? Questions about training plaintiff to recruit girls for massages. Form and foundation. Answer. Like I told you, I don't recall her being at the house at all. Question. How many homes does Jeffery have? Mr. Pegluka. Objection to the form and foundation. Answer. When I was working for him, I think he had 6 maybe. Question. Will Virginia stay with him in those homes? Mr. Pegluka. Objection to the form and foundation. Answer. I can only testify for when I was present with him, and I cannot say what she did when I wasn't present with him. Question. When you were present, would Virginia stay in the house with him? Answer. I don't recall her staying in the houses. Question. Did you train Virginia on how to recruit other girls for massages? Mr. Pegluka. Objection to the form and foundation. Answer. No. Question. Did you train Virginia on how to recruit other girls to perform sexual massages? Mr. Pegluka. Objection to the form and foundation. Answer. No. And it's absurd, and her entire story is one giant tissue of lies. And furthermore, she herself has. If she says that, you have to ask her about what she did. Question. Does Jeffrey like to have his nipples pinched during sexual encounters? Mr. Pagluka. Objection to form and foundation. Answer. I'm not referring to any advice on my counsel. I'm not talking about any adult sexual things when I was with him. Question. When Jeffrey would have a massage, would he request that the masseuse pinch his nipples while he was having a massage? Answer. I'm not talking about anything with consensual adult situations. Question. What about with underage? Answer. I am not aware of anything. Question. You are not aware of Jeffrey? Questions about Ms. Maxwell's relationship with Mr. Epstein. Has perpetrated. Cannot tell you what is true or factual or not. Question. You said you were in the home a very limited time. So average in the year, for example, 2004. How many times would you have been in his Palm Beach home? Answer. Very hard for me to state, but very little. Question. How about his New York home? Answer. Same. Were you his girlfriend in that year, in 2004? Answer. Define what you mean by girlfriend. Question. Were you in a relationship with him where you would consider yourself his girlfriend? Answer. No. Question. Did you ever consider yourself his girlfriend? Answer. That's a tricky question. There were times when I would have liked to think of myself as his girlfriend. Question. When would that have been? Answer. Probably in the early 90s. Questions about recruiting girls. An underage girl in London, and foreign girls. Answer. First of all, I resent and despise the word recruit. Would you like to define what you mean by recruit and by girls? You mean underage people. I never had to do anything with underage people, so why don't you re-ask the question in a way that I am able to answer it? Question. I'm asking if you ever said that to anybody. So if you don't understand the word recruit, and you never use that word, then the answer to that question would be no. Answer. I have no memory as I sit here today, having used that word. Question. Did you ever meet an underage girl in London to introduce her to Jeffrey, to provide him with a massage? Mr. Pagluka. Objection to the form and foundation. Answer. Run that past me one more time. Question. Did you ever meet an underage girl in London to introduce her to Jeffrey to perform a massage? Mr. Pagluka. Same objection. Answer. Are you asking me if I met anybody that was underage in London specifically to provide a massage to Jeffrey? Is that your question? Question. Yes. Answer. No. Question. Do you know who Alexander Dixon is? Answer. I don't recall her right now. Question. Do you know if... Strike that. During the time that you were working for Jeffrey, did you ever observe any foreign females, so in other words, not from the United States, that were brought to Jeffrey's home to perform massages? Mr. Pagluka. Objection to the form and foundation. Answer. Females, what age are we talking? Question. Any age. Answer. Can you repeat the question? Question. During the time you were working for Jeffrey, did you ever observe any foreign females of any age that were at Jeffrey's home to perform a massage? Mr. Pagluka. Objection to the form and foundation. Answer. Are you asking me if any foreigner, not an American person, gave Jeffrey a massage? Question. Yes. Answer. Well, as I sit here today, I can't think of anyone who is foreign. Certainly. I just can't think of anybody right this second. Question. How about any foreign girls who are under the age of 18? Answer. I already testified to not knowing anything about underage girls. Question. Were there foreign girls who were brought to Jeffrey's home by Jean-Luc Brunel for the purposes of providing massages? Mr. Pagluka, objection to the form and foundation. Answer. I am not aware of Jean-Luc bringing girls. I have no idea what you are talking about. Question. You have never been around foreign girls who are under the age of 18 at Jeffrey's homes. Mr. Pagluka, objection to the form and foundation. Answer. I already testified about not knowing about underage girls. Question. Did you provide any assistance with obtaining visas for foreign girls that were under the age of 18? Answer. I've never participated in helping people of any age to get visas. Question. Was it Jeffrey's preference to start a massage with sex? Mr. Pagluka. Objection to the form and foundation. Answer. I think you should ask that question of Jeffrey. Question. Do you know? Answer. I don't believe that was his preference. I think, you have to understand, a massage. Perhaps you are not really familiar with what massage is. Question. I am. I don't need a lecture on massage. Answer. I think you do. Mr. Pagluka. No question pending. She will ask you another question now. Questions about underage girls, sex with Jean-Luc Brunel, and outfits. Question. Were you present on the island when Prince Andrew visited? Answer. Yes. Question. How many times? Answer. I can only remember once. Question. Were there any girls under the age of 18 on the island during that one visit that you remember, that were not family or friends of or daughters of your friends? Mr. Pagluka. Objection to the form and foundation. Answer. There were no girls on the island at all. No girls, no women, other than the staff who work at the house. Girls meaning, I assume you were asking underage, but there was nobody female outside of the cooks and the cleaners. Question. Did you, as part of your duties in working for Jeffrey, ever arrange for Virginia to have sex with Jean-Luc Brunel? Mr. Pagluka. Objection to the form and foundation. Answer. Just for the record, I have never at any time, at any place, in any moment, ever asked Virginia Roberts, or whatever she is called now, to have sex with anybody. Question. Did you ever provide Virginia Roberts with an outfit of a sexual nature, to wear for Les Waxner? Mr. Pagluka. Objection to the form and foundation. Answer. I think we addressed the outfit issue. Question. I am asking you if you ever provided her with an outfit of a sexual nature to wear for Les Waxner. Answer. Categorically no. You did get that. I said categorically no. Question. Don't worry. I'm paying attention. Answer. You seem very distracted in that moment. Maxwell Exhibit 6. Flight logs. Marked for identification. Answer. Do you mind if I take a break for the bathroom? Question. It's 11:08 and we are going to go off the record now. The videographer. It's now 11:09. Questions about pictures of naked girls. People could use, just like you would use if you needed to go online to get something, that people could use. Question. Was that on a desk that you would use in your work capacity when you were at the house? Answer. It was a desk. It was a room. I didn't really use that computer. Question. Were there images of naked girls, whether they be under the age of 18 or over the age of 18, on that computer? Answer. I have no recollection of any naked people on that computer. When I was there in 2003, we are talking. Question. What about from, say, 1999 to 2003? Answer. No, I can't recollect any naked pictures. Question. Why were the computers removed from the house before the search warrant was executed? Mr. Pagluka. Objection to the form and foundation. Answer: I have no knowledge of anything like that. Questions about topless females. Foreman Foundation. Answer: I mean, I've been to his... In the mid-90s, I would have communicated with people who work for him. Question: Have you communicated with Leslie Wexner about this case? Answer: No. Question: Have you ever seen a topless female at any one of Jeffrey Epstein's properties? Mr. Pegluka. Objection to the Foreman Foundation. You've asked this question, by the way, earlier on today. Answer: Again, I testified that there are people who, from time to time, in the privacy of a swimming pool, have maybe taken a bikini top off or something, but it's not common, and certainly when I was at the house, I don't really recollect seeing that kind of activity. Question: Have you ever smoked cigarettes? Answer: Yes. Question: Have you ever smoked cigarettes with Virginia Roberts? Answer: I don't recall smoking cigarettes. United States District Court, Southern District of New York. Virginia L. Jeffery, Plaintiff. Case number 15CV07433 RWS. V. Ghislaine Maxwell, Defendant. Plaintiff's unredacted reply in support of motion to compel defendant to answer deposition questions. Plaintiff Virginia Jeffery, by and through her undersigned counsel, hereby files this reply in support of her motion to compel defendant to answer deposition questions. Instead of allowing Miss Jeffery to take a full and complete deposition, defendant flatly refused to answer questions critical to the key issues in this case. Contrary to defendant's assertions, Miss Jeffery is not engaged in a fishing expedition, but rather seeks to ask highly focused questions specifically relevant to this case. In particular, Miss Jeffery seeks to ask the defendant questions regarding her participation in or knowledge of sexual activities connected with Jeffrey Epstein's sexual abuse of females. Such questions are entirely appropriate in the discovery phase of this case, particularly when any answers will be maintained as confidential under the protective order entered in this case. As the court is aware from previous pleadings, at the heart of this case lies the issue of defendant's knowledge that Miss Jeffery was sexually abused by Jeffrey Epstein. Indeed, as the defendant boldly acknowledges in her response, at Part 2, she intends to argue at trial that, among other things, she never arranged for or asked Miss Jeffery to have sex with anyone. At trial, Miss Jeffery intends to strongly disprove defendant's false assertions and to demonstrate that defendant recruited Miss Jeffery to be involved in massages of a sexual nature with Epstein. To develop evidence to support her position, Miss Jeffery recently deposed defendant about the central subjects in her case. Defendant flatly refused to answer a number of questions, and for the majority of the others gave varying reasons of "I don't recall." For example, when faced with a police report which contains statements from approximately 30 different victims during a time frame which the defendant acknowledges she was actively working for Epstein at his various homes, defendant challenged the veracity of the victims' reports. Question: Are you saying these 30 girls are lying when they gave these reports to police officers? Answer: I'm not testifying to their lies. I'm testifying to Virginia's lies. See Declaration of Sigrid Macaulay. Macaulay Declaration at Exhibit 1, April 22, 2016. Deposition of defendant at Part 89 to 90, 83 to 84. While defendant was working with Epstein during the time period when these underage girls were visiting Jeffrey's home, defendant claimed to be at the house maybe once in 2005, ID at Part 84. Yet, according to flight manifests, in that same general time period, defendant was listed as a passenger at least 11 times, either landing in or departing from West Palm Beach, Florida, on Jeffrey Epstein's private plane. See Macaulay Deal at Exhibit 1, April 22, 2016, Depo TR at Part 84. See also Macaulay Decal at Composite Exhibit 2, Flight logs from Jeffrey Epstein's private planes. Moreover, again, according to flight logs, defendant was on Epstein's planes over 300 times, including 23 times with Miss Jeffery, when Miss Jeffery was underage. Yet, quite remarkably, defendant claimed she couldn't recall even one of those flights. See Macaulay Deal at Exhibit 1, April 22, 2016, Deposition of Defendant at Part 120 to 122. Defendant even testified that she did not recall having Miss Jeffery at her London town home with Prince Andrew. Defendant stuck to this incredible story despite flight logs establishing her travelling to London with Miss Jeffery, and despite a photograph of the three, Miss Jeffery, Prince Andrew and defendant, all standing together in defendant's home. See Macaulay Deal at Exhibit 1, April 22, 2016, Deposition of Defendant, at Part 108 to 111. Defendant's deposition consisted almost entirely of "I don't recalls" or "I refuse to answer that question," and also included a physical outburst that knocked the court reporter's computer off the conference room table. See Macaulay Decal at Exhibit 1, April 22, 2016, Deposition of Defendant, at 207 to 208. Among the many questions that defendant refused to answer at her deposition were a number of questions designed to show that defendant was well aware that, for Epstein, a massage was actually a code word, sexual activity, i.e. not a therapeutic massage, but rather activity that involved sexual gratification for Epstein. Defendant refused to answer all such questions, asserting that they involved private adult sexual relationships, which did not relate in any way to Miss Jeffery's claims, ID at Part 4. But defendant's involvement in such relationships with Epstein would show that she knew full well the fate that was in store for Miss Jeffery when she accepted defendant's invitation to come and provide massages to Epstein. Defendant admitted that she worked for Epstein from 1992 to 2009. See Macaulay Deal at. Note, for example, when asked, question, have you ever said to anybody that you recruit girls to take the pressure off you, so you won't have to have sex with Jeffery? Have you said that? Answer, you don't ask me questions like that. First of all, you are trying to trap me. I will not be trapped. You are asking me if I recruit. I told you no. Girls meaning underage. I already said I don't do that with underage people, and as to ask me about a specific conversation I had with language, we're talking almost 17 years ago when this took place. I cannot testify to an actual conversation or language that I used with anybody at any time. See Macaulay Decal at Exhibit 1, April 22, 2016, Depo TR at Part 94 to 95. Exhibit 1, April 22, 2016, Deposition of Defendant, at Part 10 to 11, 410. As the court knows, the Palm Beach police report demonstrates multiple incidents of massages being given by untrained minor children that involve sexual acts. See Macaulay Decal at Exhibit 3, Palm Beach Police Report. Defendant is also identified in that Palm Beach Police Report. See Macaulay Decal at Exhibit 3, Palm Beach Police Report at Part 75 to 76. And the details of Epstein's sexual activities with defendant, for example, are highly relevant to this case because they will help corroborate Miss Jeffery's testimony that while she was underage, she also engaged in sexual activity of an identical nature with Epstein. To allow defendant to avoid answering these questions would preclude Miss Jeffery from getting critical evidence in this case. Consider, for example, defendant recruiting an 18-year-old girl to be an assistant, bringing that girl to Epstein's home, telling her she could make more money if she would give Epstein a massage, and then instructing her to give a massage that involves sexual acts. Under defendant's theory of discovery, Miss Jeffery would be precluded from deposing her on that topic because the actions would culminate in consensual adult sex. Yet that scenario would fully validate the pattern of events that occurred with Miss Jeffery when she was under the age of 18. It would obviously show a modus operandi by Jeffery Epstein and defendant, which is clearly admissible under Fed R. Ivid 404b. Moreover, such inquiries are crucial to impeaching the defendant at trial. During her deposition, defendant attempted to characterize her work for Epstein as nothing more than a normal job handling hiring for the various mansions. See Macaulay Deal at Exhibit 1, April 22nd, 2016 Deposition TR of defendant at part 9 to 12. Ms. Jeffery should be able to contest that assertion by having defendant fully answer questions about whether that alleged job involved sexual activities, including orchestrating the hiring of females and converting massages into sexual encounters. Defendant attempts to paint the picture that Ms. Jeffery somehow is interested in all sexual relationships that the defendant may have been involved with. That is not true. Ms. Jeffery has no intention of asking unbridled questions. To be clear, Ms. Jeffery intends to ask defendant only questions that involve the following very narrow and crucial subject areas. 1. Defendant's sexual relationship with Epstein from 1992 to 2009, the time period in which she worked for Jeffery Epstein, and which Epstein, with the assistance of defendant, was engaging in sexual acts with females under the cover of massage. 2. Defendant's sexual interactions with any person in Epstein's presence during that time period. 3. Defendant's sexual activities at Epstein's residences, including his private island, Little St. Jeff's, or his aircraft during that time period. 4. Defendant's sexual activities with identified participants in Epstein's sexual abuse during that time period. And 5. Defendant's sexual interactions that occurred during or through what began as a massage. And 6. Defendant's interactions with females to introduce to Jeffrey Epstein for the purpose of performing work, including sexual massages. Defendant claims that such questions are a mere fishing expedition, without acknowledging the fact that these questions go to critical issues in this case. Other witnesses have testified regarding defendant's involvement in recruiting females for sex under the cover of a massage. During the investigation of Jeffrey Epstein, certain household staff was deposed. Alfredo Rodriguez, who was Jeffrey Epstein's household manager, testified that the defendant frequently stayed in Jeffrey Epstein's home and assisted with bringing in young girls to act as masseuses for Jeffrey Epstein. Question. Okay, going back to where we started here was, does Ghislaine Maxwell have knowledge of the girls that would come over to Jeffrey Epstein's house that are in roughly the same age group as C and T, minor children, and to have a good time, as you put it? Answer, yes. Question. Okay, going back to where we started here was, does Ghislaine Maxwell have knowledge of the girls that would come over to Jeffrey Epstein's house that are in roughly the same age group as C and T, minor children, and to have a good time, as you put it? Answer, yes. Question. And what was her involvement and or knowledge about that? Answer. She knew what was going on. See Macaulay Deal at Exhibit 4, Alfredo Rodriguez, July 29, 2009. Depart TR at 196 to 177. See also Macaulay Decal at Exhibit 4, Alfredo Rodriguez, July 29, 2009. Depo TR at 96 to 101. Noting that high school-age girls come to the home where Jeffrey Epstein and Ms. Maxwell reside. Juan Alessi, another household employee, also testified that young girls were regularly present at Jeffrey Epstein's home, where Ghislaine Maxwell resides. See Macaulay Decal at Exhibit 5. Juan Alessi, November 1st, 2005, sworn statement at Part 15 to 16 and 21. Specifically, Juan Alessi informed the Palm Beach police detective as follows. Alessi stated that towards the end of his employment, the masseuses were younger and younger. When asked how young, Mr. Alessi stated they appeared to be 16 or 17 years of age, at most. Emphasis added. See Macaulay Decal at Exhibit 3, Palm Beach Police Report, at Part 57. During Juan Alessi's November 21, 2005 sworn statement, taken by the Palm Beach Police Department, Mr. Alessi revealed that girls would come over to give massages, and he observed Miss Maxwell going upstairs in the direction of the bedroom quarters. See Macaulay Decal at Exhibit 5, Juan Alessi, November 21, 2005, sworn statement at 10. He also testified that after the massages, he would clean up sex toys that were kept in Ms. Maxwell's closet, ID at 11 to 13. See also Macaulay Decal at Exhibit 6, Juan Alessi, September 8, 2009, Depo TR at Part 76 to 77. He added that he and his wife were concerned with what was going on in the house, ID of 14, and that he observed girls at the house, including one named Virginia, ID at 21. Mr. Rodriguez also testified that defendant also had naked pictures of girls performing sexual acts on her computer. See Macaulay DeCarl at Exhibit 7, Alfredo Rodriguez, August 7th, 2009, Depart TR, at 311 to 312. See also Macaulay DeCarl at Exhibit 6, 1 Lessie, September 8th, 2009, Depo TR at Part 40 to 41. I know she, Maxwell, went out and took pictures in the pool because later on I would see them at the desk or at the house. And nude. 99.9% of the time they were topless. They were European girls. Question. Did they appear to be doing any sexual? Answer. Yes, ma'am. And in these instances, were there girls doing sexual things with other girls? Answer. Yes, ma'am. Question. And I'm still talking about the pictures on Miss Maxwell's computer. Answer. Yes, ma'am. Upon leaving his employment, Rodriguez testified that defendant threatened him that he should not tell anyone about what happened at the house. Answer. I have to say something. Mrs. Maxwell called me and told me not to ever discuss or contact her again in a threatening way. Question. When was this? Answer. Right after I left, because I called one of the friends for a job and she told me this, but, I feel intimidated, so I want to keep her out. Question. She made a telephone call to you, and what precisely did she say? Answer. She said, I forbid you, that I will be sorry if I contact any of her friends again. She says something like, don't open your mouth or something like that. I'm a civil humble. I came as an immigrant to service people, and right now you feel a little... I'm 55, and I'm afraid. First of all, I don't have a job. But I'm glad this is on tape because I don't want nothing to happen to me. This is the way they treat you. Better do this, and you shut up, and don't talk to nobody and... Question. When you say this is the way they treat, who specifically are you talking about when you say that word they? Answer. Maxwell. See Macaulay DeCarl at Exhibit 4, Alfredo Rodriguez, July 29, 2009, Dep TR at 169 to 172. In sum, at the core of this case are statements made by Miss Jeffery that she was recruited by defendant to be paid as a masseuse, yet was enticed or coerced into engaging in sexual acts with Epstein and defendant for money. She has further explained that the recruitment of females through the offer of some legitimate position was the typical way in which defendant and Epstein lured unsuspecting females to the house before converting the relationship into a sexual one. Miss Jeffery has described the frequency of these massages, the sexual tendencies of the participants, the manner in which the massages became sexual in nature, and defendant's role at each stage. In response, defendant has called Miss Jeffery's entire account untrue and obvious lies. Defendant has instead tried to portray her role as nothing more than an Epstein employee, performing typical household management duties. Any personal knowledge defendant has of Epstein's sexual tendencies, habits, and use of massage for sex is entirely relevant to either corroborate Miss Jeffery's account. Likewise, defendant's participation in any sexual acts with Epstein, in his presence, on his properties, using his mode of converting massages into sex, or with females will directly corroborate Miss Jeffery's account. On the other hand, without access to the answers to these inquiries, Miss Jeffery will be unable to expose the bias of defendant, unable to thoroughly cross-examine defendant's position that she was just a lowly employee, and most importantly unable to demonstrate, through the defendant's own admissions, that Miss Jeffery's statements about Epstein and defendant were absolutely true, and not obvious lies. Finally, defendant fails to recognize that, for the discovery purposes at issue here, relevance is an extremely broad concept. A.M. Ferren of Musicians of the United States and Canada v. Sony Music Entertainment Inc. Number 15CV05249 GBDBCM 2016 WL 2609-307 at 3, SDNY, April 29, 2016. And once relevance is shown, the party resisting discovery bears the burden of demonstrating that, despite the broad and liberal construction afforded the federal discovery rules, the requests are irrelevant, or are overly broad, burdensome, or oppressive. ID. Here the requests are not overly broad, as Ms. Joffrey's specific explanations of the targets of her questions make clear. Moreover, answering the questions is not oppressive, particularly given the fact that defendant has placed all substantive aspects of the deposition under seal. Of course, once defendant answers the question, and her answers are placed under seal, the parties can file any further motions that may be required to determine whether the answers may be introduced at trial. Conclusion. Defendant should be ordered to answer questions regarding sexual activity connected with Epstein's sexual abuse and sexual trafficking organization as specifically identified above. Date, May 11th, 2016. Respectfully submitted, Boyce, Schiller and Flexner LLP. Note: this daytime business address is provided for identification and correspondence purposes only and is not intended to imply institutional endorsement by the University of Utah for this private representation. Certificate of Service. I hereby certify that on the 11th day of May 2016, I electronically filed the foregoing document with the Clerk of Court by using the CM-ECF system. I also certify that the foregoing document is being served this day on the individuals identified below via transmission of notices of electronic filing generated by CM-ECF. Signed, Sigrid S. Macaulay. Exhibit 4. United States District Court, Southern District of Florida. Jane Doe No. 2. Plaintiff. Case number 08CV-80119 versus Jeffery Epstein. Defendant. Jane Doe No. 3. Case number 08CV-80232. Plaintiff versus Jeffery Epstein. Defendant. Jane Doe No. 4. Case number 08CV-80380. Plaintiff versus Jeffery Epstein. Defendant. Jane Doe No. 5. Case number 08CV-80381. Plaintiff versus Jeffery Epstein. Defendant. Jane Doe No. 6. Case number 08CV-08994. Plaintiff versus Jeffery Epstein. Defendant. Jane Doe No. 7. Case number 08CV-80993. Plaintiff versus Jeffery Epstein. Defendant. CMA. Plaintiff. Case number 08CV-80611 versus Jeffery Epstein. Defendant. Jane Doe. Redacted. Case number 08CV-80893. Plaintiff versus Jeffery Epstein. Defendant. Jane Doe No. 2. Case number 08CV-80469. Plaintiff versus Jeffery Epstein. Defendant. Jane Doe No. 101. Case number 09CV-80591. Plaintiff versus Jeffery Epstein. Defendant. Jane Doe No. 102. Case number 09CV-80656. Plaintiff versus Jeffery Epstein. Defendant. Videotaped deposition of Alfredo Rodriguez, taken on behalf of the plaintiffs pursuant to a re-notice of taking deposition. Dulces tessum. Answer: I don't remember, sir. Question: the next page is a message in the upper left dated January 13, 2005 from CW, correct? Answer: yes. Question: that's the same C that we've been talking about, correct? Answer: yes. Question: that was at 7:30 p.m., correct? Answer: yes. Question: and you don't recall what that particular call was about, right? Answer: no, sir. Question. The message dated January 20, 2005 from Maria. Do you see that on the bottom right? Answer. Yes. Question. Do you know who that is? Answer. I think I have a different page. Question. You're a little ahead of me. January 20th, 2005. Mr. Crichton. I think that's page 31. The witness. I don't remember who she was, sir. By Mr. Mermelstein. Question. You don't recall what that message was about? Answer. No, sir. Question. What about the next page? There was a message that Eva called. Answer. Yes. Question. Dated January 21st, 2005. Answer. Yes. Question. Do you know who Eva is? Answer. Yes. Question. Who is Eva? Answer. The Assistant Comptroller from the New York office. Question. Do you remember her last name? Answer. Polish last name, I guess? She was Russian. She is Russian, actually. Question. Did you ever travel to any other residences that Mr. Epstein had? Answer. No. Question. Are you aware he had a residence in the Virgin Islands? Mr. Crichton. Form. The witness. Yes. By Mr. Mermelstein. Question. And would he sometimes travel to that residence from Palm Beach? Answer. Yes. Question. Okay. Do you recall on any occasion who would travel with him to the Virgin Islands? Mr. Crichton. Form. The witness. No, sir. By Mr. Mermelstein. Question. I think we were talking about the money before. The household account. Sometimes you gave gifts. Answer. Yes, I was told to buy some gifts. Question. For whom? Answer. For the guests. Question. Okay. And what kind of gifts? Answer. Shoes, sweaters, clothes. Question. So were you instructed to buy something in particular at a particular store? Answer. They would go to the store. If they liked something, I will go after and pay them and retrieve it. Question. Okay. So would this be a girl who was staying at the house? Answer. Yes. Question. Okay. This was one of the girls who traveled with Mr. Epstein to Palm Beach, correct? Answer. Yes. Question. And so Mr. Epstein would instruct you to go shopping with this girl? Answer. Yes. Question. And instructed you to pay for whatever it was she wanted to buy? Answer. Yes. Question. Was there a price limit or anything of that nature? Answer. No, sir. Question. So when the girl decided what she wanted, you would... Answer. I would write them a check. Question. In that instance, you would pay by check? Answer. Yes. Question. Any other instances where you gave gifts to girls at the instruction of Mr. Epstein? Answer. No. I was just told, when they told me I will buy the item. Question. I'm sorry? Answer. When I was told to purchase this item for them, I will do that, but not on any other occasions. Question. What do you mean not in any locations? Answer. Any other occasions. Question. Not any other occasions. Okay. Did you ever buy flowers for a girl? Answer. Yes, sir. Question. Tell me about that. Answer. I was told to buy flowers and roses for a girl performing in high school. Question. Which girl was that? Answer. I don't remember the name, sir. Question. What was Mr. Epstein's relationship to this girl? Mr. Crichton. Form. The witness. I think she was an acquaintance. Friend. By Mr. Mermelstein. Question. She was a friend? Answer. Yes, sir. Question. Now, she was performing at the high school in what capacity? Answer. There was like a play in the graduation for high school. Question. A play for graduation? Answer. Yes, in the high school theatre there was some kind of performance. Question. Was it like a theatre production? Answer. Yeah, something like that. I didn't go inside, so I didn't know what was going inside. Question. Why'd you say it was for graduation? Answer. Because everybody was the graduation outside. There were parents, there were a lot of people at the school. Question. Okay. A lot of high schools have theatre production companies and they put on plays, correct? Mr. Crichton. Form. The witness. It was towards the end of the year. Well, I think I overheard that there was a graduation performance of some kind. By Mr. Mermelstein. Question. But you didn't go in, so you don't know. Answer. No, sir. Question. But this was a high school student you were bringing the flowers to, is that correct? Answer. Yes. Question. Had you seen this girl before at the El Brillo Way property? Answer. Yes, sir. Question. You had seen her a number of times? Answer. Yes, sir. Question. Do you recall her name? Answer. I don't recall her name, sir. Question. Now you said you never went inside the theatre. Answer. No, sir. Question. Okay, how did you get to the flower store? Answer. I called the girl to her cell and she will come to the back door and I give her the flowers. Question. Was anyone else around at the time? Answer. No, sir. Question. And you mentioned this was a girl you had seen before? Answer. Yes. Question. Was this girl who had come to give you massages to Mr. Epstein? Mr. Crichton. Form. The witness. I don't know if she was doing massages, but she was at the house. By Mr. Mermelstein. Question. What would she have been there for? Answer. To visit him. Question. This was a high school girl who was coming to visit Mr. Epstein at the house? Answer. She came to the house, I opened the door and I left, you know. Question. Did you take her to the kitchen like you did? Answer. Yes. Question. So you brought her to the kitchen just like you did for the girls who gave massages, correct? Answer. Yes, sir. Question. Did you ever pay her? Answer. I don't remember, sir, but probably I did. Mr. Crichton. Form, move to strike. Speculation. By Mr. Mermelstein. Question. Why do you say you probably did? Answer. Because I was the only one paying. Well, not the only one, but, you know. But chances are I paid her, but I don't remember that particular instance that I gave her money. Question. Is it fair to say that the girls who came to the Palm Beach residence, these are not the girls who were staying there. The girls who came were there to give massages, correct? Mr. Crichton. Form. The witness. Yes. By Mr. Mermelstein. Written down anywhere? Answer. No. Question. Is my understanding that C and T either came to his house alone to visit with Mr. Epstein, or brought other girls in their age group to Mr. Epstein? Were you familiar with that type of recruitment process of girls bringing other girls? Mr. Crichton. Form. The witness. Yes. By Mr. Edwards. Question. Can you tell me more about what you know about girls bringing other girls that are relatively the same age to come to Jeffrey Epstein's house, and to use your words, have a good time? Mr. Crichton. Form. The witness. It's hard to know who they knew, but I think that was. They feel better themselves when they're in a group than going by themselves, but I don't know somebody recruiting. By Mr. Edwards. Q. Okay. And you've talked about, at least referred to yourself, I believe, to the police, and as well today as a human ATM machine, right? Mr. Crichton. Form. The witness. Something like that. I was supposed to carry cash at all times. By Mr. Edwards. One of the primary reasons why you carried cash was to pay the girls in this age group of C and T for whatever happened at the house, right? Mr. Crichton. Form. The witness. Yes. By Mr. Edwards. Q. That's a fair statement, right? Mr. Crichton. Form. The witness. Yes. By Mr. Edwards. Q. Okay, and when C, let's use her for example, would bring somebody else to the house, did you pay C, as well as whomever she brought to the house? Pay them both? A. No, I pay only one person. Q. Okay. My understanding, and tell me if this is wrong or you can corroborate this, is that Mr. Epstein would pay the girl that was actually performing whatever was happening in the room. For now, we'll call it a massage, as well as anybody who brought that person over to the house. They would both get paid cash. Are you familiar with that? Mr. Crichton, form. The witness, no. By Mr. Edwards. Q. If C brought another girl over to the house, and C stayed downstairs, but this other girl went upstairs with Mr. Epstein, which one would you pay? A. I don't know because I was told who to pay. Q. And Sarah Kellen always told you? A. Sarah told me pay so-and-so. Q. So if we were going to ask anybody else about the exact method, in terms of who would get paid and for what, who would the people be? I mean, other than Mr. Epstein, who else could we ask these questions? A. Sarah. Q. Sarah Kellen? A. Yes. Q. She would know this? A. Yes. Q. What about Ghislaine Maxwell? Mr. Crichton. Form. The witness. You're talking about the boss. I don't know. By Mr. Edwards. Q. To your knowledge, was Ghislaine Maxwell aware of these girls that are in the age group of C and T, coming to Jeffrey Epstein's house to have a good time? Mr. Crichton. Form. The witness. I have to say something. Mrs. Maxwell called me and told me not to ever discuss or contact her again in a threatening way. By Mr. Edwards. Q. When was this? A. Right after I left because I called one of the friends for a job, and she told me this, but, you know, I feel intimidated and so I want to keep her out. Q. What exactly did she say? First of all, was this a telephone call? A. Yes, she was in New York. Q. She called you on your cell phone? A. Yes. Q. Is this the cell phone that was issued to you by Mr. Epstein? A. No, it was my personal phone. I was already... Q. Gone. A. Yeah, this is free 4 months down the road. Q. So if you left in... A. February, March, it was May or June. Q. Of 2005? A. Yes. Q. And you got a call from Ghislaine Maxwell out of the blue? A. Yes. Q. And do you know what prompted that telephone call? A. Because I contact somebody in New York to get a job. Q. Who was that person? A. I contact Jean-Luc and I contact Eva, the Swedish girl. She used to be very good friends with Mr. Epstein because she asked me she needed somebody in New York. Q. What does Eva do? A. Eva was a model many years ago, and he married. Eva is the mother of the girl who was on the wall. Q. Who is on the wall of Mr. Epstein's house? A. Yeah. Q. Alright. There was a younger girl model that's on the wall of Mr. Epstein's house, and this lady, Eva, is her mother. A. Yes. Q. And at some point in time, you called her in New York to get a job? A. That's right. Q. And you also called him Jean-Luc Bonnell. That's his name, right? A. Jean-Luc, yeah. I don't remember his last name. Q. Does that sound familiar to you? Jean-Luc Bonnell? A. Yeah. Q. What did Eva and or Jean-Luc say about employing you? A. No, they said they're going to find out, and obviously the first thing they did was talk to Mrs. Maxwell. Q. She made a telephone call to you, and what precisely did she say? A. She said, I forbid you, that you're going to be... that I'll be sorry if I contact any of her friends again. Q. Okay. Other than you will be sorry if you contact any of my friends again, did she say anything else about what you know about Mr. Epstein, and or what goes on at his house? A. She says something like, don't open your mouth or something like that. But you have to understand, I'm a civil humble. I came as an immigrant to service people. And right now you feel a little... I'm 55 and I'm afraid. First of all, I don't have a job, but I'm glad this is on tape because I don't want nothing to happen to me. This is the way they treat you. Better do this and you shut up and don't talk to nobody and... Q. When you say this is the way they treat, who specifically are you talking about when you say the word they? A. Maxwell. Q. And usually when you say the word they, you're not only talking about one person. A. Wealthy people. Q. Are you also putting Jeffery Epstein in that category? Mr. Crichton. Form. The witness. I didn't talk to him directly most of the time. By Mr. Edwards. Q. What's the reason why, if you were his head of security, that you wouldn't have more direct contact with him? Why is that? Mr. Crichton. Form. The witness. He wanted that way, you know, so yeah. I had to talk to Sarah. Sarah is not available. Talk to Leslie in New York. He didn't want to be disturbed. By Mr. Edwards. Q. Even while you were in the same house with him, he still had other people you could talk to directly, but he was not one of them. A. Yeah. Q. When you were fired, you were not fired directly by him? A. No. Q. It was through somebody else? A. Miss Maxwell. Q. Okay. But it was for upsetting him for taking the wrong car? A. Yes. Q. Okay. Ever since this communication that Miss Maxwell made you, where she called you sometime in May or June of 2005, and have you felt threatened? A. Yes. Mr. Crichton. Form. By Mr. Edwards. Q. Have you felt reluctant to come forward and give truthful, honest, and full disclosure of all information that you know about in this case? Mr. Crichton. Form. The witness. I said this off the record, but I will say it on the record. Being in the Epstein case for me resulted in 2 years I have. I won't bring the names, but I was in the 3rd interview to get hired, as a household manager in Palm Beach, and they told me you are the Jeffery Epstein guy. Not in the sense I did something wrong because of the scandal, so they shunned the job away from me. And so I was afraid that this is very powerful people, and one phone call and you finish, so I'm the little guy. Even I'm wearing a tie, I'm talking from my heart. This is the way it is. By Mr. Edwards. Q. I feel for you. I am sorry that you have to be in this position. Mr. Crichton. Move to strike this. By Mr. Edwards. Q. Well, when you apply for these jobs and they turned you down and gave you the reason that you're the person involved in the Jeffrey Epstein scandal, was it that they are associated or friends with Jeffrey Epstein? Or is it that you have information and you have this confidentiality, but you're revealing some certain information that Mr. Epstein would not like? Mr. Crichton. Form. The witness. Both. By Mr. Edwards. Q. Both? A. Both. Q. And since then, given what you just told us about these people being very powerful, are you afraid for your life, given the fact that you're involved to some extent in this case? Mr. Crichton. Form. The witness. I just started thinking about this, because I went through... The first time I went to the deposition, I was in Palm Beach, and I did my duty. I mean, I tell what I know, but now I know there is more digging. All I want is this... to get on with my normal life and stuff. By Mr. Edwards. Q. So when you come here today to testify, your main objective is to get back to your normal life and get out of the spotlight of this case? Yes? A. Yes. Q. And in doing so, have you held back some of the details that you know about that happened in this case to remove yourself from the spotlight? Mr. Crichton. Form. The witness. No, sir. By Mr. Edwards. Q. Okay. Have you ever talked to Ghislaine Maxwell after that telephone call, where she called you and you felt threatened? A. No. Q. Okay. So going back to where we started here was, does Ghislaine Maxwell have knowledge of the girls that would come over to Jeffrey Epstein's house, that were in roughly the same age group as C and T, and to have a good time, as you put it? Mr. Crichton. Form. The witness. Yes. By Mr. Edwards. And what was her involvement and or knowledge about that? Mr. Crichton. Form. The witness. She knew what was going on. By Mr. Edwards. Q. You referred to her at one point in time as Jeffery Epstein's companion, but then later on you said that if she flew on a different airplane, and oftentimes or sometimes she slept in a different bed from Mr. Epstein. Did that seem unusual to you? Mr. Crichton. Form. The witness. It was odd, but, and again, everything is odd in Palm Beach. By Mr. Edwards. Q. Okay, I don't mean to laugh. A. Mr. Epstein fly to Jet Aviation. She fly to Galaxy Aviation, but they never flew the same. By Mr. Langino. Q. Are you currently in fear of Mr. Epstein? A. Not at this particular moment, but it's something I have to be worried about, yes. Q. Are you personally afraid of criminal prosecution? A. No. Q. Do you believe that you did anything illegal? A. Illegal, no. Mr. Langino. I have no further questions, thank you. Mr. Crichton. We're going to break in about 15 minutes. Do you want to start and go for 15 minutes, or do you want to... It's up to you. Ms. Azil. I'll start. Mr. Willits. When are we going to quit, folks? Mr. Crichton. In 15 minutes. The videographer. Might as well change tapes. Mr. Edwards. Bob has to get back, so we've agreed we're going to come back some other time. Mr. Willits. Why don't we just stop now? Ms. Azell. Okay. Mr. Edwards. Rather than you start. Mr. Azil. Yeah, I won't get very far. Mr. Edwards. Sorry to do this with you. We didn't finish. Mr. Crichton. So we're stopped? Mr. Edwards. We're stopped. The videographer. Off the record. Thereupon, the videotaped deposition was adjourned at 5:30 p.m. The State of Florida, County of Dade. I, the undersigned authority, certify that Alfredo Rodriguez personally appeared before me on the 29th day of July, 2009, and was duly sworn. Witness my hand and official seal this 31st day of July 2009. Michelle Payne, Court Reporter, Notary Public, State of Florida. Certificate. The State of Florida, County of Dade. I, Michelle Payne, Court Reporter and Notary Public, in and for the State of Florida at large, do hereby certify that I was authorized to and did stenographically report the videotaped deposition of Alfredo Rodriguez, that a review of the transcript was requested, and that the foregoing pages, numbered from 1 to 269 inclusive, are a true and correct transcription of my stenographic notes of said disposition. I further certify that said videotape disposition was taken at the time and place herein above set forth, and that the taking of said videotape disposition was commenced and completed as herein above set out. I further certify that I am not an attorney or counsel of any of the parties, nor am I a relative or employee of any attorney or counsel of party connected with the action, nor am I financially interested in the action. The foregoing certification of this transcript does not apply to any reproduction of the same, by any means, unless under the direct control and or direction of the certifying reporter. Dated this 31st day of July 2009. Michelle Payne, Court Reporter. United States District Court, Southern District of New York. Virginia L. Joffrey, Plaintiff. Case number 15CV-07433, RWS, versus Ghislaine Maxwell, Defendant. Plaintiff's non-redacted motion for leave to serve 3 deposition subpoenas by means other than personal service. Plaintiff Virginia Joffrey, by and through her undersigned counsel, hereby files his motion for leave to serve 3 deposition subpoenas by means other than personal service. The 3 persons to be subpoenaed, Jeffery Epstein, Sarah Kellen, and Nadia Marcinkova, were each involved in the sexual abuse and sexual trafficking at issue in this case. It appears that all 3 of them have evaded attempts to personally serve them, and 2 of the persons, Epstein and Kellen, have attorneys who have not been authorized by their clients to accept service. Ms. Jeffery seeks leave to provide service by several alternative means that are designed to assure actual notice is provided to these persons. See Declaration of Sigrid Macaulay Deal at Composite Exhibit 1, Subpoenas for Jeffery Epstein, Sarah Kellen, aka Sarah Kensington and Sarah Vickers, and Nadia Marcinkova. This court has repeatedly held that Fed R. Civ P. 45 permits alternative service in appropriate circumstances, and this case presents such circumstances. Accordingly, the court should grant Ms. Jeffery leave to serve deposition subpoenas by alternative means. Background. At the heart of this case lies Ms. Jeffery's allegations that she was sexually abused by Jeffery Epstein and the defendant. Ms. Jeffery has also alleged that Epstein and the defendant were aided by others who played key roles in the sex trafficking organization, including Sarah Kellen and Nadia Marcinkova. Defendant has called Ms. Jeffery a liar, and Ms. Jeffery is now in the process of assembling testimony and evidence to prove the truth of her allegations. Apart from the defendant in this case, Jeffery Epstein is the most important person for Ms. Jeffery to depose. It was Epstein who gave the directions to Maxwell to recruit Ms. Jeffery and bring her to Epstein's mansions to be sexually abused. At several points during her recent deposition, Mrs. Maxwell refused to answer Ms. Jeffery's questions about Epstein, but instead told her she should go ask Epstein about the subject. See e.g. TR of Depo of Defendant, April 22nd, 2016 at 100. Q. Was it Jeffrey's preference to start a massage with sex? A. I think you should ask that question of Jeffery. ID at 146 to 147. Q. So would Ms. Jeffery be brought on trips that were for the purpose of work and decorating the house? A. Like I said, I never worked with her, but you would have to ask Jeffery what he brought her on the trip for. ID at 38.9 to 90. Q. Does Epstein have any knowledge of any illegal activity that you've conducted? A. If you want to ask Jeffery questions about me, you would have to ask him. See Macaulay Decal at Exhibit 2. Because of Epstein's importance to this case, Ms. Jeffery has diligently tried to personally serve Epstein with a subpoena for his deposition. Epstein, however, appears to have no interest in answering questions under oath about the scope of his sex trafficking organization, and he has not authorized his lawyer to accept service of the subpoena. On March 7, 2016, Ms. Jeffery's counsel contacted counsel for Epstein to seek agreement that he would accept service of the subpoena in this matter. See Macaulay Decal at Composite Exhibit 3, Electronic Correspondence to Attorney Marty Weinberg. Ms. Jeffery was unable to obtain that agreement, so she retained an investigative company to attempt to locate Epstein for the purposes of personal service. As explained in the attached affidavit, the Alpha Group investigators commenced efforts to personally serve Epstein on April 26, 2016. See Macaulay Decal at Exhibit 4, Affidavit of Douglas G. Mercer, Chief Investigator, Alpha Group. Those efforts have continued for weeks and included over 16 attempts to personally serve Epstein, including as recently as May 18, 2016, at which time the investigator affixed a subpoena to the front door of Epstein's residence and mailed copies of the subpoena to both of his New York addresses, along with a witness check. Counsel for Ms. Jeffery also provided a copy of the subpoena to Marty Weinberg, Epstein's attorney. Jeffery Epstein is not the only key witness who has been evading Ms. Jeffery's efforts to depose them. The next echelon in a sex trafficking organization below Epstein and the defendant includes Sarah Kellen and Nadia Marcinkova. Ms. Jeffery alleges that they were heavily involved in the sex trafficking. Both Kellen and Marcinkova appear repeatedly on the flight logs of Jeffery Epstein's aircraft. The U.S. Attorney's Office for the Southern District of Florida specifically identified both Kellen and Marcinkova as among 4 named potential co-conspirators of Epstein in the non-prosecution agreement it executed with Epstein as part of his guilty plea to Florida state sex offense charges. See Non-Prosecution Agreement. In RE, investigation of Jeffery Epstein at 7. Additionally, both Kellen and Marcinkova previously... Note: as recently as today, Ms. Jeffrey's counsel continues to attempt to negotiate acceptance of service of the subpoena for Mr. Epstein, which now includes a request that his deposition take place in the US Virgin Islands, but has still not received an agreement to accept service. See Macaulay de Calle at Composite, Exhibit 3, Correspondence with Marty Weinberg, counsel for Jeffery Epstein. Invoked their Fifth Amendment privileges when asked about their involvement in Epstein and defendant's sex trafficking ring. At her recent deposition, defendant appeared to be well aware of the fact that Epstein had potential co-conspirators. See e.g. TR of Depo of Defendant, April 22, 2016 at 49. Q. Are you aware that Sarah Kellen was named as a co-conspirator in the case involving Jeffrey Epstein? A. I am aware. See Macaulay de Calle at Exhibit 2. As with Epstein, however, Kellen and Marcinkova appear to be evading efforts to serve them. On March 31, 2016, Ms. Jeffrey's counsel reached out to Sarah Kellen's counsel to seek agreement that she would accept service of the subpoena in this matter. See Macaulay de Calle at Exhibit 5, electronic correspondence with Bruce Reinhardt of McDonald Hopkins, LLP, in West Palm Beach, Florida. Mr. Reinhardt represented that Ms. Kellen refused to allow her counsel to accept service of the subpoena, so Ms. Joffrey was forced to commence the efforts to attempt to personally serve her with the subpoena. As explained in the attached affidavit, the Alpha Group investigators commenced efforts to personally serve Kellen on April 26, 2016. See Macaulay Deal at 4 Affidavit of Douglas G. Mercer, Chief Investigator, Alpha Group. Those efforts have continued with over 19 attempts at service, and concluded as recently as May 18, 2016, at which time the investigator affixed the subpoena to the front door of Kellen's residence, and mailed copies of the subpoena to both of her New York addresses. Ms. Joffrey's counsel also provided a copy of the subpoena to Kellen's attorney. Marcinkova has also been evading service. Ms. Joffrey has had her investigators make efforts to attempt to personally serve Marcinkova at her New York residence, and also made efforts to try to personally serve her while on a trip to California, but has been unable to obtain personal service. Ms. Joffrey's investigators made over 10 attempts to personally serve Marcinkova. See Macaulay Deal at Exhibit 4, Affidavit of Douglas G. Mercer, Chief Investigator, Alpha Group. In addition, counsel for Ms. Joffrey reached out to Ms. Marcinkova's former counsel, but he indicated that he could not accept service as he no longer represents her. See Macaulay de Calle at Exhibit 6, Electronic Correspondence with Jack Goldberger at Atterbury, Goldberger and Weiss, PA, in West Palm Beach, Florida. In other litigation relating to Jeffrey Epstein, both Marcinkova and Kellen asserted their Fifth Amendment rights when asked questions about defendants' recruitment of underage girls. Q. Do you know Ghislaine Maxwell? A. Fifth. Q. Is that somebody who helped Jeffrey Epstein to devise the scheme to allow him access to various and a variety of underage minor females? A. Fifth. Q. Is Sarah Kellen somebody that was also involved in the planning of this scheme to gain access to underage minor females? A. Fifth. See Macaulay de Calle at Exhibit 7, Nadia Marcinkova, April 13, 2010, Dep TR at Part 29-30. GIU FF RE 001171-211172. Q. Isn't it true that yourself, Ghislaine Maxwell and Sarah Kellen had access to a master of list of underage minor females' names and phone numbers so they could be called for the purposes of coming to Jeffrey Epstein's house to be sexually molested? A. Fifth. See Macaulay de Calle at Exhibit 7, Nadia Marcinkova, April 13, 2010, Dep TR at Part 33-34. GIU FFR E 001173. Q. Do you know Jane Doe 102? Virginia Joffrey? A. Fifth. See Macaulay DeCarl at Exhibit 7. Nadia Marcinkova, April 13th, 2010. Deptiara Part 47-48. GIUFFRE 001176. Q. Are you aware of Jeffery Epstein and Ghislaine Maxwell's sexual interaction with Jane Doe 102 when she was a minor? Q. This is one of many underage minor females that was trafficked, basically around the globe, to be sexually exploited and abused. Is this correct? A. Fifth. Was that typical of Jeffery Epstein and Ghislaine Maxwell to sexually abuse minors on Jeffery Epstein's airplane? A. Fifth. Q. And also typical of Ghislaine Maxwell and Jeffery Epstein to prostitute or pimp out underage minors to friends? A. Fifth. See Macaulay DeCarl at Exhibit 7, Nadia Marcinkova, April 13th, 2010. Deptiara at page 47-48. Joffrey 001176. Q. Ghislaine Maxwell is somebody who you know to be bisexual, true? A. Fifth. Q. You know that Ghislaine Maxwell engaged in sexual acts with underage minor females, true? A. Fifth. See Macaulay DeCarl at Exhibit 7. Nadia Marcinkova, April 13th, 2010. Deptiara Part 58-59. Joffrey 00179. Q. Did Ghislaine Maxwell introduce you to Jeffery Epstein for the first time? The witness. On the instruction of my lawyer, I must invoke my Fifth Amendment right. See Macaulay DeCarl at Exhibit 8. Sarah Kellen, March 24, 2010. Deptiar, page 21. Joffrey 001676. Q. Alright. Ms. Kellen, would you agree with me that there was an agreement between Jeffery Epstein, Ghislaine Maxwell, Jean-Luc Brunel, yourself, and Nadia Marcinkova to bring in girls from out of state that were underage? The witness. On the instruction of my lawyer, I must invoke my Fifth Amendment right. See Macaulay DeCarl at Exhibit 8. Sarah Kellen, March 24th, 2010. Depont, Triar, Part 38, Joffrey 001680. Q. Would you agree with me that Ghislaine Maxwell provides underage girls to Mr. Epstein for sex? The witness. Upon the instruction of my lawyer, I must invoke my Fifth Amendment privilege. See Macaulay DeCarl at Exhibit 8. Sarah Kellen, March 24th, 2010. Deptiar, page 100. Joffrey 001695. Both Marcinkova and Kellen are key witnesses in this action because they were present with Mr. Epstein and Maxwell during the time period when Virginia Joffrey was with Epstein and Maxwell. Argument. A. The court should permit alternative service. In the unique circumstances of this case, this court should grant Miss Joffrey leave to serve Jeffery Epstein, Sarah Kellen, and Nadia Marcinkova via means other than personal service because they are evading service of process, and there are other means to assure actual notice. Under Rule 45b(1) of the Federal Rules of Civil Procedure, serving a subpoena requires delivering a copy to the named person. The purpose of requiring delivery to a named person is to ensure receipt, so that notice will be provided to the recipient, and enforcement of the subpoena will be consistent with the requirements of due process. Aristocrat Leisure Limited v. Deutsche Bank Trust Co. Americas 262 FRD 293304 SDNY 2009. Quoting Med Diagnostic Imaging PLLC v. Care Core Nats LLC NOS 06 Civ 7764 and 06 Civ 13516 2008 WL 3833238 at 2 SDNY August 15, 2008. Internal quotation marks omitted. See also First City, Texas Houston, NA v. Raffidane Bank 197 FRD 250 255 SDNY 2000. Finding that attaching a subpoena to the door and mailing another copy to counsel of record was sufficient. Cases not only from this court, but also from others in the Second Circuit, have interpreted that rule liberally to allow service so long as the type of service used was calculated to provide timely actual notice. Aristocrat Leisure Limited, 262 FRD at 304, quoting Care Corps, 2008 WL 3833238 at 2, noting that nothing in the word delivering in Rule 45b1 indicates personal service, and a personal service requirement can be unduly restrictive. See also Cordius Trust versus Kummerfeld, number 99, Civ 3200, 2000 WL 10268 at 2, STNY, Jan 3rd, 2000, holding that because alternative service by means of certified mail reasonably ensures actual receipt of the subpoena by the witness, the delivery requirement of Rule 45 will be met. JP Morgan Chase Bank, NA v. IDW Group, LLC, number 08, Civ 9116 PGG, 2009 WL 1313259 at 2, SDNY, May 11th, 2009. This court joins other courts in this district in holding that effective service of a deposition subpoena under Rule 45 is not limited to personal service. Internal quotation omitted. A prerequisite for using means other than personal service is typically that the party requesting the accommodation diligently attempted to effectuate personal service. Ocean First Bank vs. Hartford Fire Inc. Co. 794 F Support 2D 752754 ED Minch 2011, citing Franklin v. State Farm A Fire and Casualty Co. 2009 WL 315293 at 2 ED Mitch 2009. Here, Ms. Joffrey has diligently attempted to make personal service on each of the three individuals, having made multiple attempts to personal service them, including going to different locations at different times on different days, and attempting to reach them through their attorneys. See Macaulay de Cull at Exhibit 4, Affidavit of Douglas G. Mercer, Chief Investigator Alpha Group. Indeed, it appears that the only reason that personal service has been unsuccessful thus far is that the important witnesses Ms. Joffrey is attempting to serve are fully aware of her efforts and are attempting to evade service. This court will recall that efforts to evade service are a familiar practice of Jeffery Epstein and his colleagues. As described in earlier pleadings in this case, for example, the defendant herself refused to comply with a deposition subpoena in an earlier case brought by one of Jeffrey Epstein's sexual assault victims. See Deckel of Sigrid Macaulay at Composite Exhibit 9, Maxwell Deposition Notice, Subpoena and Cancellation Payment Notice, and January 13, 2015 Daily Mail article. Ms. Joffrey proposes that she be permitted to serve her deposition notices by means other than personal service. Ms. Joffrey asks this court to rule that she be permitted to serve each of the three individuals in ways that are reasonably calculated to give them actual notice. The specific means that Ms. Joffrey proposes are the means that her investigators took on May 18th of posting the subpoenas to the addresses associated with each of the witnesses and mailing the subpoenas to those addresses with the witness fee check and providing copies of the subpoenas via email to the witnesses' known counsel. See Macaulay de Cull at Exhibit 4, Affidavit of Douglas G. Mercer, Chief Investigator Alpha Group. Means such as those described above have been approved by this court in other cases. For example, in medical diagnostic imaging, PLLC vs. Care Corps National LLC, 2008 WL 3833238, STNY 2008, CATS J. This court allows service of a deposition subpoena to be made through mailing a copy of the subpoena to the witness's place of employment, along with a copy of the court's order directing the witness to comply with the subpoena or face sanctions. ID at 3. Similarly, in JP Morgan Chase Bank, NA, v. IDW Group LLC, number 08, Civ 9116 PGG, 2009 WL 1313259, at 3 STNY, May 11th, 2009, this court allowed service of a deposition subpoena to be made by sending a copy of the deposition subpoena to the witness's place of business and residence by certified mail, leaving a copy of the deposition subpoena at the witness's residence and place of business with a person of suitable age and discretion, and remitting a copy of the deposition subpoena by electronic mail and certified mail to counsel for a related corporation. And in at least two cases, this court has found that certified mailing of a subpoena to the witness alone satisfies Rule 45. See Cordius Trust v. Kummerfeld, 1999 US Dist, Lexis, 19980, 5-6, SDNY 1999, Ultradent Products Inc. vs. Heyman, number M885 RPP, 2002 WL 3111, 9425 at Free, SDNY, September 24, 2002. Here the means of service exceed those approved in those other cases and should be permitted. Conclusion. Ms. Joffrey should be granted leave to serve Jeffery Epstein, Sarah Kellen, and Nadia Marcinkova with deposition subpoenas by means other than personal service. As Ms. Joffrey has made multiple attempts at personal service, Ms. Joffrey should be granted leave to serve deposition subpoenas by the means employed by her investigators, of posting the subpoenas to the known locations and also sending the subpoenas via US mail. Dated May 25, 2016. Respectfully submitted, Boyce, Schiller and Flexner, LLP. Note: the daytime business addresses are provided for identification and correspondence purposes only, and is not intended to imply institutional endorsement by the University of Utah for this private representation. Certificate of Service. I hereby certify that on 25th day of May 2016, I electronically filed the foregoing document with the Clerk of Court by using the CM ECF system. Copies of this filing were also provided by email to Martin Weinberg, counsel for Jeffery Epstein, and Bruce Reinhardt, counsel for Sarah Kellen. Signed, Sigrid S. Macaulay. Exhibit C. United States District Court, Southern District of Florida. Case number 08-80736, Civ Mara Johnson. Jane Doe number 1 and Jane Doe number 2. v. United States. Jane Doe number 3 and Jane Doe number 4's motion, pursuant to Rule 21, for joinder in action. Come now, Jane Doe number 3 and Jane Doe number 4, also referred to as the new victims, by and through undersigned counsel, to file this motion pursuant to Federal Rule of Civil Procedure 21 to join this action, on the condition that they not relitigate any issues already litigated by Jane Doe number 1 and Jane Doe number 2, also referred to as the current victims. The new victims have suffered the same violations of their rights under the Crime Victims' Rights Act, CVRA, as the current victims. Accordingly, they desire to join in this action to vindicate their rights as well. Because the new victims will not relitigate any issues previously litigated by the current victims, and because they are represented by the same legal counsel as the current victims, the government will not be prejudiced if the court grants the motion. The court may, at any time, add new parties to the action, Fed R. Civ P. 21. Accordingly, the court should grant the motion. Note: as minor victims of sexual offences, Jane Doe number 3 and Jane Doe number 4 desire to proceed by way of pseudonym, for the same reasons that Jane Doe number 1 and Jane Doe number 2 proceeded in this. Factual background. As the court is aware, more than 6 years ago, Jane Doe number 1 filed the present action against the government, alleging a violation of her rights under the CVRA, 18 U.S.C. 3771, DEI. She alleged that Jeffery Epstein had sexually abused her and that the United States had entered into a secret non-prosecution agreement, MPA, regarding those crimes in violation of her rights. At the first court hearing on this case, the court allowed Jane Doe number 2 to also join the action. Both Jane Doe number 1 and Jane Doe number 2 specifically argued that the government had failed to protect their ZVRA rights, inter alia, to confer to reasonable notice, and to be treated with fairness. In response, the government argued that the CVRA rights did not apply to Jane Doe number 1 and Jane Doe number 2 because no federal charges had ever been filed against Jeffery Epstein. The court has firmly rejected the United States position.
In a detailed ruling, the court concluded that the CVRA extended rights to Jane Doe No. 1 and Jane Doe No. 2, even though federal charges were never filed. DE 189. The court explained that because the MPA barred prosecution of crimes committed against them by Epstein, they had standing to assert violations of the CVRA rights. ID. The court deferred ruling on whether the two victims would be entitled to relief, pending development of a fuller evidentiary record. ID. Two other victims, who are in many respects similarly situated to the current victims, now wish to join this action. The new victims joining at this stage will not cause any delay, and their joinder in this case is the most expeditious manner in which to pursue their rights. Because the background regarding their abuse is relevant to the court's assessment of whether to allow them to join, their circumstances are recounted here briefly. Continued note. Fashion. Counsel for the new victims have made their true identities known to the government. Jane Doe No. 3's circumstances. As with Jane Doe No. 1 and Jane Doe No. 2, Jane Doe No. 3 was repeatedly sexually abused by Epstein. The government then concealed from Jane Doe No. 3 the existence of his MPA from Jane Doe No. 3 in violation of her rights under the CVRA. If allowed to join this action, Jane Doe No. 3 would prove the following. In 1999, Jane Doe No. 3 was approached by Ghislaine Maxwell, one of the main women whom Epstein used to procure underage girls for sexual activities, and a primary co-conspirator in his sexual abuse and sex trafficking scheme. In fact, it became known to the government that Maxwell herself regularly participated in Epstein's sexual exploitation of minors, including Jane Doe No. 3. Maxwell persuaded Jane Doe No. 3, who was then 15 years old, to come to Epstein's mansion in a fashion very similar to the manner in which Epstein and his other co-conspirators coerced dozens of other children, including Jane Doe No. 1 and Jane Doe No. 2. When Jane Doe No. 3 began giving Epstein a massage, Epstein and Maxwell turned it into a sexual encounter, as they had done with many other victims. Epstein then became enamored with Jane Doe No. 3, and with the assistance of Maxwell converted her into what is commonly referred to as a sex slave. Epstein kept Jane Doe No. 3 as his sex slave from about 1999 through 2002, when she managed to escape to a foreign country and hide out from Epstein and his co-conspirators for years. From 1999 through 2002, Epstein frequently sexually abused Jane Doe No. 3, not only in West Palm Beach but also in New York, New Mexico, the US Virgin Islands, in international airspace, on his Epstein's private planes, and elsewhere. Epstein also sexually trafficked the then minor Jane Doe, making her available for sex to politically connected and financially powerful people. Epstein's purposes in lending Jane Doe, along with other young girls, to such powerful people, were to ingratiate himself with them for business, personal, political, and financial gain, as well as to obtain potential blackmail information. One such powerful individual that Epstein forced then minor Jane Doe No. 3 to have sexual relations with was former Harvard law professor Alan Dershowitz, a close friend of Epstein's and well-known criminal defense attorney. Epstein required Jane Doe No. 3 to have sexual relations with Dershowitz on numerous occasions while she was a minor, not only in Florida, but also on private planes, in New York, New Mexico, and the US Virgin Islands. In addition to being a participant in the abuse of Jane Doe No. 3 and other minors, Dershowitz was an eyewitness to the sexual abuse of many other minors by Epstein, and several of Epstein's co-conspirators. Dershowitz would later play a significant role in negotiating the MPA on Epstein's behalf. Indeed, Dershowitz helped negotiate an agreement that provided immunity from federal prosecution in the Southern District of Florida, not only to Epstein, but also to any potential co-conspirators of Epstein. MPA 5. Thus, Dershowitz helped negotiate an agreement with a provision that provided protection for himself against criminal prosecution in Florida for sexually abusing Jane Doe No. 3. Because this broad immunity would have been controversial if disclosed, Dershowitz, along with other members of Epstein's defense team, and the government tried to keep the immunity provision secret from all of Epstein's victims and the general public, even though such secrecy violated the Crime Victims' Rights Act. Ghislaine Maxwell was another person in Epstein's inner circle and a co-conspirator in Epstein's sexual abuse. She was someone who consequently also appreciated the immunity granted by the MPA for the crime she committed in Florida. In addition to participating in the sexual abuse of Jane Doe No. 3 and others, Maxwell also took numerous sexually explicit pictures of underage girls involved in sexual activities, including Jane Doe No. 3. She shared these photographs, which constituted child pornography under applicable federal laws, with Epstein. The government is apparently aware of, and in certain instances possesses, some of these photographs. Perhaps even more important to our role in Epstein's sexual abuse ring, Maxwell had direct connections to other powerful individuals with whom she could connect Epstein. For instance, one such powerful individual Epstein forced Jane Doe No. 3 to have sexual relations with was a member of the British royal family, Prince Andrew, aka Duke of York. Jane Doe No. 3 was forced to have sexual relations with this prince when she was a minor, in 3 separate geographical locations. In London, at Ghislaine Maxwell's apartment, in New York, and on Epstein's private island, in the US Virgin Islands, in an orgy with numerous other underage girls. Epstein instructed Jane Doe No. 3 that she was to give the prince whatever he demanded, and required Jane Doe No. 3 to report back to him on the details of the sexual abuse. Maxwell facilitated Prince Andrew's acts of sexual abuse by acting as a madame for Epstein, thereby assisting in internationally trafficking Jane Doe No. 3 and numerous other young girls for sexual purposes. Another person in Epstein's inner circle of friends, who becomes apparent with almost no investigative effort, is Jean-Luc Brunel. Epstein sexually trafficked Jane Doe No. 3 to Jean-Luc Brunel many times. Brunel was another of Epstein's closest friends and a regular travelling companion, who had many contacts with young girls throughout the world. Brunel has been a model scout for various modelling agencies for many years, and apparently was able to get US passports for young girls to work as models. He would bring young girls, ranging to ages as young as 12, to the United States for sexual purposes, and farm them out to his friends, especially Epstein. Brunel would offer the girls modelling jobs. Many of the girls came from poor countries or impoverished backgrounds, and he lured them in with a promise of making good money. Epstein forced Jane Doe No. 3 to observe him, Brunel and Maxwell, engage in illegal sexual acts with dozens of underage girls. Epstein also forced Jane Doe No. 3 to have sex with Brunel on numerous occasions, at places including Epstein's mansion in West Palm Beach, Little St. James Island and the US Virgin Islands, many including orgies that were comprised of other underage girls, New York City, New Mexico, Paris, the south of France, and California. Epstein also trafficked Jane Doe No. 3 for sexual purposes to many other powerful men, including numerous prominent American politicians, powerful business executives, foreign presidents, a well-known prime minister, and other world leaders. Epstein required Jane Doe No. 3 to describe the events that she had with these men so that he could potentially blackmail them. The government was well aware of Jane Doe No. 3 when it was negotiating the MPA, as it listed her as a victim in the attachment to the MPA. Moreover, even a rudimentary investigation of Jane Doe No. 3's relationship to Epstein would have revealed the fact that she had been trafficked throughout the United States and internationally for sexual purposes. Nonetheless, the government secretly negotiated a non-prosecution agreement with Epstein, precluding any federal prosecution in the Southern District of Florida of Epstein and his co-conspirators. As with Jane Doe No. 1 and Jane Doe No. 2, the government concealed the non-prosecution agreement from Jane Doe No. 3, all in violation of her rights under the CVRA, to avoid Jane Doe No. 3 from raising powerful objections to the MPA that would have shed tremendous public light on Epstein and other powerful individuals, and that would likely have been prevented it from being concluded in the secretive manner in which it was. Jane Doe No. 4 circumstances. If permitted to join this action, Jane Doe No. 4 would allege, and could prove at trial, that she has CVRA claims similar to those advanced by Jane Doe No. 1 and Jane Doe No. 2 based on the following. As with the other Jane Does, Jane Doe No. 4 was repeatedly sexually abused by Epstein. In or around the summer of 2002, Jane Doe No. 4,
An economically poor and vulnerable 16-year-old child was told by another one of Epstein's underage minor sex abuse victims that she could make $300 cash by giving an old man a massage on Palm Beach. An acquaintance of Jane Doe No. 4, also a minor sexual abuse victim of Epstein, telephoned Epstein and scheduled Jane Doe No. 4 to go to Epstein's house to give him a massage. During that call, Epstein himself got on the phone, a means of interstate communication, with Jane Doe No. 4, asking her personally to come to his mansion on Palm Beach. Jane Doe No. 4 then went to Epstein's mansion and was escorted upstairs to Epstein's large bathroom by one of Epstein's assistants. Shortly thereafter, Jeffery Epstein emerged and lay face down on the table and told Jane Doe No. 4 to start massaging him. Epstein asked Jane Doe No. 3 her age, and she told him she had recently turned 16. Epstein subsequently committed illegal sexual acts against Jane Doe No. 4 on many occasions. Epstein used a means of interstate communication, i.e. a cell phone, to arrange for these sexual encounters. Epstein also frequently travelled in interstate commerce, i.e. on his personal jet, for purposes of illegally sexually abusing Jane Doe No. 4. January. In the meantime, however, counsel for the victims believe that it is no longer appropriate to delay filing this motion, and accordingly file it at this time. Because the government is apparently opposing the motion, Jane Doe No. 3 and Jane Doe No. 4 have described the circumstances surrounding their claims, so that the court has appropriate information to rule on the motion. Conclusion. Jane Doe No. 3 and Jane Doe No. 4 should be allowed to join this action, pursuant to Rule 21 of the Federal Rules of Civil Procedure. Their joinder should be conditioned on the requirement that they not relitigate any issues previously litigated by Jane Doe No. 1 and Jane Doe No. 2. A proposed order to that effect is attached to this pleading. Dated December 30th, 2014. Certificate of Service. I certify that the foregoing document was served on December 30th, 2014, on the following using the court's CM-ECF system. Signed, Bradley J. Edwards. United States District Court, Southern District of New York. Virginia L. Joffrey, Plaintiff. Case number 15CV-07433 RWS. v. Ghislaine Maxwell, Defendant. Plaintiff's non-redacted motion to exceed presumptive 10 deposition limit in Federal Rule Civil Procedure 30A2A2. Plaintiff Virginia Joffrey, by and through her undersigned counsel, hereby files this motion to take approximately 7 additional depositions, in this case beyond the presumptive 10 deposition limit. Ms. Joffrey's request is still within the total number of hours allowed by the 10 deposition limit because the parties have agreed that they will split the time for all third-party witnesses, such that Ms. Joffrey will only be expending at most 3.5 hours at those additional depositions. In an abundance of caution, even though Ms. Joffrey will not likely be exceeding the total number of hours allowed for depositions, she seeks leave from this court to confirm that she may proceed with the additional depositions for the reasons stated below. Ms. Joffrey has alleged that defendant recruited females for Mr. Epstein, including underage females like herself, under the guise of working in a legitimate position, such as an assistant or as a massage therapist, only to almost immediately be coerced or enticed into engaging in sex for money. Defendant has challenged the veracity of Ms. Joffrey and appears to intend to argue that Ms. Joffrey cannot support the allegation that Ms. Maxwell recruited females for Mr. Epstein, or that the females were coerced or enticed into sex. The sexual abuse that lies at the heart of this case took place behind closed doors of Jeffery Epstein's various private mansions. Unsurprisingly, Ms. Joffrey must find supporting circumstantial evidence to support her claims. Moreover, because Mr. Epstein and defendant were travelling between Mr. Epstein's numerous homes, and thus many of the events relevant to this case took place more than 100 miles from the courthouse, Ms. Joffrey cannot compel most of the witnesses to appear via a trial subpoena. Accordingly, Ms. Joffrey seeks leave to take more than the standard 10 depositions in this case. At this time, she seeks leave to take 7 additional depositions, as articulated below.
Note: Ms. Joffrey's counsel met and conferred with defendant's counsel both in person and by phone in an effort to obtain agreement to proceed with his depositions, but was unable to attain an agreement. C. 1. Factual background. The court is aware of the scope of this case from earlier pleadings and numerous hearings. Initially, Ms. Joffrey anticipated the scope of discovery on this case would be narrow, because many of the events, such as flying to London on one of Epstein's planes with Maxwell, were supported by seemingly indisputable evidence, such as flight logs, and because the defendant's counsel initially suggested that she may invoke her Fifth Amendment rights. Instead, during her recent deposition, defendant simply failed to recall many of the most significant events in this case, or refused to respond directly to many important questions. As a result, Ms. Joffrey is now in a position where she has to call multiple witnesses to establish fundamental facts in the case. For example, defendant would not even admit that the initials GM, which are on the private plane flight logs over 300 times, represent her initials for... Extended note. Macaulay DeCal at Exhibit 1, May 17, 2016, email correspondence from Sigrid Macaulay to Laura Meniger and Jeff Pagliuca with proposed deposition calendar. Ms. Joffrey's ability to determine exactly which depositions would need to be taken was hamstrung by the defendant's refusal to sit for her deposition. As the court will recall, Ms. Joffrey made efforts to set defendant's deposition starting in February 2016, yet defendant did not sit for her deposition until after being ordered by the court on April 22, 2016. During that deposition, defendant refused to answer a number of questions and refused to acknowledge basic facts in this case, thereby causing Ms. Joffrey to have to depose a number of unanticipated witnesses. Ms. Joffrey's counsel started conferring with defendant's counsel in February 2016 and is actively engaged in discussion about these depositions that Ms. Joffrey knew she needed to take. On May 9, 2016, the parties conferred regarding deposition scheduling, and Ms. Joffrey noticed depositions in accordance with the dates and locations that defendant's counsel said were available, and on May 17, 2016, provided her with a calendar outlining those dates. See Macaulay DeCal at Exhibit 1, May 17, 2016, email correspondence from Sigrid Macaulay. Ms. Maxwell waited until one day before the first deposition scheduled to take place on May 31, 2016, to inform Ms. Joffrey's counsel that she refuses to attend the deposition of this subpoenaed witness unless Ms. Joffrey drops her request to seek additional depositions by way of this motion. If you intend to seek more than 10 depositions, or to continue the discovery cut-off post July 1st, then we will not be appearing at the depositions next week. See Macaulay DeCal at Exhibit 2, May 27, 2016, email correspondence from Laura Meniger to Bradley Edwards. This obstruction of discovery by refusing to attend subpoenaed depositions that were noticed to her about 1 month ago on May 4, 2016 should not be condoned. See Macaulay DeCal at Exhibit 3, May 4, 2016, Notice of Service and Subpoena to Joan Alessi. Defendant's counsel is also apparently refusing to appear at the other two depositions set for next week, of Maria Alessi set for Wednesday, July 1, 2016, and originally noticed on May 4, 2016, and Dave Rogers set for Friday, June 3, 2016, and originally noticed on May 4, 2016. While Ms. Joffrey has originally hoped to be able to conclude discovery on July 1, 2016, defendant's refusal to attend depositions and agree to scheduling is putting Ms. Joffrey in a position where she will need additional time to complete discovery. See Macaulay DeCal at Exhibit 4, May 26, 2016, letter from Sigrid Macaulay. Ghislaine Maxwell. Therefore, Ms. Joffrey is now required to take the deposition of pilot Dave Rogers to authenticate his pilot logs and the identity of the individuals on various flights. In addition, as the court knows, this case involves allegations that Ms. Joffrey was a victim of sexual abuse when she was under the age of 18, after being recruited by Ghislaine Maxwell and Jeffery Epstein. Ms. Joffrey has alleged that defendant recruited her and other young females, unexperienced in massage, for sex with Jeffery Epstein, by lying to them and telling them that the job was to be her personal assistant or a massage therapist. That was a ruse. Instead, defendant recruited these females for sex, with Jeffery Epstein and often with herself, and massage was a euphemism for sex in defendant's household. Defendant has stated that these claims are obvious lies. Aside from the deposition of the defendant, Ms. Jeffery has taken the deposition of one other witness, Johanna Sjoberg, on May 18, 2016. Ms. Sjoberg testified that, while a 20-year-old college student with no massage training, Ms. Maxwell, a stranger to her, approached her on her college campus and told her she would hire Ms. Sjoberg as her personal assistant. After Ms. Sjoberg began to work for defendant inside the home she shared with Epstein, defendant revealed that Ms. Sjoberg's true job was to complete sex acts with Jeffery Epstein. Defendant was explicit with her instructions, at one point scolding Ms. Sjoberg for failing to finish her job, after Ms. Sjoberg massaged Epstein without completing the sex act, and because of this failure, defendant instead had to finish her job for her, and cause Epstein and complete the sex act. See Macaulay de Carl at Exhibit 5, Deposition of Johanna Sjoberg. Accordingly, in this manner, Ms. Jeffery needs to depose other witnesses to show the veracity of her claim that defendant recruited young females inexperienced in massage for sex with Jeffery Epstein, proving that defendant was lying when she called Ms. Jeffery a liar and knew at the time she made the defamatory statement that it was untrue. Testimony like that from Ms. Sjoberg's refutes defendant's testimony and goes to her credibility and goes to the claim at the centre of this case. Additionally, to prove Ms. Jeffery's allegations that span multiple years, on multiple continents and multiple locations, Ms. Jeffery has arranged a series of depositions of persons with direct knowledge of the relevant issues. To prove her case, Ms. Jeffery believes that a minimum of 17 depositions will be required. In reviewing this list of depositions, it is important to understand that only one of them, the defendant's, will consume a full 7 hours of questioning by Ms. Jeffery's counsel, as permitted under the rules. See Fed R. Civ. P. 30D1. Aside from the defendant's deposition, all of the other depositions set by Ms. Jeffery have been pursuant to an agreement with defendant's counsel that Ms. Jeffery will be given half of the 7 hours to ask questions. In the descriptions below, the time Ms. Jeffery will have to ask questions, or thus far has asked questions, is indicated. A. Depositions taken thus far by Ms. Jeffery. 1. Ghislaine Maxwell, 7 hours. The defendant, of course, has relevant information in this case, but when defendant was deposed, she refused to answer numerous questions about alleged adult consensual sex. Those refusals are currently before the court in a pending motion to compel, DE 155, and more broadly, defendant's deposition makes it clear that she intends to contest many of the points that earlier had appeared to be potentially uncontested. For example, in pleadings before her deposition, defendant has suggested that she might invoke her Fifth Amendment right to remain silent during questioning. Indeed, just a week before her deposition, defendant filed a motion seeking the alternative relief of staying further proceedings so that she could get more information about whether to take the Fifth. See DE 101 at 2-4. During her deposition, however, defendant did not take the Fifth. Instead, she testified that she suffered from a series of memory lapses and could not recall many of the key issues in dispute in this case. As a result of defendant's inability to remember events, a variety of issues are now in dispute. For example, at her deposition, defendant indicated that she lacked recollection of, or was otherwise unable, to specifically answer the following questions. Whether defendant observed a female under the age of 18 at Jeffery Epstein's home in Palm Beach. See Macaulay de Carl at Exhibit 6, Maxwell Depo at 29. Whether defendant had met Miss Jeffery and introduced her to Epstein. ID at 33. Whether defendant, in 2011, could recall having met Miss Jeffery at the Mar-a-Lago in Palm Beach and then writing that fact in an email. ID at 35. Whether, when defendant first met, redacted. Whether defendant could recall being on a plane with redacted and Miss Jeffery, redacted. Whether the defendant knew what Nadia Marcinkova was doing at Epstein's mansion. ID at 41 and 44. Whether defendant knew the nature of the relationship between Epstein and Sarah Kellen. ID at 47 to 48. Whether defendant knew that Sarah Kellen recruited girls under the age of 18 to come to Epstein's mansions. ID at 56 to 57. Whether massage therapists at Epstein's mansions performed sexual acts. ID at 52 to 54. Whether defendant knew the age of Eva Dubbin when she, Dubbin, met Epstein. ID at 58 to 59. Whether defendant advised Johanna Sjoberg that she, Sjoberg, could obtain extra money if she massaged Epstein. ID at 61. Whether defendant introduced Sjoberg to Prince Andrew. ID at 63. Whether defendant could recall Emmy Taylor brought masseuses to Epstein's mansion. ID at 67. Whether defendant knew what Miss Jeffery was required to wear while providing massages to Epstein. ID at 68 to 69. Whether defendant could recall having a laundry basket of sex toys in Epstein's Palm Beach mansion, as described by one Alessi. ID at 70 to 75. Whether defendant could recall paying Miss Jeffery. ID at 75. Whether defendant was ever present to view Miss Jeffery massaging Epstein. ID at 75. Whether defendant could recall telling Miss Jeffery that she needed a cell phone so that she could be on call regularly. ID at 77. Whether defendant was required to be on call to come to Epstein's mansion when he wanted her to come. ID at 79. Whether defendant could recall Miss Jeffery being at Epstein's New York mansion when Prince Andrew came to visit. ID at 80 to 81. Whether defendant could recall Miss Jeffery staying at any of Epstein's 6 homes. ID at 81. Whether defendant was aware that there were over 30 individuals who were minors who gave reports to the Palm Beach Police Department who said they were sexually assaulted by Epstein during the years that defendant was working with him. ID at 89 to 91. Whether defendant introduced Miss Jeffery to Prince Andrew in London. ID at 108. Whether Miss Jeffery ever stayed at defendant's home in London. ID at 108. Whether defendant remembered taking a trip with Miss Jeffery to travel over to Europe, including London. ID at 108. Whether defendant could recall Prince Andrew being present in New York for a party where Johanna Sjoberg was also present. ID at 112 to 13. Whether a picture depicting Prince Andrew, Miss Jeffery and defendant was taken at defendant's London town home. ID at 113 to 14. Whether defendant ever flew on one of Epstein's planes with a 17-year-old. ID at 121 to 22. Whether the notation GM on flight logs for passengers on Epstein's planes represented the defendant, i.e. Ghislaine Maxwell. ID at 122 to 23. Whether defendant knew that the flight logs produced by Dave Rogers, one of Epstein's pilots, were accurate. ID at 128 to 29. Whether defendant could recall ever being on a flight on one of Epstein's planes with Miss Jeffery. ID at 132 to 33. Whether defendant could recall Epstein and former President Clinton being friendly towards each other. ID at 135 to 36. Whether defendant could recall the purpose of a trip to Thailand with Epstein and former President Clinton was. ID at 140. Whether defendant could recall Miss Jeffery taking pictures and trips. ID at 144. Whether defendant could recollect writing down messages on memo pads from various individuals at Epstein's Palm Beach mansion. ID at 150 to 57, 159 to 60. Whether defendant could recall receiving a message on a memo pad concerning redacted. Whether defendant could explain why a minor would be calling Epstein to say they had a female for him. ID at 164. Whether defendant could recall a 16-year-old Russian girl who came to Epstein's mansion. ID at 167. Whether defendant believed that Epstein sexually abused minors. ID at 171 to 80. Whether defendant was present at Epstein's Florida mansion when police executed a search warrant. ID at 186. Whether defendant took a picture at one of Epstein's properties of a person in either a naked or semi-naked state. ID at 193. Whether defendant could recall what Epstein told her about the criminal investigation of him. ID at 194 to 95. Whether Epstein told defendant that he never had sex with Miss Jeffery. ID at 197. Whether it was an obvious lie that Epstein engaged in sexual conduct with Miss Jeffery while she was under the age of 18. ID at 202-206. Whether defendant knew whether Epstein had sex with a minor. ID at 239. Whether it was a lie for Miss Jeffery to say that defendant approached females to bring them to Epstein. ID at 244-46. Whether defendant knew Epstein had a sexual preference for minors. ID at 251-53. Whether defendant knew that redacted asked girls to come over to see Epstein for purposes of sexual massage. Redacted. Whether defendant could recall seeing redacted and Epstein together. Redacted. Whether defendant was aware of any interstate or international transportation of women, aged 18 to 28, for purposes of having sex with Epstein where they would receive compensation. ID at 278-79. Whether defendant could recall anything about a puppet or caricature of Prince Andrew in Epstein's home when Prince Andrew was there, including whether Miss Jeffery was sitting on Prince Andrew's lap with the puppet or caricature. ID at 289-93. Whether defendant could remember entering any telephone numbers into a contact book maintained by Epstein. ID at 320-22. Whether a document with Epstein's contacts, including massage contacts, was located on defendant's computer. ID at 331-34. Whether, if Alfredo Rodriguez said that defendant had knowledge that underage girls were coming over to Epstein's Florida mansion for purposes of sex, that would be a true statement. ID at 329-30. Whether defendant could recall any representative of hers informing the press that Miss Jeffery committed grand theft. ID at 344-45. Whether defendant knew what her press agent, Ross Glow, was referring to when he talked in an email about helpful leakage. ID at 349-50 and 406. Whether defendant could recall interacting with anyone other than Miss Jeffery under the age of 18 on any of Epstein's properties. ID at 384. Whether defendant had discussed with Prince Andrew any of the details of Miss Jeffery's allegations against him. ID at 400. Because defendant refused to answer those questions, Miss Jeffery needs to depose other witnesses who have the requisite knowledge to testify concerning those issues. 2. Johanna Sjoberg, 3.5 hours. Miss Sjoberg's deposition was taken on May 18th, 2016 in Fort Lauderdale. She testified as follows. Johanna confirmed that Maxwell recruited her to work as an assistant, but she was almost immediately converted into a massage therapist and worked for Maxwell and Epstein from 2001 to 2006. See Macaulay Dickel at Exhibit 5, May 18, 2016, Deposition TR at P8-9. Johanna confirms that she knew Virginia was underage when she met her on the trip to New York with Jeffrey in 2001, because Virginia couldn't get into the casino, and then later Johanna asked her and Virginia said she was 17, page 18. Johanna testified that Virginia looked young, page 18 to 19. Johanna added, "At the time, I had the impression that she did not have a family, or she had walked away from her family. And it seemed to me, they had just sort of adopted her. Not as a child, but they would take care of her." Page 88. Johanna testified that Jeffrey had to have 3 massages a day from different girls. Page 30. Johanna testified that Jeffrey told her that he had 3 massages a day because he needed to have 3 orgasms a day. It was biological, like eating. Page 32. Johanna testified that Maxwell let me know that she would not be able to please him as much as he needed, and that is why there were other girls around. Page 33. She, Maxwell, said she doesn't have the time or the desire to please him as much as he needs, and that's why there were other girls around. Page 150 to 151. Johanna confirmed that she witnessed Virginia when she was 17 in Jeffrey Epstein's New York mansion with Prince Andrew and Ghislaine Maxwell. Page 87. Johanna also testified that Prince Andrew sat with Virginia and Johanna and took a picture with a puppet in his image that had its hand and Prince Andrew's hand on their respective breasts. Page 83. Johanna testified that Maxwell bought a camera for her and asked her to take naked pictures of herself with Jeffery. Page 145. Johanna testified that Maxwell would not give her the camera because Johanna didn't finish the job when massaging Jeffery, so Maxwell had to do it and was not happy. Page 34. She told me, called me after I had left and said, I have the camera for you, but you cannot receive it yet because you came here and didn't finish your job and I had to finish it for you. She was implying that I did not get Jeffery off and so she had to do it. Q. When you say get Jeffery off, do you mean bring him to orgasm? A. Yes. Page 34 to 35. Maxwell told Johanna to always act grateful to Jeffery Epstein. Page 35. Maxwell called Johanna and the other girls her children when they were on a trip to the USVI. Page 36. David Copperfield was at a dinner at Epstein's, and there was another girl present who looked young, and Johanna asked what school she went to, and Johanna did not recognize the school name as being a college, and she said it was possible it was a high school-aged girl. Johanna said Copperfield questioned me if I was aware that girls were getting paid to find other girls. Page 37 to 38. Johanna testified she heard Jeffery call someone to try to find girls in Hawaii to send over the Frederick for Kai. Page 38 to 39. Johanna testified Jeffery told her, Clinton likes them young, referring to girls. Page 41. Johanna testified that she was naked for 25 to 50% of all massages. Page 42. Johanna testified that Jeffery made her perform sexual acts during massages, including sexual toys, and she had intercourse with him. Page 43 and 146 to 147. Johanna testified that Nadia Marcinkova and Maxwell were both with her in the USVI in 2005. Page 44. Johanna testified that Maxwell asked her to find other girls to perform massages at the house. Page 141. She gave a name of a girl from a restaurant to Maxwell, and Maxwell paid her $200 for the girl's name. Did Maxwell ever ask you to bring other girls over for Jeffery? Page 46. A. Yes. And I recall Ghislaine giving me money to bring her over. Page 141. Johanna testified that if a massage involved sexual acts, that Jeffery paid Johanna more than a normal $200. Page 100 to 101. She testified that defendant called Emmy Taylor her slave. Page 15. Later she testified that Jeffery, he told me one time Emmy was sleeping on the plane and they were getting ready to land and he went and woke her up and she thought that meant he wanted a sex act. So she started to unzip his pants and he said, No, you just have to wake up for landing. Page 143 to 144. Johanna said defendant flew her in the helicopter from the main island to the USVI. Page 55. Johanna says she believes that Virginia is sane about being abused by Jeffery and Maxwell. Basically, that I believed her, even though she never spoke to me specifically about what was going on. That once I learned everything that happened based on reading the police report, I believed her side of the story. Page 122 to 123. Q. And what experience in the house helped you form your opinion that what Virginia is saying is true? A. Jeffery being open with me about what other girls did for him, and that I was not one of those girls. He was always trying to recruit me almost in a way that I could be one of them, and travel with him and live the life of luxury if I only did this. So after 5 years of learning what was happening, I could look back knowing. I only knew Virginia a short time. Looking back, I can make assumptions about what was required of her. Page 123 to 124. She said she recalls that defendant went to dinner with Governor Bill Richardson one time when Johanna was visiting the ranch in New Mexico. Page 110. B. Future depositions sought by Miss Joffrey. Miss Joffrey has also scheduled the following depositions. 3. Juan Alessi, 3.5 hours. Mr. Alessi's deposition is scheduled for May 31st, 2016 in Florida. Mr. Alessi was one of the employees in Epstein's mansion. Mr. Alessi provided witness statements to police during the criminal investigation in Palm Beach and was previously deposed in civil cases previously brought against Mr. Epstein. Specifically, Juan Alessi informed the Palm Beach police detective as follows. Alessi states that towards the end of his employment, the masseuses were younger and younger. When asked how young, Mr. Alessi stated they appear to be 16 or 17 years of age at most. Emphasis added. See Macaulay Decal at Composite Exhibit 7, Palm Beach Police Incident Report at page 57. On November 21, 2005, the Palm Beach Police Department took a sworn statement from House employee Juan Alessi, in which he revealed that girls would come over to give massages, and he observed Miss Maxwell going upstairs in the direction of the bedroom quarters. See Macaulay Decal at Exhibit 8, November 21, 2005, sworn statement at 10. He also testified that after the massages, he would clean up sex toys that were kept in Miss Maxwell's closet, ID at 12 to 13. He added that he and his wife were concerned with what was going on at the house, ID at 14, and that he observed girls at the house, including one named Virginia, ID at 21. It is anticipated that he will testify consistently with that previous testimony. Note, as explained above, as of today, defendant's counsel sent an email refusing to attend this deposition, set for Tuesday, May 31st, 2016. Monday is Memorial Day. See Macaulay Decal at Exhibit 2. 4. Maria Alessi, 3.5 hours. Miss Alessi's deposition is scheduled for June 1st, 2016 in Florida. She was, with her husband, household staff at Epstein in the Palm Beach home he shared with defendant, and, it is anticipated, will corroborate many of the observations of her husband about minor girls and massages inside of Epstein's Florida mansion. Mr. Alessi referenced during his prior deposition the things that Miss Alessi observed with respect to the sexual massages and involvement of minor girls. Mrs. Alessi is also anticipated to testify regarding Miss Maxwell's close association with Mr. Epstein and knowledge of the visitors. 5. Dave Rogers, 3.5 hours. Mr. Rogers' deposition is scheduled for June 3rd, 2016 in Florida. Rogers was one of the pilots for Epstein's private jets and will, it is anticipated, authenticate his flight logs showing defendant and Miss Jeffery together on the same flights. Defendant refused to admit that her name is reflected in the flight logs, despite her initials GM appearing over 300 times. Therefore, such authentication is necessary, because defendant testified at her deposition she could not remember even the most basic things about flights in the flight logs. For example, when asked if GM represented her initials on the flight log, defendant responded, "How do you know GM is me?" See Macaulay Decal at Exhibit 5, Maxwell Depo at 29, at 122, and GM can stand for any level. It could be Georgina, George, ID at 123. Miss Jeffery is also seeking additional flight logs in Mr. Rogers' possession that will further corroborate defendant's involvement with Jeffery Epstein. 6. Ronaldo Rizzo, 3.5 hours. Mr. Rizzo is scheduled for June 10th, 2016 and will be able to testify regarding his observations of defendant and Epstein with underage girls less than 18 years of age. Mr. Rizzo was originally set for deposition on May 13th, 2016, which was noticed on April 11th, 2016, and defendant requested that Miss Jeffery reschedule that deposition just days before the scheduled date. 7. Jean-Luc Brunel, 3.5 hours. Mr. Brunel's deposition is set for June 7th, 2016, in New York. He has relevant information because he has known Maxwell and Epstein for many years, and was present with Epstein and defendant on many occasions at Epstein's homes in New York, Palm Beach, and the USVI, and he has personal knowledge of the disputed issues in this case. Ross Go, 3.5 hours. Mr. Go is defendant's press agent, who issued the press statement at issue in this case on defendant's behalf. He will be able to testify regarding the defamatory statement, its distribution, any other defamatory statements that were distributed, and any information he had regarding the basis for the statement. Ms. Jeffery has requested that the defendant agree to produce Mr. Go rather than requiring the time and expense of having to serve a subpoena on Mr. Go, located in London under the Hague Convention, but counsel for defendant has not agreed to produce Ross Go for deposition. Dana Burns, 3.5 hours. Ms. Burns' deposition is set for June 8, 2016 in New York City. Information redacted. 10. Jojo Fontanella, 3.5 hours. Jojo Fontanella is a critical witness because he has been working as Jeffery Epstein's butler in his New York mansion for a number of years, including during the time that Miss Jeffery was staying the night at the mansion when she was a minor child. Virginia interacted with Mr. Fontanella frequently during the time she was with Mr. Epstein and the defendant. Mr. Fontanella will be able to testify to what he observed at the New York mansion, including his observation regarding the age and number of females who visited the house each day. Mr. Fontanella will be able to testify regarding defendant's presence at the home at various times and what he observed defendant doing while she was at the New York mansion. 11. Detective Joe Ricari, 3.5 hours. During defendant's deposition, defendant questioned the veracity of the Palm Beach police report containing the accounts of the numerous minor children who were also sexually abused by Jeffery Epstein. Defendant referred to at least one of those children as a prostitute, which is false. See Macaulay DeCull at Exhibit 5, Maxwell Deposition at 173, 8-12, 359, 11-18. The Palm Beach police report also includes statements about the defendant. Detective Ricari is expected to testify regarding his investigation, what he observed, the evidence he collected from Mr. Epstein's Palm Beach mansion, the modus operandi of the Epstein organization, and the interviews he conducted with a number of females who were subject to abuse at the Palm Beach mansion. He will also testify regarding Jeffery Epstein's, who is in a joint defense with the defendant, and his campaign to attack the credibility of the numerous minor children who reported sex offences against him. Attacking the credibility of their victims, including Miss Jeffery, is a part of Epstein and defendant's modus operandi. 12. Former Palm Beach Police Chief Michael Rita, 3.5 hours. Chief Rita is scheduled for deposition on June 20th, 2016. He was the police chief who was responsible for overseeing the Palm Beach Epstein investigation. He has made public statements about the 40 victims of Jeffery Epstein's abuse. He has made public statements about the fact that after he started the investigation into the crimes that took place at the Palm Beach mansion, he was followed by strange men and investigated. He also has made public statements that he sent to victims regarding the failure of the government to properly handle the matter. Rita is relevant to many issues, among others. Defendants claimed innocence by the fact that she was never formally charged. 13. Emmy Taylor, 3.5 hours. Emmy Taylor was defendant's assistant during this time Miss Jeffery was being abused. Miss Taylor was on flight logs to Europe with Miss Jeffery and other locations in the United States. Johanna Sjoberg testified that Emmy Taylor was referred to by the defendant as my slave, and that Miss Taylor trained Miss Sjoberg to give massages while Miss Sjoberg was naked. Emmy Taylor will be able to testify as to what she observed and experienced during the years she was with defendant and Epstein. Miss Jeffery is still attempting to locate Miss Taylor, but she is believed to reside in London. 14. Completely redacted. 15. Nadia Marcinkova, 3.5 hours. Ms. Marcinkova's deposition is set for June 16, 2016 in New York. Ms. Marcinkova was specifically identified by the U.S. Attorney's Office for the Southern District of Florida as a potential co-conspirator of Epstein in the non-prosecution agreement it executed with Mr. Epstein as part of his guilty plea. She has relevant information because she observed the recruitment of underage girls for sex and, in fact, participated in sex acts with minors. She was also on numerous flights with defendant, in contradiction to defendant's testimony, and she can provide valuable testimony about Maxwell's role in the recruitment of females. 16. Sarah Kellen, aka Sarah Kensington, or Sarah Vickers. 3.5 hours. Ms. Kellen's deposition is set for June 22, 2016 in New York. Ms. Kellen specifically identified by the U.S. Attorney's Office for the Southern District of Florida as a potential co-conspirator of Epstein, in the non-prosecution agreement it executed with Mr. Epstein as part of his guilty plea. She has relevant information because she was present during the time when Virginia was with Epstein and the defendant, and she travelled with all of them during this critical time period. It is believed that she worked at the direction of and directly under Ms. Maxwell and was taught by Ms. Maxwell how to recruit females for sex with Mr. Epstein. Note: Marcinkova, Kellen and Epstein have not been personally served and are all subject to Ms. Joffrey's motion for alternative service, DE 160. 17. Jeffery Epstein, 3.5 hours. Ms. Joffrey's counsel have been in touch with Epstein's counsel and is continuing to work to schedule his deposition. Epstein lies at the centre of this case, and he can testify that the defendant recruited females for sex with him, including Mrs. Joffrey, under the offer of being a massage therapist, and ultimately paid these females for sex. He can testify that defendant lured dozens, if not hundreds of young females, including many underage females, to his residences for sexual purposes. 2. Discussion. Ms. Joffrey has attempted to conduct discreet, focused discovery in this case to limit any burdens on the defendant and on the court. Nonetheless, this case presents numerous challenges that require that she take more than 10 depositions, not the least of which is defendant's extraordinary lack of memory about many events that would appear to have indisputably taken place. Ms. Joffrey, however, is not seeking to exceed the allotted hours for depositions under Rule 45, only the number of depositions. Ms. Joffrey seeks leave of court to 7 additional depositions, for a total of 17 depositions. Under the rules, each party is entitled to take 10 depositions, which total 7 hours each. Fed R. Civ P 29D1. Thus, the presumptive time limit for depositions is a total of 70 hours. 10 depositions times 7 hours per deposition. For the convenience of opposing counsel, Ms. Joffrey has stipulated that they may have half of the 7-hour disposition time for each third-party witness. Thus, if the court grants Ms. Joffrey's motion, she will end up taking less than 70 hours of deposition testimony. Specifically, she will only take 1 deposition of 7 hours, defendants, and 16 depositions of 3.5 hours, a total of 66.5 hours of depositions. In light of the accommodation she had extended to opposing counsel, Ms. Joffrey requested that opposing counsel agree that both sides could schedule additional depositions beyond the presumptive limit of 10. Defendant refused to agree, and is also in disagreement about the proposed schedule for depositions, despite the fact that Ms. Joffrey scheduled depositions based on the dates defendant's counsel represented were available for depositions in this case. At defendant's counsel's request, Ms. Joffrey scheduled depositions of witnesses who lived in the same geographical location on consecutive days to limit the travel time and expense. See Macaulay Decull at Exhibit 1. Sadly, it appears that defendant's counsel may be attempting to delay Ms. Joffrey's ability to obtain depositions, because certain witnesses are avoiding service and others were difficult to locate, and the time period for the close of discovery is swiftly approaching. The court will recall that the defendant managed to delay her deposition until April 22, 2016, through unnecessary motion practice. And now that the need to depose other witnesses has been established, defendant's counsel are employing other delay tactics. The court currently has before it, for example, Ms. Joffrey's motion for leave to serve 3 deposition subpoenas by means other than personal service, DE 160. As recounted at greater length in that motion, 3 of the critical witnesses in this case, Jeffery Epstein, Sarah Kellen, and Nadia Marcinkova, have all thus far managed to evade service of process despite repeated, diligent, and expensive efforts at personal service. Of course, all 3 of these witnesses are persons who have worked very closely with defendant in the past. Epstein is also in a joint defense agreement with defendant. In other situations, Ms. Jeffery has been forced to delay taking depositions because of defense counsel. For example, Ms. Jeffery served a subpoena on Mr. Rizzo and opposing counsel on April 11, 2016, for a deposition a month later on May 13, 2016. Just days before the deposition, defendant's counsel said they didn't realize the deposition was scheduled and that they could not proceed forward on that date. See Macaulay de Carl at Exhibit 9, May 5, 2016 email correspondence regarding scheduled depositions. This forced Ms. Jeffery's counsel to have to reset the witness for June 10, 2016. Of course, with each delay, Ms. Jeffery is hamstrung in identifying which further witnesses need to be deposed. Under Rule 30A of the Federal Rules of Civil Procedure, any party who wishes to conduct more than 10 depositions within stipulation by the opposing party must seek leave of the court. Fed R. Civ P 30A 2A1. Once such a motion is made, the court must grant a request to exceed 10 depositions, unless the additional depositions will be unreasonably cumulative or duplicative. The requesting party had a prior opportunity in discovery to obtain the information sought, or the burden or expense of additional depositions would outweigh any likely benefit. In R.E. Weatherford, Intel, Set, Litig, Number 11, Civ, 1646, LAC JCF, 2013, WL 5762923, at 2, SDNY, October 24, 2013, citing Fed R. Civ P 26B to C. Reniola v. Bratton. 243 F 3D 610 628 2D Sir 2001. Given the liberal discovery allowed by the rules, the burden on the party seeking additional depositions is not great. Rule 30A2's 10 deposition limit is a useful and appropriate stop sign, not as a road closed sign. Once any party has taken 10 depositions, it makes perfect sense to require that party to demonstrate the need for more. But their showing need not be onerous. If the need exists, discovery should not be prevented. Scott v. City of Sioux City, Iowa. 298 FRD 400 402-203, ND Iowa 2014. As the court can readily determine from the summary of anticipated testimony above, none of the anticipated testimony is unreasonably cumulative or duplicative. Rather, all of the anticipated testimony goes to central and now disputed issues in the case. The court should be aware that at every turn, defendant appears ready to brand Miss Jeffery as a liar who cannot be believed. Thus, obtaining witnesses like Miss Sjoberg, who can corroborate that she is telling the truth, is more important in this case than it would be in many others. It is equally important that Miss Jeffery be able to depose the witnesses who can refute defendant's testimony. The court can also readily determine that Miss Jeffery has not had any prior opportunity to obtain discovery of the witness she seeks to depose. The case is only now in the fact discovery phase, and she has had no opportunity to previously depose these third-party witnesses. Finally, there is no substantial burden involved with deposing 7 additional witnesses. Any assessment of burden must take into account the scope of the underlying case. Ms. Jeffery is seeking both compensatory and punitive damages that will total millions of dollars. Against that backdrop, a handful of additional depositions cannot be seen as unduly burdensome. Moreover, this is not a situation where defendant lacks means to pay for counsel to attend the depositions. Defendant's vast wealth does not appear to be in doubt. During the meet and confer on this issue, the defendant's substantive reason for not stipulating to these additional depositions is that, with regard to 3 of the witnesses, Epstein, Kellen, and Marcinkova, it appears likely that they will invoke their Fifth Amendment right to refuse to answer some questions about defendant's involvement in the sexual abuse of Miss Jeffery, but until those witnesses actually take the Fifth, the conclusion that they will actually take the Fifth is at a minimum premature. Note, defendant has thus far refused to produce documents regarding the extent of her assets, arguing that until the punitive damages phase of this proceeding is reached, the discovery is not relevant. Nonetheless, public information suggests significant assets, and the possibility that she is transferring assets outside the reach of the court's jurisdiction. See, e.g., alleged Epstein Madam sells $16 million Manhattan townhouse, New York Post, April 28, 2016, available at http://newyorkpost.com/2016/04/28/alleged Epstein Madam sells 16M Manhattan townhouse. The witnesses may, for example, answer some questions and not others. And in any event, even if they take the fifth when asked about defendant's sexual abuse of minors, those invocations will quite likely be admissible against the defendant at trial. The Second Circuit has squarely held that a witness's invocation of a Fifth Amendment rights can, in proper circumstances, be used against a party. The Second Circuit's seminal decision is Liberty v. United States, 107 F3D 110 121, Second Circuit 1997, which upheld the drawing of adverse interferences based on a non-party's invocation of a Fifth Amendment right to remain silent. The Second Circuit instructed that the circumstances of a given case, rather than status of particular non-party witnesses, determines whether non-party witnesses' invocation of privilege against self-incrimination is admissible in course of civil litigation. ID at 122223. The circuit also held that in determining whether non-party witness invocation of privilege against self-incrimination in course of civil litigation and drawing of adverse interferences is admissible, the court may consider the following non-exclusive factors. 1. Nature of witness relationship with and loyalty to party. 2. Degree of control which party has vested in witness in regard to key facts and subject matter of litigation. 3. Whether witness is pragmatically non-captioned party in interest, and whether assertion of privilege advances interests of witness and party in outcome of litigation, and 4. Whether witness was key figure in litigation and played controlling role in respect to its underlying aspects. Idea 124-25. Clearly, many of these factors are going to weigh heavily in favour of drawing an adverse interference against defendant. For example, Jeffery Epstein is a pragmatically non-captioned party in interest. Note, the court should be aware that these are also the three witnesses who have been attempting to evade service of process. Regarding issues of whether he and defendant together sexually abused Ms. Jeffery, and defendant is in a joint defence agreement with Epstein. Also, some of the most important events in this case took place in private bedrooms, where just 3 people were present, Ms. Jeffery, defendant, and Epstein. With defendant denying these events, the fact that Epstein may take the fifth could provide decisive information to the jury. But the court need not make any determinations now as to precisely how these factors will play out. Instead, it is enough to note that the very important and unique evidence may be secured from the deposition of each of these 3 individuals, and therefore Ms. Jeffery should be permitted to take their deposition. Conclusion. Ms. Jeffery respectfully requests that she be allowed to take a total 17 depositions in this case. Dated May 27, 2016. Respectfully submitted. Certificate of Service. I hereby certify that on 27th day of May 2016, I electronically filed the foregoing document with the Clerk of Court by using the CM-ECS system. I also certify that the foregoing document is being served this day on the individuals identified below via transmission of notice of electronic filing generated by CM or ECF. Signed, Sigrid S. Macaulay. United States District Court, Southern District of New York. Virginia L. Jeffery, Plaintiff. Case number 15 CV 07433. RWS. V. Ghislaine Maxwell, Defendant. Non-redacted declaration of Sigrid S. Macaulay in support of plaintiff's motion to exceed presumptive 10 deposition limit in Federal Rule of Civil Procedure 30A2A2, filed under seal. I, Sigrid S. Macaulay, declare that the below is true and correct to the best of my knowledge as follows. 1. I am a partner with the law firm of Boyce, Schiller & Flexner, LLP, and duly licensed to practice in Florida, and before this court, pursuant to this court's September 29,
2015 order granting my application to appear pro hac vis. 2. I respectfully submit this declaration in support of plaintiff's motion to exceed presumptive 10 disposition limit in Federal Rule of Civil Procedure 30A2A2, filed under seal. 3. Attached hereto as Composite Exhibit 1 is a true and correct copy of the May 17th, 2016 email correspondence from Sigrid Macaulay. 4. Attached hereto as Exhibit 2 is a true and correct copy of the May 27th, 2016 email correspondence from Laura Menninger. 5. Attached hereto as Exhibit 3 is a true and correct copy of the Notice of Service and Subpoena to Dwan Alessi. 6. Attached hereto as Exhibit 4 is a true and correct copy of the May 26, 2016 correspondence from Sigrid Macaulay. 7. Attached hereto as Exhibit 5 is a true and correct copy of the May 18, 2016 deposition transcript of Johanna Sjoberg. 8. Attached hereto as Composite Exhibit 6 is a true and correct copy of the April 22, 2016 deposition transcript of Ghislaine Maxwell. 9. Attached hereto as Exhibit 7 is a true and correct copy of the Palm Beach Police Report. 10. Attached hereto as Exhibit 8 is a true and correct copy of the November 21, 2005 sworn statement of Dwan Alessi. 11. Attached hereto as Exhibit 9 is a true and correct copy of the May 4, 2016 email correspondence from Laura Menninger. I declare under penalty of perjury that the foregoing is true and correct. Signed, Sigrid S. Macaulay, Esquire. Exhibit 5. United States District Court, Southern District of New York. Case number 15CV07433, RWS. Virginia L. Joffrey, plaintiff. V. Ghislaine Maxwell, defendant. May 18, 2016. 9:04 a.m. Confidential. Deposition of Johanna Sjoberg, pursuant to notice taken by plaintiff at the offices of Bois, Schiffer and Flexner, 401 Las Olas Boulevard, Fort Lauderdale, Florida, before Kelly Ann Willis, a registered professional reporter, certified real-time reporter, and notoriety public within and for the state of Florida. The videographer. We are now on the record. This begins videotape number 1 in the deposition of Johanna Sjoberg in the matter of Virginia Joffrey versus Ghislaine Maxwell. Today is May 18th, 2016. The time is 9:04 a.m. This deposition is being taken at 401 East Las Olas Boulevard, Fort Lauderdale, Florida. The videographer is Ryan Kick. The court reporter is Kelly Ann Willis. We both represent Magna Legal Services. Will counsel and all parties present state their appearance and whom they represent? Miss Macaulay. Yes, I am Sigrid Macaulay, with the law firm of Bois, Schiller and Flexner, and I represent Virginia Joffrey. And I have here 2 colleagues of mine, Meredith Schultz and Sandra Perkins, from my firm as well. Ms. Menninger. Hi, I'm Laura Menninger from Haddam Morgan and Foreman, and I represent Ghislaine Maxwell. Mr. Lewis. I'm Dor Lewis from Sinclair Lewis and Zeventic. I'm here on behalf of the deponent. Thereupon, Johanna Sjoberg. A witness named in the notice heretofore filled, being of lawful age and having been first duly sworn, testified on her oath as follows. Examination. By Miss Macaulay. Q. Good morning, Johanna. Thank you for coming. I'm going to talk to you a little bit about the deposition process before we get started, to make sure you understand what's going to happen here today. You just heard there's a videographer, and he's going to be taking your video during this deposition, and generally what's happening in the course of the deposition. And then you have a court reporter here, who takes down the words that we say, and it's a little bit tricky because I tend to speak quickly sometimes and speak over people, and she needs to get down all of the words. So I'll try to do my best to go slower and make sure I'm not talking over you. And similarly, If you've got an answer to a question, make sure you're verbally responding, not just nodding or making a gesture, because she can't get that down. We want to make sure our responses are verbal. I'll try to remind you of that if that happens. Have you ever been deposed before? A. No. Q. No. Okay. So what's going to happen is I'm going to ask questions and you'll give answers. And like I said, everybody will be recording those. Is there any reason, any medical reason, anything you've taken today that would cause you to not be able to give truthful testimony today? A. No. Q. No. Okay. Alright, so we're going to get started, and if you have any questions during the deposition, or you need to stop to take a break, you can just let me know and we'll take that break. So the only thing I ask is, if we're in the midst of a question, you finish the answer before we take a break. A. Sure. Q. But I'll try to make sure that I take regular breaks as well. You stated your name for the record. Can you tell me your date of birth? Q. That makes you how old now? Q. Okay. And where are you currently living? Note: this stuff is redacted to protect the witness's identity. Q. And I'm going to show you what I'm going to mark as the first two exhibits in this matter. And I'm going to ask the court reporter if I can mark those. The referred to document was marked by the court reporter for identification as Sjoberg Exhibits 1 and 2. By Miss Macaulay. Q. Okay. I'm going to show you what I'm marking as Exhibit 1. It's going to be the re-notice of your videotaped deposition, which is simply a notice I'm going to show you. And then Exhibit 2 is the subpoena that we served on you. So you're here today pursuant to our notice of deposition and the subpoena that we served on you. Are you familiar with the subpoena? Have you seen that document before? A. Yes. Q. Okay, great. Alright. Do you know a female by the name of Ghislaine Maxwell? A. Yes. Q. And when did you first meet Miss Maxwell? A. 2001. March probably. End of February or beginning of March. Q. And how did you meet her? A. She approached me while I was on campus at Palm Beach Atlantic College. Q. And what happened when she approached you? A. She asked me if I could tell her how to find someone that would come and work at her house. She wanted to know if there was, like, a bulletin board or something that she could post, that she was looking for someone to hire. Q. And what did you discuss with her? A. I told her where she could go to put up a listing, and then she asked me if I knew anyone that would be interested in working for her. Q. Did she describe what that work was going to be? A. She explained that she lived in Palm Beach and didn't want butlers because they're too stuffy. And so she just liked to hire girls to work at the house, answer phones, get drinks, do the job a butler would do. Q. And did she tell you what she would pay for that kind of a job? A. At that moment, no, but later in the day, yes. Q. And what did she say? A. $20 an hour. Q. Was there anybody else with Miss Maxwell when you met her? A. There was another woman with her. I don't recall her or what she looks like or how old she was. Q. And what happened next? A. And then she asked me if I would be interested in working for her, and she told me that she was. I could trust her and that I could jump in her car and go check out the house at that moment if I wanted to. And so I said, sure, let's do it. I went to her home with her. Q. And where was that home? A. In Palm Beach. Q. And did she describe that home as being her home? A. She described it as being her home and alluded to the fact that it was her and Jeffrey's home, and that she had homes all over the world. Yes. Q. And what happened when you arrived at the home? A. I believe she just showed me around. Q. Do you recall meeting anybody at the home? A. I don't recall if I met Jeffrey at that time or the next time that I was there. Q.
How did you meet Jeffrey? Did Maxwell introduce you to Jeffrey?
A. Yes.
Q. What do you recall of your first meeting with Jeffrey?
A. I remember him being in a bathrobe. I recall talking to him about how I was a major in psychology, and he had studied psychology, and so he spoke with me about different topics. I remember thinking this guy is very smart. That was my first impression.
Q. And when you refer to Jeffrey, are you referring to Jeffrey Epstein?
A. Yes.
Q. How did the meeting... You said Maxwell took you to the home. Do you remember how that meeting ended?
A. Well, she dropped me back off at campus.
Q. And did you... A. She got my number and I took her number, and then she called me the next weekend to work. Q. So at that point you started working for Ms. Maxwell?
A. At that time, yes.
Ms. Menninger. Objection. Leading. Sorry.
By Ms. Macaulay.
Q. Did you then start working for Ms. Maxwell after that first meeting?
A.
She called me and I went over to the home the next Sunday to work. Q. And what work? Can you describe for me the first day of work? What work you performed?
A.
Sure. I remember answering the phones and taking messages. And at one point she asked me to go pick up printer ink, and I took her car to Office Depot to get ink. She asked me to go buy some magazines, so I went to Palm Beach Daily News and brought a few magazines. She and I went. She wanted to take me shopping to Worth Avenue, but it was a Sunday, and the Neiman Marcus was closed, so we went back to, a little bookstore. And I remember she bought, I think, 5 pairs of reading glasses, because she thought Jeffrey would like them. He had them all over the house. On every table there was reading glasses.
And that's about it. It was a pretty simple day.
Q. Were you paid that day for that work?
A. Yes.
Q. And how much were you paid? Do you remember?
A. I don't remember how many hours I was there. I was there. She paid me cash.
Q. So Maxwell paid you?
A. Yes.
Q. And then was she the one who trained you with what? With respect to what you were supposed to do during the day, directed you to, like you said, go to?
A. I believe she was the one that was kind of showing me around.
Q. And how long did you work in that position answering phones and doing...
A. Just that one day.
Q.
Just that one day.
And did your duties change?
A. Well, the next time she called me, she asked me if I wanted to come over and make $100 an hour rubbing feet.
Q. And what did you think of that offer?
A. I thought it was fantastic.
Q. And did you come over to the house for that purpose?
A. Yes.
Q. And when you came over to the house, was Maxwell present?
A. I don't recall.
Q. And what happened that second time you came to the house?
A.
At that point I met Emmy Taylor, and she took me up to Jeffrey's bathroom and he was present, and her and I both massaged Jeffrey. She was showing me how to massage. And then he got off the table, she got on the table. She took off her clothes, got on the table, and then he was showing me moves that he liked. And then I took my clothes off. They asked me to get on the table so I could feel it. Then they both massaged me. Q. So it was more than a foot massage at that point?
A.
Yeah, it was mostly, like legs and back. Q. Was everybody in the room without clothes on?
A.
When they were on the massage table, yes. Q. Did they, when they got off the massage table to perform the massage, did they dress or did...
A. Yes.
Q. They dressed. And do you recall who paid you for that first day that you did the massages?
A. I don't recall.
Q. Do you recall whether Maxwell was at the house during that first day when you were doing the massage with Emmy and Jeffrey? Ms. Menninger. Objection. Asked and answered. By Ms. Macaulay. Q. You can answer.
A. I don't recall.
Q. Who did Emmy work for?
A. Ghislaine.
Q. Did Maxwell ever refer to Emmy by any particular term? A. She called her slave. Q. You said your job duties changed. Did you start to travel as part of your job with Jeffery and Ghislaine? A. Yes. The next time they called me, they asked me to go to New York. Q. And did you? Do you recall when that was, approximately? A. That was Easter of 2001. Q. And do you recall who was on the plane with you for that trip? Ms. Menninger. Objection. Leading. Form. Ms. Macaulay. Actually, I'm going to stop really quickly, and I'm going to ask for the next exhibit, please. Ms. Menninger. This is free? Ms. Macaulay. Yes. I'm going to mark this as exhibit free for purposes of the deposition. The referred to document was marked by the court reporter for identification as Sjoberg Exhibit Free. By Ms. Macaulay. Q. Johanna, I'm going to direct you. I flagged some pages, but for the record, I'm going to say what pages they are before I hand you the exhibit. A. Sure. Q. These are Jeffery 00748 and 00758 are the 2 pages right now I may refer you to. The document itself is 000721 through 789. And these are flight logs from pilot David Rogers that have been produced in this case. Ms. Menninger. Objection. Foundation. Asking the witness any questions about this document. The witness. Can I touch it? Ms. Macaulay. Yes, you may. Ms. Menninger. I just have to say things every now and then. The witness. Okay. By Ms. Macaulay. Q. So you mentioned that you travelled to New York. If you turn to flag page, which should be 000748, at the top of that document, you're going to see a date of April 2001. I'm just going to ask you to go down to the... If you look at the line on the left where it says 9 for the date, and look over where it has the names, do you see... Can you identify your name on that list? A. Yes. Q. And can you tell me, I know there are initials there, who else, to the extent you remember, was on the plane with you? Ms. Menninger. Objection. Foundation. Leading form of question. By Ms. Macaulay. Q. Johanna. Do you recall who was on the plane with you that day? Ms. Menninger. Objection. Foundation. Form. Leading. The witness is reading the document. By Ms. Macaulay. Q. You can answer. A. Okay. J.E. Jeffery Epstein. E.T. Emmy Taylor. V.R. Virginia Roberts. B.K. I do not recall. And myself. Ms. Menninger. Objection. The witness is reading the document. By Ms. Macaulay. Q. And do you recall where you flew when you travelled that first time with Jeffery Epstein? A. We left from Palm Beach and landed in Atlantic City for a few hours because there was a storm in New York, and then got back on the plane a few hours later and landed in Teterboro. Q. And you said that you recall landing in Atlantic City. Did you go into Atlantic City? A. Yes. Went to one of Trump's casinos. Q. Did you actually go into the casino itself? A. Yes. Q. Do you recall Virginia, at the time Virginia Roberts being present with you? A. Yes. Q. Do you recall if she went into the casino? A. She was underage. I did not know anything about how old you had to be to gamble legally. I just knew she could not get in because of an ID issue, so she and I did not gamble. Q. In your opinion, did Virginia look young in your view? A. Yes. Q. Did you at that time wonder why she was travelling with Jeffery? A. At that time I did not. Q. Did you later wonder that? A. Yes. Q.
And what was your impression? Ms. Menninger. Objection. Vague. Speculative. The witness. We're jumping ahead. Is that okay? By Ms. Macaulay. Q. Yes, that's okay. A. A few days later, I remember asking her questions to try to figure out her role, why she was there, and she gave me vague answers and was never specific. And so I thought perhaps she just was an assistant, someone that did massages well. I wanted to believe that she was innocent. Q. Did you ever refer to her as being orphan-like? A. I did. Q. And how did that come about? A. No, to you, I said that to you. I just saw her as perhaps someone who may not have had a strong family, and they took her under their wing. Q. Now, you mentioned remembering going to Atlantic City. Where did you go after Atlantic City? A. Once we landed in New York, Emmy and I went in a car and drove around the city for a half hour or so, just to see some of the city. Q. And then where did you go after doing the sightseeing? A. We went to the townhouse on East 71st. Q. And can you describe that location for me? A. Sure. Between Madison and Park. I think the address might have been 9 East 71st Street. Q. And who owned that home? A. As far as I knew, Epstein. Q. Can you describe for me physically what... A. Palatial. When you walk up, it looks like a normal door to a townhouse, and when you walk in, I thought there were 4 floors. I heard there were 7 floors. I didn't see them all. Q. And do you recall who, if anybody, was at Jeffrey's home when you arrived? A. Yes. When I first walked in the door, it was just myself, and Ghislaine headed for the staircase and told me to come up to the living room. Q. And what happened at that point when you came up to the living room? A. I came up and saw Virginia, Jeffrey, Prince Andrew, Ghislaine in the room. Q. And did you meet Prince Andrew at that time? A. Yes. Q. And what happened next? A. At one point, Ghislaine told me to come upstairs and we went into a closet and pulled out the puppet, the caricature of Prince Andrew, and brought it down. And there was a little tag on the puppet that said Prince Andrew on it, and that's when I knew who he was. Q. And what did the puppet look like? A. It looked like him, and she brought it down and presented it to him, and that was a great joke because apparently it was a production from a show on BBC, and they decided to take a picture with it, in which Virginia and Andrew sat on a couch. They put the puppet on Virginia's lap, and I sat on Andrew's lap, and they put the puppet's hand on Virginia's breast, and Andrew put his hand on my breast, and they took a photo. Q. Do you remember who took the photo? A. I don't recall. Q. Did you ever see the photo after it was taken? A. I did not. Q. And Miss Maxwell was present during the... Was Miss Maxwell present during that? A. Yes. Q. What happened next? A. The next thing I remember is just being shown to which room I was going to be staying in. Q. When you exited the room that you were in where the picture was taken, do you recall who remained in that room? A. I don't. Q. Do you recall seeing Virginia exit that room? A. I don't. Q. During this trip to New York, did you have to perform any work when you were at the New York house? A. I performed at least one massage that I recall. Q. And who instructed you to give that massage? A. Jeffrey. Q. And can you describe for me what happened during that massage? A. Near the end, he asked me to rub his nipples while he masturbated. Q. And did that take place? A. It did not. Q. And why not? A. I was not comfortable with it, and so I left the room. Q. Did you say anything to him before leaving the room? A. I believe I said, I'm done. Q. Do you recall what his reaction was to that? A. I do not.
At the time, at that moment, I do not. Q. Did you recall later what...
A. Well, we had a conversation a little later, talking about his expectations, and that was the conversation where he said that the next trip they were going on was to the island in the Virgin Islands, and I will be invited. However, there will be, quote, sex stuff happening. Q. Can you describe for me what that, in New York, where you massaged, and what that looked like? A. He had one room that was the massage room. It was about the size of a spa room in a spa. It had high ceilings. It had dark tapestry on the walls. It was a very dark room. There was a very large picture of a naked woman whom I don't recall. That's all I remember. Q. In the New York home, did you observe photos around the house? A. I don't recall. Q. In the Palm Beach home that we were talking about earlier, did you recall seeing photos in that? A. Yes. Q. And did you recall seeing photos of naked females in that home? A. Yes. Q. Approximately, can you tell me where you would see those in the home? A. I definitely saw them in his bathroom. And I can't recall if they were in the main living areas. Q. Did you see them in the stairwell up to the second story of the house? A. I can't recall. Q. Do you know who the people were in those photos? Were you familiar with any of them? A. No. Q. Were you in any of those photos? A. At one point, yes. Q. And were you naked in that photo? A. Topless. Q. Do you recall seeing any naked photos of Virginia Roberts? A. I do not. Q. Where did you go next after the New York visit? A. I went to the Virgin Islands. Q. And who told you that you would be going to the Virgin Islands? A. He asked me if I wanted to go, and I said I would still like to go. Q. And do you recall who went with you to the Virgin Islands? A. I believe, well, I know Virginia was with me. Ghislaine was there, Jeffery, and there were two other women that I don't recall their names. Q. Did you travel on Jeffrey's plane to get to the Virgin Islands? A. Yes. Q. I want to show you again the flight log that you have there in front of you. If you can flip to... Miss Menninger, I'm going to object to the foundation again. By Ms. Macaulay. Q. Is that same page that you were on? The date is the 11th. A. Yes. Q. Do you see the tab to test there? A. Yes. Miss Menninger. Objection. Leading. The questioning is testifying now. Ms. Macaulay. Can you let me finish my question, please? By Ms. Macaulay. Q. Can you tell me who the initials are there that you see that were on the plane? Ms. Menninger. Objection. Foundation. Leading. The witness. Jeffery Epstein, Ghislaine Maxwell, AP and PK are the two women I do not recall, Virginia Roberts and myself. By Ms. Macaulay. Q. Do you recall how you flew back from the location in the US Virgin Islands? A. They put me on a commercial flight. I wanted to be home in time for Easter. Q. When you say they, do you recall who made those arrangements for you? A. It could have been Ghislaine. Q. Do you recall performing massages while you were in the US Virgin Islands? A. Yes. Q. Who was involved in... Was there more than one? A. Yes. I massaged Ghislaine at one point, and I massaged Jeffery, Virginia and I, both on the beach. Q. Were you dressed during the massage that was on the beach? A. Yes. Bikinis, probably. Most likely. Q. Do you recall what Virginia was wearing? A. I believe she was wearing a bathing suit, as well. Q. Will you pay for the massage on the beach with Virginia? A. At the end of... Before I left and flew home, Ghislaine gave me $1,000. Q. You mentioned that you massaged
you recall massaging Ghislaine on the trip to the USVI? Do you recall when that took place? A. I don't even recall what days we were there, so... Q. Do you recall where it took place? A. I believe it was, well, either in my guest cottage or one of them. There were 3 guest houses set up that were all similar and that I was staying in. Virginia and I stayed in one together, and it was either in there or in another one that was identical. Q. And was that massage performed with Virginia as well, or by you alone? A. I don't recall. Q. Were there other females in the USVI on that trip with you besides Virginia? A. 2 others. Q. And do you recall who they were? A. I do not. Q. Did you ever see Ghislaine Maxwell during that trip laying out by the pool? A. There was one time where we were all by the pool, yes. Q. Was Ghislaine Maxwell ever nude or topless by the pool? A. I don't recall. She was nude when she went swimming in the ocean. Q. At that moment in the USVI home, did you observe any photos there of nude females? A. I don't recall. Q. Besides Virginia, who you mentioned, you observed to be young. Did you observe any other females that in your view appeared to be essentially under the age of 18? A. No. Q. Did you observe any females who you thought looked young, younger than you? A. No. Q. Do you remember an individual by the name of redacted that you met during your time with Jeffery Epstein? A. In Palm Beach? Q. Yes. A. Yes. Q. Did you observe her to be young when you met her? Ms. Menninger. Objection. Vaguest of time. The witness. All of the women were generally young. I did not know the ages of really anyone, so... By Ms. Macaulay. Q. How many messages did Jeffrey receive on average in a given day? Ms. Menninger. Objection. Foundation. The witness. 3 a day. By Ms. Macaulay. Q. Let me back up for a moment. How long did you work for Jeffrey and Ghislaine? Ms. Menninger. Objection. Leading and foundation. The witness. I believe it was 5 years. 2001 to 2006. By Miss Macaulay. Q. And how many massages did Epstein receive per day on average? Ms. Menninger. Objection. Foundation. The witness. 3. By Miss Macaulay. Q. Were the massages performed by the same girl or different females? A. Different. Ms. Menninger. Objection. Foundation. By Miss Macaulay. Q. What did the females who performed the massages look like? Miss Menninger. Objection. Foundation. The witness. They all look different. Some of them were ethnic, some were blonde, some were short, some were tall. Everyone was thin. By Miss Macaulay. Q. Were the girls who performed the massages young or old? Miss Menninger. Objection. Foundation. The witness. I don't recall anyone being old. By Miss Macaulay. Q. Do you recall anybody being over the age of, say, 25? Miss Menninger. Objection. Form. The witness. Yeah, I believe there was probably a few women that were older than 25. Ms. Menninger. I'm sorry. I get a chance to object and then you can still answer. No one is going to stop you from answering. I just need to get the objection on the record. In the same way she needs to be able to talk before you. My apologies. I'm not trying to cut you off, but I am supposed to get it in before you answer. By Ms. Macaulay. Q. Did Jeffrey ever tell you why he received so many massages from so many different girls? Miss Menninger. Objection. Hearsay. By Ms. Macaulay. Q. You can answer. A. He explained to me that, in his opinion, he needed to have 3 orgasms a day. It was biological, like eating. Q. And what was your reaction to that statement?
A. I thought it was a little crazy. Q. And do you recall when you observed the other females giving massages, do you recall what they were dressed like? Did they wear scrubs or did they typically wear normal clothes? A. Normal clothes. Ms. Menninger. Objection, leading. By Miss Macaulay. Q. Do you believe that, from your observations, Maxwell and Epstein were boyfriend and girlfriend? A. Initially, yes. Q. Did Maxwell ever share with you whether it bothered her that Jeffrey has so many girls around? Miss Menninger. Objection, leading, hearsay. The witness. No, actually the opposite. By Miss Macaulay. Q. What did she say? A. She let me know that she would not be able to please him as much as he needed, and that is why there were other girls around. Q. Did there ever come a time... Did you ever take a photography class in school? A. Yes. Q. And did there ever come a time when Maxwell offered to buy you a camera? A. Yes. Miss Menninger. Objection, leading. By Miss Macaulay. Q. Did Maxwell ever offer to buy you a camera? Miss Menninger. Objection, leading. The witness. Yes. By Miss Macaulay. Q. Was there anything you were supposed to do in order to get the camera? Miss Menninger. Objection, leading. The witness. I did not know that there were expectations of me to get the camera until after. She had purchased the camera for me, and I was over there giving Jeffrey a massage. I did not know that she was in possession of the camera until later. She called me after I had left and said, I have the camera for you, but you cannot receive it yet because you came here and didn't finish your job, and I had to finish it for you. By Miss Macaulay. Q. And what did you understand her to mean? A. She was implying that I did not get Jeffrey off, and so she had to do it. Q. And when you say get Jeffrey off, do you mean bring him to orgasm? A. Yes. Q. Did Ghislaine ever describe to you what types of girls Jeffrey liked? A. Model types. Q. Did Ghislaine ever talk to you about how you should act around Jeffrey? A. She just had a conversation with me that I should always act graceful. Q. Did Jeffrey ever tell you that he took a girl's virginity? A. He did not tell me. He told a friend of mine. Q. And what do you recall about that? Ms. Menninger. Objection. Hearsay. Foundation. The witness. He wanted to have a friend of mine come out who was cardio kickboxer instructor. She was a physical trainer. And so I brought her over to the house, and he told my friend Rachel that, he said, You see that girl over there laying by the pool? She was 19. And he said, I just took her virginity. And my friend Rachel was mortified. By Miss Macaulay. Q. Based on what you knew, did Maxwell know that the type of massages Jeffrey was getting typically involved sexual acts? Miss Menninger. Objection. Foundation. Leading. The witness. Yes. By Miss Macaulay. Q. What was Maxwell's main job with respect to Jeffrey? Miss Menninger. Objection. Foundation. The witness. Well, beyond companionship, her job, as it related to me, was to find other girls that would perform massages for him and herself. By Miss Macaulay. Q. Did Maxwell ever refer to the girls in a particular way? A. At one point when we were in the islands, we were all watching a movie and she called us her children. A. Did anybody respond to that? A. I don't recall. Q. Did she ever refer to herself as a mother? A. Yes, like a mother hen. Q. Do you recall who was present at the time that she made that comment about children? A. This was the second trip that I took to the Virgin Islands, so no. I don't want to speak, incorrectly. I can't remember. I can't really remember. Q. Have you ever met David Copperfield? A. Yes.
Q. And do you recall when you initially met him? A. Yes. Q. Can you tell me what that was? A. Sure. Someone called me from the house and said that he would be there, and if I wanted to come have dinner, then I could meet him. So when I arrived at the house, he wasn't there yet, but I waited with, I believe, Sarah Kellen, and there was another girl there which I had never met and never seen. She seemed young to me. And I asked her what school she went to, kind of prodding to see if she went to one of the area colleges, and I did not recognize the name of the school. And so I thought she could be younger than college age, but I had to assume for my own sanity that she was a daughter of one of his friends. Q. But it was possible she was the school. Is it possible that the school she referred to was a high school? A. Yes. Q. And what happened at that dinner, if anything? A. He did some magic tricks. Q. Did you observe David Copperfield to be a friend of Jeffrey Epstein's? A. Yes. Q. Did Copperfield ever discuss Jeffrey's involvement with young girls with you? A. He questioned me if I was aware that girls were getting paid to find other girls. Q. Did he tell you any of the specifics of that? A. No. Q. Did you say whether they were teenagers or anything along those lines? A. He did not. Miss Menninger. Objection, leading, calls for hearsay. By Miss Macaulay. Q. Did you ever hear or observe Jeffrey talking on the phone about Frederick Fakai? A. Yes. Miss Menninger. Objection, leading. By Miss Macaulay. Q. What did you hear? A. I heard him call someone and say, Fakai is in Hawaii. Can we find some girls for him? Q. And what was your reaction to that? A. Well, I was massaging and I didn't have a reaction. I tried to remain reactionless the whole 5 years. Q. Did Jeffrey ever take you shopping? A. Yes. Q. Can you describe for me what happened? A. Sure. He took me to Victoria's Secret. I believe he picked out everything and went into the room with me. The fitting room, which was very odd. Q. Did he make any comments about being in the fitting room with you? A. He joked that one time he was in there with another girl and she said something like, Dad. But that's all I recall. Q. Did Jeffrey ever talk to you? Let me back up a moment. Have you ever been propositioned by anyone to have a baby for someone? A. Yes. Q. And who propositioned you? A. Jeffrey asked me. Q. Did he ask you more than once? A. Yes. Q. And what did he say? A. Basically just said, I want you to be the mother of my baby. Q. And you recall your response to that? A. I don't believe that I said flat out no. I didn't agree to it. I would just say, oh yeah, really? Okay. Q. Did you ever bring other girls over as Maxwell had requested? Miss Menninger. Objection, leading, hearsay, form. The witness. One time. By Miss Macaulay. Q. Let me back up a minute, just to make it a clean question. Did you ever bring friends over to massage Jeffrey? A. No. Q. And why did you not bring friends over to massage Jeffrey? A. I was living in secret about what I was doing during the massages, and I did not want my friends to know what I was doing, so I did not want anyone else coming into that. Q. Was Bill Clinton a friend of Jeffrey Epstein? Miss Menninger. Objection, foundation. By Miss Macaulay. Q. Let me back up. Do you know if Bill Clinton was a friend of Jeffrey Epstein? A. I knew he had dealings with Bill Clinton. I did not know they were friends until I read the Vanity Fair article about them going to Africa together. Q. Did Jeffrey ever talk to you about Bill Clinton? A. He said one time that Clinton likes them young, referring to girls. Q. Do you recall ever taking a trip to Jeffrey Epstein's home in New Mexico? A. Yes. Q. And do you recall who you went on that trip with? A. Sarah Callan was there. Ghislaine was there. That's all I recall. Q. Do you recall why you went on the trip to New Mexico? A. To work. Q. Did you perform massages on that trip? A. Yes. Q. Do you recall whether you performed massages with Sarah Callan on that trip? A. No. Q. Do you recall in the New Mexico home ever observing nude photos of females there? A. I don't recall. Q. When you would provide massages, would you provide those massages naked? A. On occasion. Q. On average, would you be naked if it was 100% of the time? More than 50% of the time? A. Can you repeat it? Q. Sure. When you're performing the massages, can you tell me, you said on occasion. Over the 5 years that you worked for him, how often did you perform massages naked? A. Somewhere between 25 and 50% of the time. Q. Did Epstein try to make the massages sexual? A. On occasion. Q. Would Epstein have you rub his nipples? A. Yes. Q. Would he masturbate during the massages? A. Yes. Q. Did he use sex toys or vibrators on you? A. Yes. Q. Would he leave the sex toys or vibrators out after the massage, or would he clean up after himself? Ms. Menninger. Objection. Vague form. The witness. He did not ever clean up. By Miss Macaulay. Q. Do you believe that your experience during the years you are with Jeffrey and Maxwell damaged you? Ms. Menninger. Objection. Leading form. The witness. It affected me. Damaged is a strong word. By Ms. Macaulay. And in what way did it affect you? A. It affected future relationships with men. Trust issues. Expectation issues. Q. Did you observe Nadia Marcinkova and Ghislaine at the house at the same time? Miss Menninger. Objection. Leading form. The witness. I don't recall. By Miss Macaulay. Q. On the USVI trip, the second trip that you took, do you recall Nadia Marcinkova being present? A. I believe she was present at that trip. Q. Do you recall Maxwell being present on that trip? A. Yes. Q. Do you know an individual by the name of... redacted? A. Yes. Q. And who is? Redacted. A. She was one of the girls that was around. Q. Was, redacted, around both Jeffery Epstein and Ghislaine Maxwell? A. I don't recall. Q. Do you recall where you first met? Redacted. A. In Palm Beach. Q. At Jeffrey Epstein's home? A. Yes. Q. And what... Do you recall any observations about redacted when you met her? A. To speak with, she was a little rough around the edges, and I could see the progression of her being groomed a little. They got her braces. She had terrible posture, and with a lot of massages she learned to stand up straight. So I just saw her becoming a much more confident person. Q. Do you recall how old she was when you first met her? A. I assume she was 18, but I do not know her age. Miss Macaulay, we're going to take a break really quickly, and then we will be back. So we are going to go off the record. The videographer. Off the record at 9:48. Thereupon a recess was taken, after which the following proceedings were held. The videographer. On the record at 9:58. By Miss Macaulay. Q. I'm just going to resume. I have a few more questions for you. You mentioned visiting the US Virgin Islands. Do you recall doing any activities with Maxwell when you were on the visit to the USVI? Miss Menninger. Objection. Vague as to time. The witness. I don't recall. By Miss Macaulay. Q. Do you recall ever going hiking with her? A. Yes. Q. Did Maxwell ever ask you to try to bring other girls over for Jeffery? A. At that time? Q. Yes. A. No. Q. Any other time? A. Well, she had asked me if I knew anyone that could perform massages that would come to the house. Q. And what was your understanding of that request? Miss Menninger. Objection. The witness. Well, Miss Menninger. Form. The witness. I just wondered why they wouldn't just call me. By Miss Macaulay. Q. And did you bring anybody else over to perform massages? A. I did not. Q. When you were either in the USVI or in Palm Beach, did you ever observe any females either topless or naked out by the pool? A. Yes. Q. What did you observe? A. Mostly skinny dipping. Q. Do you know who the individuals were that you observed? A. Sarah Kellen and Ghislaine. Q. Anybody else? A. Yes, but I don't recall who. Q. Did that happen on more than one occasion? A. Yes. Q. How often do you remember making those observations? A. 3 times. Q. Do you recall giving a statement to the police regarding Jeffery Epstein? A. Yes. Q. Do you recall when you gave that statement? A. I don't recall the date. Q. Do you recall the year? A. I want to say it was early 2006 or late 2005. Q. Do you recall who you met with? A. No. Q. Do you recall what you told the police? A. It was similar to this. They were asking me a lot of questions that I answered. They knew a lot. They knew what the bathroom looked like. They knew that the couch had a hot pink throw on it with green tassels. I assumed that there had been videos and they had seen me. They had seen the videos. That's what I had assumed. I didn't know that maybe people had already come forward and given them statements. Q. Did they talk to you at all about the videos? A. They said, were you aware that there were video cameras in the house? I said, no, but it would not surprise me. Ms. Macaulay. And I'm going to mark as Exhibit 4. Do you have an extra? Sorry. Did you get one? Okay. Geoffrey 0002 through 89. And I'm going to direct you to page 00076. And I'm going to hand it to you. The referred to document was marked by the court reporter for identification as Sjoberg Exhibit 4. By Miss Macaulay. Q. I'm just going to ask that you take a look at that. As you can see, under the narrative line there is a name. It says, reported by Ricari Joseph. Is that a name you recall meeting with a Detective Ricari? A. Yes. I don't recall his name, only except that he had been following me around, and he left me cards, like on my car and in my door. I tried to avoid him for a long time. Q. And can you just look at the text underneath there? A. Uh-huh. Q. And take a moment to look at that. A. Sure. Q. Does that refresh your recollection as to what you told the police during the investigation? A. There are errors in here. I was not 23 when I met him. I was 21. Q. Anything else that doesn't look correct? A. The same error. That I had met him 3 years ago, and it obviously had been closer to 5. There is also the error. He obviously misunderstood me. He did not pay for my tuition at college. I'm still paying those school loans. But he did pay for me to go to massage school and to cosmetology school. Okay, it pretty much ends here. Q. Yes, right. About halfway through the page. A. Okay. Miss Macaulay. So, Johanna, that concludes my initial piece. I'm going to reserve the rest of my time for redirect. I'm going to turn it over to Laura. Miss Menninger. Can we take just a little break? Miss Macaulay. Sure, no problem. The videographer. Off the record at 10:05. Thereupon a recess was taken, after which the following proceedings were held.
The videographer. On the record at 10:14. Examination. By Miss Meniger. Q. Hi. A. Hello. Q. We've never met before today, correct? A. Correct. Q. Can you tell me a little bit about your current job? A. Sure. I just purchased a salon. I'm a salon owner. I'm a hairstylist. Q. Congratulations. A. Thank you. Q. How long have you been a hairstylist? A. For 10 years. Q. And what did you do before that? A. I briefly did massage in the spa for about 1.5 years, and before that I was a nanny, and before that I was in school. Q. And I believe you said you studied psychology in school. A. Correct. Q. Did you graduate? A. Yes. Q. With a degree in psychology. A. Yes. Q. Where did you get training to be a massage therapist? A. Redacted. Q. And when did you do that? A. That would have been, I believe, in redacted. Q. And how long did you study there? A. I think it was a 6-month program. Q. And you worked in the spa thereafter? A. I did. Q. What was the name of the spa again? A. Redacted. Q. And are you married? A. No. Q. Do you have children? A. No. Q. And how old are you now? A. Redacted. Q. Can you tell me about your first meeting with Ghislaine Maxwell? A. Sure. I was sitting on a bench, redacted. She approached me. I was getting ready to go to a class. It was my junior year. Yes, it was the second semester of my junior year. And she and another woman approached me. The other woman didn't speak that, I recall. And she asked me about... She had a house in Palm Beach, and she was looking for someone that she could hire to work at the house, where she could post that she needed help. She then asked me if I knew anyone, and I didn't know who she was. I didn't want to take the responsibility of finding someone to work for her, and so I said, sorry, I don't. And then she said, well, maybe what about you? And I was at a point in life, I was super spontaneous and willing to skip school. So she said, come to my house, come in my car and check it out. And so I did. Q. Okay, so for those of us who don't know, is this like a college campus, like a traditional college campus? Or is it in a city setting? A. It's in a city setting. I mean, Palm Beach is not a big city. So it's on the intracoastal, and there was a big grassy area that was surrounded by buildings, so she was inside of the campus. Q. And she was looking for a bulletin board where she could post a job? A. Something like that, yes. Q. Did she have any kinds of flyers? A. Not that I recall. Q. But that's what she asked you for, directions to a bulletin board where she could post a job? A. Yes. Miss Macaulay. Objection. By Miss Meniger. Q. And it sounds like you guys got into a conversation, is that fair? A. Yes. Q. Can you describe Ghislaine Maxwell's personality? A. Well, I instantly picked up on the fact that she was British. She had on, workout clothes. I believe she was wearing all black, and she was a little snarky, but I felt comfortable enough to get in the car with her. A. And it sounds like you had contact with her over the next several years, is that fair? A. Yes. Q. And did you get to know more about her personality over those 5 years? 4 or 5 years? A. Yes. Q. And can you describe her for me? How you observed her personality to be? A. Sure. She definitely had a great sense of humour. She loved making jokes. I mean, in a very British way. I don't remember her ever laughing, but she was funny. And I remember just thinking, the first weekend that we flew to the Virgin Islands, she flew the helicopter from wherever we were, to Little St. Jeff, or whatever the name of the island was, and I just thought, wow, who is this woman? Q.
Would you say that you respected her? A. Yes. Q. When you ended up getting in the car with her and this other woman and going back to the house, who was driving the car? A. She was driving. Q. And where did she take you? A. She took me to the house in Palm Beach. Q. And can you describe the house in Palm Beach? A. Sure. It's at the end of El Brillo Way on the Intracoastal. The house was either white or pink. It was pink at one time. It may have been painted. It was nothing fancy. It was large. It was like a beach house. Q. And when you got there, do you remember meeting other people while you were there that first time? A. I remember other people being in the home. I don't really remember who was there. Q. Do you remember meeting, like, a butler or... A. Potentially a chef. Someone in the kitchen. Maybe a house manager. Yeah. Q. What was your impression of this other woman that was with Miss Maxwell at this time? A. 0. She left 0 impression on me. Q. Age, height, hair colour, nothing. A. I want to say she was brunette, age 20s, yeah. Q. And you were going for the purposes of checking out potentially working at this job? A. Yes. Q. It sounds like you met Jeffery Epstein that first time that you did go to the house, right? Miss Macaulay. Objection. The witness. I believe I either met him that time or the next time. I can't recall. By Miss Menninger. Q. Okay. And tell me about your first meeting with him. A. Sure. I met him. I believe it was in the hallway right beside the kitchen. There was a hallway. It was actually more like a room, a pantry type of room. That's where all of the pieces of paper with the phone messages would lay. And I remember sitting on the counter and speaking with him, and he was in a bathrobe and he spoke with me about me being in college and studying psychology. Q. And did you form an opinion of him in that first meeting? A. Yeah. I believe that he was smart. He was personable and could speak to anyone. Q. Did you give off any sexual vibes in the first meeting? A. No. Q. And where was Ghislaine when you were speaking with Mr. Epstein? A. I don't recall. Q. Do you recall going to a second floor of the home during that first meeting? A. I don't recall. Ghislaine said at one point you might get a massage today. That was the second time when I was in the home working. And I just thought it was crazy that I would get a massage while I was working. But it did not end up happening because the masseuse could not stay. Q. Do you know who the masseuse was that could not stay? A. No. Q. But that didn't happen on the first meeting. You believe that was the second meeting? A. Yes, that was when I was there to work. Q. How long? How did the first trip to the house end? A. She gave me her phone number, and she took my phone number, and she took me back to school. Q. And were you full-time at school at the time? A. Yes. Q. And how many classes were you taking, if you remember? A. Probably 4 or 5. Q. How long was it before you heard from Miss Maxwell again? A. Within probably 3 days. Q. And how did she contact you? A. She called me on my... At the time, I had a cell phone. It could have been on my cell phone. It could have been on my house phone. We had house phones back then. Q. I remember. Where were you living at the time? A. I was in an apartment in West Palm Beach. Q. And did you have a roommate or with family? A. I had a roommate. Q. So when Miss Maxwell called you on whatever phone it was, do you remember what she said? A. Yeah, she said, do you want to come over and work on Sunday? Q. And what did you say? A. I said, sure. Q. And did you? A. I did. Q. How did you get there? A. That I don't recall because I did not have a car. Q. Did you? A. I think my roommate dropped me off, honestly. I can remember what I was wearing. Q. You do? A. I do. Q.
What were you wearing? A. I still have the shirt. It's an old weathered blue North Carolina Tech Tar Heels t-shirt. Q. Because did Ms. Maxwell explain to you what you would be doing on that Sunday when you came to work, or was that part of the prior conversation? Ms. Macaulay. Objection. The witness. About what I was wearing? By Miss Miniger. Q. No. About what you were going to do at work. A. She had explained that she just wanted someone to help out around the house, answering phones, grabbing drinks if someone wanted a drink, running errands. Q. And so you dressed appropriate to what you believed? A. I did not know how to dress properly, apparently. I should not have worn that, but I was in college. Q. Did anyone say anything to you? A. No. Q. So when you got there, what happened? This is your second time to the house, but your first time working, right? A. Yes. I was probably introduced to a few people that were there. I was there for several hours. Do I recall every minute? No. I just recall when I would actually have to work, answer the phone, pour some drinks for people. Just water. They didn't drink alcohol. And run errands. There were a few errands that I ran. Q. You described those errands earlier? A. I did, in her car. Q. You used her car? A. Yes. Q. What kind of car was it? A. It was a Mercedes convertible. Q. Did anyone go with you? A. No. Q. You described a shopping trip. Was that in the same car? A. Yes. Q. Was that a separate trip than when you went to run errands? A. Yes. That's when Ghislaine went with me and she drove. Q. Okay. So you ran errands, came back more than once? A. Twice. Q. And then you went on a shopping trip? A. Yes. Q. During the time you were at the home, was there anything that made you suspicious? A. No. Q. O'Leary? A. No. Q. You mentioned there may have been some discussion of a massage. Do you recall that discussion? A. I had never had a massage before. So she just said there was a massage therapist coming and I may get one. Q. Did she say who it was? A. No. Q. So when you went shopping on this trip, you said Ghislaine drove the car and you went with her. Was anyone else there? A. No. Q. And where did you all go? A. We went to Worth Avenue in Palm Beach, but because it was Sunday, the stores were closed. Bless you. Mr. Lewis, thank you. The witness. So from there, we went to, I believe it was Palm Beach Daily News, which was like a little bookstore. And I remember her purchasing reading glasses for Jeffrey and some magazines. By Miss Miniger. Q. Were those things for the home? A. Yes. Q. And earlier on your errands, you had been purchasing things for the home or office? A. Yes. Q. Besides the printer cartridge, ink cartridge, do you remember anything else? A. Well, yes. Like they wanted specific magazines. I don't know if it was like Scientific American or something to that effect. It wasn't like Playboy. Q. Okay. Did you ever answer phones? A. Yes. Q. When did you answer phones? A. That day. Q. Do you remember anything notable about the phone calls? A. I just remember I always had to say, he's unavailable, can I take a message? Q. And where did you take a message? A. On a little notepad next to the phone. Q. Do you recall any small children calling the house that day? A. No. Q. Were you speaking to anyone about their school experience or anything like that? A. No. Q. Did you take any messages for famous people? A. They could have been famous and I would have been clueless. Q. Did you take messages at any other point during the time that you worked with Jeffrey? A. No. Q. And you said you remember at the end of that day being paid by Ghislaine? A. Yes.
Q. And you were paid for doing the errands and answering phones and whatever else you did? A. Yes. Miss Macaulay, objection. By Miss Meniger. Q. Did you do anything else that day in terms of errands or things around the house that you remember? A. Not that I recall. Q. Did you come back to answer phones and do errands any other day? A. No. Q. That was the only day you did it. A. Yes. Q. All right. Tell me the second time. How long was it before you got another sort of contact from anybody at the home? A. Okay, well, after that, I remember actually that day of working, I sat with Ghislaine outside of this outside table on the patio by the pool. I told her that I was getting ready to go to Nicaragua for spring break on a mission trip. I remember her going, "Why would you ever go to Nicaragua?" So I was going to be gone the next week for spring break. So she called after I returned and asked if I wanted to make $100 an hour rubbing feet. Q. Was that the whole conversation? A. That was pretty much it. I said, okay, sure, tell me when. Q. And were you excited about the prospect of rubbing feet and making $100? A. I was actually while I was on the trip in Nicaragua, I was rubbing feet. I was massaging people, their feet. So it just seemed kind of crazy that it all happened at the same time. Q. How was it rubbing feet? A. I guess I just liked doing it. I didn't know that I did, but I was massaging people's feet. Q. Were these strangers? A. No. It was a group of us that went on the trip, so we were all very close. Q. What kind of trip was it? A. It was, PBA. You had to do these things called workshop hours, which you had to do community service, 40 hours every year. And so that was the way to do them all. And you would go on these trips and help build a school or feed children or do some sort of something nice. Q. Nice. What other trips did you take while you were there? A. I did a trip and worked with Habitat for Humanity in Baltimore, and then I went back to Nicaragua the next year and did the same thing. Q. Very nice. And you were there for a whole week? A. Yes. Q. All right. So you got a call from Ghislaine after you returned? A. Yes. Q. And that's when she asked you about rubbing feet? A. Yes. Q. And did she tell you when she would like you to come over? A. It was either that night or the next day. Q. And do you know how you got there? A. No. Q. Do you know what you were wearing? A. No, I don't remember. Q. When you got there, I think you said you don't remember if Ghislaine was actually there the second time. A. I want to believe that she was there because she was my main contact, and so I would assume that she was probably at the house and greeted me. However, I do not recall if she was there. Q. It sounds like you met Emmy Taylor. A. Yes. Q. How did you meet Emmy Taylor? A. She was at the house the first day that I worked running errands, and I realized she was also a personal assistant type of person. Q. Do you know who she worked for? A. Ghislaine. It appeared to me that she worked for Ghislaine. Ghislaine sort of told her what to do and where to go. Q. And I believe you mentioned she called her slave? A. She did. It was in a joking way, but she said, yes, that's my slave. Q. You did not see her in any type of slavery situation? A. Not any chains or anything of the sort, no. Q. So tell me what you remember about the second time you went. A. The third time? Miss Macaulay, objection. By Miss Meniger. Q. I'm sorry, you're right. The third time. The second time you went to work, but the third time you were there. A. Correct. So I was escorted up to the bathroom, which is where 99% of the massages happened, and Emmy Taylor was with me and Jeffrey. And I don't remember the order, but Emmy was on the table at one point. She took all of her clothes off, got on the table. I remember thinking, okay, she's just going to strip naked and get on the table. Well, that's cool. We're cool. That's what we do. And Jeffrey was showing me how to massage on her body. And then I took my clothes off and got on the table. And then they showed me what it felt like with the both of them. And then Jeffrey got on the table and Emmy showed me how to massage. Q. So Ghislaine was not in the room. A. No. Q. You said that 99% of the massages took place in the bathroom. Did you see massages take place in other places of the house at all? A. Did I see any? No, besides us maybe hanging out on the couch and someone massaging his foot or me massaging his foot. But not like on a table. Q. So just casual foot rubbing might happen elsewhere in the home, but not a full-blown, full-body massage? Miss Macaulay. Objection. The witness. Yes. By Miss Menninger. Q. Did you see any full-blown, full-body massages out by the pool? A. Not that I recall. Q. And do you remember ever giving any yourself? A. By the pool? Q. Out by the pool, yes. A. On a table? Q. Yes. A. No. Q. All right. You said that you had subsequently been trained as a massage therapist, correct? A. Correct. Q. Would you describe it as normal massage protocol for a person to be naked under a towel during a massage? A regular massage? Miss Macaulay. Objection. The witness. Naked under a towel during a massage, the person getting massaged? By Miss Menninger. Q. Yes. A. Yes. Q. And as a massage therapist, you're trained how to drape the person so that they're covered in the right places, correct? A. Yes. Q. So when you were being trained by Emmy and Jeffrey on some massage techniques, did anyone say anything sexual during that conversation? A. Not that I recall. Q. What was the mood like? Was it, laughing? A. Yes, comfortable. Q. And just to clarify, the people who were giving the massages at the various points in time were clothed while they were doing that, correct? Miss Macaulay. Objection. By Miss Menninger. Q. In this period you just described with Emmy Taylor and Jeffrey in a bathroom upstairs on your third visit to the house, people giving the massages had their clothes on, correct? A. Correct. Q. All right. What was the next time you remember coming to the house there? A. The next time was to do a massage, all by myself. Q. Okay. And how did that one come about? A. Someone must have called me, but I don't remember who. Q. And to whom did you give the massage on this next visit to the house? A. Jeffrey. Q. Was Ghislaine present during that massage? A. No. Q. Did anything unusual occur during that massage? A. After. Q. What happened after the massage? A. He asked me how well I do orgasm, and I said, I don't, I'm a virgin. And he was quite surprised. Q. Where were you when you were having this discussion? A. In the bathroom. Q. Were you clothed? A. Yes. Q. Was he clothed? A. I don't remember him being naked. He was probably either wrapped with a towel or in a bathrobe. Q. Were you caught off guard by this question? A. Yes. Q. Was that the first time anyone had said anything sexual to you during this? A. Ever? Yes. Q. Did he say anything else that you recall during that conversation? A. I mean, we had a little bit of a conversation about it, but I don't recall specifically. Q. And how did that massage encounter end? A. Normal. There was nothing I had to do, just normal massage. Q. Did he pay you? A. Yes. Q. How much did he pay you? A. $200. Q. How did he pay you? A. Cash. Q. And where was the cash? A. I don't recall specifically. It was either he brought it upstairs with him or it would have been down on his desk. Q. And I'm assuming that you had other massages that you gave him under similar circumstances in the next years, right? A. Many, right. Q. So recalling this particular one is not sticking out in your mind? A. Yes. Miss Macaulay. Objection. By Miss Menninger. Q. Do you remember the next time after that? A. I don't. I mean, from there it's just a blur of random invites to come over and do it. Massage this, like... I would see him maybe 3 days a row. And I wouldn't see him for 2 months. It would be kind of that irregular schedule. Q. Do you ever recall a time where you came over every day for 3 weeks in a row? A. No. Q. Were you paid $200 per massage? A. Yes. Q. And how long did the massages last? A. Anywhere from 30 minutes to an hour and a half. Q. Do you ever give a 4-hour massage to him? A. Good grief, no, not that I recall. Q. Have you ever given a 4-hour massage to anyone in your whole life? A. No, I haven't. Q. Tell me how the whole idea of travelling to New York came up. A. I actually was not home. They called my apartment. My roommate answered. When I got home, she said, "You need to call Jeffery Epstein immediately. He wants to take you to New York, but they are leaving at 400. And I was excited because I had never been to New York. Q. Are you from... redacted? Answer. I am. Q. But you never went to New York? A. Just fine over it. Q. When you said they called, do you know who called your roommate? A. I don't know who called my roommate. Q. In this sort of pre-trip to New York period, do you recall discussing any of the particulars of your massages with Jeffery? With Ghislaine? Miss Macaulay. Objection. By Miss Menninger. Q. If that makes sense. A. No. Q. So before you got this call, had anyone mentioned the idea of travelling to you? A. No. Q. Did you call Jeffery immediately? A. I did. Q. And what conversation did you have with him? A. Basically he said, I want to take you to New York City. Can you be here quickly? And I got to the house and he said, do you have a passport? I said, no. He said, go get it. So I went back and picked up my passport and went back to the house before we went to the airport. Q. And why did you need your passport? A. I was ready to find out. I had no idea. Q. This was the spontaneous phrase. A. Exactly. Q. So you went and got your passport, you came back, and then what happened? A. Then we went to the airport. Q. And who is we? A. So I don't remember the ride to the airport, but the people that I recall being on the plane was Jeffery, Ghislaine, Virginia, and I. Q. And when was the first time you met Virginia? A. I believe it was that day. Q. In your previous visits to the house, had you seen her there? A. Not that I recall. Q. And what was your impression the first day you met her? A. She seemed young and blonde and cute. Q. What was her personality like? A. I honestly don't recall her personality. Bubbly. Q. Did you see her in the plane or on the trip to New York engaged in any kind of affectionate or sexual contact with Jeffery? A. No. Q. With Ghislaine? A. No. Q. How did it come to be that you were in a casino in Atlantic City? A. As we were flying, Jeffery said, why didn't you go sit in the cockpit to check out the landing? So we were sitting there, and the pilots told me to go back and tell him that we can't land in New York, and that we were going to have to land in Atlantic City. Jeffery said, great, we'll call up Trump and we'll go to... I don't recall the name of the casino, but we'll go to the casino. Q. And what happened with an ID issue? Miss Macaulay. Objection. The witness. All I know is that she was not going to be allowed to gamble, and so I spent time with her.
We were just walking around. I don't remember what we did. Because either she didn't have an ID or she was too young. I don't remember specifically why. I just knew that she could not gamble. By Miss Menninger. Q. Okay, so you walked around with her in Atlantic City? A. Uh-huh. In the casino. We never left the casino. Q. Were you disappointed that you couldn't gamble? A. No. Q. When you were walking around and talking to her, did you learn anything about her? A. Not that I recall. Q. Did you have an impression about why she was on the trip? A. At that point, no. I was so new to the whole thing. I was just trying to figure out my position and who everybody was. At that point, I had no idea. I didn't know anything sexual was happening at all. So I just felt like she was just another visitor. Q. Did she tell you at that time that she had been to New York with Jeffrey before? A. Not that I recall. Q. Did she tell you anything about Ghislaine during that walkabout? A. No. Q. And then you all travelled on to New York that same night? A. Yes. Q. How long were you in New York for that visit? A. It was maybe 2 nights. Q. And where did you sleep at night? A. I slept in one of the guest rooms at his townhouse on 71st Street. Q. And did you stay in the same room as Virginia? A. No. Q. Do you know where she stayed? A. No. Q. All right. And then when you got into Manhattan, how did it come to be that you were doing some sightseeing? A. Well, they knew that I had never been, so I believe Jeffrey asked the driver and Emmy just to drive me around to see the Empire State Building. That's all I remember. It was late. It was dark. It wasn't long, maybe 30 minutes. Q. When you got back to the house, what happened? A. I walked into the front door and Ghislaine stuck her head over the grand staircase and asked me to come upstairs into the living room. Q. And can you describe the living room? A. Oh, it was very large and very formal. And Jeffrey and her and Virginia and Prince Andrew were there. Q. What were they all doing when you came in? A. Just socializing. I don't remember them doing an activity. It was just being together. Q. Was anyone unclothed? A. No. Q. Was this the same room where Jeffrey had a desk? A. It could have been, but I can't remember. Q. Did you go to New York more than one time? A. Yes. Q. How many times did you go to New York? A. 2 times. Q. This was the only time that you met Prince Andrew in New York, though? A. Yes. Q. When you came upstairs, where was Virginia sitting? A. I don't remember. Q. Do you remember what she was wearing? A. No. Q. She was already there when you got back from sightseeing? A. Yes. Q. Tell me what happened with the caricature. A. Ghislaine asked me to come to her closet. She just said, come with me. We went to a closet and grabbed the puppet of Prince Andrew. And I knew it was Prince Andrew because I had recognized him as a person. I didn't know who he was. And so when I saw the tag that said Prince Andrew, then it clicked. I'm like, that's who it is. And we went back down to the living room, and she brought it in. It was just funny because he thought it was funny because it was him. Q. Tell me how it came to be that there was a picture taken. Miss Macaulay. Objection. The witness. I just remember someone suggesting a photo, and they told us to go get on the couch. And so Andrew and Virginia sat on the couch, and they put the puppet on her lap. And so then I sat on Andrew's lap, and I believe on my own volition, and they took the puppet's hands and put it on Virginia's breast, and so Andrew put his on mine. By Miss Menninger. Q. And this was done in a joking matter? Miss Macaulay. Objection. The witness. Yes. By Miss Menninger. Q.
Do you recall a photo being taken of that event? A. Yes. Q. You've never seen the photo? A. No. Q. You don't know whose camera it was? A. No. Q. Virginia was sitting on the couch next to Andrew, not in a big leather armchair? A. Maybe. I'm just trying to remember how I remember it. Q. To the best of your recollection, you went and sat on Andrew's lap, correct? A. Yes. Q. On his knee? A. Yes. Q. And Virginia was not sitting on his knee, correct? A. I don't recall. I just remember I was. She might have been on his other knee, like Santa. I don't remember. Q. After that, do you remember any other pieces of that social engagement? A. No. Q. Do you know where you went? A. From there I went to bed. Q. Were people drinking? A. No. Q. Did you hear Ghislaine Maxwell tell Virginia to do anything while you were in that room? A. No. Q. Do you recall what happened the next day in New York? A. Bits. I mean, that was the day I went to Victoria's Secret. I went and walked around by myself and went to a souvenir shop. Got a mug or something, that's all I recall. Q. Did you go anywhere with Virginia? A. Oh my gosh, yes. We went to Phantom of the Opera. Q. Who else went? A. I think it was just she and I forgot about that. Thank you for that memory. Q. It's my job. Anything else you remember about that day in New York? A. No. Q. You said you were given a massage to Jeffrey while you were there on that trip. Or was it a subsequent trip? A. That trip. Q. And how did that come to be? A. Either he or somebody asked me to go and do it. Someone showed me to the room, but I don't remember who it was. Q. Can you describe that room? A. Yes. It was high ceilings, dark. There were like dark red walls or dark blue carpeting or something. It had a massage table set up in the middle, and there was a large, I want to say like a 15-foot photo. Either photo or painting of a naked girl. Q. Pornographic or artistic? A. No, I wouldn't say pornographic. Artistic. Q. Artistic. Was Ghislaine present during that massage? A. No. Q. Did something about that particular massage session stand out to you? A. Yes. That was when I was first asked to squeeze and rub his nipples while he pleasured himself. Q. And did he say that's what he was going to do? A. Yes, he was just very blunt about it. He said, "Rub my nipples, I'm going to jerk off." And I was like, "No, done." Q. And you walked out? I did. Q. Were there any repercussions of you walking out? A. Amazingly, no. Knowing what I know now, I'm surprised I was ever called back. But no, I just stood my ground and walked out. I'm not comfortable with that. Q. Do you know personally whether anyone else had said no to him? A. No. Q. Did anyone ever tell you that they had been in a massage scenario and told him no? A. No. Q. Do you recall when in your trip the massage occurred? A. Well, it was not the day we landed. It must have been that next day that we were there. Q. Do you remember anything else about Virginia from that trip other than the Prince Andrew thing and Phantom of the Opera? A. Well, we were getting ready to leave to go to the airport and we were waiting. She and I sat on the steps in the foyer. I do remember just kind of asking a few questions to try and understand her role, because at that point now I knew what he wanted from me in the massage. But she did not make it clear to me that she was participating in that. So I was prodding gently to see if there was anything happening that shouldn't have been, because I was getting the impression that she told me she was 17. Q. She told you she was 17? A. Uh-huh. Q. How did that come up? A. I asked her. Q. Was anyone else present during this conversation? A. No. Q. You mentioned in your earlier testimony that she seemed orphan-like. A. Yes. Q. But you said there was something you had said to Miss Macaulay, correct? A. Correct. Q. That was not said at the time? A. Right, no. At the time I was getting an impression that she did not have a family, or she had walked away from her family. And it seemed to me, they had just sort of adopted her, not as a child, but they would take care of her. Q. Did you observe anyone speaking to her as a child? Like, make up your bed? A. No. Q. Did you observe whether she was using drugs during that trip? A. No. Miss Macaulay. Objection. By Miss Menninger. Q. Did you ever observe her using drugs? A. Not that I recall. Q. Did she tell you that she was using Xanax? A. No. Q. Cocaine? A. No. Q. Ecstasy? A. No. Q. Heroin? A. No. Q. When was the second trip you took to New York? A. Later, maybe 2005. I don't know. I could look in the flight record. Q. That's all right. A. I don't remember exactly. Q. That's all right. You just recall it being several years or so after? A. Yes. Several years later. Q. And just so I'm clear, can you just list for me the places you recall travelling with Jeffery? A. Yes. That first trip was New York and the Virgin Islands, and then not again until around 2005. We went to New Mexico and to New York City and the Virgin Islands. Q. So you were in New York twice, and the Virgin Islands twice, and New Mexico once? A. Yes. Q. Anywhere else? A. No. Q. Were those primarily on the private plane? A. Yes. Q. You said you flew commercially once to get back? A. Yes. Q. Did you recall any other commercial flights? A. He bought a couple of flights for me when I wanted to go up to New York for personal reasons. One time I went to New York commercially, and I was there with friends, but I did go over to his house while I was in the city. Q. And that's not the trip to New York? A. No, separate. Q. Would you characterize your relationship with Jeffery as friendly? Miss Macaulay. Objection. The witness. Yes. By Miss Menninger. Q. If you asked him to buy a ticket to New York, that might be something that he would do? A. I never asked him to do anything for me, but I always told him I was interested in something, and he was offered. Q. The second trip to New York. Anything memorable about that? The one that you mentioned that was with Jeffery. A. I do recall Nadia being there. While I massaged, he gave him a facial, but nothing sexual happened. Q. And do you recall if Ghislaine was part of that trip or not? A. I remember her being in New Mexico. Q. What do you remember about her being in New Mexico? A. I remember she took me to... When they were building the ranch, they had a little 3-bedroom home, just like a prefab home. She took me over there, so we went for a little walk. I remember she had 2 new puppies named Max and Minnie, little Yorkies. And I want to say that it was around Jeffrey's birthday when we were there, but nothing. There was no, celebration or cake with candles. It was just another day. Q. You said that the Virgin Islands were a part of that second trip as well. A. Yes. Q. And do you remember Ghislaine being part of the Virgin Islands the second time? A. Yes. That's when she called, went to bed and kissed us all on the head and called us her children. Q. Who were the other participants in that session? A. That's who. I don't recall who was there, but I want to say that Nadia was. Q. But Virginia was not there? A. Virginia was not there. Q. Do you recall the point in time in which Virginia went away? A. Sort of. After the trip to New York, I was given her phone number to call.
And I remember one time I tried to get a hold of her. Her boyfriend answered. A boyfriend, I would assume, and he sounded like he was high. And I couldn't find out where she was, and then from there on she was out of the picture. Q. Do you recall how long after the New York trip that occurred? A. I would say it was probably within a month or two. Q. Did she tell you she was working elsewhere? A. No. Q. Did you ask her? A. No. Q. Did she mention that she was a waitress? A. No. Q. And worked at Taco Bell? A. Uh-huh. Q. Did you speak to her boyfriend or a boyfriend at any other time associated with her? A. No. Q. Did you meet her boyfriend? A. No. Q. Her fiancé? A. No. Miss Macaulay. Objection. By Miss Meniger. Q. When you were on the plane with Jeffrey during these 2 trips, he was present on all of those flights? A. Yes. Q. Did you observe any sexual behavior happening on the plane? A. No. He told me a story of something that had happened one time. Q. Did it involve Ghislaine Maxwell? A. No. Q. Did it involve Virginia Roberts? A. No. Q. And you didn't see anything? A. No. Q. You did give massages to Ghislaine Maxwell, correct? A. Yes. Q. On how many occasions? A. Maybe somewhere between 5 and 10. Q. Was that over the course of the 5 years? A. Yes. Q. Was there some point during that 5 years where Ghislaine Maxwell was not around as much? A. Yes. Q. Do you recall when that was? A. In the middle. Q. Did you know why that might be? A. No. Q. Is that about the time that you started seeing Nadia more frequently? A. Yeah, I guess she was probably in the picture more. Her and Sarah both had kind of been around the most. Q. Did you observe Nadia or Sarah appearing to act like Jeffrey's girlfriend? A. Nadia, not Sarah. Q. What did you observe? A. She was just very loving, kissing him. Q. Did you know how old she was? A. I didn't know. Q. So you gave massages to Ghislaine 5 or 10 times. Was there anything unusual about those massages? A. No. Q. You've been quoted in the press perhaps as saying that she wasn't very picky? A. About massage? Q. About her massages. A. Not like Jeffrey, I guess. I mean, saying that meant that, I would do whatever I wanted to do in the massage, whereas Jeffrey was like, do my foot, do my leg. He would kind of narrate what he wanted. She just wanted a massage, so if that makes sense. Q. She may have been naked under a towel. A. Definitely. Q. In a regular massage fashion? Miss Macaulay. Objection. The witness. Yes, actually, I do recall an instance where I was massaging her and Jeffrey came into the room and he did something sort of sexual to her, whether it was fondling her or slapping her butt or something, and she brushed him off like she was embarrassed. By Miss Meniger. Q. So she never asked you to touch her in a sexual manner, correct? A. No. Q. And she did not rub her breasts on you, for example? A. No. Miss Macaulay. Objection. By Miss Meniger. Q. She did not demand that you perform oral sex on her? A. No. Q. Did she not demand that you undress during your massages? A. No. Q. There was nothing from her that was sexual during the massages that you gave to her? Miss Macaulay. Objection. The witness. Correct. By Miss Macaulay. Q. Do you recall when the last time you gave her a massage was? A. I don't recall. Q.
Do you recall meeting with her in about 2006 when she was in town for some helicopter training? A. I do recall that. Q. Do you recall giving her some massages during that period? A. Yes. Q. Do you remember going out to dinner with her and to a movie? A. I remember to a movie, and I don't remember if we went to dinner. I remember her cooking dinner. There was another way she impressed me. She knew how to cook like a chef. She had done some culinary training. Q. And you guys had a normal type conversation? A. Yes, it was very fun. Miss Macaulay. Objection. Miss Menninger. I would like to take about a 5 to 10 minute break, if that's okay. The videographer. Off the record at 11:05. Thereupon a recess was taken, after which the following proceedings were held. The videographer. This is the beginning of Disc 2 on the record at 11:25. By Miss Menninger. Q. Hi, I believe when we left off I was asking you about massages that you gave to Ghislaine. Did Ghislaine pay you when she got a massage from you? A. Yes. Q. Do you know how much she paid you? A. I believe it was $200. It was the going rate. Q. The same as you were getting paid by Jeffery, correct? A. Yes. Q. Ghislaine was not present when you were giving massages to Jeffery, correct? Miss Macaulay. Objection. The witness. Correct. By Miss Menninger. Q. At some point Jeffery became more aggressive with you, correct? A. Correct. Miss Macaulay. Objection. By Ms. Menninger. Q. At what point was that? A. In the last year. Q. And what does that mean to you, became more aggressive? A. He was pressuring me to do more than I was comfortable with doing. Q. Is that what ultimately caused you to leave working for Jeffery? A. What caused me to leave was when it was made public what I was doing. Q. What do you mean by that? A. Well, after I had spoken with the police and there was a police report, I did not realize that was public knowledge journalists would get a hold of. So at one point the news channel 12 showed up at my door asking me questions. Q. When Jeffery was pressuring you to do more than you felt comfortable with, did you observe him being more aggressive in general, outside of the massage context? Miss Macaulay. Objection. The witness. No. By Miss Menninger. Q. Do you know whether he was taking any type of steroids? A. No. Q. Did you ever see him wearing a patch or something like that? A. I don't recall. Q. Did you tell anyone that Jeffery was becoming more aggressive with you, contemporaneous with when it was happening? Miss Macaulay. Objection. The witness. No. By Miss Menninger. Q. When Jeffery asked you to do other things besides a normal massage, did he offer to pay you additionally? A. Yes. Q. How much? A. $100 extra. Can I clarify? Q. Absolutely. A. He didn't ever say he would pay me more, but when the massage was more than just a massage and it was sexual, then he would pay me more. Q. It wasn't a discussion, it's just what happened? A. Correct. Q. Thank you for clarifying. The things that took place with you and Jeffery behind closed doors were when you were a consenting adult, correct? A. Yes. Miss Macaulay. Objection. The witness. Correct. By Miss Menninger. Q. And you did not have knowledge of what took place with other women behind closed doors and Jeffery, correct? Miss Macaulay. Objection. The witness. Correct. By Miss Menninger. Q. Do you recall giving an interview to a reporter from the Mail on Sunday? A. Yes. Q. You told that reporter, I believe, that the police report painted a picture that it was a big orgy all the time, but it wasn't? A. What I saw, I did not see anything out in the open sexually. Me, personally. Q. Right, you did not see orgies happening in the pool, for example. A. No. Q. You did not see people engaging in sexual conduct out in the open areas of the home, correct? A. Right. Miss Macaulay. Objection. By Miss Menninger. Q. When you became aware of the allegations against Jeffrey, those came as a surprise to you, correct? Miss Macaulay. Objection. The witness. Correct. By Miss Menninger. Q. And the surprise was that it involved underage girls making that allegation, correct? Miss Macaulay. Objection. The witness. Correct. By Miss Menninger. Q. You were asked some questions with Miss Macaulay about nude photographs that were present in the home. Holmes? A. Uh-huh. Q. In Palm Beach, I believe you said there were some in the room where the massage table was? A. Yes. Q. Can you tell me what you recall seeing? A. It wasn't candid photos. They were all, staged. Q. Like a model? A. Yes. And I don't recall necessarily knowing any of the people in those photos. I remember at one point there was a photo of myself, but... Q. Were they fully frontally nude, or were they staged? With, parts of body showing? A. I really only remember topless photos. I don't remember full frontal photos. Q. So exposing the breasts, but not exposing the genitalia? A. Not that I recall. And Ghislaine's bathroom, I believe there was a photo of her topless, or a painting. Q. A painting? A. Uh-huh. Q. Did you see any nude or semi-clad photos of young girls? A. No. Q. Preteens, for example? A. No. Q. Something you would consider child pornography? A. Never. Q. Other than in the bathroom or the massage room at the Palm Beach home, do you recall any other place in the Palm Beach home where you saw any of these topless photos of women? A. I remember there being photos everywhere, and the ones that stick out in my memory are the ones... There was a photo of Ghislaine with the Pope. It would not surprise me if there were naked photos around. I just didn't retain them in my memory. Q. So when you say there were photos everywhere, you mean just photos in general? A. Yes. They had a lot of photos around the house. Miss Macaulay. Objection. By Miss Menninger. Q. And Ghislaine was not topless in a photo with the Pope, just so I'm clear. A. Correct. Q. I just want to make sure we get that record really clear. So you recall there being photos everywhere? You just remember a couple sticking out in your brain as being topless? A. Yes. Q. And the walls on the staircase to the upstairs were not just covered with nude photographs to your recollection? A. To my recollection, I don't remember. Q. Did you observe what you would consider to be child pornography on any computer in the home? A. No. Q. Did you observe anyone taking photographs of young girls in the home? A. No. Q. The photograph of yourself that you saw, was that something that you had posed for? A. Not professionally, but I was just sitting, and I believe Jeffrey took the photo. I was just sitting on a couch upstairs in the bathroom. Q. It wasn't taken by a hidden camera? A. No, I was smiling in the picture. Q. And likewise, in the New York home, did you see anything... You described a large painting or a photograph that was in the massage room? A. Yes. Q. Do you recall any other photos of semi-clad or naked females? A. I don't recall. Q. Anything that you would consider to be child pornography that you saw in the New York home? A. No. Q. And likewise in New Mexico? A. I don't recall. Q. Do you recall seeing any semi-clad photos in New Mexico at all? A. I do not recall. Q. And the Virgin Islands? A. Yes, in his bathroom, master bathroom. Q. And what do you recall, if anything, about that photo? A. There was a photo of me in there. Q. And again, was that something that you were okay with? A. Yes. Q. Jeffrey Epstein never told you that he knowingly had sexual contact with an underage girl, correct? Miss Macaulay. Objection. The witness. When I asked him if the accusations were true after I spoke with the police, he said yes, but they lied about their age. By Miss Menninger. Q. How did that conversation came about? A. He asked me if the police had ever spoken to me, and I asked him, is it true? Q. And you were talking about underage girls? A. Correct. Q. And he said that he had been lied to by those girls? A. Yes. Q. Did he say anything else to you about it? A. No. Q. Did you ask him anything else about it? A. No. Q. Did you attempt to have any conversation like that with Ghislaine Maxwell? A. No. Q. I saw one press report that said you had met Cate Blanchett or Leonardo DiCaprio? A. I did not meet them, no. When I spoke about them, it was when I was massaging him, and he would get off. He would be on the plane a lot at that time, and one time he said, "Oh, that was Leonardo," or "That was Cate Blanchett," or "Bruce Willis," that kind of thing. Q. So name-dropping. A. Yes. Q. So you had not met Cate Blanchett or Leonardo DiCaprio? A. I have not. Q. Would you remember if you had? A. I would hope I would remember. Q. Did you meet Cameron Diaz? A. No. Q. Bill Clinton? A. No. Q. Did you see Bill Clinton on the island? A. No. Q. Did you see Bill Clinton in a helicopter being flown by Ghislaine Maxwell? A. No. Q. Did Ghislaine Maxwell ever tell you that she had flown Bill Clinton in her helicopter? Miss Macaulay. Objection. The witness. I don't recall her saying that. By Miss Menninger. Q. Did you ever meet Senator... redacted? A. I don't know what he looks like. I might have. Q. If I told you he was from Maine, would that stick out in your mind? A. It should, but I do not recall meeting him. Q. Do you ever remember meeting Prime Minister Ehud Barak from Israel? A. No. Q. Do you recall meeting any Prime Minister? A. No. Q. Any foreign president? A. No. Q. Nobel Prize winners? A. Not to my knowledge. Q. Naomi Campbell? A. No. Al Gore? A. No. Q. Alan Dershowitz? A. No. Q. Les Wexner? A. No. Q. Tom Pritzker? A. No. Q. Kevin Spacey? I may have already asked you, but have you met Kevin Spacey? A. No. Q. Did you meet Governor Bill Richardson of New Mexico? A. I want to say that he was supposed to come to dinner when we were in New Mexico. I don't know if I met him. I believe that he and Ghislaine had dinner separate from myself. Q. Jean-Luc Brunel? A. Yes. Q. You did meet him? A. Yes. Q. Tell me about that. A. He was just in the house at one time in Palm Beach. Q. Socializing? A. Yes. Q. Did you observe him to be with underage girls? A. I don't recall. Q. Did you give him a massage? A. I don't think I did. I gave a lot of guest massages. I don't recall any of their names, so it could have been any of those people besides the movie stars. Q. You would know? A. Exactly. Q. And did you engage in sexual contact with any of the guests for whom you gave a massage? A. No. That's why he would call me for his guests, because I was not comfortable with the sexual contact. So he still wanted to employ me as a massage therapist, but it was all normal. Q. So this was an actual conversation that you had? A. No, but I noticed. I noticed that I was massaging him less and less and massaging his guests more. Q. So there was a change in the frequency with which you were giving Jeffery Epstein massages? A. Right. Q. And an increase corresponding to massages you were giving to guests, correct? A. Yes. Q. Did any of the guests for whom you gave a massage mention that they expected something sexual? A. No. Q. Did they ask you to engage in sexual contact and you refused? Miss Macaulay, objection. The witness, no. By Miss Menninger. Q. Marvin Minsky? A. I don't know that. Q. George Lucas? A. No. Q. Donald Trump? A. No. Q. Did you ever massage Donald Trump? A. No. Q. Sorry, I have to ask, but did you ever have sex with Alan Dershowitz in the back of a limousine with Virginia and Jeffrey present? Miss Macaulay, objection. The witness, absolutely not. By Miss Menninger. Q. Do you know who Alan Dershowitz is? A. I do. Q. You would remember? A. I would remember that. Q. Did you ever see Virginia Roberts with any of the people that I just asked you about? A. No. Q. Did Virginia ever talk to you about having been with any of those people? Miss Macaulay, objection. The witness, no. By Miss Menninger. Q. Did she tell you that she had met any of those people? A. No. Q. I believe you saw in that police report a reference to a friend of Jeffrey named Glenn and his wife? A. Uh-huh. Q. Do you remember them? A. Vaguely. Q. Tell me what you remember. A. I remember they had an apartment on Breakers Row. I went up there and massaged. It may have been more than once, but I only really remember one time. But there was nothing sexual. Q. Neither with the wife nor with Glenn? Right. Do you remember the apartment? A. I only remember that I had to carry my massage table up some stairs. Q. So you actually gave the massage on a massage table? A. Yes. Q. Does that help you place it in time as to when they might have occurred? In other words, A. Well... Q. Did you get your massage license at some point and a massage table? Miss Macaulay, objection. The witness. Yes, he brought me my massage table around the time that I went to massage school. So it could have been any time after. If I had thought really hard, I could remember when I went to school. But I want to say it's around 2003. By Miss Menninger. Q. Nothing sexual happened with Glenn. A. No. Q. Did Glenn ask you to give him a massage on the floor of the home? A. I don't recall. Q. Did you ever discuss Glenn with Virginia? A. Not to my recollection. Q. Did you ever go to Virginia's home? A. No. Q. Do you know where she lived? A. No. Q. Did she talk about it? A. Not that I remember. Q. Did you see anything in your interactions with Virginia that led you to believe that she was a sex slave? Miss Macaulay, objection. The witness. No. By Miss Menninger. Q. Did you see anyone forcing her to remain in the home? A. No. Q. Did you see her look traumatized at some point? Miss Macaulay, objection. The witness. No. By Miss Menninger. Q. Did you see anything that led you to believe Virginia Roberts had been trafficked? Sexually trafficked to third parties? Miss Macaulay. Objection. The witness. No. By Miss Menninger. Q. Did Virginia ever tell you that she had been trafficked? A. No. Miss Macaulay. Objection. By Miss Menninger. Q. Did you hear anyone direct Virginia Roberts to go have sex with someone? A. No. Q. Did Jeffrey ever ask you to go have sex with another person? A. No. Q. Did Ghislaine Maxwell ever ask you to go have sex with another person? A. No. Q. Did Ghislaine Maxwell ever ask you to give a massage to someone else? A. No. Q. Did Ghislaine Maxwell ever ask you to dress up in any outfit? A. No. Q. Did she ever buy you an outfit for you to wear in terms of a sexual profile? A. No. Q. Did she tell you what kind of clothes you should buy? A. No. Q. Did she direct you to go get Brazilian bikini waxes? A. No. Q. Did she direct you to go get your teeth whitened? A. No. Miss Menninger. I would like to mark as an exhibit. I have no recollection what number we're on. Thank you. Exhibit 5. The referred to document was marked by the court reporter for identification as Sjoberg Exhibit 5. By Miss Menninger. Q. Have you seen this article before? A. It has followed me everywhere. Miss Macaulay. I'm sorry. Can I just ask you to put the Bates numbers on the record? Miss Menninger. Sure, it's Bates marked Joffrey 1131 through 1138. By Miss Menninger. What do you mean it has followed you everywhere? A. Well, if you Google me, it comes up. Q. I wanted to just ask you a couple of questions. On the third page, towards the bottom, there is a photograph that begins, "We had a picture taken," and just to orient you, this is in the discussion around the Prince Andrew meeting you had. Did you meet Prince Andrew any other time besides the time you already described in your testimony? A. No. Q. If you want to take a look at that paragraph before I ask you questions. A. Okay. Q. In that paragraph, it describes that Virginia sat on the chair, and then Andrew sat on another chair, and you sat on his lap. Miss Macaulay. Objection. By Miss Menninger. Q. Is that what it says? A. That's what it says. Q. Do you recall telling that to the reporter? A. Yes. Q. And this was back in 2007 or so? A. Yes. Q. As you sit here today, does that refresh your recollection that Virginia was sitting in one chair and you were sitting on another with Andrew? A. Yeah, if I said that, then I remember it that way. I'm just trying to remember. Whether we were on a couch or a chair, I just remember the boobs part, the hand on the boobs. Q. I understand that part stands out, and I also completely understand if you don't remember things that happened a long time ago. A. Right. Q. I'm just wondering if, having looked at this news article, it refreshes your memory that Virginia was sitting in a different place. A. In a different chair? Q. Does it? A. It does say that. Does it refresh my memory? Q. Okay, that's fine. A. Yeah, sure. Q. If it doesn't, it doesn't. I'm just asking. Did Virginia say anything to you about having met Prince Andrew before this time in New York? Miss Macaulay. Objection. The witness. She did not say. By Miss Menninger. Q. Did Prince Andrew say or do anything that led you to believe that he had met Virginia prior to that time? A. I don't recall. Q. Did you ever see Al Gore on the island? A. No. Q. Did you see his wife, Tipper Gore, on the island? A. No. Q. What is your understanding of what the lawsuit we are here today is about? A. I understand that Ghislaine is calling Virginia a liar, and so Ghislaine is suing Virginia. I'm sorry, strike that. Reverse it. Right, Virginia is suing Ghislaine for defamation. Q. And do you know what Virginia said about Ghislaine? A. That Ghislaine recruited her. Q. Do you know anything else that Virginia said about Ghislaine? A. Only what was spoken to me. Q. And I should clarify, don't tell me anything your lawyer has conveyed to you. A. Exactly, that's all I know. I met with Virginia once last summer. Q. Okay, tell me about that. A. There was a moderator between us, like an investigator, and she was in Palm Beach, and it was more about Jeffrey. It was less about Ghislaine. I don't remember specifically about Ghislaine at all. Q. So you met with Virginia and an investigator at the same time? A. Yes. Q. And they were, what, talking to you about Jeffrey in what context? Miss Macaulay. Objection. The witness. Basically, they were trying to find people that would help her get her story out, because this is when Dershowitz was saying nothing was happening and he was calling her a liar, and she was just trying to find people to back up her story. By Miss Menninger. Q. And what did you understand her story to be? Did she tell you? A. That she was recruited to give massages, sexual massages, and have sex with people such as Dershowitz and Andrew. But I knew none of that at the time. Q. Right. Did you tell them anything? Did you tell them during that meeting that you knew of anything about her being recruited to give sex to either Jeffrey or to other people? Miss Macaulay. Objection. The witness. Can you rephrase? By Miss Menninger. Q. Yes, that wasn't a very good question. What did you say during this meeting with Virginia and her investigator? A. Basically that I believed her, even though She never spoke to me specifically about what was going on, but once I learned everything that happened based on reading the police report, I believed her side of the story. Q. And did she tell you what her side of the story was? A. Just that she wasn't a liar, that, she was there to have sex with men that Jeffrey wanted her to sleep with. Q. Did she tell you in that meeting who she had sex with? A. No. Q. Did she name any of the famous people? A. Only Dershowitz came up. Q. Did you two talk about the incident in New York with the puppet? A. I don't recall. Q. And you formed this opinion about whether she was a liar based on things that you've read in the police report? Miss Macaulay. Objection. The witness. I formed my opinion based on my experience in the house. By Miss Menninger. Q. Okay. And what experience in the house helped you form your opinion that what Virginia is saying is true? A. Jeffrey being open with me about what other girls did for him, and that I was not one of those girls. He was always trying to recruit me, almost in a way that I could be one of them and travel with him, and live the life of luxury if only I did this. So after 5 years of learning what was happening, I can look back knowing I only knew Virginia for a very short time. Looking back, I can make assumptions about what was required of her. Q. Did she tell you how old she was when she said she started working with Jeffrey? A. She didn't. Q. Did she tell you how long she had worked with Jeffrey? A. No. Q. Have you read all the things that have been attributed to her in the press? A. Many of them. Miss Macaulay. Objection. The witness. I don't know that I've read all of them, but I have read some. By Miss Menninger. Q. In this meeting with Virginia and the investigator, you said Ghislaine Maxwell did not come up. A. Not that I recall. Q. Do you know the name of the investigator? A. Valerie Rivera. Q. Have you read the statement that Ghislaine Maxwell issued to the press? A. No. Q. Do you know what it says? A. No. Q. You said you have read some of Virginia's statements to the press, but not all of them? A. I don't know how many there are. I know I read something. I don't know if I read all of them. Q. Have you read her book manuscript? A. No. Miss Macaulay, objection. By Miss Menninger. Q. Did she tell you that she was writing a book? A. No. Q. Did she tell you she was trying to get a book deal? Miss Macaulay, objection. The witness. No. By Miss Menninger. Q. Did she tell you that he hired a ghostwriter? A. No. Miss Macaulay, objection. By Miss Menninger. Q. Did she tell you that she hired a literary agent? Miss Macaulay, objection. The witness. No. By Miss Menninger. Q. Did you speak with John Connolly? A. Yes. Q. When did you speak with John Connolly? A. He was first calling me around the time that everything was coming out in 2006, and I didn't say a lot to him, but I did say a few things. And I asked him not to use my name, and he used my name. And then he quoted me as saying things I never said. Q. Do you know to whom he quoted things that you had never said? A. I don't remember the news outlet, no. Q. So it was published somewhere? A. Somewhere on the internet. Q. Something that you said to John Connolly got twisted? A. Yes. He put words in my mouth. Q. And it was misreported and published? Miss Macaulay. Objection. The witness. Correct. By Miss Menninger. Q. Have you spoken to him lately? A. No. He called me again at the beginning of last year, around New Year's last year, but I did not return his call. Q. Do you recall what it is he attributed to you falsely? A. It was mostly about how I felt about certain things. I don't remember specifically what he said, but he was giving an opinion for me that I never spoke to him about. Q. And that you did not hold? A. Well, I can't remember what it was. Yeah. Q. Okay. Do you know whether Virginia has lied about any of her experiences? Miss Macaulay. Objection. The witness. I don't know that she has lied. By Miss Menninger. Q. Do you know that she has told the truth? A. As far as I know, she has. Q. Do you know whether the press has accurately reported everything that Virginia has said? Miss Macaulay. Objection. The witness. I don't know. By Miss Menninger. Q. Other than John Connolly and the police, who else have you spoken to about your experience? A. Well, the woman from the Daily Mail. Her name is Wendy Lee. Q. And that's Defendant's Exhibit 5. Not Defendant's Exhibit, just Exhibit 5, correct? A. Correct. Q. Did Wendy Lee accurately report your statements? A. She did a little bit of embellishment as well, but the facts are all true. Q. And what parts do you believe are embellished? A. Near the end, when she was doing the summary, when she wrote, "Sure, I had a good time, but I also think it damaged me a bit." I don't recall saying that. And there's another part in here where she said, I said that I made a deal with the devil, which I never would have said that. The word she used. Q. On page 2 of 8 is about even with the hem of your skirt. A. I made a pact with the devil in exchange for excitement and glamour. I was only a college student. I was hard up and foolish. That I never said. Any of that. I was a college student, that's true. Hard up and foolish, I would have never called myself foolish. Q. Were you paid any money for this interview? A. I was paid $1,500. Q. And how long did the interview last? A. A couple of hours. Q. Where did it take place? A. At Cafe Boulud in the Brazilian Court Hotel in Palm Beach. Q. Who else besides Wendy Lee and John Connolly and the police? Miss Macaulay. Objection. By Miss Menninger. Q. And Virginia and the investigator. Miss Macaulay. Objection. By Miss Menninger. Q. Did you talk to her about your experience? A. Family and friends. Did you speak to any other reporters? A. I had other reporters calling me. I avoided almost all of the calls. I had someone coming at me, stalking me. I do not know who he was. He offered me $25,000 to give a story, and I turned him down. Q. Who? A. He showed up in my work multiple times. Q. There were other stories printed in the Daily Mail, not by Wendy Lee. Later. Did you see any of those stories? I'm sorry, let me be a little clearer. That attributed comments to you. A. I don't recall specifically, but I feel like I stayed on top of it, and I wasn't surprised when my name was brought up. Q. Do you recall giving another interview? A. No, never. Q. Do you recall anything that was printed other than the John Connolly thing that you believe to be inaccurate? A. No. Q. Was there anybody else present when you were interviewing with Wendy Lee? A. No. Q. Was she recording it on a recorder? A. Yes. Q. Have you ever heard that recording? A. No. Q. Do you know whether the police were recording their interview with you? A. Yes. Q. Have you ever heard that recording? A. No. Q. Did you ever receive notification that you were named as a victim in any of Jeffery Epstein's criminal cases? A. No. Q. Other than the $1,500 from Wendy Lee, did you receive any other money for making any statements? A. No. Q. Did you give an interview to Virginia's attorneys? A. Yes, right? Miss Macaulay, you can say yes. By Miss Menninger. Q. When was that? A. 2 weeks ago, roughly. Q. And who was present during that meeting? A. My lawyer and several others. Q. Several other what? A. Lawyers. I don't know. I don't know who they all are. Q. So, Miss Macaulay, you recall being there? A. Yes. Q. Ms. Schultz, you recall being there? A. No, I didn't learn it. No, you weren't there. Q. Brad Edwards? A. Yes. Q. Paul Castle? A. Maybe. I don't remember. Q. And how was that interview recorded? A. I don't know. It may have been. I don't remember. Q. Did anyone ask your permission to record it? A. Maybe. I don't recall. Q. Were you shown any documents during that meeting? A. Flight logs. Q. Any other documents? A. No. Q. What did Miss Macaulay or Mr. Edwards or any of the other lawyers say to you about Ghislaine Maxwell? A. They just asked impressions and never said anything about her. Q. Were you shown a copy of any report that came out of that interview? A. Which interview? Q. The one with the Virginia's attorneys. Miss Macaulay. Objection. The witness. No. By Miss Menninger. Q. You testified earlier about an incident with a camera that Ghislaine Maxwell had given you. I want to ask you some questions about that. A. Sure. Q. Do you know when that was? A. That was in 2002. Q. And when does that date stick out? A. Because I was living specifically and where I had the phone call. Q. Tell me what you remember about the conversation. A. I had been over to her house prior massaging Jeffrey, and I got a phone call from her, and she told me she had a camera for me for my photography class, but yet she couldn't give it to me yet, because during the massage I didn't finish my job, and she had to finish it for me. Q. Did she say what she meant? A. No, but I knew. Q. Was there any other time that you had discussed with her finishing your job? A. Not that I recall. Q. Any other time you just recall discussing with her anything about your sexual contact with Jeffrey? Miss Macaulay. Objection. The witness. No. By Miss Menninger. Q. Did she give you the camera? A. I did get the camera. Q. Okay. When did she give you the camera? A. I guess the next time I went to the house. Q. What was said at that time? A.
I honestly don't know that she handed it to me. I remember it being there for me. Q. What kind of camera was it? A. A Canon Rebel 35mm. Q. Do you still have it? A. I do not. No one uses 35mm anymore. Q. What's that? A. No one uses 35mm. Q. Back to the cell phone conversation. A. Right. Q. Was it your birthday? A. It was just I was taking a photography class and I needed a camera. Q. Do you know her to be a photographer? A. Not a professional, but I knew she was interested in photography. Q. Did you see her with cameras? A. Yes. Q. Did you see her taking photographs of nude people? A. No. Q. Did she ever ask you to take a photograph of you, semi-clad or naked? A. Did she ever ask to take a photo of me? Q. Semi-clad or naked? A. No. Q. Did she ever ask to take a photograph of you at any point? A. I don't remember. Q. Did you tell anyone else about this conversation? You couldn't give it to me now because I haven't finished my job. A. No. Ms. Menninger. I think I'm going to reserve the rest of my time for recross, so you all, I guess, can take a break. Mr. Lewis. Can I have 1 second? Ms. Menninger. Sure. Miss Macaulay. We can go off the record? The videographer. Off the record at 12:09. Thereupon a recess was taken, after which the following proceedings were held. The videographer. On the record at 12:10. By Miss Menninger. Q. Sorry, just a couple of more questions. It sounds like maybe there was an additional telephone conference that one might construe as a meeting with attorneys. Is that true? A. Correct. Q. Alright, tell me about that. A. They just wanted to... We had met prior, and they just wanted to clarify a few things and ask a few more questions. Q. Okay, what did they clarify? A. Any other specific times that I had, seen Ghislaine naked? Or if I had, had any sexual massages with her? Any type of questions like that? Q. Okay. And what did you tell them about having any sexual messages with Ghislaine? A. That I was not asked to perform anything with her. Q. And you did not? A. Correct. Q. And what did you tell them about specific times of seeing Ghislaine Maxwell naked? A. Only when she would swim or get a massage. Q. And that's swimming. You mentioned earlier skinny dipping? A. Correct. Q. And I think you said perhaps some other time that you saw her jump off a dock and swim. A. Correct. Yes. Q. In the nude? A. Yes. Q. And then you saw her under a towel during massages? A. Yes. Q. Is there any other time that you recall seeing Ghislaine Maxwell naked? A. No. Q. Is there anything else about that telephone conference with the attorneys to clarify that you recall the topics? A. No. Miss Menninger. All right, thank you. I think we can go off the record now. The videographer. Off the record at 12:12. Thereupon a lunch recess was taken, after which the following proceedings were held. The videographer. On the record at 12:54. Further examination. By Ms. Macaulay. Q. Johanna, I'm going to ask you a couple of more, just follow-up questions. When Laura was talking to you, she mentioned some names of famous people that most of which you had not met. Did you ever meet anybody famous when you were with Jeffrey? A. I met Michael Jackson. Q. Oh, really? And when was that? A. At his house in Palm Beach. At Jeffrey's house in Palm Beach. Q. Did you massage him? A. I did not. Q. Anybody else you remember? I know you mentioned David Copperfield earlier. Anybody else? A. No, I'd remember that. Q. I believe you also testified that you had never had a massage before you started working with Jeffery and Ghislaine. Is that correct? A. I don't recall having a massage before then. Q. And I think you said on the first day, when you were doing the clerical work, Maxwell mentioned that you might be able to get a massage. Is that correct? A. Yes. Q. Did you tell Maxwell that you had never had a massage at that point? A. I don't remember. Q. Did you remember telling Jeffery that you never had a massage? A. No. Q. And then you were talking about the massage. The first massage when you were being in the room with Jeffery and Emmy? A. Uh-huh. Q. And I know you said Emmy was naked or took off her clothes at some point? A. Uh-huh. Q. And then laid on the table. And then you changed positions with her? Is that what happened? A. Yes. I don't remember the sequence, but at one point I was, and Jeffery was. Q. And in the time when there was changeover, for example, when you're on the table and Emmy is not on the table, and Jeffery is not on the table, did Emmy at that point remain naked, or did she actually stop and get dressed, and continue massaging? A. I don't recall her getting dressed, but I would probably remember if she massaged naked. Q. Do you know if Jeffery remained naked during that massage? A. He was never, naked standing up. He always covered himself with a towel. Q. I believe I asked this, but I just want to clarify to make sure that I did. Did Maxwell ever ask you to bring other girls over for Jeffery? A. Yes. Q. Yes. A. Yes. Q. And what did you do anything in response to that? A. I did bring one girl named... Redacted. No, redacted. It was some girl named Redacted that I had worked with at a restaurant, and I recall Ghislaine giving me money to bring her over. However, they never called her to come. Q. And then I believe you mentioned that one of your physical fitness instructors... You brought a physical fitness instructor, was that correct? A. Correct. Q. And what did she do? A. She gave him, a training session, twice. Q. Twice. Did anything sexual in nature happen during the session? A. At one point he lifted up her shirt and exposed her bra, and she grabbed it and pulled it down. Q. Anything else? A. That was the conversation that he had told her that he had taken this girl's virginity, the girl by the pool. Q. Okay. Did Maxwell ever say to you that it takes the pressure off of her to have other girls around? A. She implied that, yes. Q. In what way? A. Sexually. Q. And earlier Laura asked you, I believe, if Maxwell ever asked you to perform any sexual acts, and I believe your testimony was no, but then you also previously stated that during the camera incident that Maxwell had talked to you about not finishing the job. Did you understand not finishing the job, meaning bringing Jeffery to orgasm? Ms. Menninger. Objection. Leading. Form. By Ms. Macaulay. Q. I'm sorry, Johanna, let me correct that question. What did you understand Maxwell to mean when she said you hadn't finished the job with respect to the camera? Ms. Menninger. Objection. Leading. Form. The witness. She implied that I had not brought him to orgasm. By Ms. Macaulay. Q. So, is it fair to say that Maxwell expected you to perform sexual acts when you were massaging Jeffery? Ms. Menninger. Objection. Leading. Form. Foundation. The witness. I can answer? Yes. I took that conversation to mean that is what was expected of me. By Ms. Macaulay. Q. And then you mentioned, I believe, when you were testifying earlier, that Jeffery told you a story about sex on the plane. What was that about? Ms. Menninger. Objection. Hearsay. The witness. He told me one time Emmy was sleeping on the plane and they were getting ready to land, and he went and woke her up, and she thought that meant he wanted a blowjob. So she started to unzip his pants, and he said, No, 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 you just have to be awake for landing. By Ms. Macaulay. Q. Do you recall witnessing any sexual acts on the plane? A. No. Q. Did Emmy ever talk to you about performing sexual acts on the plane? A. No. Q. We looked earlier at the police report, and I just want to clarify, you identified some areas where there were discrepancies in that report. And you can take another look at it if you want, but other than the discrepancies you pointed out, is that a recollection of what you remember telling the detective? A. Yes. Miss Menninger. Objection. Outside the scope of cross. By Miss Macaulay. Q. You mentioned that there was a time when you noticed that Maxwell was around a little bit less. A. Uh-huh. Q. And I believe you said that was during the middle of the time you were with Jeffrey. Do you remember approximately when that was, year-wise? A. I don't. I would say it was probably sometime between 2003 and 2004. Q. And what made you think that? A. I just saw her less and less at the house. Q. Were you there more at the house during that time period? A. No, not necessarily. It's just at the beginning she was around a lot, and then I would see her occasionally without him. The one time we spent a few days together in 2006, she wasn't there at all. Q. So you saw her in the... Is it fair to say that you saw her in the 2005 and 2006 timeframe? A. Yes. Q. Then we were talking about the photography earlier, and about the photographs. Did Maxwell ever ask you to take nude photos of yourself for Jeffrey? A. She asked me to take photos of myself for Jeffrey, yes. Q. And did you do that? A. I did not. Q. And the photos that were around, that were in the bathroom, that you mentioned a couple of times, places that there were photos of you, who took those? A. He did. Q. And when we were talking about the Palm Beach house and you were describing an area where there were just a lot of photographs, is it fair to say that there could have been nude photographs amongst those photos that you saw? A. Yes. Q. And earlier you testified that you don't have knowledge of what happens behind closed doors, but you also said that Jeffrey had told you what other girls did for him, and that he wanted you to do those things for him. Is it fair to say that you knew that other girls were performing sexual acts? A. Yes. Miss Menninger. Objection, foundation, form. By Miss Macaulay. Q. And I know you mentioned previously that your relationship and the interaction with him progressed over time. Did there come a time when you were expected to have sexual intercourse with Jeffrey? A. Yes. Q. And when was that? A. 2005. Miss Macaulay. That's it. I just do want to also put on the record that we're designating the testimony as confidential under the protective order. Further examination. By Ms. Menninger. Q. Okay. You just testified that you have knowledge. You had knowledge that of what Jeffrey was doing behind closed doors with other girls. Was that your testimony? A. Based on what he had told me. Q. Okay. So Jeffrey told you things that he had done with other girls? A. Yes. Q. You did not observe any of those things? A. No. Q. You did not talk to any of those girls about what they had done with Jeffrey behind closed doors? Ms. Macaulay. Objection. By Ms. Menninger. Q. Correct? A. No, correct. Q. The only source of knowledge you have is based on what Jeffrey told you he had done with other girls. A. Correct. Ms. Macaulay. Objection. By Ms. Menninger. Q. You said that there were possibly nude photos amongst the other photos that you saw on various walls at the Palm Beach house, correct? A. Correct. Q. None of them stood out to you? A. Correct. Q. None of them appeared pornographic? A. No. Q. You didn't see any fully frontal nude photographs, correct? A. No, not that I recall. Q. And you don't recall seeing any girls that appear to be underage, correct? A. No. Q.
You said Ghislaine asked you to take photos of yourself with Jeffery, correct? A. Correct. Q. Did she ask you to take a nude photograph of yourself or just a photograph of yourself? A. A nude photograph of myself. Q. What exactly did she say to you? A. I don't remember exactly, but I know that I never felt comfortable. I would have felt fine taking photos of myself, my face, but I knew I was never comfortable with it because I had to take photos of my body. And I also didn't know how to take a photo from standing behind. You have to have someone else involved. Q. That's my question. How would you take a nude photograph of yourself? A. Exactly. Someone else would have to do it. Q. Do you recall any of the particulars of what she said to you that led you to believe she wanted you to do that? A. No, just asking for the photos. Q. Do you know when in your time there? A. It was near the beginning because that's when I was interested in photography. Q. Was it in the context of your discussion of your photography class? A. No. Q. Was it in the context of anything? A. About the camera that she had bought for me. Q. What did she say in relationship to the camera that she bought for you and taking photographs of you? A. Just that Jeffery would like to have some photos of me, and she asked me to take photos of myself. Q. What did you say? A. I don't remember saying no, but I never ended up following through. I think I tried once. Q. This was the pre-selfie era, correct? A. Exactly. Q. I want to go back to this. You testified to two things just now with Sigrid that you said were implied to you. A. Okay. Q. The first one was it would take pressure off of Maxwell to have more girls around. A. Right. Q. What exactly did Maxwell say to you that led you to believe that was her implication? A. She said she doesn't have the time or desire to please him as much as he needs, and that's why there were other girls around. Q. And did she refer specifically to any other girls? A. No. Q. Did she talk about underage girls? A. No. Q. Was she talking about massage therapists? A. Not specifically. Q. Okay. There were other girls in the house that were not massage therapists, correct? A. Yes. Q. Nadia is another person that was around, correct? A. Yes. Q. There were other people he travelled with? A. Uh-huh. Miss Macaulay. Objection. By Miss Menninger. Q. Correct? A. Correct. Q. Other girls? A. Yes. Q. Adults? A. Yes. Q. When I say girl, I really mean women, correct? A. Correct. Q. There were other women around who hung out with Jeffery, and you don't know what they did behind closed doors, correct? A. Correct. Q. So when you heard the implication that she wanted other girls around to take the pressure off of her sexually, in your mind, that meant other adult women that he had in his life, correct? Miss Macaulay. Objection. The witness. Correct. Doing what I was expected to do in a massage, you know. By Miss Menninger. Q. Ghislaine didn't have anything to do with you bringing this woman over for a physical workout with Jeffery, correct? A. Correct. Q. She asked you to bring another girl to perform massages at the home. A. Yes. Well, she was always asking if I knew anyone else, and so I brought this one girl that I didn't even know I worked with her at a restaurant. So I didn't care what she thought of me if anything happened. But it never turned into anything. Q. She was an adult? A. She was an adult. Q. Working at a restaurant with you? A. Yes. Q. What restaurant was that? A. It's a restaurant that's closed. It's called Redacted. Q. You were asked about the famous people. You said you met Michael Jackson? A. Yes. Q. But you did not give him a massage.
A. No. Q. There were other famous people, perhaps, who were around Jeffrey's home that you didn't meet, correct? A. Correct. Q. Do you know whether Virginia Roberts has told the truth about the age she was when she met Ghislaine Maxwell? Ms. McCauley. Objection. Exceeds the scope of cross. The witness. I don't have any idea what she told them in terms of her age. By Ms. Menninger. Q. Do you know if Virginia Roberts is telling the truth about whether she spent her sweet 16th birthday with Jeffrey and Ghislaine Maxwell? Ms. McCauley. Objection. The witness. I don't know anything about that. By Ms. Menninger. Q. Do you know whether Virginia Roberts is telling the truth about whether Ghislaine Maxwell sexually assaulted her on her first day on the job? Ms. McCauley. Objection. The witness. I have not knowledge of that. By Ms. Menninger. Q. Do you have any knowledge of whether Virginia Roberts is telling the truth about about Ghislaine Maxwell forcing Virginia Roberts to go down on her? Ms. McCauley. Objection. The witness. No knowledge. By Ms. Menninger. Q. Do you have any knowledge about whether Virginia Roberts is telling the truth about whether Ghislaine Maxwell forced her to participate in orgies with other women? Ms. McCauley. Objection. The witness. No. By Ms. Menninger. Q. Do you have any knowledge about whether Virginia Roberts is telling the truth about whether Ghislaine Maxwell directed her to have sex with Prince Andrew? Ms. McCauley. Objection. The witness. No. Only based on what I've read in the media. By Ms. Menninger. Q. And Alan Dershowitz? Ms. McCauley. Objection. The witness. The same. By Ms. Menninger. Q. Prime Ministers. Ms. McCauley. Objection. The witness. No. By Ms. Menninger. Do you have any knowledge about whether Virginia Roberts is telling the truth about foreign presidents? Ms. McCauley. Objection. The witness. No knowledge. By Ms. Menninger. Q. Do you know whether Virginia Roberts is telling the truth about Ghislaine Maxwell forcing her to participate in an orgy with Prince Andrew and other underage girls on the island? Ms. McCauley. Objection. The witness. No knowledge. By Ms. Menninger. Q. Did Ghislaine Maxwell ever ask you to have her baby? Ms. McCauley. Objection. The witness. No. Ms. Menninger. No further questions. Ms. McCauley. Thank you for your time. The witness. We are done? Ms. McCauley. We are off the record. The videographer. The time is 1:11. This concludes the video deposition. Off the record. Thereupon, the taking of the deposition was concluded at 1:11 p.m. Affidavit. State of Florida. County of. Redacted. I, redacted, being first duly sworn, do hereby acknowledge that I did read a true and certified copy of my deposition, which was taken in the case of Jeffery v. Maxwell, taken on the 18th day of May 2016, and the corrections I desire to make are as indicated on the attached errata sheet. Certificate. State of Florida, County of, redacted. Before me personally appeared, redacted, to me well known / known to me to be the person described in and who executed the foregoing instrument, and acknowledged to and before me that he executed the said instrument in the capacity and for the purpose therein expressed. Witness my hand and official seal this, redacted, day of, redacted. Certificate of Oath. State of Florida. County of Miami-Dade. I, the undersigned authority, certify that Johanna Sjoberg personally appeared before me and was duly sworn. Witness my hand and official seal this 18th day of May 2016. Certificate. State of Florida. Redacted. County of Miami-Dade. I, Kellyanne Willis, a registered professional, certified real-time reporter and notary public within and for the state of Florida, do hereby certify that Johanna Sjoberg, the witness whose deposition is hereinbefore set forth, was duly sworn by me, and that such deposition is a true record of the testimony given by the witness. I further certify that I am not related to any of the parties to this action by blood or marriage, and that I am in no way interested in the outcome of this matter. In witness whereof, I have hereunto set my hand this 18th day of May 2016. Kellyanne Willis, RPR, CRR. Please note that pages 327 to 344 are just black boxes for me. I don't know whether the information is redacted or if this is just, deliberate black screen as far as court documents go. I'm sure you guys can tell me in the comments. If this ever becomes unredacted, I'll do this too. Just let me know if that happens, please. Anyway, let's carry on. Exhibit 7, Part 2. Date, 7th, 19th, 06. Palm Beach Police Department. Time, 15:01:37, Incident Report. Case number, 105000368. Continued. Photographed by CSI Pavlik and then videotaped by myself. The search was concluded at approximately 3:05 p.m., whereupon Detective Ricari and I were the last two officers in the house. Upon securing the residence, we met with a gentleman who identified himself to Detective Ricari as the lawyer for the defendant, and he was informed that the residence was secured and that copies of the inventory return had been left on the first floor table of the personal assistant's office. Detective Ricari and I returned to police headquarters and secured for the day. Narrative number 14. Reported by Dawson Michael C. 11:07:05. Entered by Altomaro Nikki A. 11:07:05. On October 20th, 2005, I assisted Detective Ricari in the execution of a search warrant at 358 El Brillo Way, Palm Beach, Florida, 33480. Upon the announcement of the search warrant, immediate contact was made with 3 white males who came out of the house or surrounding structures. Those males were identified as Jesus Banisak, Daniel Estes, and Mark Zeff. As other members of the police department cleared the home, I kept watch over these 3 males. Once the house was cleared, those males were turned over to Detective Ricari. Detective Dix and I were assigned to assist in the search of the main house, the cabana, and the servants' quarters. We started in the garage. All areas of the garage were searched to include 4 vehicles. These vehicles were 3 black Mercedes-Benz cars registered to Jeffery Epstein. The 4th vehicle was a Harley-Davidson motorcycle, green in color, registered to Jeffery Epstein. Nothing was recovered from the garage. A town closet and pantry located off the kitchen was searched and yielded negative results. The kitchen was searched and taken into evidence was a phone message book that was located near a house phone. North of the kitchen was an office room which contained a computer. The room had a closet that contained a locked gun locker. The combination was entered by Banasiak in the presence of Sergeant Frick, and the safe was opened. Items were taken from the room. See the completed property receipt for a detailed list. A green bathroom located on the first floor was searched and nothing was taken. A closet located just west of the green bathroom was searched. 2 massage tables were located in the closet along with a photo of a nude female from the waist up. See the property receipt for details. I searched 2 bedrooms and their adjoining bathrooms, which were located on the 2nd floor on the east side of the house. In the northeast bedroom closet, I found adult sex toys called twin torpedoes. Soap made in the shape of a penis and vagina were also found in these upstairs bedrooms. See the property receipt for details. I searched the pool cabana located on the south side of the pool. Photos were taken from the wall. See the property receipt for details. I assisted in the search of Banasiak's living quarters. Numerous CDs along with a message book were seized. See the property receipt for details. Narrative number 15. Reported by Ricari Joseph, 11:08:05. Entered by Altomaro Nikki A, 11:08:05. On November 1st, 2005, I was contacted by Atty Gus Fronstein, who advised he was willing to assist with the investigation. Attorney Fronstein advised he would try to have his client, Jeffery Epstein, available to be interviewed. I explained I would be interested in conducting an interview with his client as well as other employees that are employed within the house. Atty Fronstein advised he would return my call once he received confirmation on the interviews. On November 6, 2005, I attempted contact with Redacted at her residence. I left a business card for her to return my call. Upon returning to the police department, I had received a telephone call from Redacted. I returned her call at Redacted and spoke with Redacted. She made arrangements to respond to the station to provide an interview. At approximately 3:30 p.m, she arrived at the Palm Beach police station with her boyfriend. Her boyfriend was allowed to sit in the lobby area while Ms. Redacted was interviewed. I took Ms. Redacted to the Detective Bureau interview room. I closed the door for privacy and explained to her that I appreciated her coming to the police station for the interview. During the sworn taped statement, she advised she was at Jeffrey Epstein's house one time. Approximately 2 months ago, she was approached by a girl, Redacted, who was dating her roommate to make some quick money. Redacted advised she was in need to make some quick cash to make the rent that month. She agreed to go to the house. She had been told by Redacted that the massage would have to be done in her underwear. She advised Redacted drove with her and brought her into the house. They walked into the kitchen area and took the stairs upstairs. Redacted further stated she was brought into a master bedroom area. She advised she recalled seeing portraits of naked women throughout the room. A massage table was already out near the sauna/shower area in the master bedroom. Epstein entered the room wearing only a towel and introduced himself as Jeff. Redacted advised she recalled she and Redacted removed their clothing down to their panties. Epstein lay on his stomach area and they provided a massage on his legs and feet area. I asked Redacted if she had any formal massage training and she replied no. Due to the graphic content, I will be redacting this section. Himself on the table. He wiped himself with the towel he had on previously and went into the shower area. Redacted got dressed and met with Redacted in the kitchen area. Epstein came into the kitchen and provided Redacted $200 for bringing Redacted and paid $200 to Redacted for providing the massage. Redacted was told to leave her telephone number with Sarah, his assistant, for future contact. Redacted provided her cellular telephone number for future contact. Redacted was asked if she was recently contacted about this investigation by anyone from the Epstein organization. She replied she was called, but it was for work. She stated she was called by Sarah for her to return to work for Epstein. Redacted stated work is the term used by Sarah to provide the massage in underwear. Redacted advised she declined, as she was not comfortable in providing that type of work. The interview was concluded and the videotape was placed into evidence. Investigation continues. Narrative number 16. Reported by Ricari Joseph, 11:10:05. Entered by Altomaro Nikki A, 11:10:05. On November 7, 2005, I made telephone contact with Redacted, who advised she would be able to meet with me at her home. Detective Sandman and I travelled to her home in Redacted and made contact with Redacted. During a sworn taped statement, Redacted stated she met Jeffrey Epstein through Haley Robson. Robson would approach females who wished to work for him. Redacted stated she was asked to work for him but declined. Redacted explained that work means give massages. She was asked about any formal training in providing massages, to which she said no. Redacted said she accompanied Robson and other females who were taken to Epstein's house to provide massages. Redacted further stated she had been to the house approximately 4 or 5 times in the past year. She accompanied Robson with Redacted, the 14-year-old victim, and Redacted. Each time the girls were taken over, they were previously told they would have to provide a massage, possibly naked. It was also told that should Epstein require them to do anything extra, and they were not comfortable, just to tell him and he would stop. Redacted stated Robson received $200 for each girl she brought over to massage Jeffery Epstein. When I asked which girl appeared to be the youngest, she replied, the victim, as she stated she was 15 years old at the most. She looked really young. Redacted further stated each time she went to the house, she sat in the kitchen and waited with Robson until the massage was over. She further stated that the cook would make lunch or a snack for them as they waited. I asked her if there was anything that caught her attention within the home. Redacted stated there were a lot of naked girls in photographs throughout the house. The interview was concluded and the tape was turned into evidence. Investigation continues. Narrative 17. Reported by Ricari Joseph. 11:10:05. Entered by Altomaro Nikki A. 11:10:05. Detective Dawson and I attempted contact with Redacted in Redacted. I left my business card at a front door. Miss Redacted returned my call and arranged a meeting with me at the Palm Beach Police Department for November 8, 2005. At approximately 2 p.m., Redacted arrived at the Palm Beach Police Department. She was brought into the interview room and the door was closed for privacy. She was told that I appreciated her coming to the police station for questioning regarding an ongoing investigation. She was told that I was investigating a crime involving Jeffery Epstein and knew, based on the investigation, that she had encounters with him in the past. During a sworn taped statement, Redacted stated she had met Epstein approximately 2 years ago. She was first introduced to Epstein by Haley Robson. Robson approached her about working for Epstein and providing a massage to him for $200. The arrangements were made, and as Robson could not take her the day the arrangements were made, Redacted took Redacted. Redacted also attended Redacted and was familiar with Epstein. Redacted recalled she was brought there and entered through the back kitchen door. She had met with an assistant, Sarah, and another assistant, Adriana. Sarah brought her upstairs as she observed several photographs of naked females throughout the house. Redacted stated Epstein came in the room wearing only a towel and laid on the table. Redacted stated he picked out the oils he wanted her to use and requested she remove her clothing to provide the massage. Redacted stated that on the first massage she provided, she did not remove her clothing. Redacted stated she had returned several times after that. Each time she returned, more things happened. Redacted stated that the same thing would happen. Epstein would walk into the master bedroom/bathroom area wearing only a towel. Due to the graphic content, I will be redacting this section. Redacted added she has no formal training in providing a massage. Redacted stated she brought 2 females during her visits to provide massages. Redacted stated she brought a girl named Redacted and Redacted from Redacted. Redacted stated she received $200 for each girl she brought. Additionally, Redacted was given $200 for taking her in the very beginning. The interview was concluded and the tape was placed into evidence. Investigation continues. Narrative 18. Reported by Ricari Joseph. 11:13:05. Entered by Altomaro Nikki A. 11:14:05. On November 8, 2005, I made telephone contact with Redacted, WF Redacted, at her residence. Redacted responded to the police station for an interview reference an ongoing investigation. At approximately 2:30 p.m., she arrived at the Palm Beach police station
and was brought into the interview room for the interview. The door was closed for privacy, and she was told that I appreciated her cooperation in this case. During a sworn tape statement, Redacted stated she had met Jeffery Epstein approximately 1 year ago. She was approached by a subject known to her as Redacted. Redacted had asked her if she wanted to make money providing massages to Epstein. Redacted had heard that several girls from Redacted were doing this and making money. She agreed and was taken to the house by Redacted. Redacted had introduced her to Sarah and Epstein and brought her upstairs to her master bedroom and master bathroom, where a massage table was prepared and the proper oils were taken out. Redacted left the room and waited downstairs for Redacted. Redacted stated Epstein entered the room wearing a towel.
Due to the graphic content, I will be redacting this section.
She felt the whole situation was weird, but she advised she was paid $200 for providing the massage. She also stated Redacted received $200 for bringing Redacted to Epstein. Redacted stated she had gone a total of 15 times to his residence to provide a massage, and things had escalated from just providing a massage. Epstein began touching her on her buttocks and grabbed her closer to him as he masturbated. Epstein also grabbed her breasts and fondled her breasts with his hands as she provided the massage. Okay, I think it's very important to note here. There are a few things I'm going to have to skip here because some of these narratives go into incredibly explicit and detailed sexual acts here, and there is no way this will be allowed on YouTube whatsoever. You're going to have to trust me when I say it is detailed, it is horrible. It's just really bad, okay? You're not going to miss much. I'm going to skip ahead for this bit. I know the title will say full narration. This might not technically count as a full narration. I'm not doing this bit, okay? It's pretty bad, but it corroborates what previously happened in the report as well. Alright, let's carry on. Redacted stated the last time she spoke with anyone at the house was with Sarah during the weekend of October 2nd or 3rd, 2005. Redacted stated she had brought 2 people to the Epstein house. She provided the names of Redacted and Redacted, unknown last name. It should be noted, Redacted had been previously identified as Redacted and had been previously interviewed. The interview was concluded and the videotape was placed into evidence via the locker system. On November 9th, 2005, Sergeant Frick and I travelled to 6791 Fairway Lakes Drive in Boynton Beach, Florida, in hopes to interview Juan Alessi, the former houseman of Epstein's home. As no one was home, a business card was left for him to return my call. We then travelled to 11349 SW 86th Lane in Miami, in hopes to interview Alfredo Rodriguez, a former houseman of Epstein. We did not locate them at home. I left a business card for him to return my call. We then travelled to Redacted and met with Dean of Students, Mr. Redacted. We requested to speak with Redacted. Redacted was re-interviewed, as she still was in possession of the rental car that Epstein had acquired for her. Redacted stated that Sarah, Epstein's assistant, had called her on her cellular telephone and informed her that rental was extended for her. Sarah stated she had paid an additional $625 for her to keep the rental an extra month. Redacted was asked if she had any additional contact with either Epstein or anyone from his organization. Redacted stated she did not, other than the telephone call informing her that she could keep the car for an extra month. Redacted did not provide any additional information. On November 10th, 2005, at approximately 9:47 a.m., Alfredo Rodriguez had telephoned reference my business card found on his door. Rodriguez stated he had worked with Epstein for approximately 6 months after the previous houseman left. Rodriguez stated that it was his responsibility to keep the identity of the masseuses private. Mr. Epstein had a massage in the morning and one in the afternoon. Mr. Rodriguez stated he would rather speak about this in private. He advised he would come to the police station to speak with me.
Rodriguez stated he would return my call on Monday, November 14th, 2005. I then made telephone contact with Juan Alessi. He advised he found my card on his door and wanted to know what I needed to speak with him about. I explained to Alessi that I was conducting an investigation on his former employer, Mr. Epstein. Alessi stated he would return my call shortly, as he was in the middle of a project at his home. I received a telephone call from attorney Donald Morell from 686-2700. Mr. Morell stated he represented Mr. Alessi and did not want me speaking with his client. I then made telephone contact with the state attorney's office and confirmed that subpoenas will be issued to the former employees to assist in the investigation. I then made telephone contact with attorney Guy Fronstin, attorney for Mr. Epstein. I explained to Mr. Fronstin that I would like to speak with Mr. Epstein. He stated that Mr. Epstein is not in residence in Florida at this time and would check with him to ascertain if he could be here by Wednesday, November 16th, 2005 for an interview. Mr. Fronstin stated he would return my call should Mr. Epstein decide to come in to the police station for an interview. Investigation continues. Narrative number 19. Reported by Ricari Joseph. 11/15/05. Entered by Altomaro Nikki A. 11/16/05. On November 14, 2005, Detective Sandman and I travelled to Redacted in Redacted and spoke with Redacted. She was told of the ongoing investigation involving Epstein. Redacted advised she had gone to the house on several occasions. During a sworn tape statement, she advised she started going to the house approximately 1 year ago and was brought by Redacted, unknown last name. Redacted stated Redacted brought her into the house and she was introduced to a girl named Sarah. Once she met her, Sarah brought her upstairs into a master bedroom bathroom. Redacted stated she met Jeffrey in the bathroom. He lay on the table and picked the massage oils. She provided the massage as he lay naked on the massage bed. She stated she rubbed his calves and back area. Upon the end of the massage, Epstein removed himself from the massage table and paid her $300 for the massage. Redacted stated she had only been at the house approximately 5 or 6 times. Redacted said each time she went to the house, she was notified by Sarah, Epstein's assistant, that Epstein was in town and would like her to work. Redacted stated she returned to the house and was again led upstairs by Sarah. She provided the massage, clothed. Redacted asked if it wasn't really weird until later on. Redacted was asked if she ever removed her clothing to provide a massage. Redacted stated it was not until the 3rd time she went that she removed her clothing. Redacted stated she was notified by Sarah that Epstein wanted her to come to work. She arrived at the house and was led upstairs by Sarah. We've got another explicit bit here, so I'm gonna skip this. It's some heavy stuff, but it corroborates the previous reports as well. I'm going to continue from page 353, about halfway down. Redacted stated on the last time she went to provide a massage, she was notified by Sarah to come to the house and work. Redacted stated she was now dating her current boyfriend and did not feel comfortable going. She recalled it was approximately January 2005. She said she went, already thinking that this would be the last time. She went upstairs and went into the master bedroom. She met with Epstein, who was wearing only a towel as he entered the room to lie on the table. Redacted stated Epstein caught her looking at the clock on several occasions. Epstein asked her if she was in a hurry. Redacted stated her boyfriend was in the car waiting for her. Redacted further stated that Epstein got upset as she wasn't enjoying the massage. She told him that she didn't want to continue and she would not be back. Epstein told her to leave as she was ruining his massage. I asked her if she had any contact with Epstein's organization. She stated she received $200 from Western Union in Royal Palm Beach and Okeechobee Boulevard as a Christmas gift. Redacted advised she had no formal training in providing any massages. Redacted also stated she was 16 years old when she first went to Epstein's house. At approximately 4:22 p.m., I made telephone contact with Redacted at Redacted. She agreed to meet with me at a public place. I suggested she come to the police station for an interview. Redacted did not want to meet at the police station. I recommend we meet at the Palm Beach Garden Mall in the food court area. She agreed, and an appointment was made for November 15, 2005 at 5 p.m. at the food court. Investigations continue. Narrative number 20. Reported by Sandman Jennifer R. 11/16/05. Entered by Altamaro Nikki A. 11/17/05. On 10th 20th 2005, I assisted executing a search warrant at 358 El Brillo Way in the town of Palm Beach, County, Florida, under the direction of Affiant Detective Joe Ricari. Detective Melnicock and I searched the pantry room that is west next to the kitchen. This room had all white cabinets with a dark grey and black countertop. We did not find anything in this room. We searched the yellow and blue room that is west next to the pantry room. This room had a very large statue of a man with a bow. Taken into evidence from this room were 9 photographs in frames of various women. We searched the main entrance foyer that is to the north of the yellow and blue room. This room contained 2 bamboo chairs and ottomans with cushions. It also contained a round table with numerous books. We searched another blue room that is west of the foyer. This room had a stereo system and bookshelves that were from the floor to the ceiling. Taken into evidence from this room were 8 photographs in frames of various women and/or Epstein, the owner of the residence. We searched the room to the west of the blue room that has sliding glass doors that lead out to the pool. In this room, in a dresser, were 2 DVDs and 2 VCR tapes. These items were taken into evidence. We searched a 2004 black Chevy Suburban bearing Florida tag X99EGL, registered to Jeffery Epstein, DOB 01-2053, which was located on the east side of the driveway facing south. I found a thrifty rental agreement between the passenger seat and the middle console. The name on the rental agreement was Johanna Sjoberg from 622 Holly Drive, Palm Beach Gardens, Florida 33410. The phone number on the rental agreement was 561-714-0546. The vehicle rented was a white 2005 Chrysler Sebring bearing Florida tag W99 Fun. The vehicle was rented on 9th 25th 05 at 17:58 hours and was returned on 9th 26th 05 at 16:52 hours. The last 4 numbers of the credit card used are 9821. Detective Melnicock found a piece of paper in the middle console that said I used the cash in here to fill up the tank and was signed by Johanna. I searched the 2005 black Cadillac Escalade ESV bearing Florida tag Q299GT, registered to Jeffery Epstein, date of birth 01-2053, which was located on the west side of the driveway facing south. I did not find anything in this vehicle. All of the items that were taken into evidence were photographed in the place they were located and then turned over to crime scene. Narrative 21. Reported by Ricari Joseph. Entered by Altamaro Nikki A. Dates 11/17/05. On November 15, 2005, Detective Salmon and I travelled to Redacted in Redacted. We met with Redacted, a 17-year-old juvenile who was not in school this day due to a cold from which she was suffering. Redacted was told that I needed to speak with her in reference to an ongoing investigation involving a subject she would know as Jeffery Epstein. Prior to speaking with her, I explained that because of the fact that she is a minor, I needed to speak with her parents prior to speaking with her. She telephoned her father, Mr. Redacted, on his cell phone and explained to him that Detective Salmon and I were there to speak with her. I spoke with Mr. Redacted on the telephone and informed him I needed to speak with his daughter in reference to an ongoing investigation. Mr. Redacted advised he had no problem with us speaking with his daughter. During a sworn taped statement, Redacted stated she met Jeffery Epstein over a year ago. She was 16 years of age and was approached by Redacted, who informed her that she could make monies providing a massage to Epstein for $200. Redacted had informed her that she would have to provide this massage topless. Redacted made the arrangements with Epstein and his assistants and took Redacted to the house. Redacted stated Redacted, and she entered through a glass door that led into a kitchen. Redacted took her upstairs to a master bedroom and master bathroom. She recalled the bathroom had a large pink couch, sauna, and matching shower. It is at this point that, once again, we're going to have to skip. This is at page 355. If you guys are into that thing, I wouldn't recommend it. I'm going to continue from partway down page 356, skipping past the sensitive material. Redacted was asked if Epstein knew her real age. Redacted stated he knew as he asked her questions about herself and high school. He was aware she attended and is still attending Redacted. The interview was concluded. I suggested Redacted inform her parents of what occurred at the Epstein house. Redacted stated she would tell her father as he was unaware this had occurred. I left my business card for any questions they may have. We left the area and returned to the police station. The tape was placed into evidence. Investigation continues. Narrative number 22. Reported by Ricari Joseph. Entered by Altamaro Nikki A. 11/17/05. On November 15, 2005, Officer Munyan and I responded to the Palm Beach Gardens Mall food court section to meet with Redacted. At approximately 5:10 p.m., Redacted arrived and met with us at the food court. Redacted provided a sworn taped statement in which she stated she had been at the Epstein house over 50 times. She began going to Epstein's house when she turned 18 years old. Redacted was asked if she knew of the ongoing investigation. Redacted stated she was aware there was an investigation, as she had been told by other girls that were interviewed. Additionally, she has had several telephone conversations with Epstein's assistants as to what had been going on during the investigation. I asked Redacted how she was introduced to Epstein. Redacted stated she did not want to disclose who brought her to the house, but she would respond to any other questions. When I asked her what happened at the house, Redacted stated, everything happened. And once again, I will need to skip past this bit. Does corroborate with the previous statements. I cannot talk about this on YouTube. You're going to have to trust me again. I asked her how much she was paid each time she went to Epstein's residence. Redacted stated she got paid $300 every time she went to the house. She was told to bring other girls to him to provide massages. Redacted declined, stating that she does what she does and did not want to introduce anyone else to do what she does. Redacted stated she had never received any formal training in providing massages. I showed Redacted a photo lineup in which Nadia Marcinkova was placed in position 6. She reviewed the 6 photographs and immediately identified Nadia Marcinkova as the person with whom she had intercourse. Additionally, it was the same person she watched have intercourse with Epstein. She signed the photo lineup under Nadia Marcinkova's photo as the person she identified. We then left the mall and returned to the police station. The photo lineup and tape were placed into evidence. Investigation continues. Narrative number 23. Reported by Ricari Joseph, 11/29/05. Entered by Altamaro Nikki A. 12/01/05. On November 17, 2005, I received a phone message from Ati Guy Fronstin, who advised to call his cellular phone reference his client Jeffery Epstein. I telephoned his cell phone and left a message for him to return my call. I did not receive a call back on Thursday, November 17, 2005. On Friday, November 18, 2005, I retrieved another voicemail from my work phone from Mr. Fronstin advising he would not produce his client Jeffery Epstein for any statement. Fronstin stated he had spoken with ASA Lana Belolovic and expressed Mr. Epstein has a passion for massages. I called ASA Lana Belolovic and confirmed that Fronstin had telephoned her reference this case. Although nothing was discussed, Mr. Fronstin did advise her that Epstein is very passionate about massages. I also spoke with ASA Delia Weiss, reference the previous employees, Juan and Maria Alessi. She advised that they had been served through a subpoena process server. They were both scheduled to appear on Monday, November 21st, 2005 at 12 p.m. On November 21st, 2005, I met with ASA Weiss, attorney Donnie Morrill, and Juan and Maria Alessi at the State Attorney Office. ASA Weiss had requested a court reporter to be present to take the statement of the Alessi S. I spoke with Maria Alessi in the presence of her attorney, Donnie Morrill. She advised she had worked for Epstein for 8 years, from the period of 1994 through 2002. She advised she had never had any direct conversations with him. This stated it was her husband who spoke directly with Epstein. Her work consisted of doing house cleaning, shopping, and other preparations when Epstein would arrive in town. Alessi stated the preparations consisted of preparing the house and bathrooms for his arrival. She advised she did view several masseuses that arrived at the house. She advised that 2 or 3 girls would come during the day and provide the massages. The girls that arrived looked young in age. Mrs. Alessi did not know any of the girls personally, and what was different. She was told that when Epstein was in residence, he did not want to encounter the Alessis during his stay in Palm Beach. I then spoke with Mr. Alessi in the presence of his attorney, Donnie Morrill. Mr. Alessi stated that he was employed for 11 years with Mr. Epstein. He originally was hired as a part-time employee and then moved up into a full-time position. His duties included everything. Alessi stated he was the house manager, driver, and house maintenance person. It was his responsibility to prepare the house for Epstein's arrival. When asked about cooks or assistants, Alessi stated they travelled with Epstein on his private plane. He remembered dealing with his girlfriend, Ms. Maxwell, originally, and then dealt with Epstein directly. I asked Mr. Alessi about massages that occurred within the home. Mr. Alessi stated Mr. Epstein had up to 3 massages a day. Each masseuse that visited the house was different. Alessi stated that towards the end of his employment, the masseuses were younger and younger. When asked how young, Mr. Alessi stated they appeared to be 16 or 17 years of age at the most. The massages would occur in Epstein's bedroom or bathroom. There were times he recalled that he would set up the massage tables either in Epstein's bedroom or in his bathroom. I asked if there were things going on other than a massage. Alessi stated that there were times towards the end of his employment that he would have to wash off a massager/vibrator and a long rubber penis, which were in the sink after the massage. Additionally, he stated the bed would almost always have to be made after the massage. Alessi was never privy to what went on during the massages. He was asked if he remembered any names of the girls that massaged Epstein. He tried to remember and was unable to provide any exact names of any girls. Alessi was asked about any contact with anyone from the Epstein organization. Alessi said he did speak with Mr. Epstein shortly after my initial contact with him to find out what was going on. Alessi also stated that approximately on November 11, 2005, he was contacted by a private investigator from the law offices of Roy Black. The investigator had called him to meet with him to ascertain what he was going to tell the police. Alessi stated they met at the Carrabba's restaurant in Boynton Beach and discussed the same questions I was asking him. I informed Mr. Alessi and Mr. Morrill that as this is an ongoing investigation, that anything we discuss should be confidential. They both acknowledged the fact that the information would be kept confidential. It should be noted that a court reporter was present during the interviews and would be providing a copy of the statements to me when they became available. On November 21, 2005, I received a voicemail from Mr. Fronstin, who advised he would not be making Mr. Epstein available for any statements. He did have some words that he wanted to relay on behalf of Mr. Epstein. I telephoned his office and left a message for him to return my call. On November 29, 2005, I received a call back from Mr. Fronstein, who left a voicemail after hours on November 28, 2005, advising he would return my call during normal business hours to speak with me, reference the case on November 29, 2005. Narrative number 24. Reported by Ricari Joseph. 11/29/05. Entered by Altomaro Nikki A. 12/01/05. On November 29, 2005, at approximately 2:30 p.m., I received a telephone call on the department-issued cell phone. Mr. Fronstein stated he was calling to relay information that Mr. Epstein wished he could relay. Mr. Fronstein stated that he would not allow Mr. Epstein to speak with me at this time. He further stated that Mr. Epstein is very passionate about massages. He continued that Mr. Epstein had allegedly donated over $100,000 to the Ballet of Florida for massages. The massages are therapeutic and spiritually sound for him. That is why he has had many massages. Mr. Fronstein stated he appreciated the way the investigation has not been leaked out into the media. I explained to Mr. Fronstein that it is as important to protect the innocent if the allegations are not substantiated. Mr. Fronstein was told of the allegations that the private investigators assigned to the case had been portraying themselves as police officers. Additionally, I explained that my cell phone had been called by the private investigators. Mr. Fronstein advised he was not aware of that and advised they were under the direction of attorney Roy Black in Miami. Mr. Fronstein further stated Epstein had originally called Mr. Dershowitz in Boston, who recommended Roy Black in Miami, who asked Mr. Fronstein to assist. I informed him that if and when any charges would be presented, I would notify him. The call was then terminated. Investigation continues. Narrative number 25. Reported by Ricari Joseph. Entered by Altomaro Nikki A. Date 12/16/05. A review of the telephone message books, which were obtained during the search warrant, was conducted in which various messages from different dates were made to Jeffrey Epstein. The telephone message books have a duplicate copy, carbon copy, which once a phone message is written into the book, the top copy is then torn on the perforated edge and the carbon copy is left in the book. First names of girls, dates and telephone numbers were on the copy of the messages. I recognized various numbers and names of girls that had already been interviewed. The body of the messages was time of the day that they called for confirmation of work. Other names and telephone numbers were located in which the body of the messages were "I have girls for him" or "I have 2 girls for him." These messages were taken by Sarah for Jeffrey Epstein. Based on the context of the body of the messages, I requested subpoenas for subscriber information on the telephone numbers and the time frame involved. Copies of the messages were made for evidentiary purposes. I obtained redacted yearbooks for 2005, 2004, and 2003. I first reviewed the 2005 yearbook and located most of the girls I had spoken with. Additionally, I located redacted. Based on the corrected name spelling, I was able to locate her to her residence in redacted. On December 8, 2005, Detective Caristo and I responded to redacted in redacted. I located redacted at her home. She advised she is attending redacted and is participating in the early release program so she can maintain her part-time job. As she is still a minor, I left my business card to have her mother return my call to request an interview with her daughter. We then left the area. I also had previously researched the telephone number for redacted and telephone number redacted. A subpoena had been issued for the information on redacted. The telephone number was registered to redacted of redacted. A query of redacted revealed that she is the daughter of redacted and is currently residing at redacted. Detective Caristo and I attempted contact with redacted with negative results. I left my business card on her front door requesting she return my call. We then responded to redacted. I also attempted contact with Mr. Redacted with negative results. I left my business card for him to return my call. On December 9, 2005, I received a telephone call from redacted mother, who was made aware of the ongoing investigation in Palm Beach. Redacted advised she was told of everything that occurred at Epstein's house involving Epstein and his staff. She advised she would allow me to question her daughter about what occurred and would cooperate with the investigation. Redacted provided me with redacted cellular telephone number to schedule an appointment for an official interview. I telephoned her cellular telephone and made a tentative appointment for Monday, December 12, 2005. I then received a telephone call from Redacted, father of Redacted, who stated he found the business card on his door. I explained that I was conducting an investigation and needed to speak with Redacted, as she may have information that could assist in the investigation. Mr. Redacted stated that his daughter no longer resides with him and has her own trailer in another trailer park. He advised he would tell her to call me. On December 12, 2005, due to a conflict with schedules, arrangements were made to meet with Redacted on Tuesday, December 13, 2005 at 5 p.m. On December 13, 2005, Detective Dawson and I travelled to Redacted and met with Redacted. During a sworn tape statement, Redacted stated that when she was 16 years old, she was taken to Epstein's house to provide a massage for money. Redacted stated it was before Christmas last year when Redacted approached her and asked if she needed to make money for Christmas. Redacted stated she did and agreed to provide a massage for money. Redacted made arrangements to take Redacted to the house and drove Redacted to the house to work. Redacted stated she could not remember the street name, but would be able to drive to the street. They drove to the last house on the street and pulled in the last house on the left side. They walked up the driveway and entered through a side gate which led to a kitchen door. They knocked on the door and were encountered by an employee who Redacted described as a Spanish-looking lady. They informed her that they were expected. They were then encountered by a white female with long blonde hair. Redacted was unable to remember the name of the white female with blonde hair, but knew she was Epstein's assistant. She was led upstairs by the white female, who explained that there would be lotions out already and Epstein would choose the lotion he wanted her to use. She was led through a spiral staircase which led to a master bedroom and bathroom. The massage table was already set up in the bathroom. Redacted described the bathroom as a large, spacious bathroom with a steam room and shower beside it with a sink to the right. Redacted was introduced to Jeff, who was on the phone when she entered. Jeff was wearing a white towel and lay on his stomach so that Redacted may massage his feet and calves. Redacted started the massage with the massage oil Jeff chose and rubbed his feet and calves. Jeff got off the phone and requested she massage his back as well. Redacted began rubbing his back and got to the small of his back. It is at this point that, once again, I'm going to skip past the explicit details that follow. Continuing from page 362, about 4/5 of the way down. Jeff told her there was $200 for her on the dresser within the master bedroom. Jeff also told her that there was an additional $100 that was to be given to Redacted for bringing her there to massage him. Jeff told her to leave her telephone number with his assistant as he wanted to see her again. Jeff stated his assistant would contact her to work again soon. I asked her if she ever received any formal massage training, to which Redacted stated she did not. Redacted stated it was the only time she ever went to work for Jeff, and knew what happened to her was wrong. She states she no longer speaks to Redacted because she was upset that Redacted took her there. She further stated that she had never been contacted for any additional work. The interview was terminated and we left the area. Investigation continues. Narrative number 26. Reported by Dix Allen C. 12/18/05. Entered by Altamaro Nikki A. 12/19/05. On 1/02/005 at approximately 09:30 hours, I assisted with the execution of a search warrant at 358 El Brillo Avenue, Palm Beach. Initially, I was assigned to enter the residence and conduct a sweep of the premises for safety purposes. I then accompanied CSEU Tech Pavlik
while she photographed the exterior of the house. Once this was complete, I was assigned to search certain areas of the house, with Detective Dawson as part of the search warrant. We began in the garage, searching 3 Mercedes-Benz vehicles, a Harley-Davidson motorcycle, and adjacent closets in the garage. Nothing of evidentiary value was located. We then searched 2 closets off the kitchen area on the east side. These can best be described as pantry or storage closets. Nothing of evidentiary value was obtained. A small office with adjoining bath was then searched. In the bath area, I located a phone message book with recent messages. This item was seized as evidence. Please note this bath and shower area are not used as designed, but are storage areas containing a variety of items, to include a gun safe in the shower and assorted household items. We then searched a bath area and closet at the base of the main stairs in the foyer. Inside the closet, 2 massage tables were located, as well as partial nude female photographs. These items were later seized as evidence. Nothing of evidentiary value was noted in the bathroom. We then searched 2 bedrooms upstairs on the east side of the residence. Located in the bathroom of the south bedroom was penis-shaped soap. Located in the bedroom of the northern bedroom was penis and vagina-shaped soap, as well as an adult sex toy. These items were seized as evidence. We then searched the pool cabana located in the southwest corner of the property. Several photographs of nude females were seized as evidence. I was then assigned to stand by with a person I believe was Douglas Chalette. Mr. Chalette was in the residence at the beginning of the search warrant. He was present during the warrant service and subsequent search. I stood by with him until the search was completed, and I departed the residence. I had no conversation with him regarding the reason for our presence. Regarding seized evidence, all items were photographed in place and then collected by CSEU personnel. This concludes my involvement in this case. Narrative number 27. Reported by Crowell, Curtis D. 12/21/05. Entered by Altomaro, Nikki A. 12/21/05. On Thursday, October 20th, 2005, at approximately 0936 hours, I insisted in the execution of a search warrant located at 358 El Brillo Way, Palm Beach, Florida, residence of Jeffery Epstein. I was instructed by Case Agent Detective Joseph Ricari to secure all computer and media-related material from the residence. Upon my arrival, I was directed by Detective Ricari to a room designated as the kitchen staff office. I observed a silver in color CPU with the left side cover removed, exposing the CPU's hardware sitting on the floor next to a glass-type desk. The CPU had no discernible identifiers or features indicating a make or model. This CPU was powered off with the power cord not plugged in. The keyboard and mouse were atop the CPU. It should be noted that the CPU was not connected to a monitor, printer, or other media device. On the back panel of the CPU, observed an AV card with RCA jacks attached. This type of hardware would allow audio and video to be downloaded onto the CPU's hard disk. The ends of the RCA jacks were unattached at the time of the search, and no external camera was located within this room. The CPU was located on the right side of a desk that held a flat panel LCD screen. The desk also held another keyboard and mouse, indicative of a second computer. However, no other computer was found. It appeared as though a second computer had been recently removed, as the cable's ends from the monitor, keyboard and mouse were in the same area. A further search of the room revealed no media storage devices, i.e. CDs, floppy disks, zip drives, etc. This type of media is commonly stored in an area where computers are placed, yet no media was found. After completing a search of this room, I secured the CPU and turned all items over to the evidence custodian for future forensic analysis via a property receipt. I was then directed by Detective Ricari to a room designated as the garden room, where I observed a wooden desk facing west. The desk held a flat-screen LCD monitor, keyboard, mouse, media card reader, and printer. However, no CPU was located. All of the cables were removed from an area where a computer had once been. A search of the desk area revealed no signs of any immediate devices. Detective Ricari directed me to a third location, designated as the Cabana Room, which is detached from the residence and located just south of the pool. In the southeast corner of the room, I observed an office-type setting, with an L-shaped desk holding a flat-screen LCD monitor, keyboard, mouse and printer. However, no CPU was located. All of the cables were removed from an area where a computer had once been. A search of the desk area revealed no signs of any immediate devices. Detective Ricari directed me to a second detached structure located on the southeast corner of the property. This area of this structure was assigned with single letters to identify a particular part of the room. In the office area, designated as Room B, I observed a powered-on Dell Dimension 2350 attached to an LCD flat-panel monitor. The screen displayed an open Microsoft Internet Explorer browser with URL address of http://home.bellsouth.net. I observed no other active windows in the Start panel window and photograph screen. The power cord was removed from the back of the Dell CPU and I disconnected the cable modem to prevent remote access. At that time, the Dell CPU, marked with serial number 6WTVN21, was secured and turned over the evidence custodian for future forensic analysis via property receipt. I also located several media-related items within Room B, which were recorded onto a property receipt and turned over the evidence custodians. I then responded to a bedroom designated as Room F, where I observed a white in color CPU marked Premio. The Premio CPU was in a computer desk which held a white CRT monitor, both of which were powered on. The CRT monitor displayed a message from Norton Antivirus Software warning of an expired subscription. I observed no other active windows in the Start panel window and photograph screen. I removed the power cable from the back of the Premio CPU and shut down all other media. The Premio CPU, marked with serial number 20000910078, was secured and turned over the evidence custodian for future forensic analysis via property receipt. I also located several media-related items within Room F, which were recorded onto a property receipt and turned over the evidence custodians. This concluded my participation in the search of the residence. Narrative number 28. Reported by Ricari Joseph. Date 12/21/05. Entered by Altamaro Nikie. Date 12/21/05. On December 20th, 2005, I contacted ASA Delia Weiss in an attempt to subpoena the Epstein former houseman, Alfredo Rodriguez. Rodriguez, who resides in Miami, had eluded the process servers previously and was not served the investigative subpoena. A telephone message was left as she is not available during the week of 12th of the 19th, 2005. I made contact with State Attorney, Investigator Theresa Wyatt, and requested the same via telephone message. I then researched the victim's redacted cellular telephone subpoena data, which had been received from a previous subpoena request. I analysed the records which depict several calls from Haley Robson. The telephone calls start on February 6, 2005 at 12:49 p.m, the same day which the victim and the victim's father stated the incident occurred at Epstein's house. The first incoming call was from Robson's residence at 561-333-0180. The second incoming call from Robson's cellular phone, 561-308-0282, occurred at 1:02 p.m. The call durations were 1 minute or less. The time frame was within 13 minutes apart. It should be noted that Robson's residence was in close proximity to the victim's. The next call occurred at 5:50 p.m. when the victim telephoned Robson's residence. Several calls were made after the above-mentioned calls, both incoming and outgoing to Robson. Further analysis showed no telephone calls to either Robson's cellular telephone or Robson's residence were registered prior to February 6, 2005. Additionally, I also conducted an analysis on the telephone calls from 305 710 5165. The subscriber information confirmed that the address is registered to Paul A. Lavery from Hialeah, Florida. The address was cross-referenced to the office of Kirali and Riley Private Investigators. I researched the webpage www.rileykirali.com, which also showed various cases in which they assisted. I also located another website under www.coralspringsparkleandrotary.org, in which Mr. Riley attended a Miami Rotary meeting and confirmed Atty. Roy Black is among his clientele. The telephone calls received Lavery had telephone contact with Redacted and Redacted, either just after I attempted to interview them or just prior. A background was conducted on Lavery, which revealed he holds a current private investigator license. A criminal arrest record revealed he had been previously arrested for possession of cocaine and solicitation of prostitution. I also researched the girls using www.myspace.com. This website is a new social networking service that allows members to create unique personal profiles online in order to find and communicate with old and new friends. The site allows one to establish your own myspace.com page and decorate the page any way one wishes. I found the following people have MySpace sites: Haley Robson, Redacted, several times, and Redacted. I received a singular wireless packet which contained a CD which contained the results of the subpoena request for verbatim calls on Redacted. An analysis will be conducted in the near future on the phone numbers called. Investigation continues. Narrative number 29. Reported by Ricari Joseph, 12/27/05. Entered by Altomaro Nikki A, 12/29/05. Upon doing research on the message books recovered in the search warrant, I located the identity of Redacted. The telephone number Redacted was registered to Redacted. She currently is 17 years old and is attending the Redacted. I responded to Redacted, also known as the Redacted. I located Redacted inside the foundation and informed her that I was investigating a case against Jeffery Epstein and knew she had been at the house. Redacted started to cry and advised she had put that part of her life behind her. I explained that although she is 17 years old, I needed to inform her parents that she would be interviewed. She provided her home telephone number. I attempted contact and left voicemail messages at the house to speak with her parents. Detective Caristo and I then located Redacted at her residence, located at Redacted in Redacted. I attempted to interview her about Jeffery Epstein. She advised she is so in love with Jeff Epstein and would do anything for him. She further explained that she would not speak with us about him either negative or positive. She asked us to leave her property. I informed her that although she did not wish to speak with us, I had sufficient information at this point in this investigation to know she was at Epstein's house and provided girls to Epstein to work. I also explained that prior to our arrival at her residence, I had telephone contact with her father, Redacted, who was told she would be interviewed. Redacted is currently 17 years old, and as a juvenile, parental notification would be required. We then left the area and returned to the police station. While at the police station, I left another telephone message for Redacted's parents. I began an analysis of Sarah Kellen's cellular telephone. The telephone number is 917-855-3363, is assigned to Sarah Kellen, and the financially responsible party is Jeffery Epstein of 457 Madison Avenue, in New York City, New York. The time frame which was subpoenaed was September 2005 through October 2005. There were 87 pages of calls made either to the cell phone or from the cell phone. The local 561 numbers were analysed. A spreadsheet was prepared and placed into the attachment file of who was called. The unknown numbers were researched using phonefinder.com and subpoenas were requested to determine subscriber information. This was done to identify additional victims or witnesses. The analysis revealed that Kellen had called the victim/witnesses frequently,
when Epstein was in the town of Palm Beach to work. This confirms what the girls interviewed had previously stated. Keller would notify them when Epstein was in town and their willingness to work. The CD was placed into evidence. Investigation continues. Narrative number 30. Reported by Ricari Joseph. 10306. Entered by Altamaro Nikki A. 10306. On December 29, 2005, I received a facsimile from National Compliance Center from Singular Wireless for telephone number 561-308-0282. This was the telephone number for Haley Robson during the time frame when the victim, redacted, was brought to the Epstein house to work. An analysis of the phone records of all incoming and outgoing calls show that on February 6, 2005, the day the victim, redacted, was brought to the house, Robson first called Sarah Kellen, Epstein's assistant, at 917-855-3363 at 12:50 p.m. EST. The next call was made to Epstein's house in Palm Beach at 12:52 p.m. EST. The following call was made to the victim, redacted, at 1:01 p.m. EST and at 1:02 p.m. EST. This confirms the information provided by the victim and victim's father. I photocopied the records and enlarged the page 8 of 10 to show the calls made by Robson on February 6, 2005. To this date, I have not heard from Redacted's parents. I will attempt to establish contact with them during the evening hours. I received a package from Atty Guy Frontstein, which was hand-delivered at the police station. Within the package was a letter from Alan Dershowitz and 2 www.myspace.com profiles. The profiles were that of Redacted and Redacted. MySpace.com is a social networking service that allows members to create unique personal profiles online in order to find and communicate with old and new friends. This package was in response to a previous meeting in which Mr. Dershowitz called to assist in the investigation in providing any additional witnesses such as house employees who have been reluctant to speak with law enforcement. I reviewed the profiles Mr. Dershowitz enclosed. Redacted, who designed her blog to be redacted, still attends Redacted, sends and receives messages from friends which contain some profanity. Upon reviewing her friends' comments section from MySpace, most of her good friends sent messages to establish contact and invite her to go out. I then reviewed Redacted weblog, which was provided by Mr. Dershowitz. Miss Redacted designed her blog to be redacted. Her blog states that her interests include music, theatre, and weed, marijuana. I reviewed her packet in which Redacted declares her love for her live-in boyfriend. She also describes using marijuana with her boyfriend, Redacted. The letter Mr. Dershowitz sent advised he was looking into the allegation that one of the private investigators used by the private attorneys of Epstein attempted to impersonate or state that they were police officers from Palm Beach. Mr. Dershowitz advised that the investigators used to interview Redacted had quite a distinct speech impediment, and did not claim to be, nor did they impersonate themselves as a police officer. This package was sent to both ASA Lana Bololovic and ASA Delia Weiss at the State Attorney's Office. I made telephone contact with ASA Weiss to confirm she received the package and request an interview with Sarah Kellen, Nadia Marcinkova, and Janice Banasiak. She advised she would assist in attempting to contact Mr. Dershowitz. On January 3, 2006, I received a telephone call from ASA Weiss, who informed me that she made telephone contact with Mr. Dershowitz. She had requested the employees be available the week of January 3, 2006. Mr. Dershowitz informed her that the assistants are out of the country and will require additional time to locate them and make them available. Investigation continues. Narrative number 31. Reported by Mino Laurie S. 10306. Entered by Altamaro Nikki A. 10306. On Thursday, 03/31/05, I started conducting surveillance at 358 El Brillo. At this point, I observed at 11:55 hours a tan Altima bearing FL tag A303AN in roadway black SL bearing FL tag V55 RFW in drive. Tan Honda Civic bearing FL tag X98APM in roadway. Black Chevy Suburban in driveway and a black Caddy Escalade in driveway. At 13:25 hours, I observed tan Honda Civic X98APM in roadway. Black Chevy Suburban in driveway, black Caddy Escalade in drive, and a white Kia car bearing FL tag D651BQ. At 16:15 hours, I observed a tan Honda Civic X98APM in roadway. Black Chevy Suburban in drive, black Caddy Escalade in driveway, and a white Kia car D651BQ in roadway. On Friday 04/01/05, I continued surveillance at 358 El Brillo. At 11:30 hours, I observed a tan Honda Civic bearing FL tag X98APM in roadway, black Caddy Escalade in driveway, and a tan unknown make/model bearing FL tag A303AN in roadway. At 12:27 hours, I observed a tan Honda Civic X98APM in roadway, black Caddy Escalade in driveway, and a black Chevy SUV located behind the Escalade. At 13:45 hours, I observed a tan Honda Civic X98APM in roadway and a black Chevy SUV in driveway. At 13:58 hours, I observed a tan Honda Civic X98APM in roadway, black Chevy SUV in driveway, black Caddy Escalade in driveway, and a dark unknown model/make car parked in garage. On Saturday, 04/02/05, I continued surveillance at 358 El Brillo. At 07:13 hours, I observed a red Explorer bearing FL tag J98JEI in roadway, and a black Caddy Escalade in driveway. At 08:14 hours, I observed a red Explorer J98JEI in roadway, black Caddy Escalade in driveway, and a tan Honda Civic X98APM. At 09:52 hours, I observed a red Explorer J98JEI in roadway, black Caddy Escalade in driveway, tan Honda Civic X98APM in roadway, and also a grey unknown make/model with a BM in trunk, retrieving landscaping tools. At 11:55 hours, I observed a grey Camaro bearing FL tag redacted, parking in the roadway in front of 358 El Brillo. AWF, blonde hair, teens to early 20s, thin and tall, wearing a white tank top and short blue jean shorts, exited the vehicle and walked to the rear of the house. I also observed a red Explorer J98JEI in roadway, tan Honda Civic X98APM in roadway, and a black Caddy Escalade in driveway. At 13:10 hours, I observed a red Explorer WF driver leaving the area, tan subcompact on roadway, and a red neon bearing FL tag redacted. Then observed 3 WFs, approximately 16 to 18 years of age, jogging. All 3 females ran into the driveway. There were 2 with blonde hair and 1 brown hair. On Sunday, 04/03/05, I continued surveillance at 358 El Brillo. At 07:19 hours, I observed a tan Honda Civic X98APM in roadway and a black Caddy Escalade. At 0:34 hours, I observed a tan Honda Civic X98APM in roadway and a black Caddy Escalade in driveway. At 10:57 hours, I observed only the tan Honda Civic X98APM. On Tuesday, 04/05/05, I continued surveillance at 358 El Brillo. At 10:52 hours, I observed a red Explorer J98JEI in roadway, a green Explorer bearing FL tag F91KAK in roadway, a grey Altima bearing FL tag A303AN in roadway, white Ford truck H58LRA in roadway, black Mercedes in driveway being washed by a BM, and an unknown dark car parked in the garage. At 10:59 hours, a blue Chevy Suburban drove to the house of 358 El Brillo and parked in the driveway. At 11:19 hours, I observed the white Ford truck H58LRA leave the area, and the drive was the Pullman. At 11:26 hours, I observed a grey unknown make/model car park in roadway. WM got out of the car and walked to a house on the south side of El Brillo. At 14:06 hours, I observed a red Explorer parked on roadway and a large white box truck parked behind the surveillance Suburban.
Narrative number 32. Reported by Bates Michael J. 1st0306. Entered by Altomaro Nikki A. 1st0306. On 03/31/05 at approximately 1500 hours, while conducting surveillance at 358 Old Brillo, I observed a black Cadillac Escalade, unknown tag, a black Chevrolet Suburban, unknown tag, a black Mercedes S600 FL tag, U90BQL, parked in the east driveway next to the three-car garage. There was a tan Honda Civic FL tag X98APM, parked on the street in front of the residence. At approximately 1700 hours, I observed the black Suburban, black Escalade, black Mercedes, and tan Honda Civic parked in the same place. At 1750 hours, there was no change in vehicles. At 1840 hours, I observed the black Escalade, black Suburban, and black Mercedes, along with a silver Hyundai Accent, FL tag A136AN, all parked in the east driveway, and a red Ford Explorer, FL tag J98JEI, parked on the street in front of the residence. At 2000 hours... No, that's not it. At 2000 hours, I observed the black Escalade, black Suburban parked in the east driveway, and the red Explorer and tan Civic parked on the street. On Friday, 04/01/05, at approximately 1700 hours, I observed the black Escalade and black Suburban parked in the east driveway and the tan Honda Civic parked on the street in front of the residence. At 1820 hours, I observed the Suburban and Civic in the same place and a gold Chevrolet Camaro FL tag redacted parked on the street in front of the residence. At 2250, there was no change. At 2330, I observed the black Escalade parked in the driveway and the red Explorer parked on the street in front of the residence. On Saturday, 04/02/05, at approximately 1700 hours, I observed a black Escalade, unknown tag, parked in the driveway and a tan Honda Civic FL tag X98AMP parked in the street in front of the residence. At 1805 hours, the Escalade and Civic were in the same position and the black Mercedes FL tag 090BQL was also parked in the east driveway. At 1920 hours, the Escalade and Civic were the only vehicles and both were in the same position. At 2030 hours and 2145 hours, there were no vehicles observed. At 2115 hours, I observed a black Mercedes, four-door parked in the east driveway FL tag G14CT. At 2300 hours, 2350 hours, and 0045 hours, the black Mercedes was the only vehicle observed. Narrative number 33. Reported by Ricari Joseph. 1st/05/06. Entered by Altomaro Nikki A. 1st/05/06. I made contact with Mr. Redacted, father of Redacted, who was told that I wished to interview his daughter. Mr. Redacted stated he was aware and had spoken with his daughter about the incident. He stated that his daughter had previously told him that she was hired to model lingerie at a Palm Beach mansion. Mr. Redacted stated he knew nothing else about what she did when she went to work. Mr. Redacted advised he would cooperate with the investigation and make his daughter available for interviews. I asked if she was available for an interview. Redacted stated she was not at home at the moment. I informed him I would make contact with her at a later time. Mr. Redacted expressed his interest in the resolution in this matter, as he stated this information has affected his daughter emotionally. On January 4, 2005, I acquired the subpoenas from the State Attorney's Office for Singular Wireless, Metro, PCS, Verizon, Bell South Telecommunications, and Sprint for the unknown telephone numbers from Sarah Kellen's cellular telephone. The subpoenas were sent to the respective telephone carriers for subscriber information. I received a telephone call from State Attorney's Office, who informed me that the former houseman for Jeffery Epstein, Alfredo Rodriguez, was present at the State Attorney's Office for an interview. Rodriguez was issued an investigative subpoena for an interview on the ongoings at Epstein's house during his employ.
I responded to the State Attorney's office and encountered Mr. Rodriguez waiting in the lobby. I brought Mr. Rodriguez to the interview room. During a sworn taped statement, Mr. Rodriguez stated he was employed by Jeffery Epstein for approximately 6 months. He was referred by associates and his employment lasted the months of November. He was referred by associates and his employment lasted the months of November 2004 through May 2005. His responsibilities as house manager included being the butler, chauffeur, chef, houseman, run errands for Mr. Epstein, and provide for Epstein's guests. Rodriguez advised he had very limited contact with Mr. Epstein. If Rodriguez needed to relay a message to Mr. Epstein, he would have to notify Epstein's secretary, Leslie, in New York City, who would then notify Epstein's personal assistant, Sarah, who would relay the message to Epstein. Rodriguez stated Epstein did not want to see or hear the staff when he was in residence. I asked Rodriguez if Epstein received many guests during his stay in Palm Beach. Rodriguez advised he had many guests. I asked specifically about masseuses coming to the house. Rodriguez stated he would have 2 massages a day. Epstein would have 1 massage in the morning and 1 massage in the afternoon every day he was in residence. Rodriguez stated he would be informed to expect someone and make them comfortable until either Sarah or Epstein would meet with them. Rodriguez stated once the masseuses would arrive, he would allow them entry into the kitchen area and offer them something to drink or eat. They would then be encountered by either Sarah or Epstein. They would be taken upstairs to provide the massage. I asked Rodriguez if any of the masseuses appeared young in age. He advised he didn't ask their ages but felt they were very young. Rodriguez stated they ate like his own daughter who is in high school. Rodriguez stated they would eat tons of cereal and drink milk all the time. Rodriguez stated the girls that would come appeared to be too young to be masseuses. He stated one time under Epstein's direction he delivered a dozen roses to Redacted for one of the girls that came to provide a massage. He knew the girls were still in high school and were of high school age. I asked Rodriguez about the massages. He felt there was a lot more going on than just massages. He would clean Mr. Epstein's bedroom after the alleged massages and would discover massager/vibrators and sex toys scattered on the floor. He also said he would wipe down the vibrators and sex toys and put them away in an armoire. He described the armoire as a small wood armoire which was on the wall close to Epstein's bed. Epstein ordered Rodriguez to go to the dollar, rent a car for the same girl he brought the roses to, so that she could drive herself to Epstein's house without incident. Rodriguez said the girl always needed rides to and from the house. Rodriguez referred himself as a human ATM machine and was ordered by Epstein to maintain a minimum balance of $2,000 on him at all times. When a girl would come by the house and Mr. Epstein was either not in residence or was not at home at the time, Rodriguez was to provide the girl masseuse several $100s for their time and to notify Epstein the amount they were given. Epstein also ordered Rodriguez to purchase several gifts and provide them as tips to the girls. I asked what kind of gifts. Rodriguez stated he purchased iPods, jewelry, anything the girls would want. Rodriguez stated the amount of girls that came to the house was approximately 15. Each of the girls knew each other and all seemed to know at Redacted who Mr. Epstein was. When asked to identify these girls, Rodriguez stated he could not at the moment, but he knew he wrote their names down on a journal he kept during his employ with Mr. Epstein. He kept a journal in the event he needed to explain either to Mr. Epstein or his assistants what was done at the house, or who visited the house, as he stated he was in charge of Mr. Epstein's personal security while in Palm Beach. I informed him I would need to review this journal, to which he stated he would research the book and contact me to provide the book. The interview was concluded and left the area. I returned back to the police station when the microcassette was placed into evidence. At approximately 7:20 p.m, I was notified Rodriguez located the journal and would call me on January 5, 2005 to provide the journal. Investigation continues. Narrative number 34. Reported by Ricari Joseph.
First 0906. Entered by Altamaro, Nikki A. First 1006. On January 5, 2006, I attempted to meet with Alfredo Rodriguez to recover the folder or journal in which he kept the notes that were given to him during his employ with Mr. Jeffery Epstein. He kept this folder to justify what he did during his employ should the need arise to justify what occurred with the monies he had to keep, or any questions as to the petty cash he withdrew from the household account from the bank. At approximately 10 p.m., I attempted contact with Mr. Rodriguez and discovered he was assisting his wife at her place of employment and would not be able to meet with me. Mr. Rodriguez stated he would meet with me on January 6, 2006 in Broward County in the morning hours. On January 6, 2006, at approximately 9 a.m., I received a telephone call from Mr. Rodriguez who advised he had the file in hand and would be traveling northbound to meet with me in Broward County. At 10:50 a.m., I met with Alfredo Rodriguez at the parking lot of Bank of America in Boca Raton on Yamato Road and Military Trail, known as the Polo Center. Rodriguez produced a green folder which contained documents, a note with Mr. Epstein's stationery with direction to deliver a bucket of roses to Redacted, after Redacted's high school drama performance. Also in that same note was direction to rent a car for Redacted, and direction to extend the rental contract. I returned to the Palm Beach police station and placed the folder into evidence. I received a fax from Verizon from the subpoena request sent on 010406 for telephone number 561-302-1844. The phone number is registered to Dr. Perry Bard from West Palm Beach. Dr. Bard is a chiropractor and has an office located 4275 Okeechobee Boulevard in West Palm Beach. The cellular number is Dr. Bard's personal cellular number. On January 9, 2006, Detective Caristo and I traveled to 622 Holly Drive in Palm Beach Gardens in an attempt to locate Johanna Sjoberg, who had been previously seen on the property and identified through her Florida driver's license and Florida license plate. A business card was left for her to return my call. We then travelled to the Redacted and located Redacted. Redacted agreed to speak with us and, in a private room within the school, provided us a taped statement. During the statement, Redacted advised that when she was 15 or 16 years of age, she was taken to Jeffrey Epstein's house by her associate, Redacted. Redacted stated this occurred late May 2004 or early June 2004. She was told she could model lingerie for money for a wealthy Palm Beacher. She remembered they travelled by yellow cab from their residence in West Palm Beach to Epstein's house. She remembered encountering Epstein at the front door during the evening hours. He introduced himself and brought them into the kitchen so that the chef could prepare something for them to eat. After having a meal, Redacted and Epstein brought Redacted upstairs to a master bedroom which had a large bathroom. She observed a large-style shower, sauna, and there was a large massage bed also in the bathroom. Epstein entered a room within the bathroom and came out wearing only a towel. Redacted said they would provide a massage on his feet. Redacted asked why they are doing this. Redacted told her this was part of the routine and told her to rub his legs and calves. Epstein had told Redacted to get comfortable. Redacted continued rubbing Epstein's calves and feet. At Epstein's direction, Redacted then left the room, leaving Redacted there by herself. Epstein told Redacted to get comfortable. At this point, I'm going to stop this explicit stuff because it goes into explicit graphic detail. Also, I'm sorry if I'm talking too quickly. I'm trying to be as clear as I can. I've been doing this for hours, so my apologies. She was paid $200 each time she went. Each time she went, she was reminded not to speak of what happened at the house and that she would be contacted again. She began to purposely miss the calls when either Sarah or Epstein would call her. She once brought a friend, Redacted, unknown last name, to work for Epstein. She was paid $200 for bringing Redacted. Redacted stated she no longer returned to work for Epstein.
She also stated that she wanted to notify the police of what happened at the house. Redacted stated she was scared of what could have happened to her or her family if she notified authorities. On January 10th, 2006, I received the results from the subpoena from Bell South Telecommunications for telephone number redacted. The number is assigned to Mr. Redacted. Redacted father in redacted. I also received the results from Western Union, which confirmed the money order sent to redacted from Jeffery Epstein in New York City. The wire was sent by Jeffery Epstein of 457 Madison Avenue in New York City on December 23, 2004 at 12:05 p.m. The amount of $222 was charged to Epstein's credit card so that redacted could receive $200 in redacted. The $22 was for processing and local fees to send the money via Western Union. A copy of the check presented to redacted was also attached to the receipt of the wire. This confirmed what redacted advised she received as a Christmas bonus from Epstein. Investigation continues. Narrative number 35. Reported by Recari Joseph. 1:10:06. Entered by Altamaro Nikki A. 1:10:06. I received and reviewed the singular wireless results from the subpoena requests for subscriber information for telephone numbers 561-818-8361, 561-389-6874, and 561-309-0079. The first number, 561-818-8361, is assigned to Janice Banasiak in care of Jeffery Epstein of 457 Madison Avenue in New York City. Banasiak is the current houseman/house manager for 358 El Brillo Way in Palm Beach, Florida, 33480. The second number, 561-389-6874, is assigned to Christiana Venero of 1685 61st Drive in West Palm Beach. Research conducted on Vereno revealed she is a licensed massage therapist with a Florida conditional/active license number MA39723. Venero had been previously arrested for battery/unwanted touching and DUI. Requests for copies of the reports involving the arrests were requested from the Palm Beach County Sheriff's Office. The last number, 561-309-0079, is assigned to Thomas Rofrano of 9850 Out A1A in Palm Beach Gardens. Research on Mr. Rofrano revealed that he is a Florida chiropractic physician. Vehicles that were previously documented on the property while surveillance was being conducted were researched. I determined a tan Chevrolet Camaro, bearing Florida license redacted, was seen on the property in which a young white female was seen entering the Epstein property. Research was conducted which revealed that the vehicle is registered to redacted of redacted. Mr. Redacted has two daughters, redacted and redacted. Redacted is currently residing in Connecticut and redacted is residing with her father in redacted. Research on redacted revealed she was recently involved in a traffic stop in Lake Clark Shores in May 19, 2005. A request to discover any information from the stop was requested. I spoke with ASA Delia Weiss, who informed me that Janice Banasiak will be available for an interview tomorrow at the State Attorney's Office in West Palm Beach at 1:30 p.m. I informed her that I will be at her office for the interview. Narrative number 36. Reported by Recari Joseph. Entered by Altamaro Nikki A. 1st 2306. On January 19, 2006, Detective Caristo and I met with Johanna Sjoberg at 622 Holly Drive in Palm Beach Gardens. Sjoberg was identified as a licensed massage therapist who had previously been seen on Epstein's property when physical surveillance was done. Sjoberg was told of the ongoing investigation, and I felt she may have information pertaining to the case. During a sworn taped statement, Sjoberg stated she met Epstein 3 years ago
when Ghislaine Maxwell approached her while she was attending Palm Beach Atlantic College to work around Epstein's house. Maxwell had told her that they needed some girls to work at the house to answer phones and run errands. Sjoberg accepted the job and began working at Epstein's house on El Brillo in Palm Beach. Sjoberg stated it was a part-time job during the time she went to Palm Beach Atlantic College. She continued going to Epstein's house and would be notified when Epstein would travel to Palm Beach. Sjoberg advised she would be notified by Maxwell, Epstein, or Sarah, his assistant, when he would travel to Palm Beach. Sjoberg stated she began providing massages to Epstein before she became a massage therapist. She continued giving massages not only to Epstein but to Nadia Marcinkova and Sarah, his assistant. Sjoberg was asked about what occurred during the massages. Sjoberg stated as she was 23 years old when she met Epstein, anything that happened was between two consenting adults. I explained to her that she was not in any trouble, however, as part of this investigation I needed to ask certain questions. Sjoberg stated that there were times that Epstein would ask her to perform during the massages. He would instruct her to rub his nipples as he masturbated himself. Sjoberg stated she felt grossed about the behaviour, but as she was getting paid, she just continued. Sjoberg also advised she would, on occasion, perform the massages naked. Epstein would on occasion utilise the vibrator/massager on her vagina area when she performed the massages. Sjoberg explained that Epstein never exposed himself to her as he maintained himself covered under the towel he would be wearing. When Epstein would masturbate, he would be covered. I asked if Sjoberg ever received any gifts or any gratitudes from Epstein. Sjoberg advised aside from being paid well, she advised Epstein took care of her tuition from Palm Beach Atlantic College. She received a rental car for a week when her scooter broke down. Additionally, she received other gifts from Epstein. Epstein also recommended her to another client who resides at Breakers Row in Palm Beach. The client she was referred to was Glenn, unknown last name, and his wife, who she provided a massage to. The statement was concluded and placed into evidence upon our return to the Palm Beach Police Department. While at the police station, I researched Florida tag redacted, which was also previously seen on the property when there was physical surveillance being done at the property. The vehicle is registered to redacted of redacted. Researching Mr. Redacted and the vehicle revealed that his daughter, Redacted, had been driving the vehicle and was cited for unlawful speed in Lake Clark Shores. The vehicle is a tan Chevrolet Camaro 2-door. I researched Redacted, date of birth, Redacted, resides at Redacted in Redacted. Redacted has a MySpace page called www.myspace.com/redacted. In her webpage shows various photos of Redacted photographed at a beach. An interview is forthcoming. A review of the video discs, which was extracted at the Palm Beach County Sheriff's Office Computer Crime Unit, revealed that only one hidden camera was functional at the time. Several images of Epstein working at his offices were seen. Additional footage of Sarah Cannon and Nadia Marcinkova was seen. There was other footage of females seen. The identity of the females is unknown at this time until such time as I meet with certain females to show the video footage to confirm if, in fact, it is them on the video. At this time it appears that Redacted and Haley Robson are seen sitting with Epstein beside his desk in the evening hours. Due to poor lighting, a direct confirmation cannot be made at this time. Investigation continues. Narrative number 37. Reported by Ricari Joseph, 1:30:06. Entered by Altamaro Nikki A, 1:30:06. On January 25, 2006, Detective Caristo and I responded to Redacted in Redacted and met with Redacted. Redacted stated last year, when she was 17 years of age, she met Jeffery Epstein through her former roommate, Redacted. Redacted was allegedly dating Epstein at the time. Redacted and Redacted had once cohabitated together when they modelled. Redacted explained Redacted called her on her telephone and advised her that she was in Palm Beach and requested to see her. Redacted made arrangements to meet with her at Epstein's house. Redacted arrived and met Epstein and went Redacted arrived and met Epstein and Redacted. Redacted and Redacted went to the Palm Beach Mall together and went shopping. Redacted advised that Redacted and she had received money from Epstein to go to the mall. They visited Victoria's Secret and purchased undergarments from the store utilizing monies given by Epstein. Redacted advised she purchased one item, and Redacted purchased various items. The money used to purchase the items was the money given by Epstein. Redacted and Redacted continue shopping and having a day together. Redacted stated Redacted explained how she and Epstein have been dating each other, and he has been paying all of her bills. Redacted claimed Redacted advised they met in New York and had been dating ever since. They later returned to Epstein's home and encountered Epstein. He had a brief conversation with Redacted about her modelling career. He knew of her modelling career from Redacted. He requested to see her modelling portfolio and explained that he could help her with modelling jobs. Redacted had her book with her to show Redacted and show the book to Epstein. He commented negatively about her photographs and portfolio. Redacted felt uncomfortable with the comments made, as she had been working with other professional modelling companies who had offered her work from the photographs. Epstein requested to see what was purchased in the mall. Redacted took out the undergarments, which were purchased. She immediately showed Epstein different sets purchased. Epstein then requested to view what Redacted purchased. Redacted was reluctant to show the outfit. However, since it was Epstein's money that purchased the item, she pulled it out of the bag. Epstein asked her to try it on. Redacted looked at Redacted, who told her, "Yeah, try it on." It's at this point that once again I'm going to move past the explicit content. However, the MO is the same. Continuing from halfway in page 379. Narrative number 38. Reported by Ricari Joseph. Entered by Altamaro Nikie. 1:31:06. On January 27, 2006, I made telephone contact with Cristiana Venero at 772-878-7280. Venero is a licensed massage therapist who had frequented the home of Jeffery Epstein. Ms. Venero has been unable to meet with me in Palm Beach County, and because she lives and works in Port St. Louis, a telephone interview was conducted. I explained to Ms. Venero that there was an ongoing investigation involving Jeffery Epstein. Venero stated she knows Epstein and has been employed by him for approximately 3 years. Epstein has paid Venero to perform Swedish massages, deep tissue, on him and other guests. Venero explained that approximately 3 years ago she met Ghislaine Maxwell and Jeffery Epstein through a mutual friend. Epstein and Maxwell were looking for a massage therapist. Venero stated, since that time, she is notified when Epstein is coming to Palm Beach. Venero stated she comes to his house and provides the massage or massages. Venero explained she has also massages guests and assistants. Venero continued that she is paid $100 an hour for the massage. I asked Venero if anything occurred during the massage that would have made her feel uncomfortable. Venero stated she only provided massages and that was it. She never was approached for anything else. I asked if Epstein ever asked her to rub his chest. She stated she would not rub his chest as that is not part of her massage. Venero explained that she was not Epstein's type. The girls she would see at Epstein's house were very thin, beautiful, and without tattoos. Venero explained she has several tattoos that are visible. Maxwell and Epstein have commented negatively about her tattoos previously, when she has provided massages. Venero stated she only provided massages for Epstein and his associates, and nothing happened during those massages. Venero stated as she does Swedish-style massages, the patient is usually sore after the massages. Venero stated as she does Swedish-style massages, the patient is usually sore after the massages. I thanked her for her assistance and the interview was concluded at this time. I received a facsimile from T-Mobile Cellular Service on telephone number 561-317-5844, which is assigned to David Rogers, pilot for Mr. Epstein, who resides in Lake Worth. Rogers' telephone number was dialed on several occasions by Sarah Callan. A background on Rogers indicated he has a valid FFA pilot. He has a valid FAA pilot license first class for the Southern FAA region.
Rogers has another historical FAA license for airline transport pilot. Investigation continues. Narrative number 39. Reported by Ricari Joseph, 2:14:06. Entered by Altamaro Nikki A, 2:16:06. On Friday, February 3rd, 2006, I had made arrangements to meet with Johanna Harrison at the Palm Beach Police Station. At approximately 1 p.m, Harrison and her friend, Victoria Bean, arrived at the police station. During an interview with Harrison, she stated she met Epstein when she turned 18 years old and was brought to Epstein's house to provide a massage. She advised this occurred on May of 2005. She advised Haley Robson had informed her if she wanted to provide a massage for $200. Harrison agreed and was brought to Epstein's house to provide a massage. Harrison stated she had been to the house on many occasions during the massage sessions. Harrison also stated she would remove her clothing to provide the massage on Epstein. Harrison advised Epstein would pay her $300 to rub his back, legs, and chest. During the massages, Epstein would... Okay. It's at this point, once again, I'm going to move past the explicit graphic content. Bean advised it occurred one time and she never returned to Epstein's house. The interview was concluded and Bean was escorted to the lobby. I located a telephone number for Redacted and attempted to contact her on several occasions. I called Redacted and spoke with Miss Redacted, who advised she would speak with me in Redacted, where she resides. Due to a scheduling conflict, we were unable to meet. I informed her I would contact her to schedule another appointment to speak with her about this investigation. I have attempted to meet with her and make telephone contact with negative results. On February 13, 2006, I met with David Rogers at 7318 Heathfleet Drive in Lake Worth. Rogers was identified as Epstein's pilot. I spoke with Rogers, who advised he has been employed with Epstein since 1991. He flies both planes for Epstein, depending where he wants to fly to. Rogers was asked about passengers in the plane he flies. Rogers stated unless Epstein flew to his island off of St. Thomas, there would be no way of knowing who the passengers were. I mentioned a recent flight to Ohio, where Rogers flew to Ohio to pick up Redacted. Rogers stated he recalled flying on several occasions and did remember Redacted. Rogers stated once he is in the cockpit, he does not know who the passengers are. When he prepares the passenger manifest, he lists Epstein and his assistants, he knows by name, Sarah and Adriana. Rogers stated he would list either female or male passengers on the manifests, only to keep account on the passengers. Mrs. Rogers came into the living room and recommended that her husband consult with an attorney. Mr. Rogers agreed he would speak with the family attorney to inform him of this questioning, explained to Mr. Rogers that he was not the suspect of this investigation, and ceased all questions. Based on the fact Rogers could not advise who passengers were in the plane, I then left the area. I attempted to locate Redacted at Redacted in Redacted. I left my business card for her to return my call. On February 14, 2006 at 12:06 p.m, I received a call back from Miss Redacted. On my voicemail, Miss Redacted left her telephone number for a return call 561-662-3098. I left her a message to return call. Investigation continues. Narrative number 40. Reported by Ricari Joseph, 2/21/06. Entered by Altamaro Nikki A, 2/22/06. On February 15, 2006, I made telephone contact with Redacted, who provided directions to where I could locate her. Del Caristo and I responded to 806 Old Dixie HY in Lake Park to meet with Redacted. Upon my arrival, I met with Redacted in the parking lot directly behind MAACO Auto Painting. She was advised I was there to speak with her about an ongoing investigation that concerned Jeffery Epstein in Palm Beach. Redacted stated she knows Epstein very well and did not want to speak with me about Mr. Epstein. She was very fond of Epstein and did not want to speak with me about anything concerning Jeffrey Epstein. I explained to her that she was seen at the house and I would like to speak with her. She stated she knew there was an investigation and that I had spoken with other people and therefore I should know what happened at Epstein's house. Redacted ended the conversation and walked back into her boyfriend's business, Blanton Automotive. Detective Caristo and I left the area and returned to the police station. Investigation continues. Narrative number 41. Reported by Ricari Joseph. Entered by Altamaro Nikki A. 4th 10th 06. A grand jury session was requested during the month of February 2006, in which all the girls that had been interviewed would have been called to testify before the grand jury to seek an indictment against Jeffrey Epstein. Due to subsequent meetings with the state attorney's office and defense attorney Alan Dershowitz, the grand jury was postponed until a later time. Dershowitz had provided a package of material on the main victims in this case, in which they appear on myspace.com and speak about alcohol use and some marijuana use. The state attorney's office wanted time to review the material. I requested additional subpoenas from the state attorney's office, in which I requested information from Dollar Rent-A-Car and Jet Aviation. The information requested from Dollar Rent-A-Car was for the rented vehicle by Alfredo Rodriguez while under the employ of Epstein for one of the victims. The other subpoena requested was for Jet Aviation for dates and times when Epstein's planes were in Palm Beach County. I continued to research other names that were required, either from interviews or intelligence gathered during the investigation. I located Redacted in Redacted. I responded to Redacted in Redacted. During the interview, Redacted stated she knew I would be speaking with her. Redacted stated she was first introduced to Epstein when she turned 18 years old. Redacted stated she was sure of her age as it was her senior year in Redacted. She advised she was brought there to make money and was told she would have to provide a massage to this Palm Beach guy. She remembered she met Epstein and his assistant Sarah in the kitchen area. She stated she was taken by one of her friends, Redacted. She stated she went upstairs with Sarah while Epstein got ready for the massage. At this point, I'm going to skip past the explicit bit again. Sorry if I'm stuttering a lot, by the way. My throat is very dry. I'll be taking a break soon. The interview was concluded as Redacted did not have any other information to provide. I then learned from the original victim, Redacted, the defense attorney, had learned of her identity. I spoke with the father of the victim, who stated there had been a private investigator on his house photographing his family and chasing visitors who come to the house. He provided a Florida license of E79-4EH. The vehicle is registered to Ivan Robles of West Palm Beach. Robles is a private investigator intern who is licensed by the state. I informed the state attorney's office of the above information. I received the grand jury subpoenas to be delivered to 3 victims for a grand jury session to be held on April 18th through April 20th, 2006. Investigation continues. Narrative number 42. Reported by Ricari Joseph, 4th 1406, entered by Altamaro Nikki A, 4th 1806. The grand jury subpoenas were personally served to the individuals they were issued to. On April 5, 2006, at approximately 7:30 p.m., I personally served the parents of Redacted, who had informed me that the private investigators were still photographing the family. On April 10, 2006, at approximately 2:30 p.m., I served Redacted at her residence in Redacted. The subpoena was given to her mother, Redacted. I learned through one of the victims, Redacted, that she was personally contacted through a source that has maintained contact with Epstein. The source assured Redacted she would receive monetary compensation for her assistance in not cooperating with law enforcement. Redacted also stated she was told, "Those who help him will be compensated and those who hurt him will be dealt with." I told Redacted that tampering with a witness/victim is an arrestable offence and very serious. I asked her who approached her during this encounter. Redacted originally was reluctant to provide the name of the person who approached her, to offer her not to testify because she felt they were still friends. On April 11, 2006, Detective Dawson and I travelled to Tallahassee, Florida, and met with the victim, Redacted, identified redacted, WF redacted, as the person who approached her in Royal Palm Beach while she was home during spring break in March 2006. Redacted also stated she did not want to pursue the intimidation charges on Redacted. Redacted was concerned that the defense attorney was given a copy of the report, as certain things she had told me in confidence were repeated to her by Beale. Prior to our departure, the victim was given a copy of her subpoena for the grand jury, which was scheduled to commence April 18, 2006. Upon our return from Tallahassee, I notified the state attorney's office of what was told to me. I also notified them that the subpoenas were delivered to the witnesses and they will be calling for arrangements for the date and time needed for the grand jury. I spoke with ASA Weiss and informed her of the possible intimidation by the defense. On April 13th and April 14th, 2006, I attempted contact on several occasions with ASA Weiss and ASA Beloglavic to ascertain when the victims needed to report for grand jury testimony. Messages were left on their voicemail. On April 17, 2006, during the hours of 9 a.m. and 11:30 a.m., I again left messages for ASA Weiss and ASA Beloglavic for either of them to return my call, as I had not heard from the state attorney's office as to the time and date of the grand jury. At approximately 12:30 p.m., I went to the state attorney's office and located ASA Weiss and ASA Beloglavic in their offices. I entered ASA Beloglavic's office, who informed me she was going to return my call. She explained that an offer was made to the defense, Atty Guy Fronstin and Atty Alan Dershowitz. The offer is 1 count of aggravated assault with intent to commit a felony, 5 years probation with adjudication withheld. Epstein would have to submit to psychiatric/sexual evaluation and no unsupervised visits with minors. When asked about all the other victims, ASA Beloglavic stated that was the only offer made as to one victim. Redacted. ASA Beloglavic cell phone rang and went to voicemail. She checked her voicemail and played the message on speaker. The caller identified himself as Attorney Guy Fronstein and acknowledged the deal made between them. Fronstein stated in the message he spoke with his client, Jeffery Epstein, and agreed to the deal. Fronstein asked to call off the grand jury as they would accept this deal. Beloglavic stated a probable cause would be needed to book Epstein in the county jail and would let me know as to when it would be needed. I explained my disapproval of the deal and not being consulted prior to the deal being offered. However, I expressed that was only my opinion and the final approval would come from the Chief of Police. She explained to have Chief Writer call Barry Krishna about the deal. I left the area and returned to the police station where I briefed the chief about the deal offered. I checked my voicemail messages and discovered a message from Redacted, stepmother for the victim, Redacted. She was calling because the state attorney's office still had not returned any of her calls as to when they are needed for this case. I then called ASA Beloglavic's office and left messages for her to call the victims on this case and explain to them what the state attorney's office had done. On April 17, 2006, at approximately 4:30 p.m., State Attorney Investigator Tim Valentine called to officially notify me of the cancellation of the grand jury. He requested I contact the victims that had been served to appear to notify them of the cancellation. I advised Valentine that, as this grand jury session was called based on the State Attorney's Office decision to have the victims heard by the grand jury, that I felt it was the State Attorney's Office responsibility to contact the victims and advise them of the reason they were no longer needed. Narrative number 43. Reported by Rakari Joseph, 5/04/06. Entered by Altamaro Nikki A, 5/04/06. As I had not received any contact from anyone at the State Attorney's Office on May 1st, 2006, I prepared 3 arrest warrant requests and submitted them to the State Attorney's Office. The packages were delivered to the Crimes Against Children Unit in care of Asa Lana Beloglavic. Jeffrey Epstein's arrest warrant was requested for 4 counts of unlawful sexual activity with certain minors and 1 count of lewd and lascivious molestation. Sarah Kellen, Epstein's assistant's arrest warrant request was for 4 counts of principal in the first-degree unlawful sexual activity with certain minors and 1 count of principal in the first-degree lewd and lascivious molestation. Haley Robson's arrest warrant request was for lewd and lascivious acts on a victim under 16 years of age. The receipt of delivery was signed and brought back to the Records Division at the Police Department. On May 3, 2006, at approximately 2:54 p.m., I received a telephone call from Asa Delia Weiss on my cellular telephone. Asa Weiss advised she has been taken off of the Jeffery Epstein case because her husband is employed with attorney Jack Goldberger. Attorney Goldberger is the attorney of record for Jeffrey Epstein. His previous attorney, Guy Fronstein, has been fired from representation. ASA Lana Belovec has been assigned the case. ASA Weiss stated she could no longer speak about the Epstein case with me. I thanked her for her telephone call. ASA Weiss further stated that Asa Belovec will be calling me. Narrative number 44. Reported by Ricari Joseph, 5th 1506, entered by Altamaro Nikki A, 5th 1506. On May 10, 2006, information was received that Epstein's associate, Leslie Wexter, the Limited Inc. CEO's plane had arrived in West Palm Beach, PBIA. The plane, a Gulfstream 4 bearing a N900LS registration, was on the tarmac at Galaxy Aviation. As Epstein had recently acquired the services of a new attorney, and the fact that Epstein's house is currently under remodeling, it was believed that Epstein may be in Palm Beach. I conducted physical surveillance at the residence, 358 El Brillo Way. I observed a large construction crew conducting remodeling at the house. The contractor, David Knorr, was observed driving a Ford Explorer, white in colour. The vehicle has a Florida registration of F30QQF. Knorr left Epstein's house and travelled north on County Road. Detective Caristo and I conducted surveillance on Knorr. Knorr travelled to several construction sites and checked on certain jobs. Surveillance was discontinued on Knorr, and Detective Caristo and I travelled to Galaxy Aviation. I observed the white plane with a blue stripe along the body and tail of the plane. The tail number was visible on the bottom of the tail, and closer to the body of the plane. We maintained visual surveillance on the plane until 4:54 p.m., when a caravan of Cadillac Escalades drove onto the tarmac. We observed several people exit the vehicles and discovered that they were part of the executive team for Limited Inc. The executives were in Palm Beach County for an executive meeting for the day. They arrived in Palm Beach County on May 9, 2005 at 9:30 p.m. and were scheduled to leave on the 10th at 5 p.m. On May 12, 2006, I met with ASA Lana Belovec at the State Attorney's office. She explained that her boss, Barry Krishna, was requesting this case be taken to the grand jury again. I explained to her I had requested arrest warrants for Jeffrey Epstein, Sarah Kellen, and Haley Robson. I asked that she either issue the warrants or direct file, as so much time has elapsed since the original request to the grand jury. I explained that the Palm Beach Police Department had concluded the case in December of 2005 and has been waiting for the case to go forward. Belovec stated the original offer was again offered to the new defense attorney. She was waiting for their answer by Friday, May 19, 2006. She stated she would advise me of the answer. Narrative number 45. Reported by Ricari Joseph. 6:05:06. Entered by Altamaro Nikki A. 6:06:06. On May 22, 2006, I received several phone calls throughout the day from Mr. Redacted, who stated he had been followed aggressively by a private investigator. Mr. Redacted stated that as he drove to and from work and running errands throughout the county, the same vehicle was behind him running other vehicles off the road in an attempt not to lose sight of Mr. Redacted's vehicle. I explained to him, as Mr. Epstein had retained new legal counsel, it was possible it would be new private investigators following him to observe his daily activities. I also explained to him that there was a meeting scheduled with Asa Lana Belovec and attorney Jack Goldberg at Mr. Krishna's office, scheduled on June 1st, 2006 at 9 a.m. I attempted to call ASA Lana Balolovec to inform her of the private investigators following Mr. Redacted. However, she was on her vacation during the week of May 22nd through May 30th, 2006. On May 23, 2006, I received other phone calls from Mr. and Mrs. Redacted, who advised they were able to acquire the private investigator's license plate information. The subject following them was again driving very aggressively and caused Mrs. Redacted to run off the road. Mrs. Redacted stated the vehicle is a green Chevy Monte Carlo bearing Florida tag I-35XGA. The vehicle is registered to Zachary Bachard of Jupiter, Florida. Bachard is employed with Candor Investigations from Jupiter, Florida. Bachard is a licensed private investigator in the state of Florida. Since the discovery of the threat made against one of the victims in this case, Redacted, I requested subpoenas for all calls made to and received from Redacted during the month of March 2006 for her cell phone and home phone. I had confirmed with Florida State University the exact dates of spring break for 2006. The spring break was from March 4, 2006 through March 12, 2006. I received a subpoena from Spirit/Nextel with all calls made during the month of March 2006. I reviewed the 989 calls made and received during the month of March 2006. I observed on March 7, 2006, Redacted made and received 35 calls during that day. The above table reflects the date of the calls, time of day, EST, duration of call in seconds, inbound or outbound calls, and calls made to or from Redacted's phone. On March 7, 2006 at 11:03 a.m., Redacted made a call to the victim, Redacted, which lasted 492 seconds, 8 minutes and 2 seconds. The victim then returned the call at 11:16 a.m., which lasted 6 seconds. The victim then made contact with Redacted at 11:22 a.m. for 877.2 seconds, 14 minutes and 6 seconds. These sequences of calls were consistent with what the victim had described to me on the date of the intimidation. Immediately after speaking with the victim, Redacted makes a call to Sarah Kellen, Epstein's assistant, which lasts for 48 seconds. A call is then immediately received, a telephone number registered to a corporation affiliated with Jeffery Epstein, located at 457 Madison Avenue in New York. An extensive computer check revealed 457 Madison Avenue is a business address in which Epstein has his corporations assigned to. Epstein had corporation attorney Darren Indyke register the business and register himself as an agent. I also observed Epstein has his El Zorro Ranch Corporation, New York Strategy Group, Ghislaine Corporation, J. Epstein and Company, and the Financial Strategy Group registered to this same address. Finally, a third call is received by Redacted at 12:02 p.m. from the same corporate number, which lasts 12 minutes and 1 second. It should be noted that there is no further contact with either the victim during the month of March or April of 2006. I also noted that there was no further contact with Sarah Kellen or Jeffrey Epstein during the remainder of the month of March or April 2006. On June 1st, 2006, Asa Lana Balolovec telephoned me to inform me of the meeting that occurred with attorney Jack Goldberger and her reference this case. She advised she would make her determination on whether to file on this case or not by Monday, June 5th, 2006. Investigation continues. Narrative number 46. Reported by Ricari Joseph. Entered by Altamaro Nikki A. 7th, 12:06. On July 29, 2006, I had spoken to Asa Lana Balolovec, who informed me that the case will be sent to the grand jury for charges. She informed me that the grand jury would convene on July 19, 2006 to hear the Epstein case. Balolovec stated, State Attorney Barry Krishna made the determination to go to the grand jury to hear the case. On July 12, 2006, I spoke with Mrs. Redacted's mother of the victim, Redacted, who inquired about the status of the case.
I explained to her that I was told we would be going to the grand jury during the week of July 19, 2006. She stated she had not been contacted as of yet by the State Attorney's Office for any information. I provided her with the telephone numbers to the State Attorney's Office. Investigation continues. Narrative number 47. Reported by Ricari Joseph. Entered by Altamaro, Nikki A. 80306. On July 18, 2006, I received a grand jury letter to appear before the grand jury on July 19, 2006, referenced the Jeffery Epstein case. On July 19, 2006, I responded to the grand jury room and testified before the grand jury. At the conclusion, Aser Belolovec stated the grand jury returned with a true bill for felony solicitation of prostitution. On July 25, 2006, Epstein turned himself into the county jail and was released on a $3,000 bond. Epstein is to return for arraignment on August 25, 2006 at 8:45 a.m. Attention please clerks. Please show this case cleared by arrest with the arrest of Jeffery Epstein, WM 01-20-1953. End of report. Exhibit 1. From Jeffrey E. gvacation@gmail.com. Sent Monday, January 12, 2015, 10:03 a.m. to Gmax. You can issue a reward to any of Virginia's friends, acquaintance, family that come forward and help prove her allegations are false. The strongest is the Clinton dinner, and the new version in the Virgin Islands, the Stephen Hawking participated in an underage orgy. I'm sorry, how the fuck would that even work? You cannot run from me, children. Oh god, I'm so sorry. I've been doing this a while. Let's continue. Please note, the information contained in this communication is confidential, may be attorney-client privileged, may constitute inside information, and is intended only for the use of the addressee. It is the property of JEE. Unauthorized use, disclosure, or copying of this communication, or any part thereof, is strictly prohibited and may be unlawful. If you have received this communication in error, please notify us immediately by return email or by email to gvacation@gmail.com, and destroy this communication and all copies thereof, including all attachments, copyright all rights reserved. How about no? From Roscoe. Ross at activityreputation.com. Sent Tuesday, February 24, 2015, 3:36 a.m. To Gmax, Philip Barden. Subject: VR grade rape. Prior case dismissed as prosecutors found her not credible. Ghislaine. Some helpful leakage. In today's Daily Mail print edition and on web. www.dailymail.co.uk/news/article 2965360. Prince Andrew's sex slave accused 2 teens, rape 3 years. Join Jeffrey Epstein's harem, HTML. And www.nydailynews.com/news/world/sex slave Prince Andrew accused 2 men rape 1998 article 12125569. Mum told a detective about her daughter's past drug abuse, and also how many kids in Royal Palm Beach are involved in drugs, witchcraft and animal sacrifice, according to a confidential report by the Palm Beach County Sheriff's Office. Best, Ross. Roscoe, Managing Partner, Acuity Reputation. Okay, got a few of these charts. So, we're going to do this in order from log ID, email sent date, email from, email to, CC address if applicable, subject matter, type of privilege, privilege action, page count, and doc type. Log ID 1. Email send date 2/12/2015 6:14. Email from Virginia Joffrey. Email to smccauley@bsflip.com. No CC address. Subject matter: email chain with Joffrey, Edwards, and Castle. RE attorney impressions and legal advice relating to deposition testimony. Type of privilege:
AC privilege and work, product, /joint defense, /common interest. Privilege action, withheld. Page count, free. Doc type, MSG. 2. 2nd 16/2015 105. Stan Pottinger at AOL.com. SM Macaulay at bsfllp.com. brad at pathtojustice.com. Robbie Jennage at y7mail.com. Email chain with Jeffery, no. Discussion of evidence among client and attorneys. AC privilege and work, product, joint defense, common interest. Withheld, 2, MSG. Free. 2nd 16/2015 1537. I'll tell you what, it's easy if I just say it. Email from Virginia Jeffery. Email to smacaulay at bsflip.com. Subject matter. Email chain with Jeffery, Macaulay, Pottinger, and Edwards. RE information provided by client to assist in legal advice. Type of privilege, attorney-client /joint defense /common interest. Okay, is it worth doing this? 12 16/2015 1537. Virginia Jeffery. S. Macaulay at bsfllp.com. Email chain with Jeffery, Macaulay, Pottinger, and Edwards. RE information provided by client to assist in legal advice. Attorney-client, joint defense, common interest, work product. Withheld, 2 MSG. Okay, so what I'm going to do going forward is I'm going to omit the email to. I'm just going to keep the name of the email from. I'm going to keep the email send date, and I'm going to keep the subject matter. The type of privilege, I'm not going to say unless it's interesting, because it's mainly attorney and clients, that kind of stuff. None of the juicy stuff. So that's what I'm going to do going forward. Yeah, most of this privilege action page count doc type, it's all the same. So to save time, I'll be omitting that stuff. But you can probably see it on the video. 2/16/2015 16:15 Sigrid Macaulay. Email chain with Jeffery, Macaulay, Pottinger, and Edwards. RE information provided by client to assist in legal advice. 2/16/2015 16:24 Virginia Jeffery. Email chain with Jeffery, Macaulay, Pottinger, and Edwards. RE information provided by client to assist in legal advice. 2/16/2015 16:24 Sigrid Macaulay. Same as above. 2/21/2015 16:45. Discussion of evidence among 2/21/2015 16:45 Sigrid Macaulay. Discussion of evidence among client and attorneys. 2/21/2015 16:58 Virginia Jeffery. Discussion of evidence among client and attorney. 2/21/2015 17:05 Brad Edwards. Same as above. 2/21/2015 17:10 Sigrid Macaulay. Same as above. 2/21/2015 17:16 Same as above. 2/23/2015 14:21 Same as above. 2/23/2015 14:29 Same as above. 2/23/2015 16:01 Same as above. I'm going to start mentioning the log IDs now. Log ID 15, 2/24/2015 17:51 Sigrid Macaulay. Email chain with Macaulay, Jeffery, and paralegals. RE seeking information to assist in legal advice with attachment. 16. No details aside from subject matter, attached case research. 17. 2/16/2015 12:59 Virginia Jeffery. Email chain with Jeffery, Macaulay, and legal assistant. RE legal document with attachment. 18. No information apart from an attached draft legal document. 19. 2nd 28/2015 17:47 Virginia Jeffery. Email with Jeffery, Macaulay, Edwards, and Henderson. RE discussion of draft statement. 20. 3rd 13/2015 17:29 Stan Pottinger. Email chain with Jeffery, Edwards, Macaulay, Henderson, and Pottinger. RE legal advice on media issues. 21. 3/13/2015 17:49 Virginia Jeffery. Email chain with Jeffery, Edwards, Macaulay, and Pottinger. RE legal advice on media issues. 22. 3/13/2015 17:56
email from Stan Pottinger at AOL.com. Subject matter, email chain with Jeffery, Edwards, Macaulay, Henderson, and Pottinger, RE legal advice on media issues. 23. 3/13/2015, 1800, Brad Edwards, same as above. 24. 3/13/2015, 1824, Virginia Jeffery, same as above. 25. 3/15/2015, 1825, Virginia Jeffery, same as above. 26. 3/13/2015, 2153, Virginia Jeffery. Email chain with Jeffery, Edwards, Macaulay, Henderson, and Pottinger, RE legal advice on media issues. Okay, that's the same as above. 27. 3/13/2015, 2338, Brad Edwards. Email chain with Jeffery, Edwards, Macaulay, Henderson, and Pottinger, RE legal advice on media issues. 28. 3/13/2015, 2340, Virginia Jeffery. Email chain with Jeffery, Edwards, Macaulay, same as above. 29. Email send date 3/17/2015, 1520. Email from Virginia Jeffery. Subject matter, providing information to assist in legal advice, RE potential legal action with attachments. Log ID 30, 3/17/2015, 1840. Stan. Email chain with Jeffery, Edwards, Pottinger, and Macaulay, RE legal advice related to VRS. 31. 3/17/2015, 1942, Virginia Jeffery, same as above. 32. 3/20/2015, 1542, 43, Sigrid Macaulay. Email chain with Jeffery, Edwards, Henderson, Pottinger, Macaulay, and BSF staff, RE legal advice related to VRS. 33. 3/20/2015, 1557, Sigrid Macaulay. Providing legal advice, RE potential deposition. 34. 3/24/2015, 2119, Sigrid Macaulay. Email chain with Jeffery, Edwards, Henderson, Macaulay, and BSF staff, RE legal advice related to VRS. 35. 3/24/2015, 2121, Virginia Jeffery, same as above. 36. 3/24/2015, 2136, Andreas Ortiz, same as above. 37. 3/24/2015, 2221, Virginia Jeffery, same as above. 38. 3/26/2015, 200, Sigrid Macaulay, same as above. 3/26/2015, 221, Virginia Jeffery, same as... Oh no. Email chain with Jeffery, Edwards, Henderson, Macaulay, and BSF staff, RE legal advice related to VRS. Okay, someone was taken off there. 40. 3/26/2015, 222, Sigrid Macaulay, same as above. 41. 3/26/2015, 300, Virginia Jeffery, same as above. 42. 4/1/2015, 2132, Virginia Jeffery. Jeffery conveying information sought by attorney to assist in legal advice with attachments. 43. 4/2/2015, 701, Brittany Henderson. Providing draft legal document for client review with attachment. 44 is the attachment. 45. 4/3, 2015, 1532, Brittany Henderson. Email chain with Jeffery, Henderson, Edwards, and legal assistant, RE legal document with attachment. 46 is the attachment. 47. 4/8, 2015, 2034, Virginia Jeffery, seeking legal advice related to VRS. 48. 4/9, 2015, 323, Virginia Jeffery. Email chain with Jeffery and Macaulay, RE legal advice, RE legal filings with attachments. 49. 4/9, 2015, 716, Sigrid Macaulay. Email chain with Jeffery, Edwards, Henderson, Macaulay, and BSF staff, RE legal advice, RE media issues. 50. 4/9, 2015, 926, Brad Edwards. Email chain with Jeffery, Edwards, and Macaulay, RE legal advice, RE media issues. 51. 4/9, 2015, 933, Sigrid Macaulay. Email chain with Jeffery and Macaulay, RE legal advice, RE media issues. 52. 4/9, 2015, 1246, Sigrid Macaulay. Conveying legal advice, RE draft legal documents to client with attachments. 53. No info. Conveying legal advice, RE draft legal documents to client with attachments. Same for log IDs 54 and 55. Log ID 56, 4th of the 10th, 2015, 1459, Sigrid Macaulay. Providing legal advice, RE media issues. 57, 4th of the 10th, 2015, 1537, Virginia Jeffery. Same as above. 58, 4th of the 10th, 2015, 1731, Sigrid Macaulay. Email chain with Jeffery, Macaulay, Henderson, Edwards, Pottinger, and legal assistant. RE legal documents with attachments. 59. Attached draft legal document. 60. Same as above. 61. 4th of the 10th, 2015, 1740. Virginia Jeffery. Email chain with Jeffery, Macaulay, and BSF staff regarding legal advice related to VRS. 62. 4th of the 10th, 2015, 1910. Virginia Jeffery. Same as above. 63. 4th of the 10th, 2015, 1928, Sigrid Macaulay. Same as above. 64. 4th of the 10th, 2015, 1933, Virginia Jeffery. Same as above. 4th of the 10th, 2015, 2001, Sigrid Macaulay. Same as above again. Email chain with Jeffery, Macaulay, and BSF staff regarding legal advice relating to VRS. I will admit this doesn't change much. 66. Email sent date 4th of the 10th, 2015, 2004, Virginia Jeffery. Email chain with Jeffery, Macaulay, and BSF staff regarding legal advice related to VRS. 4th of the 10th, Log ID 67, 4th of the 10th, 2015, 2004, Sigrid Macaulay. Same as above. 68. 4th of the 10th, 2015, 2346, Virginia Jeffery. Email chain with Jeffery, Macaulay, legal assistant. RE seeking and providing information sought by attorney to assist in providing legal advice with attachments. 69. 4th, 13, 2015, 1352, Sigrid Macaulay. Email chain with Jeffery, Pottinger, Edwards, and Macaulay, RE legal advice regarding potential public statements. 70. 4th, 13, 2015, 1356, Virginia Jeffery, same as above. 71. 4/14, 2015, 2338, Brad Edwards, providing legal advice related to VRS. Log ID 72, email send date 4/16, 2015, 11:14, email from Virginia Jeffery, subject matter, email chain with Jeffery and Macaulay, RE legal advice regarding media issues. 73, 4/16, 2015, 11:47, Sigrid Macaulay, same as above. 74. 4/24/2015, 1922. Sigrid Macaulay. Providing legal advice, RE records retention with attachments. 75. Log ID is the attachment. Log ID 76. 4th, 24th, 2015, 1959. Virginia Jeffery. Email chain with Jeffery and Macaulay, RE legal advice regarding potential deposition. 77. 4th, 27th, 2015, 2120, Brad Edwards, seeking information to assist in providing legal advice. Log ID 78, email send date 4/30 of 2015, 6:42. Email from Brittany Henderson, subject matter legal documents provided to assist in providing legal advice. Log ID 79, sent 4/30 of 2015, 7:02, from Brittany Henderson. Subject matter, email chain with Jeffery, Henderson, and paralegal, RE seeking and providing information to assist in providing legal advice. 80. 4th, 30th, 2015, 7:05, Virginia Jeffery. Email chain with Jeffery, Henderson, Edwards, Macaulay, and legal assistant, RE seeking information to assist in providing legal advice. 81. 5th of the 4th, 2015, 2004, Virginia Jeffery. Email chain with Jeffery, Henderson, Edwards, Macaulay, and legal assistant, RE seeking information to assist in providing legal advice with attachment. 82. 5th, 11th, 2015, 1820, Sigrid Macaulay. Email chain with Macaulay, Jeffery, Edwards, Pottinger, Henderson, and paralegal, RE seeking and providing information to assist in legal advice with attachments. 83. 5th, 11th, 2015, 1834, Virginia Jeffery. Email chain with Jeffery, Macaulay, Edwards, Pottinger, and paralegal, RE seeking information to assist in providing legal advice, RE potential litigation. 84. 5th 11th 2015, 1840. Sigrid Macaulay. Email chain with Jeffery and Macaulay RE case research with attachment. 85. 5th 11th 2015, 1845. From Sigrid Macaulay. Subject: providing and seeking information to assist in legal advice or a potential legal action with attachment. ID 86. Date: 5th 11th 2015, 1847. From Virginia Goffrey. Email chain with Goffrey and Macaulay RE seeking information to assist in providing legal advice or a potential litigation. ID 87. 5th 11th 2015, 1856. From Virginia Goffrey. Email chain with Goffrey, Macaulay, Edwards, Pottinger, and paralegal RE seeking information to assist in providing legal advice RE potential litigation. 88. 5th 17th 2015, 2237. From Sigrid Macaulay. Providing litigation documents to client with attachments. ID 89 is the attachment. 90. 5th 17th 2015, 2240. Sigrid Macaulay. Providing legal advice RE legal agreement with attachment. ID 91, date 5th 11th 2015, 1840. From Virginia Goffrey. Subject: discussion of confidential agreement with attachments. Log IDs 92 and 93 are said attachments. 94. 6th of the 5th, 2015, 1916. Sigrid Macaulay. Conveying attorney mental impression regarding hearing. ID 95. 6th of the 6th, 2015, 1720. Virginia Goffrey. Email chain with Goffrey and Macaulay RE attorney mental impression regarding hearing. ID 96. 6th of the 25th, 2015 to 26. Sigrid Macaulay. Providing advice RE status and strategy of ongoing legal matters. ID 97. 7th of the 17th, 2015, 1419. Sigrid Macaulay. Subject: discussion with S. Macaulay regarding file related to representation by B. Josefberg. Log ID 98. Date 7/27/2015, 2153. From Virginia Goffrey. Subject matter: providing information to assist in legal advice RE potential litigation. 99. 7th 29th 2015, 1945. Sigrid Macaulay. Conveying legal advice on media issues. 100. 8th of the 5th 2015, 1951. Sigrid Macaulay. Email chain with Jeffery, Macaulay, and paralegals. RE information sought to assist in providing legal advice. 101. 8th of the 6th 2015, 214. Sigrid Macaulay. Email chain with Jeffery, Macaulay, legal intern, and paralegal. RE seeking information to assist in providing legal advice. RE potential litigation. 102. Date 8th 6th 2015, 2:45. Sigrid Macaulay. Email chain with Jeffery, Macaulay, legal intern, Edwards, and paralegal. RE seeking information to assist in providing legal advice. RE potential litigation. ID 103. Date 8th of the 6th 2015, 2:55. Virginia Goffrey. Email chain with Jeffery, Macaulay, legal intern, and paralegal. RE seeking information to assist in providing legal advice. RE potential litigation. ID 104. Date 8th of the 6th 2015, 3:48. Sigrid Macaulay. Email chain with Macaulay, Jeffery, and paralegals. RE seeking information to assist in legal advice with attachments. ID 105. Date 8th 6th 2015, 3:51. From Virginia Goffrey. Subject matter: email chain with Goffrey, Macaulay, legal intern, and paralegal. RE seeking information to assist in providing legal advice. RE potential litigation. 106. 9th of the 1st, 2015, 1854. Sigrid Macaulay. Providing and seeking information to assist in legal advice. RE potential legal action with attachment. ID 107. 9th of the 7th, 2015, 1824. Virginia Joffrey. Providing information sought by attorneys to provide legal advice with attachment. ID 108 is said attachment. 109. 9th of the 7th, 2015, 1858. Sigrid Macaulay. Email chain with Jeffery, Edwards, Pottinger, and Macaulay. RE collection of information to assist in providing legal advice. RE potential litigation. ID 110. Date 9/15th, 2015, 2158. Virginia Joffrey. Email chain with Jeffery and Macaulay. RE draft legal document relating to litigation. Log ID 111. Sent 9/15th, 2015, 2204. From Sigrid Macaulay. Subject matter: email chain with Jeffery and Macaulay. RE draft legal document relating to litigation. ID 112. 9/15th, 2015, 2207. From Virginia Joffrey. Same as above. ID 113. 9th of the 20th, 2015, 12:15, Sigrid Macaulay, conveying information about potential legal action. ID 114, date 9th 20, 2015, 14:47, Virginia Jeffery, email chain with Jeffery and Macaulay re potential legal action. ID 115, date 9th 20th, 2015, 1916, from Virginia Jeffery, same as above. ID 116, date 9th 20th, 2015, 1929, Sigrid Macaulay, same as above. ID 117, date 9th 20th, 2015, 1930, from Virginia Jeffery, subject matter, email chain with Jeffery and Macaulay re potential legal action. ID 118, 9th of the 21st, 2015, 14:48, from Sigrid Macaulay. Subject matter, communication re invitation of lawsuit with attachments. IDs 119, 120, 121, 122 are attachments. Log ID 123. Email sent 9th 21st, 2015, 14:51, from Virginia Jeffery. Subject matter, email chain with Jeffery and Macaulay re potential legal action. Log ID 125. Email from Virginia Jeffery, Brad Edwards, Paul Castle, Brittany Henderson and other, Sigrid Macaulay, Meredith Schultz, David Boyce, Jack Scarola, Stan Pottinger, Ellen Brockman, legal assistants, professionals retained by attorneys to aid in the rendition of legal advice and representation. Subject matter. Plaintiff has objected that defendant's requests are overly broad and unduly burdensome, as individually logging all privilege responsive documents will be overly burdensome. Plaintiff contends that requests targeting such privileged information are not reasonably calculated to lead to the discovery of admissible evidence, are not important to resolving the issues, are not relevant to any party's claim or defense, are not proportional to the needs of the case, and creates a heavy burden on plaintiff that outweighs its benefit. Therefore, plaintiff has employed categorical logging pursuant to Local Civil Rule 26.2c. Correspondence re Jane Doe No. 1 and Jane Doe No. 2 v. United States, CVRA case, case number 0880736 Civ Mara, pending in the Southern District of Florida, documents withheld pursuant to the privilege asserted, including communications from Ms. Jeffery to the attorneys listed seeking legal advice related to the CVRA case. Communications from the attorneys to Ms. Jeffery giving legal advice or giving attorney mental impressions related to the DVRA case, communications sending or attaching attorney work product related to the CVRA case, and or communications sending or attaching client revisions to attorney work product related to the CVRA case, and communications re evidence. Log ID 126. Email send date, emails, letters, and other communications from 9th of the 21st, 15 to present. Email from Virginia Jeffery, Brad Edwards, Paul Castle, Brittany Henderson, Sigrid Macaulay, Meredith Schultz, David Bowles, Stephen Zach, Stan Pottinger, Ellen Brockman, legal assistants, professionals retained by attorneys to aid in the rendition of legal advice and representation. Subject matter. Plaintiff has objected that defendant's requests are overly broad and unduly burdensome. Yeah, it is the same as above. Is it the same as above? No, it's not. Let me redo. Plaintiff has objected that defendant's requests are overly broad and unduly burdensome, as individually logging all privileged responsive documents would be overly burdensome. Plaintiff contends that requests targeting such privileged information are not reasonably calculated to lead to the discovery of admissible evidence, are not important to resolving the issues, are not relevant to any party's claim or defense, are not proportional to the needs of the case, and creates a heavy burden on plaintiff that outweighs its benefit. Therefore, plaintiff has employed categorical logging pursuant to Local Civil Rule 26.2c. Correspondence re Jeffery v. Maxwell case, 15 CV 07433 RWS, pending in the Southern District of New York, since the date of the filing, September 21st, 2015. Documents withheld pursuant to the privilege asserted included communications from Ms. Jeffery to the attorneys listed seeking legal advice related to the Maxwell case, communications from the attorneys to Ms. Jeffery giving legal advice or giving attorneys mental impressions related to the Maxwell case, communications sending or attached attorney work product related to the Maxwell case, and or communications sending or attaching client revisions to attorney work product related to the Maxwell case, and communications re evidence. Log ID 127. Email send date. Emails, letters, and other communications from January 2015 to present. Email from Virginia Jeffery, Brad Edwards, Paul Castle, Brittany Henderson, Sigrid McCauley, Meredith Schultz, David Bowl, Stephen Zack, Stan Pottinger, Ellen Brockman, legal assistants, professionals retained by attorneys to aid in the rendition of legal advice and representation. Subject matter. Plaintiff has objected that defendant's requests are overly broad and unduly burdensome, as individually logging all privileged responsive documents would be overly burdensome. Plaintiff contends that requests targeting such privileged information are not reasonably calculated to lead to the discovery of admissible evidence, are not important to resolving the issues, are not relevant to any party's claim or defense, are not proportional to the needs of the case, and creates a heavy burden on plaintiff that outweighs its benefit. Therefore, plaintiff has employed categorical logging pursuant to Local Civil Rule 26.2c. Correspondence R.E. Bradley Edwards and Paul Castle v. Alan Dershkowitz case, case number 00072, pending in the 17th Judicial Circuit, Broward County, Florida. Documents withheld pursuant to the privilege asserted, including communications from Ms. Jeffery to the attorneys listed seeking legal advice related to the Dershowitz case, communications from the attorneys to Ms. Jeffery giving legal advice or giving attorney mental impressions related to the Dershowitz case, communications sending or attaching attorney work product related to the Dershowitz case, and or communications sending or attaching client revisions to attorney work product related to the Dershowitz case, and communications RE evidence. Log ID 128. Email send date. Emails, letters, and other communications from 2009 to present. Email from Virginia Jeffery, Bob Josenberg, Catherine W. Azil, Amy Adiri, other Podhurst attorneys, legal assistants, and professionals retained by attorneys to aid in the rendition of legal advice. Subject matter. Plaintiff has objected that defendant's requests are overly broad and unduly burdensome, as individually logging all privileged responsive documents would be overly burdensome. Plaintiff contends that requests targeting such privileged information are not reasonably calculated to lead to the discovery of admissible evidence, are not important to resolving the issues, are not relevant to any party's claim or defense, are not proportional to the needs of the case, and creates a heavy burden on plaintiff that outweighs its benefit. Therefore, plaintiff has employed categorical logging pursuant to Local Civil Rule 26.2c. Correspondence R.E. Jane Doe, number 102 v. Jeffery Epstein, Epstein case, case number 109-80656, Siv Murrah, Johnson, Southern District of Florida. Documents withheld pursuant to the privileges asserted included communications from Ms. Jeffery to the attorneys seeking legal advice related to the Epstein case, communications from the attorneys to Ms. Jeffery giving legal advice or giving attorney mental impressions related to the Epstein case, communications sending or attaching attorney work product related to the Epstein case and or communications sending or attaching client revisions to attorney work product related to the Epstein case, and communications RE evidence. Log ID 129, email sent date 6th of the 10th, 2015, from Virginia Jeffery. Subject. Email chain with Jeffery and McCauley seeking information to assist with attorney advice. 103. No date. Subject. Letter from Virginia Jeffery to David Bowles conveying requested information to assist in providing legal advice. ID 131. Date 4th of the 30th, 2015. Brittany Henderson. Communication RE VRS registrations. 132. Date 4th, 29th, 2015. Andreas Ortiz. Email chain with McCauley, Edwards, Garvin, Henderson, Jeffery, and BSF staff. RE legal advice RE VRS communications. ID 133, 4th to 29th, 2015, Brittany Henderson. Communication RE legal advice RE VRS communications. Log ID 134, email send date 4th 17th, 2015, email from Paul Castle. Subject, email chain with Castle, McCauley, Edwards, Garvin, Belluth, Henderson, Jeffery, and BSF staff. RE legal advice RE VRS registrations. ID 135, date 4/17th, 2015, from Sigrid McCauley, same as above. ID 136, same date, Brad Edwards. Email chain with Castle, McCauley, Edwards, Garvin, Belluth, Henderson, Jeffery, and BSF staff. RE legal advice RE VRS registrations. Okay, that's the same as above. ID 137, date 2nd, 26, 2015, from Sigrid McCauley. Email chain with Jeffery and McCauley, RE non-testifying expert. ID 138, 2/26, 2015, Sigrid McCauley. Communication RE non-testifying expert. ID 139, 2nd 11th, 2016, Sigrid Macaulay. Email chain with Jeffery, Macaulay, Edwards, Pottinger, and BSF staff, RE Media Communications. ID 140. Sent 2nd 11th, 2016, Sigrid Macaulay. Email chain with Jeffery, Macaulay, Edwards, Pottinger, and BSF staff, RE Media Communications. Yep. Is it the same for those two? Yep. ID 141. Date 2nd 11th, 2016. From Stan Pottinger. Email chain with Jeffery, Macaulay, Edwards, Pottinger, and BSF staff, RE Media Communications. ID 142. 2nd of the 9th, 2016. Email chain with Jeffery and Pottinger, RE Media Communications. IDs 143 and 144 are these attachments. ID 145. Date 6th 10th, 2015. Virginia Jeffery. Email chain with Jeffery and Macaulay, RE ongoing litigation. ID 146. Date 4th 29th, 2015. Virginia Jeffery. Email chain with Henderson, Macaulay, Edwards, Garvin, and BSF staff, RE VRS Communications. ID 147. 4th of the 10th, 2015. Virginia Jeffery. Email chain with Boyan, Jeffery, Macaulay, and BSF staff, RE Legal Advice, RE VRS Registrations. ID 148. 2nd 26th, 2015. Virginia Jeffery. Email confirming legal advice, RE non-testifying expert. Log ID 149. Email sent date 2nd 11th, 2015. From Virginia Jeffery. Subject matter, email chain with Jeffery and Pottinger, RE Media Communications. Log ID 150. Sent 2nd 11th, 2015. From Virginia Jeffery. Email chain with Jeffery, Macaulay, Pottinger, and BSF staff, RE Media Communications. ID 151. Sent 1st of the 13th, 2015. Virginia Jeffery. Email chain with Pottinger and Jeffery, RE Anticipated Litigation. Log ID 152. Sent emails, letters, and other communications from January 2015 to present from Virginia Jeffery, Brad Edwards, Paul Castle, Brittany Henderson, Sigrid Macaulay, Meredith Schultz, David Bowles, Stephen Zach, Zan Pottinger, Ellen Brockman, legal assistants, professionals, retained by attorneys to aid in the rendition of legal advice. Subject matter. Plaintiff has objected that defendant's requests are overly broad and unduly burdensome, as individually logging or privileged responsive documents would be overly burdensome. Plaintiff contends that requests targeting such privileged information are not reasonably calculated to lead to the discovery of admissible evidence, are not important to resolving the issues, are not relevant to any party's claim or defense, are not proportional to the needs of the case, and creates a heavy burden on plaintiff that outweighs its benefit. Therefore, plaintiff has employed categorical logging pursuant to Local Civil Rule 26.2c. This categorical entry is regarding correspondence are a potential legal action against entities and individuals. Documents withheld pursuant to the privileges asserted included communications from Ms. Jeffery to the attorneys listed seeking legal advice related to potential lawsuits, communications from the attorneys to Ms. Jeffery giving legal advice or giving attorney mental impressions related to the lawsuits, communications sending or attaching attorney work product related to potential lawsuits, and/or communications sending or attaching client revisions to attorney work product related to potential lawsuits and communication RE evidence. Log ID 153, email send date, email and letter communications, email from the law enforcement entity, Virginia Jeffery, David Bowles, Stan Pottinger, Sigrid Macaulay, Paul Castle, Brad Edwards. Subject matter. Plaintiff has objected that defendant's requests are overly broad and unduly burdensome, as individually logging all privileged response documents. As individually logging all privileged responsive documents will be overly burdensome. Plaintiff contends that requests targeting such privileged information are not reasonably calculated to lead to the discovery of admissible evidence, are not important to resolving the issues, are not relevant to any party's claim or defense, and not proportional to the needs of the case, and creates a heavy burden on plaintiff that outweighs its benefit. Therefore, plaintiff has employed categorical logging pursuant to Local Civil Rule 26.2c. This categorical entity is regarding correspondence re the currently ongoing criminal investigation of defendant and others. Oh, we got there. Oh. Exhibit 3. United States District Court for the Southern District of New York. Jeffery v. Maxwell, 15 CV 07433 RWS. Ghislaine Maxwell's privilege log amended as of May 16, 2016. Note, per Local Rule 26.2, the following privileges are asserted pursuant to British law, Colorado law, and New York law.
Okay. Some things I'm going to omit here. The subject matter remains the same. Privilege is very similar. So I'm going to do log ID, date, the from and the to, and the CC and relationship of parties if I can. Alright, let's go. Log ID 1, date 2011-03-15, from Ghislaine Maxwell to Brett Jaff Esquire, relationship of parties, attorney-client. Log ID 2, date 2011-03-15, from Brett Jeffrey Esquire to Ghislaine Maxwell, relationship attorney-client. Log ID 3, date 2015-01-02, from Ross Go to Ghislaine Maxwell, same relationship. 4, 2015-01-02, Ghislaine Maxwell to Ross Go, attorney, agent, and client. Log ID 5, 2015-01-02, Ross Go to Ghislaine Maxwell, CC Brian Basham, same relationship. Log ID 6, 2015-01-06, from Ghislaine Maxwell to Jeffery Epstein, relationship of parties, common interest. Log ID 7, date 2015-01-06, from Ghislaine Maxwell to Jeffery Epstein and Alan Dershowitz Esquire, attorney-client. Number 8, 2015-01-10, Ghislaine Maxwell to Philip Barden Esquire and Ross Go, same relationship. Log ID 9, 2015-01-10, Ghislaine Maxwell to Philip Barden Esquire, relationship attorney-client. Log ID 10, dates 2015-01-09 and 2015-01-10, Roscoe to Philip Barden Esquire, CC Ghislaine Maxwell, relationship of parties, agent, attorney-client. ID 11, 2015-01-11, Ghislaine Maxwell to Jeffery Epstein, common interest. ID 12, 2015-01-11, Philip Barden Esquire to Roscoe, CC Ghislaine Maxwell, attorney, agent, client. ID 13, 2015-01-11, Philip Barden Esquire to Ghislaine Maxwell, CC Roscoe, same relationship. ID 14, dates 2015-01-11 and 2015-01-17. Those are two dates. No, I'll redo that. ID 14, dates 2015-01-11 to 2015-01-17. Jeffery Epstein to Ghislaine Maxwell, common interest. ID 15, 2015-01-13. Ghislaine Maxwell to Jeffery Epstein, same. 16, 2015-01-13. Philip Barden Esquire to to Martin Weinberg Esquire, common interest. ID 17, date 2015-01-13. From Philip Barden Esquire to Ghislaine Maxwell, CC Mark Cohen, attorney-client. ID 18, 2015-01-21. Roscoe to Philip Barden Esquire and Ghislaine Maxwell, agent, attorney-client. 19th, Jeffery Epstein to Ghislaine Maxwell, common interest. ID 20. Okay, I missed a date there. It'll be the same as this. 2015-01-21 to 2015-01-27. Ghislaine Maxwell to Jeffery Epstein, common interest. ID 21, 2015-04-22. Jeffery Epstein to Ghislaine Maxwell, common interest. ID 22, various dates. Agent of Haddon, Morgan and Foreman and Laura Menninger to Agent of Haddon, Morgan and Foreman and Laura Menninger. Agent of Attorney and Attorney. ID 23, date various. From Mary Borgia and Laura Menninger to Mary Borgia and Laura Menninger, attorney work product. ID 24th, dates 2015-10-21 to 2015-10-22. From Darren Indyke, Laura Menninger to Darren Indyke, Laura Menninger. Attorneys are parties to common interest agreement. Exhibit 6. United States District Court, Southern District of New York. Virginia L. Joffrey, plaintiff, v. Ghislaine Maxwell, defendant. 15 CV 07433 RWS. Defendant Ghislaine Maxwell's responses and objections to plaintiff's second request for production of documents. Defendant Ghislaine Maxwell, by and through her undersigned counsel, hereby responds to plaintiff's second request for production of documents. The requests. Preliminary statement and general objections. 1. This response is made to the best of Ms. Maxwell's present knowledge, information, and belief. Ms. Maxwell, through her attorneys of record, have not completed the investigation of the facts related to this case, have not completed discovery in this action, and have not completed preparation for trial. Ms. Maxwell's responses to plaintiff's requests are based on information currently known to her and are given without waiving Ms. Maxwell's right
to use evidence of any subsequently discovered or identified facts, documents, or communications. Ms. Maxwell reserves the right to supplement this response in accordance with Fed R. Civ P26E. 2. Ms. Maxwell objects to the request to the extent they attempt to impose any requirement or discovery obligation greater than or different from those under the Federal Rules of Civil Procedure, the local rules of this court, or any orders of the court. 3. Ms. Maxwell objects to the requests to the extent they seek documents or information protected by the attorney-client privilege, the Work Product Doctrine, Rule 408 of the Federal Rules of Evidence, any common interest privilege, joint defense agreement, or any other applicable privilege. 4. Ms. Maxwell objects to the request to the extent they seek documents or information outside of Ms. Maxwell's possession, custody, or control. 5. Ms. Maxwell objects to the request to the extent they seek information which is not relevant to the subject matter of the litigation and/or is not reasonably calculated to lead to the discovery of admissible evidence. 6. Ms. Maxwell objects to the request to the extent they are overly broad, unduly burdensome, and/or propounded for the improper purpose of annoying, embarrassing, or harassing Ms. Maxwell. 7. Ms. Maxwell objects to the request to the extent they are vague and ambiguous or imprecise. 8. Ms. Maxwell objects to the requests to the extent they seek information that is confidential and implicates Ms. Maxwell's privacy interests. 9. Ms. Maxwell incorporates by reference every general objection set forth above into each specific response set forth below. A specific response may repeat a general objection for emphasis or for some other reason. The failure to include any general objection in any specific response does not waive any general objection to that request. 10. The requests seek information that is confidential and implicates Ms. Maxwell's privacy interests. To the extent such information is relevant and discoverable in this action, Ms. Maxwell will produce such materials subject to an appropriate protective order pursuant to Fed R. Civ P26C, limiting their dissemination to the attorneys and their employees. Objections to definitions. 11. Ms. Maxwell objects to definition number 1 regarding agent to the extent that it purports to extend the meaning beyond those permissible by law. 12. Ms. Maxwell objects to definition number 3 regarding defendant. The definition is overly broad and unduly burdensome to the extent it attempts to extend the scope of the requests to documents in the possession, custody, or control of individuals other than Ms. Maxwell or her counsel. 13. Ms. Maxwell objects to definition number 5 regarding employee. Ms. Maxwell is an individual sued in an individual capacity, and therefore there is no past or present officer, director, agent, or servant of hers. Additionally, attorneys and paralegals are not employees of Ms. Maxwell, given that she herself is not an attorney and therefore cannot employ attorneys. 14. Ms. Maxwell objects to definition number 10 regarding you or your. The definition is overly broad and unduly burdensome to the extent it attempts to extend the scope of the requests to documents in the possession, custody, or control of individuals other than Ms. Maxwell or her counsel. Objections to instructions. 15. Ms. Maxwell objects to instruction number 1, in particular the definition of the relevant period, to include July 1999 to the present, on the grounds that it is overly broad and unduly burdensome, and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. The complaint at paragraph 9 purports to describe events pertaining to plaintiff and defendant occurring in the years 1999 to 2002. The complaint also references statements attributed to Ms. Maxwell occurring in July 2015, defining the relevant period as July 1999 to the present. It is vastly overbroad, irrelevant, and not reasonably calculated to lead to the discovery of admissible evidence, and as to certain of the requests, is intended for the improper purpose of annoying or harassing Ms. Maxwell, and it implicates her privacy rights. Thus, Ms. Maxwell interprets the relevant period to be limited to 1999 to 2002 and December 30th, 2014 to January 31st, 2015, except to the extent that the answers relate to any activity of defendant with respect to the practice which has been alleged and the duties alleged to be performed by defendant, activities being defined as sexual abuse or trafficking of any female, in which case her answers reflect the period 2000 to today. Ms. Maxwell specifically objects to production of any documents outside that period, except as specifically noted. 16. Ms. Maxwell objects to instruction number 3 on the grounds that it is unduly burdensome and is intended for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell cannot possibly recall the specific disposition of documents, particularly electronic documents, dating back over 16 years. However, Ms. Maxwell, prior to this litigation, has long had a practice of deleting emails after they are being read. 17. Ms. Maxwell objects to instruction numbers 5, 8, 9, 12, and 17 to the extent they seek to impose obligations to supply explanations for the presence or absence of such documents, to specifically identify persons or documents, to provide information concerning who prepared documents, the location of any copies of such documents, the identities and contact information for persons who have custody or control of such documents, the reasons for inability to produce portions of documents, and the natural person in whose possession they were found. Beyond the requirements of Rule 34. This instruction improperly seeks to propound interrogatories pursuant to Rule 33. 18. Ms. Maxwell objects to instructions number 13 on the grounds that it is unduly burdensome and is intended for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell cannot possibly recall the specific circumstances upon which a document dating back 16 years has ceased to exist. 19. Ms. Maxwell objects to instruction number 15 to the extent that it calls for documents or information protected by the attorney-client privilege, the work product doctrine, or any other applicable privilege. 20. Ms. Maxwell objects to instruction numbers 18 and 19 to the extent they require information on any privilege log above and beyond the requirements of Local Civil Rule 26.2. Specific objections and responses to plaintiff's second request for production of documents. Document request number 1. Produce all documents that your attorneys reviewed and or relied upon in the March 21, 2016 meet and confer discussion where Mr. Pegluka stated that 1. Plaintiff made false allegations concerning her sexual assault. 2. She made them in roughly the same time frame that plaintiff was abused by Jeffery Epstein. 3. That the allegations were made against a number of individuals in the area. And 4. That the allegations were found to be unfounded by local police. Response. Ms. Maxwell has no knowledge or of any statements made by Mr. Pegluka during the March 21, 2016 meet and confer, and hence has no documents responsive to this request. Further, this request inaccurately characterizes the statements of Ms. Maxwell's counsel during the March 16, 2016 meet and confer. Ms. Maxwell further objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, the common interest privilege, or any other applicable privilege. Ms. Maxwell also objects to this request to the extent it calls for information relating to Virginia Roberts Joffrey that exists within the public domain, the internet, or in public court records, and which are equally available to both parties and can be obtained from some other source that is more convenient, less burdensome, and less expensive. Subject to and without waiver of the foregoing, defendant refers to the public documents and news reports regarding plaintiff's allegations of sexual abuse and investigation of the same, which have been previously produced, are available in the public domain, or referenced in court papers. Defendant also refers plaintiff to documents within the possession, custody, and control of plaintiff and her counsel, including without limitation Mr. Bradley Edwards, which were requested in defendant's first set of discovery requests, but were not produced despite certification of plaintiff and plaintiff's counsel that such responses were truthful and complete. Without waiver of any such objections, Ms. Maxwell has made available documents related to some of Ms. Joffrey's false allegations of sexual assaults in her second supplemental Fed R Civ P 26A 1A disclosures. Document request number 2. Produce all documents concerning how any such police report or how any such recounting, retelling, summary, or description of any such police report, as referenced in interrogatory number 1, came into your possession. This request includes, but is not limited to, all documents concerning how, when, and by whom such reports, or descriptions of reports, were obtained from a minor child's sealed juvenile records and files. Response. Ms. Maxwell objects to this request in that there is no interrogatory number 1 to which the request corresponds. She further objects to the request in that it improperly seeks to propound an interrogatory in the form of a request for production of documents and is a contention interrogatory barred according to plaintiff's interpretation of the local rules. The request embeds a number of assumptions that are not true and for which plaintiff supplies no basis for assertion of their veracity. Ms. Maxwell likewise objects to this request because it seeks to documents or information protected by the attorney-client privilege, the work product doctrine, the common interest privilege, or any other applicable privilege. Finally, Ms. Maxwell also objects to this request to the extent it calls for information relating to Virginia Roberts Joffrey that exists within the public domain, the internet, or in public court records, and which are equally available to both parties and can be obtained from some other source that is more convenient, less burdensome, and less expensive. Defendant refers to the public documents and news reports regarding plaintiff's allegations of sexual abuse and investigation of the same, which have been previously produced, are available in the public domain or referenced in court papers. Defendant also refers plaintiff to documents within the possession, custody, and control of plaintiff and her counsel, including without limitation Mr. Bradley Edwards, which were requested in defendant's first set of discovery requests, but were not produced despite certification of plaintiff and plaintiff's counsel that such responses were truthful and complete. Without waiver of any such objections, Ms. Maxwell has made available documents related to some of Ms. Joffrey's false allegations of sexual assaults in her second supplemental Fed R. Civ P 26A 1A disclosures. Ms. Maxwell is withholding documents responsive to this request on the basis of the attorney-client and work product privileges. Document request number 3. Produce all documents concerning how information or knowledge of the local police's findings or opinions concerning Ms. Joffrey's allegations of sexual assault as a minor child came into your possession, including but not limited to documents concerning any statements made by law enforcement or any state attorney, written or oral concerning such allegations. Response. Ms. Maxwell objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, the common interest privilege, or any other applicable privileges. Ms. Maxwell also objects to this request to the extent it calls for information related to Virginia Roberts Joffrey that exists within the public domain, the internet, or in public court records, and which are equally available to both parties and can be obtained from some other source that is more convenient, less burdensome, and less expensive. Subject to, and without waiver of the foregoing, defendant refers to the public documents and news reports regarding plaintiff's allegations of sexual abuse and investigation of the same, which have been previously produced, are available in the public domain, or referenced in court papers. Defendant also refers plaintiff to documents within the possession, custody, and control of plaintiff and her counsel, including without limitation Mr. Bradley Edwards, which were requested in defendant's first set of discovery requests, but were not produced despite certification of plaintiff and plaintiff's counsel that such responses were truthful and complete. Without waiver of any such obligations, Ms. Maxwell has made available documents related to some of Ms. Joffrey's false allegations of sexual assaults in her second supplemental Fed R. Civ P 26A 1A disclosures. Ms. Maxwell is withholding documents responsive to this request on the basis of the attorney-client and work product privileges. Document request number 4. Produce all documents concerning any investigations, internal or otherwise, by any law enforcement or governmental agency regarding the illegal disclosure, illegal purchase, and or theft of sealed juvenile police records concerning plaintiff. Response. Ms. Maxwell objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, the common interest privilege, or any other applicable privilege. Ms. Maxwell also objects to this request to the extent it calls information related to Virginia Roberts Joffrey that exists within the public domain, the internet, or in public court records, and which are equally available to both parties and can be obtained from some other source that is more convenient, less burdensome, and less expensive. Defendant objects to this request to the extent that it characterizes the gathering of public information as illegal. Subject to and without waiver of the foregoing, defendant has been unable to locate any documents responsive to this request. Document request number 5. Produce all documents concerning any rape, sexual assault, sexual intercourse, or other sexual encounter involving plaintiff. This request includes, but is not limited to, 1. Any documents concerning any sexual assault of plaintiff while a minor, 2. Any police reports or documents concerning any police reports that were created concerning such claims of sexual assault, and 3. Documents concerning any communications received by you or your agents or attorneys by other individuals that reference any sexual assault of plaintiff while a minor. Response. Ms. Maxwell objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, the common interest privilege, or any other applicable privilege. Ms. Maxwell also objects to this request to the extent it calls for information related to Virginia Roberts Godfrey that exists within the public domain, the internet, or in public court records, and which are equally available to both parties and can be obtained from some other source that is more convenient, less burdensome, and less expensive. Subject to and without waiver of the foregoing. Defendant refers to the public documents and news reports regarding plaintiff's false allegations of sexual abuse and the investigation of the same, which have been previously produced, are available in the public domain, or referenced in court papers. Defendant also refers plaintiff to documents within the possession, custody, and control of plaintiff and her counsel, including without limitation Mr. Bradley Edwards, which were requested in defendant's first set of discovery requests, but were not produced despite certification of plaintiff and plaintiff's counsel that such responses were truthful and complete. Defendant objects to the characterization of plaintiff's documented false claims of sexual contact as rape or sexual assault. Without waiver of any such objections, Ms. Maxwell has made available documents related to some of Ms. Godfrey's false allegations of sexual assault in her second supplemental Fed RCIV P26A1A disclosures. Document request number 6. Produce any joint defense agreement entered into between you and Jeffery Epstein from 1999 to the present. Response. Ms. Maxwell objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, the common interest privilege, or any other applicable privilege. Defendant is withholding production of any such agreement on the basis of such privileges. Document request number 7. Produce any documents concerning any joint defense agreement entered into between you and Jeffery Epstein from 1999 to the present. Response. Ms. Maxwell objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, the common interest privilege, or any other applicable privilege. Defendant is withholding documents on the basis of such privileges. Document request number 8. Produce any documents concerning any of your attorneys or agents' communications with Jeffrey Epstein's attorneys or agents from 1999 to the present relating to the issue of sexual abuse of females, or any documents concerning any of your attorneys or agents' communications with Jeffrey Epstein's attorneys or agents from 1999 to the present relating to the recruitment of any female under the age of 18 for any purpose, including socializing or performing any type of work or services. Response. Ms. Maxwell objects to this request on the grounds that it is cumulative and duplicative. Ms. Maxwell has already produced documents related to her communications with Jeffrey Epstein in response to plaintiff's first request for production of documents, all of which document her denial that she did recruit any female under the age of 18 for any purpose. Ms. Maxwell also objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, the common interest privilege, or any other applicable privilege. Subject to and without waiver of the foregoing, defendant has been unable to locate any additional documents responsive to this request. Document request number 9. Produce any joint defense agreement entered into between you and Alan Dershowitz from 1999 to the present. Response. Ms. Maxwell objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, the common interest privilege, or any other applicable privilege. Subject to and without waiver of the foregoing, defendant has been unable to locate any documents responsive to this request. Document request number 10. Produce any documents concerning any joint defense agreement entered into between you and Alan Dershowitz from 1999 to the present. Response. Ms. Maxwell objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, the common interest privilege, or any other applicable privilege. Subject to and without waiver of the foregoing. Defendant has been unable to locate any documents responsive to this request. Document request number 11. Produce any documents concerning any of your attorneys or agents' communications with Alan Dershowitz's attorneys or agents from 1999 to the present. Response. Ms. Maxwell objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, the common interest privilege, or any other applicable privilege. Defendant is withholding communications between Mr. Dershowitz's counsel and defendant's counsel, which contain work product and concern joint defense or common interest matters. Document request number 12. Produce all documents concerning Virginia Joffrey, aka Virginia Roberts, whether or not they reference her by name. This request includes, but is not limited to, all communications, diaries, journals, calendars, blog posts, whether published or not, notes, handwritten or not, memoranda, mobile phone agreements, wire transfer receipts, or any other document that concerns plaintiff in any way, whether or not they reference her by name. Response. Ms. Maxwell objects to this request as overly broad, unduly burdensome, and interposed for improper purposes. Response to this request would literally entail in defense counsel reviewing for privilege every single document in their possession related to this case. Ms. Maxwell further objects to this request on the grounds that it is cumulative and duplicative. Ms. Maxwell further objects to this request as exceeding the scope of this court's March 17, 2016 order. Ms. Maxwell also objects to this request to the extent it calls for information relating to Virginia Roberts Goffrey that exists within the public domain, the internet, or in public courts records, and which are equally available to both parties and can be obtained from some other source that is more convenient, less burdensome, and less expensive. Ms. Maxwell further objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, the common interest privilege, or any other applicable privilege. Subject to the foregoing objections, Ms. Maxwell and her counsel are not going to review every document in their possession for any additional documents responsive to this request. Document request number 13. Produce all contracts, including but not limited to indemnification agreements and employment agreements between you and Jeffery Epstein, or any entity associated with Jeffery Epstein from 1999 to the present. Response. Ms. Maxwell objects to this request on the grounds that it is cumulative and duplicative and is overly broad. Ms. Maxwell further objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, the common interest privilege, or any other applicable privilege. Subject to and without waiver of the foregoing, defendant has been unable to locate any such documents. Document request number 14. Produce all documents concerning any contracts, including but not limited to indemnification agreements and employment agreements between you and Jeffery Epstein or any entity associated with Jeffery Epstein from 1999 to the present. Response. Ms. Maxwell objects to this request on the grounds that it is cumulative and duplicative and is overly broad. Ms. Maxwell further objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, the common interest privilege, or any other applicable privilege. Subject to and without waiver of the foregoing, defendant has been unable to locate any such documents. Document request number 15. Produce all documents concerning the identity or identities of the individuals or entities paying your legal fees concerning the above captioned action, and all documents concerning the identity or identities of the individuals or entities paying Roscoe or any entities associated with Roscoe for any work he performed on your behalf. Response. Ms. Maxwell objects to this request on the grounds that it seeks multiple categories of documents within a single request for production. Ms. Maxwell further objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, the common interest privilege, or any other applicable privilege. Ms. Maxwell is producing her engagement letter with her counsel in this action. Defendant has been unable to locate any additional documents responsive to this request. Document request number 16. Produce all documents concerning any action or lawsuit brought against you from 1999 to the present, including but not limited to actions or lawsuits brought in foreign jurisdictions. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell further objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, or any other applicable privilege. Subject to and without waiving the above objections, Ms. Maxwell has been unable to locate any documents responsive to this request. Document request number 17. Produce all documents concerning any statement made by you or on your behalf to the press or any other group or individual, including draft statements concerning Ms. Joffrey by you, Roscoe, or any other individual, from 2005 to the present, including the dates of any publications and, if published online, the Uniform Resource Identifier, URL, address. Response. Ms. Maxwell objects to this request on the grounds that it is cumulative and duplicative. Ms. Maxwell also objects to this request to the extent it calls for information that exists within the public domain, the internet or in public court records, and which are equally available to both parties and can be obtained from some other source that is more convenient, less burdensome, and less expensive. Ms. Maxwell further objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, or any other applicable privilege. Ms. Maxwell is not producing documents that are available in the public domain. Ms. Maxwell has been unable to locate any additional documents responsive to this request. Document request number 18. Produce all documents concerning which individuals or entities you or your agents distributed or sent any statements concerning Ms. Jeffery, referenced in request number 18, made by you or on your behalf. Response. Ms. Maxwell objects to this request on the grounds that it is cumulative and duplicative. Ms. Maxwell also objects to this request to the extent it calls for information that exists within the public domain, the internet or in public court records, and which are equally available to both parties and can be obtained from some other source that is more convenient, less burdensome, and less expensive. Ms. Maxwell further objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, or any other applicable privilege. Ms. Maxwell is not producing documents that are available in the public domain. Ms. Maxwell has been unable to locate any additional documents responsive to this request. Document request number 19. Produce all documents concerning any alleged illegal activity involving plaintiff from the relevant period. This request includes, but is not limited to, any documents concerning the Roadhouse Grill in Florida. Response. Ms. Maxwell objects to this request as vague and confusing. Ms. Maxwell is unaware of all illegal activities in which plaintiff may have been engaged in during the stated time period, and documents concerning those activities are uniquely within plaintiff's possession, custody, and control. Ms. Maxwell further objects to this request to the extent it seeks documents or information protected by the attorney-client privilege, the work product doctrine, the common interest privilege, or any other applicable privilege. Ms. Maxwell also objects to this request to the extent it calls for information relating to Virginia Roberts Guthrie that exists within the public domain, the internet or in public court records, and which are equally available to both parties and can be obtained from some other source that is more convenient, less burdensome, and less expensive. Subject to and without waiver of the foregoing, the defendant refers to the public documents and news reports regarding plaintiff's allegations of sexual abuse and investigation of the same, which have been previously produced, are available in the public domain, or referenced in court papers. Defendant also refers plaintiff to documents within the possession, custody, and control of plaintiff and her counsel, including without limitation Mr. Bradley Edwards, which were requested in defendant's first set of discovery requests, but were not produced despite certification of plaintiff and plaintiff's counsel that such responses were truthful and complete. Without waiver of any such objections, Ms. Maxwell has made available documents related to some of Ms. Jeffrey's contacts with law enforcement in her second supplemental Fed R Civ P 26A 1A disclosures. Document request number 20. Produce all documents concerning any apartment or other dwelling occupied by plaintiff from 1999 to the present, including but not limited to all documents concerning the acquisition of and payment for such dwellings. This request includes, but is not limited to, any dwelling paid for in whole or in part by defendant or Jeffery Epstein. Response. Ms. Maxwell objects to this request to the extent it calls for information that exists within the public domain, the internet, or in public court records, and which are equally available to both parties, and can be obtained from some other source that is more convenient, less burdensome, and less expensive. Ms. Maxwell is not producing documents that are available in the public domain. Ms. Maxwell is not reproducing documents already produced by her and produced by plaintiff in this action. For example, in response to defendant's first set of discovery requests to plaintiff, which requested inter alia documents related to plaintiff's residences since 1999. Without waiver of any such objections, Ms. Maxwell has made available documents related to some of Ms. Jeffrey's dwellings in her second supplemental Fed R Civ P 26A 1A disclosures. Ms. Maxwell has been unable to locate any additional documents responsive to this request. Document requests concerning punitive damages. Document request number 21. Produce all copies of the complaints in any lawsuits that you have filed in any court in which you seek damages or any other financial recovery from 2014 to the present. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendants move for a protective order with regard to this request without further conferral. Document request number 22. Produce all financial statements prepared for or submitted to any lender or investor for the past 3 years by you personally or on your behalf, or on behalf of any entity in which you hold or held a controlling interest from January 2015 to the present. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome, and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 23. Produce all W-2s, K-1s, and any other documents reflecting any income, including salary, bonuses, dividends, profit distributions, royalties, advances, and annuities, and any other form of income, including all gross and net revenue received by you directly or indirectly from January 2015 to the present. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome, and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 24. Produce all tax returns filed with any taxing entity, either foreign or domestic, from January 2015 to the present by you or on your behalf, or on behalf of any entity in which you hold or held a controlling interest at the time of filing. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome, and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding or liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 25. Produce all bank statements or other financial statements which were prepared by you on your behalf or by or on behalf of any entity in which you held an ownership interest of 10% or more at any time from January 2015 to the present. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 26. Produce all deeds and titles to all real property owned by you or held on your behalf, either directly or indirectly, at any time from January 2015 to the present. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome, and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 27. Produce all passbooks or other documents showing account balances with respect to all savings accounts, checking accounts, and savings and loan association share accounts owned by you or on which you hold a right or have held a right to withdraw funds at any time from January 2015 to the present. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 28. Produce all passbooks or other documents showing account balances with respect to all savings accounts, checking accounts, and savings loan association share accounts owned by you in whole or in partly joined as co-owner, partner, or joint venture in any business enterprise or owned by an entity in which you have or have had a controlling interest at any time from January 2015 to the present. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome, and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for the plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 29. Produce all bank ledger sheets from the internet or otherwise concerning all bank accounts in which you have a right to withdraw funds, reflecting the highest balance in said accounts from January 2015 to the present. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regards to this request without further conferral. Document request number 30. Produce all bank ledger sheets from the internet or otherwise concerning all bank accounts owned by you solely or jointly as co-owner, partner, or joint venture in any business, enterprise, or any entity in which you have or have had a controlling interest from January 2015 to the present, reflecting the highest balance in said accounts for each month from January 2015 to the present. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome, and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding or liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 31. Produce all checkbooks from all accounts on which you were authorized to withdraw funds from January 2015 to the present. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome, and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 32. Produce the 2015 and 2016 balance sheets and other financial statements with respect to any and all business enterprises of whatever nature, including not-for-profit enterprises, either foreign or domestic, in which you possess any ownership interest of 10% or more, whether a partner, joint venture, stockholder, or otherwise. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome, and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending under a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 33. Produce all corporate securities, stocks or bonds, foreign or domestic, directly or indirectly, held by you or held on your behalf or for your benefit by another individual or entity, including trusts from January 2015 to the present. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome, and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is relevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 34. Produce all accounts, receivable ledgers, or other records which set forth the names and addresses of all persons or business enterprises that are indebted to you, and the amounts and terms of such indebtedness from August 2016 to the present. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome, and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information, and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 35. Produce all copies of the partnership or corporation income tax returns for any partnership or corporation, either foreign or domestic, in which you do possess or have possessed any ownership interest of 4% or more, whether as partner, joint venture, stockholder, or otherwise, from 2014 to the present. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome, and calls for the production of documentaries that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding or liability, or resolution or dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 36. Produce all title certificates, registration certificates, bills of sale, and other evidences of ownership possessed by you or held for your beneficial interest with respect to any of the following described properties owned by you or held directly or indirectly for your beneficial interest from January 2015 to the present. A. Motor vehicles of any type, including trucks, other automobiles, and 2 or 3-wheeled vehicles, motorcycles, ATV, etc. B. Aircraft of any type, including jets, propeller planes, and helicopters. C. Boats, launches, cruisers, sailboats, or other vessels of any type. D. Real estate and real property. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of omissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 37. From January 2012 to the present, to produce all documents concerning any source of funding for the Taramar project or any other not-for-profit entities with which you are associated, including but not limited to funding received from the Clinton Global Initiative, the Clinton Foundation, aka William J. Clinton Foundation, aka the Bill, Hillary, and Chelsea Clinton Foundation, and the Clinton Foundation Climate Change Initiative. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information, and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages, until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance, pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regards to this request, without further conferral. Document request number 38. Produce all memoranda and or bills evidencing the amount and terms of all of your current debts and obligations that exist presently. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome, and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 39. Produce all records indicating any and all income, whether taxable or not, received by you from all sources from January 2015 to the present. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome, and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 40. Produce all copies of any and all brokerage account statements or securities owned by you individually, jointly with any person or entity, or as trustee, guardian, or custodian, from January 2015 to the present, including in such records data purchase and amounts paid for such securities, and certificates of any such securities. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome, and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regards to this request without further conferral. Document request number 41. Produce all records pertaining to the acquisition, transfer, and sale of all securities by you or on your behalf from January 2015 to the present. Such records to include any and all information relative to gains or losses realized from transactions involving such securities. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome, and calls for the production of documents that are irrelevant to this action, and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Document request number 42. Produce all policies of insurance having any cash value that exist or existed from January 2015 to the present, which policies you or any entity controlled by you is the owner or beneficiary. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome, and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Unnumbered request. Produce all copies of any and all trust agreements that exist or existed from January 2015 to the present in which you are the settlor or beneficiary together with such documents necessary and sufficient to identify the nature and current value of the trust. Response. Ms. Maxwell objects to this request on the grounds that it is overly broad and unduly burdensome and calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Ms. Maxwell objects to this request on the grounds that it is propounded for the improper purpose of annoying or harassing Ms. Maxwell. Ms. Maxwell's personal financial information is not at issue in this matter, and information relating thereto is irrelevant. Ms. Maxwell intends to move for a protective order regarding her personal financial information and is refusing to respond and is withholding documents under the category of document requests concerning punitive damages until the motion is resolved. Based on the May 16, 2016 conferral, counsel for plaintiff has agreed to hold this request in abeyance pending either a finding of liability or resolution of dispositive motions. Plaintiff's counsel will not file a motion to compel a response to this request, nor will defendant move for a protective order with regard to this request without further conferral. Dated May 16, 2016. Respectfully submitted, Laura A. Menninger and Co., attorneys for Ghislaine Maxwell. Certificate of Service. I certify that on May 16, 2016, I served the attached document, Defendant Ghislaine Maxwell's responses and objections to plaintiff's second request for production of documents via email to the following counsel of record: Sigrid S. McCauley, Meredith Schultz, Paul G. Castle, Bradley J. Edwards. Signed, Laura A. Menninger. United States District Court, Southern District of New York. Virginia L. Joffrey, Plaintiff, Case Number 15CV07433 RWS. V. Ghislaine Maxwell, Defendant. Response to motion to compel attorney-client communications and attorney work product materials. Plaintiff Virginia Joffrey, by and through her undersigned counsel, hereby files this response to defendant's motion to compel all attorney-client communications and attorney work product placed at issue by plaintiff and her attorneys, DE 164. The motion should be denied in its entirety. Introduction. Defendant argues Ms. Joffrey and two of her attorneys, Castle and Edwards, have somehow placed at issue her confidential attorney-client communications and therefore have made a sweeping waiver of attorney-client privileges in this case. Defendant, however, fails to cite the controlling law on this issue, Federal Rule of Evidence 502. Enacted in 2008, Rule 502 was designed to block exactly the kind of argument defendant is making. Rule 502 provides that litigants are entitled to the most protective law on attorney-client privileges, either state law where the disclosure was made or federal law. The alleged disclosures in this case were made in Florida, and under Florida law did not constitute any waiver of attorney-client privilege. Indeed, defendant does not reveal to the court that the Florida judge who handled the case, during which the alleged waivers occurred, the Dershowitz case, has already considered and rejected in their entirety the very arguments that defendant is advancing here. In addition, none of the alleged disclosures were made by Ms. Joffrey, who, as the holder of the privilege, is the only individual with authority to waive it. Moreover, none of the alleged disclosures concerned the substance of confidential attorney-client communications. And finally, Ms. Joffrey will not be seeking to introduce or otherwise take advantage of any confidential attorney-client communications in this case. Accordingly, for these and other reasons, the court should deny defendant's motion in its entirety. Factual background. The CVRA case. The facts relevant to this issue begin in 2008, when attorney Bradley J. Edwards, soon joined by co-counsel Professor Paul Castle, filed a pro bono action in the Southern District of Florida under the Crime Victims' Rights Act, CVRA, 18 U.S.C. 3771. Filed on behalf of Jane Doe No. 1 and later Jane Doe 2, the CVRA action alleged that federal government had failed to protect the rights of Jane Doe 1 and other similarly situated victims of sex offences committed by Jeffery Epstein. See Declaration of Sigrid Macaulay, Macaulay Decal at Exhibit 1. Complaint filed in Jane Doe 1 v. United States, number 908 CV 80736, ST FLA, July 7, 2008. Jane Does 1 and 2 achieved many victories in this case, including a ruling that the CVRA rights of victims could apply before charges were filed. Does 1 and 2 v. United States, 817 F Sub, 2nd District, 1337, ST FLA, 2018, I think that's Florida, that they had standing to challenge the non-prosecution agreement reached between the government and Epstein. Jane Does 1 and 2 v. United States, 950 F Sub, 2nd District, 1262, ST Florida, 2013, and that plea negotiations were not protected from disclosure by any federal rule of evidence. Does v. United States, 749 F 3D 999, 11th Circuit, 2014. Congress has also followed the developments in this case closely, recently amending the CVRA to ensure that in the future, crime victims receive notice of any non-prosecution agreement entered into by the government. See Pub L 114-22, Title 1 113 A, C1, May 29, 2015, 129 Stat 240-241, adding 18 U.S.C. 3771A9 to give crime victims the right to be informed in a timely manner of any plea bargain or deferred prosecution agreement. Note: see generally Paul G. Castle, Nathaniel J. Mitchell, and Bradley J. Edwards, Crime Victims' Rights During Criminal Investigations? Applying the Crime Victims' Rights Act before criminal charges are filed, 104 J. Crim. L. and Criminology 59, 2014. On December 30th, 2014, Castle and Edwards filed a motion pursuant to Rule 21 for joinder in the action on behalf of two additional victims, Jane Doe No. 3 and Jane Doe 4. Jane Doe 3, Virginia Joffrey, subsequently decided to reveal her name. The joinder motion argued that Jane Does 3 and 4 should be allowed to join the two existing plaintiffs in the action because they had suffered the same violations of their rights under the CVRA. Macaulay Decal, Exhibit 2, Jane Does 3 and 4, joined a motion. To establish that they were victims of Epstein's sex crimes with standing to join the suit, Jane Does 3 and 4 alleged that they had suffered sexual abuse from Epstein. For example, Jane Doe 3 alleged that she had been forced by Epstein to have sexual relations with various persons, including Alan Dershowitz, who had been one of Epstein's defense attorneys negotiating the non-prosecution deal and arranging to keep it secret from the victims. Macaulay Decal, Exhibit 2 at 4. Jane Doe 3 also alleged that defendant, i.e. Ghislaine Maxwell, had participated in the sexual abuse of Jane Doe 3, ID at 4-5. After Dershowitz also filed a motion to intervene to contest the allegations, DE 282, Jane Doe 3 filed a response to Dershowitz's intervention motion. Macaulay Decal, Exhibit 3, response to motion to intervene. The response explained that the allegations against Dershowitz were relevant to at least 8 separate issues in the CVRA case, ID at 18-26. The response also explained some of the evidence supporting the allegations against Dershowitz, including sworn testimony from one of Epstein's household employees, Juan Alessi, that Dershowitz came pretty often to Epstein's Florida mansion and got massages while he was there. Side notes. The joinder motion attached as an exhibit is a corrected motion, filed on January 2, 2015. As discussed below, several paragraphs in this motion were later stricken by Judge Murrah. Also, this document is currently restricted under seal in the CVRA case, although in order sealing it is not found in the court record so far as can be determined. In light of the sealing of the document, we have marked aspects of this pleading dealing with the document as confidential. Continuing. Sworn testimony from another of Epstein's household employees, Alfredo Rodriguez, that Dershowitz was present alone at the home of Epstein without his family in the presence of young girls. Invocations of Fifth Amendment rights to remain silent by 3 of Epstein's identified co-conspirators, Sarah Kellen, Nadia Marcinkova, and Adriana Bukinska, when asked questions about whether Dershowitz had been involved with massages by young girls. Refusals by Jeffrey Epstein to discuss Dershowitz's involvement, but instead to revoke his Fifth Amendment right. ID 26-38. Several months later, on April 7, 2015, the court, Mara J., denied Jane Doe 3 and Jane Doe 4's motion for joinder. Macaulay Ducal Exhibit 4 order denying Jane Doe 3's motion to join. With regard to the 8 separate issues as to which the allegations against Dershowitz were relevant, the court addressed only the first, establishing victim status, and found that the factual details regarding with whom and where the Jane Does engaged in sexual activities are immaterial and impertinent to this central claim, i.e. that they were known victims of Mr. Epstein and the government owned them, CVRA duties, especially considering that these details involve non-parties who are not related to the respondent government, ID at 5. Accordingly, the court struck the factual details from the victims' pleading as unnecessary at that time. The court specifically recognized, however, that the details could be reasserted by the parties to the action, i.e. Jane Doe 1 and Jane Doe 2, if they could demonstrate a good faith basis for believing that such details are pertinent to a matter presented for the court's consideration, ID at 6. Following the court's ruling, additional litigation has proceeded in the CVRA case. Note: in asserting that the non-parties were not related to the respondent government, the court did not address Jane Doe 3's argument that Dershowitz, as one of Epstein's defense counsel, had helped negotiate the non-prosecution agreement and helped to arrange to keep it secret from the victims. The Dershowitz case. While the CVRA case was moving forward in the Southern District of Florida on behalf of Jane Does 1 and 2, separate litigation developed between the pro bono attorneys who had filed the lawsuit, Castle and Edwards, and Dershowitz. After the filing of the jointer motion in the CVRA case, Dershowitz took the airwaves to attack not only Jane Doe 3 but also Castle and Edwards. Typical of these attacks was one levelled on CNN, in which Dershowitz alleged if they, Castle and Edwards, had just done an hour's worth of research and work, they would have seen she is lying through her teeth. They're prepared to lie, cheat, and steal. These are unethical lawyers. They can't be allowed to have a bar card to victimize more innocent people. Hala Gorani, CNN Live, Jan 5th, 2015. Castle and Edwards then filed a state law defamation action against Dershowitz in Broward County, Florida. See Macaulay Ducal Exhibit 5, Complaint in Edwards and Castle v. Dershowitz. The complaint alleged that Dershowitz had engaged in a massive public media assault on the reputation and character of Castle and Edwards, ID at 4. Ms. Joffrey was not a party to this defamation lawsuit. The Florida court rejects a waiver of attorney-client's privilege argument. As Castle and Edwards' Florida defamation action moved forward, Dershowitz sought to make an argument that they had somehow waived their client's, Ms. Joffrey's, attorney-client privilege. On September 8, 2015, Dershowitz filed a motion to compel Castle and Edwards to produce documents and additional responses to interrogatories. Macaulay Ducal Exhibit 6, Motion to Compel. In his motion, Dershowitz argued that Castle and Edwards have waived any privilege or protection that would otherwise attach to responsive documents and information. Note: available at http://www.cnn.com/videos/world/2015/01/05 WRN UK Sex Abuse Allegations Alan Dershowitz interview.cnn. By bringing this defamation action, placing at issue the truthfulness of Jane Doe No. 3's allegations against Dershowitz, ID at 3 to 5, in his motion and replying pleading Macaulay Ducal Exhibit 8, reply in support of motion to compel, Dershowitz argued that Castle and Edwards' actions throughout the case constituted a waiver of attorney-client privilege. Castle and Edwards responded, arguing that Miss Jeffery was not a party of the defamation action and that she was the only person who could waive her privilege. Macaulay Decal, Exhibit 7 at 4-6, responds in opposition to motion to compel. Castle and Edwards also argued that there had been no waiver because confidential attorney-client communications with Miss Jeffery were not at issue in the defamation case. ID at 6-9. Castle and Edwards also later filed a surreply, further elaborating on the argument that Miss Jeffery had not waived any attorney-client privilege by publicly discussing her sexual abuse by Epstein and his associates. Macaulay Decal, Exhibit 9, surreply in support opposition to motion to compel. Castle and Edwards also explained that communications with Miss Jeffery were protected not only beginning in March 2014, but even earlier than that date, when Miss Jeffery understood that she was obtaining legal services from Castle and Edwards, ID at 1. Following this extensive briefing on waiver issues, on December 8, 2015, the Florida court, Lynch J., ruled denying Dershowitz's argument that attorney-client privileges had been waived. Macaulay Decal, Exhibit 10, order denying motion to compel. Specifically, the court denied the motion to compel, explaining pre-March 2014 communications are protected by the work product privilege and the witness has not waived the communications that were protected by the attorney-client privilege. Also, there was no waiver by the Castle and Edwards by filing suit, ID at 1. Note, and following the filing of Castle and Edwards' summary judgment motion filed on November 26, 2015. Ms. Jeffery's deposition in the defamation case. As the defamation action moved forward, Dershowitz subpoenaed Ms. Jeffery to a deposition. Macaulay Decal, Exhibit 11, composite exhibit of excerpts from transcript of deposition of Ms. Jeffery. During the deposition, held in Fort Lauderdale, Florida, Ms. Jeffery was represented by the undersigned legal counsel, who asserted objections to revealing attorney-client information, where the questions called for revealing confidential attorney-client communications. CEG ID at 22-23, 131-32, 173-74, 183, and 208. During the deposition, Ms. Jeffery specifically stated that, "I decide not to waive my attorney-client privilege at this time." ID at 174. Ms. Jeffery also denied that Castle and Edwards had ever pressured her into identifying someone as being involved in her sexual abuse. ID at 200-12. The settlement of the defamation case. Ultimately, Castle, Edwards, and Dershowitz agreed to settle their defamation case. That settlement included both a public statement and confidential monetary payments. As part of the settlement, Castle and Edwards withdrew their allegations against Dershowitz in the defamation case contained in the then-pending summary judgment motion. Macaulay Decal, Exhibit 12, Notice of Withdrawal of Summary Judgment Motion. As explained in the notice of withdrawal of this motion, the withdrawal of the reference filings is not intended to be, and should not be construed as being, an acknowledgement by Edwards and Castle that the allegation made by Ms. Jeffery were mistaken. Edwards and Castle do acknowledge that the public filing in the Crime Victims' Rights Act case of their client's allegation against defendant Dershowitz became a major distraction from the merits of the well-founded Crime Victims' Rights Act by causing delay and, as a consequence, turned out to be a tactical mistake. ID. All these actions settling the Florida defamation case took place in Florida. Legal standards for waiver. A. Federal Rule of Evidence 502 controls on the issue of waiver. Defendant asked this court to find that Ms. Jeffery has somehow waived her attorney-client privilege regarding various communications in this case. This is no small step. The attorney-client privilege is one of the oldest recognized privileges for confidential communications. Swidler and Berlin v. United States, 524 U.S. 399, 403, 1998. The privilege's purpose is to encourage full and frank communication between attorneys and their clients, and thereby promote broader public interests in the observance of law and the administration of justice. 524 U.S. at 403, internal quotation marks omitted. In setting out the legal standards pertaining to waiver of attorney-client privilege, defendant fails to cite the controlling and protective law on the issue. In a federal case, issues of alleged waiver of attorney-client privilege must be resolved under the new standards in Federal Rule of Evidence 502.
In 2008, Congress enacted Federal Rule of Evidence 502, which is entitled Attorney-Client Privilege and Work Product, Limitations on Waiver. New Rule 502 places a number of protections in place to reduce litigation over claims that a party has somehow waived attorney-client privilege. See generally. Advance Com Notice Rule 502. Notably, defendant does not discuss or even cite Rule 502 in her motion. The issue currently before the court is specifically controlled by Rule 502C, which covers situations where a disclosure in a state proceeding is alleged in a federal proceeding to establish waiver. Rule 502C provides the greater of protections found in federal or state law. C. Disclosure made in a state proceeding. When the disclosure is made in a state proceeding and is not the subject of a state court order concerning waiver, the disclosure does not operate as a waiver in a federal proceeding if the disclosure 1. Would not be a waiver under this rule if it had been made in a federal proceeding, or 2. Is not a waiver under the law of the state where the disclosure occurred. As is readily apparent from the text of the rule, there are two separate ways in which a party can prove that no waiver of attorney-client privilege has occurred. 1. By demonstrating that no waiver exists under federal law, or 2. By demonstrating that no waiver exists under the state law where the disclosure occurred. Between these two possibilities, the drafters of the rule decided to apply the most protective law that governs waiver. See Fed R. Evid, 502C, and Com Notes. The Advisory Committee on the Federal Rules of Evidence determined that the proper solution for the federal court is to apply the law that is most protective of privilege and work product. Emphasis added. B. Florida law. Florida's protective law on the attorney-client privilege provides that neither an attorney nor a client may be compelled to divulge confidential communications between a lawyer and client, which are made during the rendition of legal services. Florida State An 90-502-1C. Communication denotes more than just giving legal advice. It also includes giving information to the lawyer to enable him to render sound and informed advice. Hagens v. Gatorland, Kubota, LLC Century Inns, 45, So 3D 73 and 76, Florida 1st, DCA 2010. Under Florida law, while the burden of establishing the attorney-client privilege usually rests on the party claiming it, First Union National Bank v. Turney, 824, SO2D 172185, FLA 1st DCA 2002, when communications appear on their face to be privileged, the burden is on the party seeking disclosure to prove facts which will make an exception to the privilege applicable. Ford Motor Co. v. Hall Edwards, 1997, So 2D 1148-1153, FLA 3D DCA 2008. Russo v. Harnon, 468, So 3D 66-70, FLA 3D DCA 2014. In this case, defendant does not appear to dispute that an attorney-client privilege exists with regard to the communications between Miss Jeffery and her attorneys. Rather, defendant's argument is that the privilege has somehow been waived. See motion to compel at 1-2. Therefore, under Florida law, defendant must shoulder the burden of overcoming the privilege. Of course, because defendant failed to even cite, much less discuss Florida law, she has not carried that burden. Defendant asserts that she can force disclosure of the privileged communications between Miss Jeffery and her counsel under the at-issue doctrine. To establish this alleged waiver, defendant's motion relies on a federal district court case, Herm v. Ray, 68 FRD 574 ED Wash, 1975, which was cited in Bank Brussels Lambert v. Credit Lyonnais, Suisse, SA 210 FRD 506 509-10, SDNY 2002, LSMJ, see motion to compel at 8. As discussed below, as a matter of controlling federal authority, these cases have been repudiated by the Second Circuit. And to the same effect, Florida law also rejects the expensive Hearn approach to waiver. See Guarantee Inns Co. v. Heffernan Inns Brokers Inc., 300 FRD 590, 593-95, ST FLA 2014. Discussing Florida authorities, Florida law disfavors waiver of the attorney-client privilege and will not readily find an at-issue waiver. See Guarantee Inns Co. v. Heffernan Inns Brokers Inc., 300 FRD 590, 593, ST FLA 2014,
citing Coates v. Ackerman, Censored and Edison, PA 940, SO2D 504, 508, Fleur 2nd DCA 2006, refusing to find waiver based on the at-issue doctrine. In contrast to Hearn, under Florida law, at-issue waiver only occurs when a party raises a claim that will necessarily require proof by way of a privileged communication. Coates 940, So 2D at 508, quoting Jenny v. Airdata Women, Inc., 846, So 2D 664, 668, Fleur 2nd DCA 2003, emphasis in original. Indeed, in 2014, the Southern District of Florida rejected the Hearn at-issue analysis and instead adopted the analysis of the Third Circuit as outlined in Ron Poulenc, Rora Inc. v. Home Indemnity Co. 32 F 3D 851, 3rd District, 1994. Guarantee Inns 300 FRD at 395. The Third Circuit deemed the Hearn test to be of dubious validity because, although it dresses up its analysis with a checklist of factors, it appears to rest on a conclusion that the information sought is relevant and should in fairness be disclosed. ID at 864. The Third Circuit specifically rejected Hearn because relevance is not the standard for determining whether or not evidence should be protected from disclosure as privileged. Roan 32 F 3D at 863. Florida law tracks that of the Third Circuit. See 300 FRD at 593-95, citing Florida case law. Also under Florida law, the client, not her attorneys, holds the attorney-client privilege. See Fleur Stat An 90.5023. See also Fleur Stat An 90.5022. A client has a privilege to refuse to disclose and to prevent any other person from disclosing the contents of confidential communications when such other person learned of the communications because they were made in the rendition of legal services to the client. Some Florida courts have even recognized serious due process issues could be created by a procedure through which a client lost their privilege without an opportunity to be heard in the proceedings. See e.g. Rogers v. State, 742, So 2D 827, 829, Fleur 2D DCA 1999. Under Florida law, so long as a client has a reasonable expectation of privacy in the communication, under 90.502, the privilege is protected. McQuarters v. State, 36, So 3D 613, 636, Fleur 2010. Also under Florida law, only the client, not her attorney, can waive attorney-client privilege. See Savino v. Luciano, 92, So 2D 817, Fleur 1957, Coates v. Ackerman, Centerfit and Edison, PA 940, So 2D 504, Fleur 2D DCA 2006, and Genovese v. Provident Life and Accident Inns Co. 74, So 3D 1064, Fleur 2011. C. Federal law. Rather than discuss Florida privilege law, defendant exclusively cites federal case law. See Motion to Compel at 2-3, Table of Authorities citing early federal cases. Yet as this court has previously held in ruling on an earlier privilege motion made by defendant, state law generally provides the rule of decision in this diversity case. See Jeffery v. Maxwell DE 135 at 6 2016 WL 175918 at 6 applying New York privilege law, citing Allied Irish Banks versus Bank of AM, NA 240 FRD 96102 SDNY 2007. Because this court's subject matter jurisdiction is based upon diversity. State law provides the rule of decision concerning the claim of attorney-client privilege. Accordingly, an argument can be made that New York state law applies in this case, but defendant does not explain why she jumps to federal law. As explained above, in the particular context of a waiver argument, Federal Rule of Evidence 502 applies the more protective of state law or federal law in determining whether a waiver of privilege has occurred. In this case, the controlling federal law is at least as protective as Florida law. The controlling federal law here comes from the Second Circuit, including Inri Sinti of Erie, 546 F3D 222, Second Circuit, 2008, a case not even cited, much less discussed, by the defendant. In view of the importance of the attorney-client privilege, the Second Circuit, in that case, held that any finding of waiver should be made with caution, ID at 228. Rather than cite this controlling Second Circuit precedent, defendant relies on a 2002 case from this court applying the Hearn at-issue doctrine. See motion to compel at 8, citing Bank Brussels Lambert v. Credit Lyonnaise Suisse, SA 210 FRD 506, 509-10, STNY 2002. Ellis, Magistrate Judge, quoting Hearn v. Ray, 68 FRD 574, 581, ED Wash, 1975. Defendant goes on to argue that courts have generally applied the Hearn at-issue doctrine liberally, finding a broad waiver of attorney-client privilege where a party asserts a position, the truth of which can only be assessed by examination of the privileged communication. Motion compel at 8, internal quotation admitted. Defendant fails to recognize that the Second Circuit has explicitly disavowed the Hearn doctrine. In re Cinti of Erie, 546 F 3D 222, Second Circuit 2008, the Second Circuit explained that courts in our circuit and others have criticized Hearn and have applied its tests unevenly. ID at 227-28. Note: as a protected matter, Ms. Jeffery will also provide citations to New York state authorities in this response. The Second Circuit also noted that the Hearn test has been subject to academic criticism. See e.g. Richard L. Marcus, The Perils of Privilege, Waiver and the Litigator. 84, Mitch L. Rev, 1605, 1628-29, 1986. Note developments in the law privileged communications. 98, Harv L. Rev, 1650, 1641-42, 1985, identifying the faults in the Hearn approach. In light of these strong criticisms of Hearn, the Second Circuit decided that we agree with its critics that the Hearn test cuts too broadly and therefore conclude that the District Court erred in applying it here. Nowhere in the Hearn test is found the essential element of reliance on privileged advice in the assertion of the claim or defense in order to effect a waiver. 546 F3D at 229, emphasis added. The Second Circuit held that for an at-issue waiver to occur, a party must rely on privileged advice from his counsel to make his claim or defense. ID, emphasis added. In light of the Second Circuit's holding, recent cases from this court have explained that reliance on privileged advice in the assertion of the claim or defense is an essential element of a claim of waiver. Aristocrat Leisure Limited v. Deutsche Bank Trust Co. Americas. Number 04 Civ 10014 PKL 2009 WL 3111766 at 16 SDNY Sept 28, 2009. For the sake of completeness, it may be relevant to note that New York state privilege law applies the same. Note: the Second Circuit cited numerous cases, including cases from this court, e.g. Perea v. United Jersey Bank, NOS 94 Civ 1565 and 94 Civ 1844, 1997 WL 773716 at Free, SCNY December 11, 1997. Hearn is a problematic insofar as there are very few instances in which the Hearn factors, taken at face value, do not apply and therefore a large majority of claims of privilege would be subject to waiver. Allen v. West Point Paprelli, Inc., 848 F. Sup. 423, 429, SDNY 1994, noting that district courts within this circuit have reached conflicting decisions in the application of Hearn and rejecting reliance. Upon a line of cases in which courts have unhesitatingly applied a variation of the Hearn balancing test, Connell v. Bernstein Macaulay, Inc., 407 F. Sub. 420, 422, SDNY 1976, the actual holding in Hearn is not in point because the party there asserting the privilege has expressly relied upon the advice of counsel as a defense to the plaintiff's action. Rome Poulenc, Rora Inc. v. Home Indem Co., 32 F3D 851 864, 3rd Circuit 1994, deeming Hearn to be of dubious validity because, although it dresses up its analysis with a checklist of factors, it appears to rest on a conclusion that the information sought is relevant and should be, in fairness, be disclosed. Additional note. The Aristocrat Leisure case accordingly rejected a party's reliance on the same authority that defendant relies upon here. See Aristocrat, 2009, WL 3111766 at 16 and 6 discussing Bank Brussels Lambert v. Credit Lyonnais Suisse. SA 210 FRD 506 SDNY 2010, and then noting in the next sentence that the Hearn test relied upon by Bank Brussels recently has been criticized by the Second Circuit on this very issue. Continued. Specific and protective standard. See in RE Bank of New York, Mellon, 42 MISC, 3D 171 177 977, NYS2D 560 565, SOP CT 2013. At-issue waiver occurs when the party has asserted a claim or defense that he intends to prove by use of the privileged materials. An example of an affirmative act that does constitute at-issue waiver of privilege is a party's asserting as an affirmative defense its reliance upon the advice of counsel.
Discussion. 1. Ms. Joffrey did not waive her attorney-client privilege when Edwards and Castle filed and pursued their own defamation action against Alan Dershowitz. Defendant's lead argument is that Castle and Edwards waived Ms. Joffrey's attorney-client privilege when they filed and pursued a defamation action against Alan Dershowitz. See Motion to Compel at 10. This claim is meritless for numerous reasons, including the fact, not disclosed by defendant, that this very argument has been fully litigated before the Florida court handling that defamation action, which specifically rejected any finding of waiver. A. The Florida court presiding over the defamation action has already rejected the same waiver claim that defendant is advancing here. The claim that Castle and Edwards somehow waived Miss Joffrey's attorney-client by pursuing their own personal defamation action against Dershowitz has already been the subject of extensive briefing, and, ultimately, a Florida court ruling. Defendant has scoured the docket in the Dershowitz defamation case to collect every flyspeck of information that she believes supports her argument that the waiver has taken place. Note, New York and federal authorities also hold that when attorneys are not acting on the client's behalf, they cannot waive their client's privilege. NYCPLR number 4503A, Dylan Beck versus Hess, 73 New York, 2nd District, 278, 290, 536, NE2D 1126, 1134, NY 1989. The sine qua non of any evidentiary privilege is that it is personal to and can only be waived by the privilege holder. See also in Re von Bülow, 828 F2D 94 100-201, 2D Circ 1987. Of course, the privilege belongs solely to the client and may only be waived by him. An attorney may not waive the privilege without his client's consent. In Re Bank of New York, Mellon Court, Forex Transactions, Litic, 66F Sup, 3D 406410, STNY 2014, same, Ferreria v. Capital Specialty Inns Corp, 31 MISC 3D 1209A, 929 NYS 2D 1999, NY Subcourt 2011, CPLR 4503 makes clear that an attorney cannot waive the attorney-client privilege. Rather, waiver is only effective when done by the beneficiary of the privilege on their personal representative. See Motion to Compel at 10 to 12 and numerous associated exhibits. But, remarkably, she has not revealed to this court the most relevant information from the docket, that the Florida court considered the same waiver issues and rejecting the same arguments that the defendant now advances. This Florida court ruling, applying Florida law, is controlling here. As discussed above in the factual section of this response, in the Florida case, Dershowitz filed a motion to compel advancing legal and factual arguments identical to those the defendant is advancing here. See Macaulay Decal, Exhibit 6 at 3, Dershowitz motion to compel, arguing that Castle and Edwards have waived any privilege or protection that would otherwise attach to responsive documents, and information by bringing this defamation action, placing at issue the truthfulness of Jane Doe No. 3's allegations against Dershowitz. ID at 3, citing Hearn v. Ray, 68 FRD 574-581 ED Wash, 1975. Dershowitz claimed that information Ms. Joffrey had confidentially provided to Castle and Edwards as her attorneys had become at issue in the defamation action. Macaulay DeCal, X6 at 4-5. Dershowitz argued broadly that a whole host of alleged attorney-client communications were at issue in this case, including 1. Jane Doe No. 3's allegations against Dershowitz, asserted in the action captioned Jane Doe No. 1 et al. V. United States of America, case number 08CV 80736, SD FLA, the federal action. 2. Castle and Edwards' investigation into Jane Doe No. 3's allegations against Dershowitz. 3. Castle and Edwards' assertion in the complaint that Dershowitz was an alleged participant in the criminal conduct committed by Jeffery Epstein, and 4. Jane Doe No. 3's whereabouts and activities during the time when she claims to have been sex slave for Epstein. X6 at 3. As the briefing on the issue continued, in an October 26, 2015 response filing, Dershowitz argued that Ms. Joffrey's public statements waived the privilege, along with actions by her attorneys Castle and Edwards, X8 at 5-8. After all these arguments were fully briefed, the Florida court, Lynch J., rejected Dershowitz's arguments that any waiver of the attorney-client privilege had taken place. Macaulay DeCal, X10 at 1, defendant/counterclaim plaintiff's motion to compel production of documents and complete responses to interrogatories is hereby denied. In a December 8, 2015 order, Judge Lynch provided a short explanation of his reasoning and entered an order denying Dershowitz's waiver motion, ID. In her pending motion to compel, defendant recycles the same arguments that Dershowitz made, such as the claim that Castle and Edwards waived privilege by filing suit, motion to compel at 10, that her March 2011 interview with Scarola and Edwards was a waiver, ID at 10, and other similar claims, ID at 11 to 13. But Dershowitz already litigated these issues a few months ago in the Dershowitz case, and his claims were rejected by the Florida court. Defendant is now collaterally estopped from relitigating these identical issues here because Dershowitz had a full and fair opportunity to litigate those issues, and defendant was in a common interest agreement with Dershowitz at the time. The doctrine of collateral estoppel protects litigants and the courts from relitigating identical issues and promotes efficiency by barring unnecessary litigation. See Park Lane Hosiery Co., Inc. v. Shaw, 439 U.S. 322, 326, 1979. As this court has explained, for collateral estoppel to apply, there must have been a full... I'm going to pause here for notes. Note. Dershowitz specifically listed the following public statements by Ms. Joffrey as illustrations of how she had waived their privilege. 1. Ms. Joffrey's March 5, 2011 interview with the Daily Mail. 2. Ms. Joffrey's April 7, 2011 recorded telephone interview with attorneys Jack Scarola and Brad Edwards. 3. The January 2015 release of Ms. Joffrey's diary by Radar Online. 4. Ms. Joffrey's statements to numerous other third parties, including former boyfriends and the FBI. And 5. Ms. Joffrey's filing of this suit against defendant. X6 at 6 to 8. Other note. Dershowitz specifically argued that, among other illustrations, Castle's answers to interrogatories and testimony at his deposition in the case had waived privilege. X6 at 11 to 12. Continuing on. And fair opportunity to litigate the decision that now controls and the issue in the prior action must be identical to and decisive of the issue in the instant action. Zois v. Cooper, 268 BR 890 893 STNY 2001, Affert sub nom in Resor, 73F, Approx 509, 2nd Circuit 2003. A non-party can be bound by a decision, so long as her interests were effectively represented. Zoes 268 BR at 893. As this court can readily determine from reviewing the pleadings Dershowitz filed in the Florida case, see Macaulay DeCal at X6 and 8, Dershowitz fully briefed identical issues to those presented here. And he was effectively representing Maxwell at the time. The elements of collateral estoppel apply. Moreover, entirely apart from collateral estoppel doctrine, Judge Lynch's decision is highly persuasive. Judge Lynch was the presiding judge over the Dershowitz matter, so he was so he was intimately familiar with, for example, what matters were at issue in that particular case. Moreover, Judge Lynch is, of course, a Florida judge, skilled in applying Florida legal principles. His ruling on whether a waiver of attorney-client privilege existed under Florida law should be given heavy weight here. See Elliott Associates LP v. Blanco de la Nacion, 194 F 3D 363 370, 2nd Sir, 1999. Finally, defendant's briefing entirely ignores even the existence of Judge Lynch's ruling. In such circumstances where the defendant has failed to offer any reason for questioning Judge Lynch's holding, this court should follow Judge Lynch's lead and hold that no waiver of the attorney-client privilege exists under Florida law. And because Florida law controlled when the disclosures took place, under Fed R. Evid 502C, no waiver exists in this proceeding. Note: Zwar relied on New York law. Florida law is to the same effect as is federal doctrine. C. O'Brien v. Fed Trust Bank FSB 727, So 2D 296-298, Flad Dist, CT App 1999. Collateral estoppel prevents relitigation of issues where the identical issues previously have been litigated between the parties or their privies. Montana v. United States, 440 U.S. 147, 153-54, 1979. Continuing. B. Actions by Castle and Edwards do not waive Ms. Joffrey's attorney-client privilege. Not only has Judge Lynch already ruled on the attorney-client privilege issue, but his ruling was entirely correct. Defendant's argument rests on the proposition that Castle and Edwards had authority to waive Ms. Joffrey's privilege while they pursued their Florida defamation action. But in filing their own personal defamation claims against Dershowitz in a lawsuit where Ms. Joffrey was not a party, Castle and Edwards were not acting on Ms. Joffrey's behalf. Defendant never attempts to even explain, much less prove, how that defamation action could have benefited Ms. Joffrey. And Florida law is clear that when attorneys are not acting on their client's behalf, they cannot waive their client's privilege. See Charles W. Earhart, 1 Flat Pract, Evidence 502.6, 2015 ED, Shetler v. Shetler, 239, so S2D, 5152, Flat 4th DCA 1970. To find that an attorney waived his client's privilege, a clear record must exist concerning the attorney's attorney to waive privilege. See Bus Integration Service, Inc. v. AT&T Corp. number 06 Civ 1863, JGK, 2008 WL 318343 at 2 SDNY Feb 4th, 2008. Here, to the contrary, the record is clear that Miss Joffrey did not authorize any waiver of her attorney-client privilege. See Macaulay de Cull, Exhibit 13, Affidavit of Miss Joffrey. Miss Joffrey did not authorize any waiver. Accordingly, under Florida law, Castle and Edwards' actions did not waive Miss Joffrey's privilege. The main examples defendant offers in support of her waiver argument come from a summary judgment motion that Castle and Edwards filed. See Motion to Compel at 16. Note: for the sake of completeness, it is worth noting that both federal law and New York state law likewise require that a client waive attorney-client privilege. See e.g. Schnell vs. Schnall, 550 F. Sup. 650 653 SCNY 1982. No waiver of attorney-client privilege where attorney testified at hearing without presence or authorization of client. NYCPLR 4503 McKinney. Unless the client waives the privilege, an attorney shall not disclose or be allowed to disclose such communication, nor shall the client be compelled to disclose such communication in any action, disciplinary trial or hearing, or administrative action, proceeding or hearing conducted by or on behalf of any state, municipal or local governmental agency, or by the legislature of any committee or body thereof. Of course, that motion was filed on their behalf, not Ms. Joffrey's. To be sure, that motion contained, among other supporting information, a sworn affidavit from Miss Joffrey. But the routine step of submitting an affidavit is not a waiver of attorney-client protections, as discussed at greater length in Part 2D, Infra. And in any event, defendant does not include that affidavit among her supporting materials to her motion, much less explain how the recitation of factual information in that affidavit constitutes a waiver by Miss Joffrey with respect to communications with her attorneys. See Coon v. State, 463, so SD 201 and 203 to 204. FLA 1985. No waiver when the client merely discloses facts which were part of the communication with the client's attorney. Ms. Jeffery has not waived her privilege. C. Ms. Jeffery's confidential communications with her attorneys were never at issue in the Florida Dershowitz litigation. Defendant's argument that Ms. Jeffery's attorney-client privilege has been waived under the at-issue doctrine also fails under Florida law because her confidential communications were never at issue in the Dershowitz litigation. Florida law on when confidential attorney-client communications are at issue comes from the Florida Supreme Court's decision in Savino v. Luciano, 92 SOSD 817, flat 1957. There, the Florida Supreme Court announced the test for determining whether confidential communications were at issue, as whether a claim or defense would necessarily require that the privileged matter be offered in evidence, IOD at 819, emphasis added. See also Diaz-Verzon v. Warbridge, Oldinger Co. 54 SO3D 1007 1011 FLA 2D DCA 2010. Note, the evidentiary support for the summary judgment motion rested on 16 additional exhibits, including such obviously non-privileged materials as a Palm Beach Police Department report, flight logs from Epstein's jet, excerpts from Deposition Testimony of Epstein, Juan Alessi, Alfredo Rodriguez, and Alan Dershowitz, photographs and Epstein's telephone directory. See Menninger de Cal XE at 28. Continuing. More recent decisions from Florida have emphasized that Savino does not mean that a party waives attorney-client privilege merely by bringing or defending a lawsuit. Coates v. Ackerman, Setterfitt and Edison, PA, 940 SO2D 504, FLA 2D DCA 2006. Instead, waiver occurs only when a party must necessarily use the privileged information to establish its claim or defense. ID at 510-11, emphasis added. Most recently in Giovesi v. Provident Life and Accident Inc. Co. 74 SO3D 1064 1069 FLA 2011 as revised on denial of Reg. Nov 10, 2011, the Florida Supreme Court cited both Coates and Savino to hold that the at-issue doctrine allows discovery of privileged material only when the holder of the privilege, the client, raises the advice of counsel as a claim or defense in the action, and the communication is essential to the claim or defense, ID. Under these restrictive standards, Ms. Jeffery's communications were never at issue in her attorney's personal defamation case against Dershowitz. Consider, for example, a typical allegation Castle-Edwards complaint. Immediately following the filing of what defendant, Dershowitz, knew to be an entirely proper and well-founded pleading, Dershowitz initiated a massive public media assault on the reputation and character of Bradley J. Edwards and Paul G. Castle, accusing them of intentionally lying in their filing, of having leveled knowingly false accusations against the defendant. Dershowitz, without ever conducting any investigation of the credibility of the accusations, and of having acted unethically to the extent that their willful misconduct warranted and required disbarment. Macaulay de Cal X5 at 4:17. As is immediately apparent, this allegation does not require an examination of Ms. Jeffery's confidential communications with her attorneys. Instead, it requires an assessment of Dershowitz's state of mind with regard to his knowledge of the information that Castle and Edwards had to support the filing of the allegations. And, as supporting exhibits to the pleadings Castle and Edwards filed made clear, the adequacy of their investigation could be readily established from many sources that did not have any connection to what Ms. Jeffery may or may not have told them in confidence. See e.g. Macaulay de Cal X3 at 26-38. Recounting information supporting allegations against Dershowitz, such as sworn testimony from household employees, and invocations of the Fifth Amendment by Epstein and his co-conspirators. To be sure, Dershowitz tried to make an argument that Ms. Jeffery's communications with her attorneys might have some arguable relevance to the case. But Judge Lynch rejected that very argument, and quite properly so. Relevance is insufficient to waive privilege under Florida law. Guarantee Ins 300 FRD at 594, citing Coyne v. Schwartz, Gold, Cohen, Zacharin, and Kotler, PA, 715, So 2D, 1021, 1022, FLA 4th DCA 1998. A client does not waive the attorney-client privilege simply because her credibility could be impeached by communications with her former attorney. See Jenny v. Airdata Winman, Inc. 846, So 2D, 664, 668, FLA 2D DCA 2003. Accordingly, under Florida law, Ms. Jeffery's confidential communications with her attorneys were never at issue in the Florida litigation. D. Defendant has not met the other requirements for showing waiver of attorney-client privilege. For the foregoing reasons, defendant has failed to make the required showing for an at-issue waiver of attorney-client privilege. But even more fundamentally, defendant has failed to establish other elements necessary to find a waiver of attorney-client privilege. Defendant repeatedly refers to routine litigation actions, such as the filing of in-court affidavits, as a basis for finding some kind of waiver of privilege. See motion to compel at 16. But it is obvious that such actions do not waive attorney-client protection. Litigation requires some limited communication to third parties, including the court and opposing counsel, of information learned in the course of the attorney-client relationship. Note: the same result would attain under New York state law. See e.g. AMRE INS, Co v. US Find and Guar, Co 40 AD 3D 486 492 837 NYS 2D 616 622 2007. The at-issue doctrine applies where a party, through its affirmative acts, places privileged material at issue and has selectively disclosed the advice. Continuing. Therefore, Florida law recognizes an absolute privilege to protect attorney's statements made in communications that are preliminary to a proposed judicial proceeding, or in the institution of, or during the course and as part of, a judicial proceeding. FLA Stat An 90-502-2. See also McCullough v. Kubiak. 158, So 3D 739-740, FLA 4th DCA 2015. A waiver of the attorney-client privilege occurs only if the client voluntarily discloses in court the substance of a communication with her attorney. See e.g. DLAP v. State, 440 So 2D, 1242, 1247, FLA 1983. Criminal defendant sought to use in court favourable testimony from his investigator while blocking inquiry into other testimony. No waiver occurs when the client merely discloses facts which were part of the communication with the client's attorney. See Coon v. State 463, So 2D 201, 203, 204, FLA 1985. See also Taylor v. State 855, So 2D 126 and 29, FLA 2003. Thus, the privilege attaches to the communication with counsel, not to the underlying facts. Brookings v. State 495, So 2D 135, 139, FLA 1986. See also Lynch v. State 2 SO 3D 4766, FLA 2008. As a result, allegations that Jeffery disclosed to third parties, the same facts that she may have related to Castle and Edwards, without any evidence that she disclosed the substance of her confidential consultation with Edwards and Castle, cannot overcome her privilege. To hold otherwise would eviscerate the attorney-client privilege. Such a ruling would mean that every time an attorney filed a declaration by his client that contained the factual basis for the client's claim, the opposing party would have the right to examine all privileged communications. I'm going to add notes here. Note: New York State privilege law is to the same effect. See e.g. Nirsig v. Team 1, 76 NY 2D 363 372 558 NE 2D 1030 1034 1990, because the privilege applies only to confidential communications with counsel. See CPLR 4503. It does not immunize the It does not immunize the underlying factual information from disclosure to an adversary. Other note. As an illustration, defendant notes that in 2011, Ms. Jeffery gave an interview to the Daily Mail, motion to compel at 15, but defendant does not explain how that interview disclosed any attorney-client communications, and because any such disclosures would have been extrajudicial, they would be narrowly construed. Inri von Bülow, 828 F 2D 94 103, 2nd Sir, 1987. Continuing. Defendant has not cited any authority either in Florida or elsewhere to support his extreme assertion that Ms. Jeffery waived her privilege simply by allowing an affidavit to be filed in a court proceeding. Defendant also claims Castle, at his deposition in the Dershowitz case, waived attorney-client privilege by discussing factual information related to his investigation of Ms. Jeffery's allegations. For example, flight log information. Castle's deposition testimony did not constitute a waiver of Miss Joffrey's attorney-client privilege. Indeed, Miss Joffrey's own separate attorney, undersigned counsel, Ms. Macaulay from the law firm of Boyce, Schiller and Flexner, LLP, raised a standing objection to Castle answering any question that would require divulging any attorney-client communications. Macaulay Decal, X14, Deposition Excerpt of Paul Castle, Volume 1, dated October 16, 2015, at 3924 to 42. Virginia Roberts does not waive her attorney-client privilege with her lawyers, and they are not entitled to testify as to information that she intended to be confidential that she communicated to her lawyers. Defendant also argues that because Castle said at some unspecified point in his deposition that he knew some unidentified information about Miss Joffrey, he must have been revealing attorney-client communications. Motion to compel at 17. Of course, the information Castle and Edwards knew about Miss Joffrey was a direct result of her attorney-client communications with them. But Castle knew a vast amount of information about Miss Joffrey from the factual record in the case, such as the flight logs demonstrating flights that she took with Epstein and defendant on Epstein's jet. Defendant's logic is simply incorrect. Note: in her excerpts from Castle's deposition, defendant has not included this portion. See Meniger Decal XL. E. Miss Joffrey will not seek to use confidential attorney-client communication in her action here. For all the reasons just explained, Miss Joffrey has not waived her attorney-client privilege for events that occurred in the Dershowitz case. But one additional point bears emphasis. Defendant attempts to argue that the trial in this case will somehow be unfair if she does not receive access to confidential attorney-client communications that Miss Joffrey had with her lawyers earlier. Motion to compel at 20 to 21. But regardless of what may or may not have been at issue in the Dershowitz case, confidential communications will not be at issue here. For example, defendant writes that it would be prejudicial for Miss Joffrey to be able to support her claim in this case that she is not a liar using her attorney's testimony. ID at 21. To be clear, Miss Joffrey has no intention of calling, for example, Castle and Edwards to testify at trial in an attempt to support her claims. Thus, this will not be a case where it will be misleading to the court or any jury to hear testimony from Miss Joffrey's counsel about all the factual basis, work product, and thought process on which they relied in making the allegations in the joint motion, motion to compel at 22, for the simple reason that Miss Joffrey's counsel will not be witness in this case. Nor will Miss Joffrey be presenting a state-of-mind defense that might require a more extensive inquiry into attorney-client communications. See In Re City of Erie 546 F 3D 222 229 2nd Sir 2008. Noting absence of good faith or state-of-mind issues as a reason for not finding at-issue waiver of privilege. Nomura Asset Capital Corp. v. Cadwallader. Wickersham and Taft LLP 62AD 3D 581, 582, 880, NYS 2D 617, 618-20, NY App Div 2009. Finding no waiver where plaintiff disavowed any intention to use confidential attorney-client communications, relevance alone insufficient to put privileged materials at ease because, if that were the case, a privilege would have little effect. To be sure, at trial, Miss Joffrey will present factual testimony supporting her version of events, just as, no doubt, defendant will try to present testimony supporting her version. But such testimony from both sides does not create any waiver of attorney-client privilege. Instead, such testimony is simply the presentation of competing facts, from which the jury can decide who is telling the truth. None of this creates any need for defendant to force Miss Joffrey to reveal confidential communications. 2. Miss Joffrey did not waive her attorney-client privilege by denying fabricated evidence during her deposition. Defendant spends significant time arguing that Miss Joffrey's answers to several deposition questions about the absence of any communications from Castle and Edwards, that she provided false information, constituted a waiver of attorney-client privilege. Motion to compel at 11, arguing that never answered to the question, has Brett Edwards ever pressured you or encouraged you in any way or under any circumstances at any time to provide false information about Jeffery Epstein, constituted a waiver of attorney-client privilege. While the arguments above are sufficient to dispose of this claim, it is worth emphasizing several additional points about this specific testimony. First, disclosing the absence of communication is not the same as exposing any communication. It is a fundamental requirement of a waiver argument that a communication be exposed. See Fla Stat An 90-502, extending privilege to a communication between lawyer and client, not the absence of such a communication. See Montanez v. Publix Supermarkets Inc., 135 So 3D, 510, 512-13. Fla Dis CT App, 2014. Rejecting argument that client waived her attorney-client privilege by stating that an interrogatory answer was not her answer because this does not disclose the substance of her communications with her attorney. ZF Mitchell v. Superior Court, 37 Cal 3D 591 602 691 P2D 642 647 Cal 1984. Relevant case law makes it clear that mere disclosure of the fact that a communication between client and attorney had occurred does not amount to disclosure of the specific content of that communication, and as such does not necessarily constitute a waiver of the privilege. Second, the questions highlighted by defendant asked Ms. Jeffery whether she had ever communicated with her attorneys Castle and Edwards for purpose of committing a crime or fraud. See motion to compel at 11, recounting questions. If such a communication involving perjury had existed, it would not have been covered by the attorney-client privilege in the first instance, because it would have involved an ongoing crime or fraud. See Fla Stat An 90-502-4. There is no lawyer-client privilege under this section when the services of the lawyer were sought or obtained to enable or aid anyone to commit or plan to commit what the client knew was a crime or fraud. Answering those questions by denying the existence of a crime or fraud accordingly did not constitute waiver of confidentiality over any otherwise protected communication. Indeed, any other conclusion would essentially abolish the attorney-client privilege. A party could simply accuse the opposing side of fabricating evidence and, when that accusation was denied, argue that attorney-client privilege has been waived. This is not the law. Finally, it is important to note that throughout her deposition, Ms. Jeffery's attorney strenuously objected to any effort by Dershowitz to obtain attorney-client information. See Macaulay Decal, Exhibit 11, composite exhibit of deposition excerpts from the deposition of Virginia Godfrey, at 131-32, 17-3-74, 183-200-12. Clearly, at her deposition, Ms. Jeffery did not voluntarily waive any attorney-client privilege she held. Notes. Again, for the sake of completeness, it is worth noting that federal and New York state law also contain a crime-fraud exception to the attorney-client privilege. HSS Nordbank AG New York Branch v. Swerdlow, 259 FRD 6473, SDNY 2009, Ulico Cas Co. v. Wilson, Elsa, Moskowitz, Elderman, and Dicker. 1 AD 36223-224, 767 NYS 2D 228 2003, attorney-client privilege may not be invoked where it involves client communications that may have been in furtherance of a fraudulent scheme, an alleged breach of fiduciary duty, or an accusation of some other wrongful conduct. Additional note. Once again, these objections are not included in defendant's excerpts from the deposition. Continuing. 3. Edwards and Castle have not waived work product protection, and Maxwell has not demonstrated need to penetrate the protection. A. Work product protection has not been waived. For many of the same reasons that Ms. Jeffery has not waived her attorney-client privilege, the work product protection has not been waived. Fed R. Evid 502's protections against waiver apply not only to the attorney-client privilege, but also to the work product doctrine. On the facts of this case, Rule 502 thus extends all work product protections that exist under the law of the state where the disclosure occurred, Fed R. Evid 502 C2, i.e. Florida law, as well as the protection that exists under federal law, Fed R. Evid 502 C1. Florida law provides that work product protections extend to documents and tangible things otherwise discoverable, if a party prepare those items, in anticipation of litigation for trial. FLA R. Civ P 1.280b3. The rationale supporting the work product doctrine is that one party is not entitled to prepare his case through the investigative work product of his adversary, where the same or similar information is available through ordinary investigative techniques and discovery procedures. Universal City Development Partners Limited v. Publio. 54 So 3D 612 614 FLA 50 CA 2011. The work product of the litigant, his attorney or agent, cannot be examined, absent rare and exceptional circumstances. Surf Drugs Inc. v. Vermet, 236 So 2D 108 112 FLA 1970. In Florida, as elsewhere, a party can make a limited waiver of its work product privilege. Paradise Divers Inc. v. Upmall, 943 SO 2D 812 814 FLA Dis C App 2006. A waiver by disclosure only includes other unrevealed communications only to the extent that they are relevant to the communication already disclosed. ID citing Eastern Airlines Inc. v. Gellert, 431 SO 2D 329 332 FLA 3D DCA 1983. Waiver by disclosure does not mean that voluntary disclosure of confidential information effectively waives the privilege as to all conversations, or the whole breadth of discussion which may have taken place. Procassi v. Saitlin, 497 SO 2D 969 969-70 FLA Dis CT App 1986, citing Goldman Sachs & Co. versus Blondis, 412 F Sup 286-288 ND 3 1976. Instead, waiver by disclosure is confirmed to that specific subject during that particular conversation. Prosassi 497 SO 2D at 970, quoting Paragon v. Bergen Brunswick Corp. 77 FRD 455 461 ND Cal 1978. As with her attorney-client privilege argument, defendant has not even cited Florida law on waiver of work product protection, much less explained how she meets its demanding requirements. Moreover, the illustrations she provides do not prove any general waiver of work product protection. For example, defendant relies on the claim that Castle and Edwards have waived work product protection by disclosing a transcript of a portion of a 2011 telephone interview with Ms. Joffrey by attorneys Jack Scarola and Brad Edwards. But that recorded interview was never a confidential communication between Ms. Joffrey and the lawyers, but rather, as the transcript of the call itself makes clear, a communication that could be presented to any jury that might ultimately have to hear these facts. Macaulay DeCal, X15 at 1, transcript of Scarola Edwards' interview on April 7, 2011, emphasis added. In other words, the recorded call was simply the functional equivalent of an affidavit, and affidavits are routinely disclosed with waiving work product protections under the law of Florida and elsewhere. Defendant also argues that Castle and Edwards waived work product protection by filing a summary judgment motion in the Dershowitz case, which contained supporting exhibits, e.g. flight logs, sworn testimony by third-party witnesses, and other evidence. Motion to compel at 16. Note: New York state law is to the same effect. See Charter One Bank FSB v. Midtown Rochester LLC, 919 MISC 2D 154159 738 NYS 2D 179 186 Sup CT 2002. The disclosure of a document protected by the work product rule does not result in a waiver of the privilege as to other documents. Continuing. But providing information in support of a summary judgment motion is a routine step that attorneys take every day. While the materials produced are obviously not subject to work product protection, other materials and communications do not somehow become subject to discovery. Paradise Divers Inc. 943 SO 2D at 814. B. Defendant has not proven need to penetrate work product protection. Defendant's argument on work product protection also simply assumes that it is the same as the attorney-client privilege and can be waived under an at-issue theory. But the at-issue legal theory defendant relies on to argue incorrectly that attorney-client privilege has been waived applies only to that privilege. The work product doctrine is quite distinct from attorney-client privilege, and application of the privileges and exceptions to them differ. See West Bend Mutual Inns Co. v. Higgins, 9 SO 3D 655 656 FLA 5th DCA 2009. Genovese v. Provident Life and Accident Inc. Co. 74 SO 3D 1064 1068 FLA 2011. As revised on denial of Res 2011. The function of the work product doctrine is to protect counsel's mental impressions. West Bend Mutual 9 SO 3D at 656. To pierce the privilege, defendant must show that the substantial equivalent of the material cannot be obtained by other means. Southern Bell T and Tel Co. v. Deason 632 SO 2D 1377 1385 FLA 1994.
Defendant has not even identified any specific work product she claims to need, much less shown why she cannot get the underlying information from other sources. Under the law of Florida, and elsewhere, to establish need, a party must present testimony or evidence demonstrating that the material requested is critical to the theory of the requester's case or to some significant aspect of the case. Zirkelbach Const Inc. v. Rajan 93 So 3D 1124 1130 FLA 2D DCA 2012. Note: both federal and New York state law extend work product protections similar to those found in Florida law. See E.G. Hickman v. Taylor 329 U.S. 495 511 1947. NY Civ Practice Law and Rules 3101 C. McKinney. Indeed, New York state law may go even further than Florida's and extends absolute work product protection. See Charter One Bank FSB v. Midtown Rochester LLC 919 MISC 2D 154 159 738 NYS 2D 179 185 Supt. Cit. 2002, subsection 3101C, affords absolute immunity from disclosure of attorney's work product. Continuing. Well established in Florida is the principle that the unsworn analysis of a party's attorney and or a bare assertion of need and undue hardship to obtain the substantial equivalent is insufficient to satisfy this showing. Butler v. Hardler, 152, So 3D 705 712, FLA 1st DCA 2014. See Procter & Gamble Co. v. Swilly, 462, So 2D 1188 1194, FLA 1st DCA 1985. State v. TA 528, So 2D 974 975, FLA 2D DCA 1988. Representations by counsel not made under oath and not subject to cross-examination, absent a stipulation, are not evidence. Further, Florida courts have held that the showing of need encompasses a showing of diligence by the party seeking discovery of another party's work product. Butler v. Hardler, 152, So 3D 705, 712, FLA 1st DCA 2014. See also CSX Transap Inc. v. Carpenter, 725, So 2D 434 435, FLA 2D DCA 1999. Quashing order granting motion to compel discovery because the record did not contain affidavits supporting plaintiff's argument that it was unable to obtain the substantially equivalent information by other means without undue hardship. Falco v. N. Short Labs Corp. 866 So 2D 1255 1257 FLA 1st DCA 2004. Holding that need and undue hardship must be demonstrated by affidavit or sworn testimony. M. Brownwood Hostist v. Button 592 So 2D 367 368 FLA 4th DCA 1992. The unsworn assertions of plaintiff's counsel were insufficient to constitute a showing of need and undue hardship. Called into doubt on other grounds as stated in Columbia Hosp Corp. of S. Brownwood v. Fain, 16 So 3D 236 FLA 4th DCA 2009. Here, defendant has ample information from which she can present her case. At the core of this case is whether Ms. Joffrey lied when she said that the defendant recruited her to be sexually abused by Jeffrey Epstein. Defendant can, of course, testify to her interactions with Ms. Joffrey, as well as call other witnesses regarding the circumstances of those interactions. Defendant can also get information from her close friend, Epstein, not anymore, about the circumstances of the interactions. Defendant and Epstein are not only good friends, but they have a common interest agreement that facilitates transfer of information between the two of them. Finally, to make her showing that she is unable to obtain equivalent information from other sources, defendant would have to explain in detail what other steps she has taken to secure information from other sources, including not only Epstein but other witnesses present at Epstein's mansion. Having failed to do any of this, defendant has not made a sufficient showing to obtain work product information. Publio 54 So 3D at 614. 4. Communications with attorney Jack Scarola are covered by a joint defense agreement and are thus protected by attorney-client and work production protection. As a tag-along argument at the end of her motion, defendant argues that Ms. Joffrey has not established the existence of a common interest or joint defense agreement that embraces Jack Scarola, the attorney for Castle and Edwards in the Dershowitz litigation. Motion to compel at 23 to 24. Disclosure of that agreement involved notice to the parties to the agreement. Now that appropriate notice has been provided, the agreement can be, and has been, disclosed. See Macaulay Decal X 16 Common Interest Agreement.
In view of the existence of the valid agreement, it is clear that the reference communications involving Scarola are protected. See, e.g., Jeffery v. Maxwell, number 15, Civ 7433 RWS, 2016 WL 1756918 at 6, SDNY, May 2nd, 2016, noting common interest agreement protection, citing Gus Consulting GmbH v. Chadbourne and Park LLP, 20 MISC, 3D, 539, 542, 858 NYS 2D, 591, 593, Sub-CT 2008. Conclusion. Defendant's motion to compel should be denied in its entirety. Dated June 1st, 2006. Respectfully submitted, Weiss, Schiller and Flexner LLP. Signed, Sigrid Macaulay. Certificate of Service. I hereby certify that on the first day of June 2016, I electronically filed the foregoing document with the Clerk of Court by using the CM-ECF system. I also certify that the foregoing document is being served this day on the individuals identified below via transmission of notices of electronic filing generated by CM-ECF. Laura A. Menninger, Esquire. Signed, Sigrid Macaulay. Jeffery versus Maxwell Deposition. Virginia Jeffery. 05-03-2016. Agron Blando, Court Reporting and Video Inc. A. I believe this is when I was hoping to join the CVRA case. Q. Alright. And how do you know when this document was filed? And actually, just to be clear, about halfway there's actually a second document that was filed, so this is a composite exhibit. Let me be very clear. So after page 13, there's a second document that is stylized Jane Doe 3 and Jane Doe 4's corrected motion pursuant to Rule 21 for joinder inaction. Do you see that? A. Did you say page 14? Q. It is on the 14th page of this document. Do you see that? A. I do. Q. And so this composite exhibit 2 has both a motion and a corrected motion. Do you see that? A. Yes. Q. And were both of those pleadings authorized by you to be filed? A. Yes. Q. In other words, you wanted to join the CVRA action in or about December 30th, 2014, correct? A. I'm not aware of the exact dates. There's no dates on this, but I did try to join the motion, yes. Q. All right. If you can look at the top line of the document. A. Yes. Q. Does it say entered on FLSD? A. Oh, it does too. I'm sorry, yes. Q. That's all right. So does that refresh your memory as to about when you first sought to join the CVRA action? A. Yes. Q. December 30th, 2014, correct? A. Yes. Q. And the corrected motion was filed a few days later, correct? A. Yes, correct. Q. If I could turn to Defendant's Exhibit 3, which was January 21st. Exhibit 3 marked. Mr. Edwards, thank you. Q. By Miss Menninger. Do you recognize this document? A. Yes, I do. Physical features of Ghislaine Maxwell? A. I can tell you that she had very large natural breasts. I can tell you that her pubic hair was dark brown, nearly black. I don't remember any specific birthmarks or moles that I could point out that would be relevant. Q. Any scar? A. I don't remember any scars. Q. Any tattoos? A. No tattoos. Q. When did you next go to the El Brillo house? A. I believe it would have been the next day. Q. You believe it would have been, or was it? Mr. Edwards. Form. A. I know that it was consecutive, that I continued to go there after the first time that the abuse took place there. It was consecutive that I was there, I believe, over the next course of weeks. Q. By Miss Menninger. What day of the week was the first time you went? A. I don't know. Q. Do you know whether you went the very next day or not? A. I believe I did. Q. All right. How did you get there the very next day? Mr. Edwards. Form. A. I believe my dad dropped me off again. Q. By Miss Menninger. When you say you believe, do you recall him doing that or are you guessing? A. I don't... Well, this is how I figure this. I don't remember Ghislaine picking me up from Mar-a-Lago. I didn't have my own car. So the only way I could have really gotten there would have been my dad picking me up. Dropping me off. Q. Do you have a distinct recollection of your father dropping you off there more than one day in a row? A. Yes. Q. You do not recall the car he was driving? A. Like I said, he always drove trucks. That's as good as I can get. Q. And you worked on weekends as well at Mar-a-Lago, or no? A. No. Q. So the second day would have had to be... A. I wouldn't say directly. Q. How? A. I'd say I stayed with my parents for, I think I finished school at Crestwood. So I would have been in, I guess 8th grade? Finished 8th grade? And then, I don't know. I really don't know. Around 8th grade? Q. You went to growing together? A. I think it was then. Q. And how many years did you live at growing together? A. Over a year. Q. Were you ever in foster care? A. What growing together was like a group home that sent you away to foster parents every night. Q. So you lived in other people's homes during the period of time you were assigned to growing together? A. Well, you stayed at growing together during the day, and then at night you get sent home with parents. Q. Did you go to school while you were at growing together? A. Yeah, they offer education there. Q. So the education was at growing together? A. Yeah. Q. You did not attend a Palm Beach County... A. I did, but you had to earn your levels up to be able to go outside. So I don't remember what level you have to get up to go out to another school. I think there was, 7 levels or something. And you had to make it to, level 4 to be able to go to outside school. Q. So for some period of time you were assigned to growing together, and you were going to school at growing together. And for some period of time you were going to other schools and coming back to growing together? A. Correct. Q. And then when you came back to growing together, you were sent to spend the night at a family's home? A. Yes. Q. So you never slept at growing together? A. No. Q. Did you live... Other than living at or staying at growing together during the day and sleeping at these other homes at night, is there anywhere else that you recall living in the period at 3? I think it's redacted. I really can't make up the telephone number. Q. Okay. Do you see relationship? Can you read that? A. Friend. Q. Okay. Do you see just below that there's a line that says number 21? A. Do not stop. Sorry, do not sign application until requested to do so by administering an oath. Q. Okay. A. Applicant signature age 13 or older. Q. Oh, it's by the signature line? A. Yes. Q. And that's your signature? A. Yes. Q. Alright. And this is the document that you recall filing out for your first passport? A. I don't recall doing it, but yes, it's in my handwriting, and it's got all of my information on it. Q. Okay. And on the line, box 23, it's got your driver's license checked off, right? A. July 23rd. Yeah, I really can't make out. And when they say massage, that means erotic, okay? That's their term for it. I think there are plenty of other witnesses that can attest to what massage actually means. And I'm telling you that Ghislaine told me to go to Glenn Dubbin and give him a massage, which means sex. Q. Okay, so Ghislaine Maxwell told you to go give a massage to Glenn Dubbin? A. Correct. Q. That's your testimony? A. That is my testimony. Q. Alright. Ghislaine Maxwell told you to go give a massage to redacted, correct? A. Correct. Q. Ghislaine Maxwell told you to give a massage to Prince Andrew, correct? A. Correct. Q. Ghislaine Maxwell told you to give a massage to Bill Richardson, correct? A. Correct. Q. When did Ghislaine Maxwell tell you to give a massage to Bill Richardson? A. I don't know dates. Q. Where were you? A. When it happened? Q. When Ghislaine Maxwell used the words, go give a massage to Bill Richardson, where were you? Mr. Edwards. Object to the form mischaracterizes her testimony. A. I can't tell you where we were. I know where I was sent to. I don't know where we were when she told me to do that. Q. By Miss Menninger. Where were you sent to? A. New Mexico. Q. By Ghislaine Maxwell. Mr. Edwards. Object to the form. Mischaracterizes her testimony again. A. Are you smiling at me because... Q. By Miss Menninger. No, I am asking you to answer the question. A. I have answered the question. I was sent to New Mexico. Q. Okay. Where were you sent from? A. I already answered that. I don't know where I was sent from. Q. Okay. A. I was flying everywhere with these people. Q. Where were you sent by Ghislaine Maxwell to have sex with Jean-Luc Brunel? Mr. Edwards. Object to the form. Mischaracterized her testimony. A. Many places. Q. By Miss Menninger. Ghislaine Maxwell sent you to many places to have sex with Jean-Luc Brunel. Mr. Edwards. Object to the form. A. It happened at many places, yes. Q. By Miss Menninger. You had sex with Jean-Luc Brunel at many places is what you're saying, correct? A. I was sent to Jean-Luc Brunel at many places to have sex with him. Q. When did Ghislaine Maxwell send you to a place to have sex with Jean-Luc Brunel? A. You are asking? Mr. Edwards. Form. A. Me to answer the impossible. Q. By Miss Menninger. Alright. When did Ghislaine Maxwell send you to have sex with the owner of a large hotel chain? Mr. Edwards. Object to the form. Mischaracterization. A. I'm going to keep answering the questions the same way that I keep answering them. I don't know where it was when she said to go do this. Q. By Miss Menninger. Okay. Where were you sent to have sex with the owner of a large hotel chain by Ghislaine Maxwell? Mr. Edwards. Object to the form. A. I believe that was one time in France. Q. By Miss Menninger. Which time in France? A. I believe it was around the same time that Naomi Campbell had a birthday party. Q. Where did you have sex with the owner of a large hotel chain in France around the time of Naomi Campbell's birthday party? A. In his own cabana townhouse thing. It was part of a hotel, but I wouldn't call it a hotel. Jeffrey was staying there. Ghislaine was staying there. Emmy was staying there. I was staying there. This other guy was staying there. Don't know his name. I was introduced by Ghislaine to go and give him an erotic massage. Q. She used the words erotic massage? A. No, that's my word. The word massage is what they would use. That's their code word. Q. Was she in the room when you gave this erotic massage to the owner of a large hotel chain? A. No, she was not in the room. She was in another cabana. Q. And other than telling you to go give the owner of this large hotel chain a massage, do you remember any other words she used to you to direct you in what you should do? A. Not at the time, no. Q. Where were you and where was Miss Maxwell when she directed you to go have sex with Marvin Minsky? Mr. Edwards. Object to the form. A. I don't know. Q. By Miss Menninger. Where did you go to have sex with Martin Minsky? No. Marvin Minsky. A. I believe it was the U.S. Virgin Islands. Jeffrey Epstein's island in the U.S. Virgin Islands. Q. And when was that? A. I don't know. Q. Do you have any time of year? A. No. Q. Do you know how old you were? A. No. Q. Other than Glenn Dubbin, redacted, Prince Andrew, Jean-Luc Brunel, Bill Richardson, another prince, the large hotel chain owner, and Marvin Minsky. Is there anyone else that Ghislaine Maxwell directed you to go have sex with? A. I am definitely sure there is, but can I remember everybody's name? No. Q. Okay. Can you remember anything else about them? A. Look, I've given you what I know right now. I'm sorry, this is very hard for me and very frustrating to have to go over this. I don't recall all of the people. There was a large amount of people that I was sent to. Q. Do you have any notes of all these peoples that you were sent to? A. No, I don't. Q. Where are your notes? A. I burned them. Q. When did you burn them? A. In a bonfire when I lived at Titusville because I was sick of going through this shit. Q. Did you have lawyers who were representing you at the time you built a bonfire and burned these notes? A. I've been represented for a long time, but it was not under the instruction of my lawyers to do this. My husband and I were pretty spiritual people and we believed that these memories were worth burning. Q. So you burned notes of the men with whom you had sex while you were represented by counsel in litigation, correct? Mr. Edwards, object to the form. A. This wasn't anything that was a public document. This was my own private journal, and I didn't want it anymore, so we burned it. Q. By Miss Menninger. When did you write that journal? A. Just over time. I started writing it probably in, I don't know, I can't speculate. 2012? 2011? Q. So you did not write this journal at the time it happened? A. No. Q. You started writing this journal approximately a decade after you claim you finished being sexually trafficked, correct? A. Yes. Q. And you started writing a journal after you had a lawyer, correct? A. Correct. Q. Including Mr. Edwards, who is sitting right here, correct? A. Correct. Q. What did that journal look like? A. It was green. Q. And what else? A. It was just a spiral notebook. Q. Okay, and what did you put into that green spiral notebook? A. Bad memories. Things that I've gone through. Lots of things, you know. I can't tell you. There was a lot of pages. It was over 300 pages in that book. Q. Did you ever show that book to your lawyers? A. No. Q. Did you show that book to anyone? A. My husband. Q. Did you show it to anyone else besides your husband? A. No. Q. Did you tear out pages and give them to Sharon Churchner? A. No. I wrote, those pages that you're talking about, I wrote for her specifically. She wanted to know about the Prince Andrew incident. Q. So that's a different piece of paper. A. Yeah, that's just random paper. Q. So you had a green spiral notebook that you began sometime in 2011 or 2012, in which you wrote down your recollections about what had happened to you, and you burned that in a bonfire in 2013. Did I get that right? A. You got that right. Q. And do you have no other names of people to whom you claim Ghislaine Maxwell directed you to have sex, correct? A. At this time, no. Q. Is there any document that would refresh your recollection that you could look at? A. If you have a document you'd like to show me, I will be glad to look at it and tell you the names I recognize off of that. Q. I'm just asking you if there's a document you know of that has this list of names in it. A. Not in front of me, no. Q. Where is the original of the photograph that has been widely circulated in the press of you with Prince Andrew? A. I probably still have it. It's not in my possession right now. Q. Where is it? A. Probably in some storage boxes. Q. Where? A. In Sydney. Q. Where is Sydney? A. At some family's house. We got the boxes shipped to Australia, and they were picked up off the porch by my nephews and brought to their house. Q. Which is where? A. In Sydney. Q. Where in Sydney? A. Redacted. Q. And who lives in that house? A. Well, it's owned by my mother-in-law and father-in-law, but my nephews live in that house. Q. What are their names? A. I'm not giving you the names of my nephews. Q. What's the address of the house? A. Why would you want that? Q. I want to know where the photograph is. I'm asking you where the photograph is, and you've just told me it's somewhere in Redacted? A. Yes. Q. So where in Redacted is the photograph located? A. If I can't 100% say that the photograph is there, it could be at my house that I presently live in. I'm not going to give you the address of my nephew's residence. Q. When is the last time you saw the photograph in person? A. When I packed and left America. Q. Colorado? A. Yes. Q. Alright. So you had that photograph here with you in Colorado? A. Yes. Q. What's on the back of the photograph? A. I'm sorry? Q. Is there anything on the back of the photograph? A. There's like the date it was printed, but no writing or anything. Q. Okay. Does it say where it was printed? A. I don't believe so. I think it just... I don't remember. I just remember there's a date on it. Q. Whose camera was it taken with? A. My little yellow Kodak camera. Q. Who took the picture? A. Jeffery Epstein. Q. And where did you have it developed? A. I believe when I got back to America. Q. So where? A. I don't know. Q. Palm Beach? A. I don't know. Q. What is the date the photograph was printed? A. I believe it's in March 2001. Q. Okay. A. But that's just off of my photographic memory. It could be different, but I think it's March 2001. Q. You have a photographic memory? A. I'm not saying I have a photographic memory, but if I look at the back of the photo and I remember what it says, I believe it was March 2001. Q. Did the photograph ever leave your possession for a while? A. I gave it to the FBI. Q. Okay. And when did you get it back? A. When they took copies of it. Q. When was that? A. 2011. Q. When they came to interview you? A. Yes. Q. So from 2011 until you left Colorado, it was in your personal possession? A. Yes. Q. What other documents related to this case are in that storage boxes in Australia? Mr. Edwards. Object to the form. A. Documents related to this case. I don't know. I really can't tell you. I mean, there's 7 boxes full of Nerf guns, my kids' toys, photos. I don't know what other documents will be in there. Q. By Miss Menninger. Did anyone search those documents after you received discovery requests from us in this case? A. I haven't been able to obtain those boxes. I can't get them sent back up to me. It's going to cost me a large amount of money, and right now I'm trying to look after my family, so I'm not able to afford to get them up. Q. You live in Australia, correct? A. I do. Read it. Miss Menninger. We're going off the record. Mr. Edwards. Yeah, that's fine. She'll read. The videographer. That concludes today's proceedings. We're off the record at 5:28. Proceedings concluded at 5:28 p.m. United States District Court, Southern District of New York. Virginia L. Jeffery, Plaintiff v. Ghislaine Maxwell, Defendant. 15 CV 07433 RWS. Defendant's response in opposition to motion to exceed presumptive 10 deposition limit. Defendant Ghislaine Maxwell, Ms. Maxwell, files this response in opposition to plaintiff's motion to exceed presumptive 10 deposition limit and states as follows. Introduction. Despite having taken only 3 depositions to date, plaintiff prematurely requests permission to exceed the presumptive 10 deposition limit imposed by Fed RCIV P 30A2A1 and to conduct 17 separate depositions, almost twice the limit. Without legal support, plaintiff attempts to conflate the presumptive time limitation for each deposition of 7 hours with a right to take a total of 70 hours of depositions. This is an absurd reading of the federal rules. The presumptive 10 deposition limitation is an independent limitation and speaks to the number of separate deponents, not deposition time. Indeed, the 2 independent limitations do not even appear in the same section of the rules. The heart of plaintiff's argument is that Ms. Maxwell inconveniently testified and denied plaintiff's claims, rather than invoking the Fifth Amendment. This dashed plaintiff's apparent hope to obtain an adverse interference, rather than actually having to prove her case against Ms. Maxwell. Instead, Ms. Maxwell fully testified for the entire 7 hours, responded to all questions posed to her, and testified based on her actual knowledge. Ms. Maxwell's testimony simply bears no relevance to plaintiff's request to take more than 10 depositions of non-party witnesses. Note, plaintiff flatly misrepresents to the court that Ms. Maxwell refused to answer the questions posed to her, as the actual transcript amply demonstrates. Ms. Maxwell did not avoid any questions and answered all questions to the best of her recollection relating to alleged events 15 years ago. The majority of the bullet point summary of the matters about which Ms. Maxwell could not testify were based either on a lack of any personal knowledge or the fact that the events claimed by plaintiff did not actually happen. Continuing. Conspicuously absent from plaintiff's motion are A. Any actual information she believes these witnesses may provide, which is neither cumulative nor duplicative of other information already disclosed in this case. B. The fact the information can be obtained from other sources. And C. Facts demonstrating that the burden and expense of the discovery is justified by the needs of this case. Indeed, she has not established that testimony is even relevant to the actual issues in this matter. Plaintiff's inability to establish these factors requires denial of the motion. 1. Plaintiff's request is premature. First, the request to exceed the presumptive 10 deposition limit is premature. Courts generally will not grant leave to expand the number of depositions until the moving party has exhausted the 10 depositions permitted, as of right under Rule 30A2A, or the number stipulated to by the opposing party. Gen. Elec Co. v. Indem Ins Co. of N. AM number 306CV232, CFD 2006 WL 1525970 at 2, Decon May 25, 2006. This guideline makes sense because a moving party must not only justify these depositions it wishes to take, but also the depositions it has already taken. ID citing Barrow v. Greenville in Dep, Tshirt District, 202 FRD 480-482 ND Text 2001. This rule is in place because a party could indirectly circumvent the cap on depositions by exhausting the maximum allotted number to those that she could not justify under the Rule 26b-2 standards, and then seek leave to exceed the limit in order to take depositions that she could substantiate. ID at 483. Here, plaintiff seeks a preemptive determination that she should be permitted 17 depositions, almost twice the presumptive limit, yet her proposed depositions are not calculated to lead to admissible evidence in this case. By way of example, plaintiff identifies Nadia Marcinkova, Sarah Kellen, aka Sarah Kensington or Sarah Figures, and Jeffery Epstein as alleged co-conspirators with each other. She requests the depositions of each. Plaintiff anticipates each will invoke the Fifth Amendment. In other words, she will not obtain any discoverable information from them. Plaintiff makes a bizarre argument that somehow this testimony can be used to create an adverse interference against Ms. Maxwell, despite the fact that Ms. Maxwell did not invoke the Fifth Amendment and she testified fully and answered every question posed to her, with the only exception the irrelevant and harassing questions plaintiff posed to her concerning her adult, consensual sexual activities. In other words, depositions of Marcinkova, Kellen, and Epstein would serve plaintiff's goal to make a convoluted legal argument, not to actually seek discoverable information. In light of this, the burden or expense of the proposed discovery outweighs its likely benefit, considering the needs of the case, the parties' resources, the importance of the issues at stake in the action, and the importance of the discovery in resolving the issues. Atkinson v. Good, number 01, Civ 0721, LAK HBP 2009 WL 890682 at 1, SDNY, April 2, 2009. Fed R Civ P26B1. If plaintiff chooses to use her depositions in this manner, she risks utilizing 3 of her available 10 depositions for an illegitimate purpose. She should not be rewarded with a preemptive carte blanche in advance to take additional depositions. Note: invocation of the Fifth Amendment by a third-party witness cannot be used to create an adverse interference against a party in a civil action. See United States v. District Council of New York City and vicinity of United BHD of Carpenters and Joiners of AM, number 90, Civ 5722 CSH. 1993 WL 159959 at 5 SDNY May 12, 1993. The general rule is that an individual's claim of Fifth Amendment protection is personal and does not give rise to adverse inferences against others. Brenner v. World Boxing Council, 675 F2D 445 459 N7, 2nd Sec. Cert denied. 459 US 835 1982. Furthermore, since King was a non-party witness, no adverse inference against appellees could have been drawn from his refusal to testify. Continuing. 2. The proposed depositions are cumulative, duplicative, and not relevant to the central issues of the dispute. Plaintiff has not met the requisite showing to permit in excess of 10 depositions. In Sigala v. Spikoris 00CV 0983 ILG 2002 WL 721078 at 3 EDNY March 7, 2002, the court set forth the general principles relevant to a party's application to conduct more than 10 depositions. The federal rules presumptively limit the number of depositions that each side may conduct to 10. See Fed R Civ P 30A2A. A party must obtain leave of court, which shall be granted to the extent consistent with the principle stated in Rule 26b-2 if a proposed deposition would result in more than 10 depositions being taken. Accord Universal City Studios v. Ramirez 104F Sub 2D 334 342 STNY 2000. Landry v. St. James Parish should be Boulevard. No Civ A 991438 2000 WL 1741886 at 2 EDLA Nov 22nd 2000. The purpose of Rule 30A-2A is to enable courts to maintain a tighter rein on the extent of discovery and to minimize the potential cost of wide-ranging discovery. Whittingham v. Amherst Call, 163 FRD 170 171-72, D. Mass 1995, citation admitted. Accordingly, the mere fact that many individuals may have discoverable information does not necessarily entitle a party to depose each such individual. Dixon v. Sir Tainted Corp. 164 FRD 685-692 DCAN 1996. The factors relevant to determining whether a party should be entitled to more than 10 depositions are now set forth in Fed R Civ P 26b2c, and include whether 1. The discovery sought is unreasonably cumulative or duplicative, or can be obtained from some other source that is more convenient, less burdensome, or less extensive. 2. The party seeking discovery has had ample opportunity to obtain the information by discovery in the action, and 3. The burden or expense of the proposed discovery outweighs its likely benefit, considering the needs of the case, the party's resources, the importance of the issues at stake in the action, and the importance of the discovery in resolving the issues. Atkinson 2009 WL 890682 at 1 SDNY, April 2, 2009. Internal quotations omitted. Note: Rule 26b(1) has since been modified to read 1. The discovery sought is unreasonably cumulative or duplicative, or can be obtained from some other source that is more convenient, less burdensome, or less expensive. 2. The party seeking discovery has had ample opportunity to obtain the information by discovery in the action, or 3. The proposed discovery is outside the scope permitted by Rule 26b(1). The scope of discovery permitted by 26b(1) is non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, considering the importance of the issues at stake in the action, the amount in controversy, the party's relative access to relevant information, the party's resources, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. Thus, the factors to be considered have simply been moved to a new number with cross-reference. Oh, good God. Continuing. Weighing these factors, there is no basis for permitting more than the presumptive 10 deposition limit. First, as highlighted by the motion, the information purportedly sought is cumulative and duplicative. Duplicative, that's a hard word. By way of example, plaintiff has already deposed Johanna Sjoberg, a former Epstein employee, Juan Alessi, a former Epstein employee, and David Rogers, former Epstein pilot. She further seeks to depose Maria Alessi and Joe Fontanella, former Epstein household employees, as well as redacted, and Emmy Taylor, identified as assistants to Ms. Maxwell or Mr. Epstein. The information plaintiff claims each of the witnesses may have is identical to that of each other. What they observed while working for Epstein, plaintiff goes so far as to state that Maria Alessi's deposition is expected to corroborate the observations of her husband's. Plaintiff admits that the purpose in seeking the additional depositions is obtaining witnesses, like Ms. Sjoberg, who can corroborate that plaintiff is telling the truth. Yet, Ms. Sjoberg did not corroborate that plaintiff is telling the truth. Instead, she testified that she was hired as an adult by Jeffrey Epstein to provide professional massages, that Ms. Maxwell never asked her for any type of sexual massage, that she never saw plaintiff giving a massage to Ms. Maxwell, nor did she see Ms. Maxwell receive a massage from any underage girl, indeed in her 5+ years working for Mr. Epstein. She never saw any person underage at his home. Regardless, plaintiff is looking in vain for more testimony of exactly the same character, precisely the type of testimony the presumptive limit is intended to prevent. Similarly, the expected deposition testimony of former Palm Beach detective Joe Ricari and former Palm Beach Police Chief Michael Rita are duplicative of each other. Note: Mr. Rogers' deposition, held last Friday and requiring a separate trip to Florida for Colorado counsel, after his scheduled court hearing on Thursday, served simply to authenticate flight logs. There are far more convenient, less burdensome, and less expensive methods by which such information could have been obtained, such as a verifying affidavit, yet plaintiff chose to unnecessarily burden counsel, the witness and counsel for the witness with a 3-hour deposition to accomplish the same end. Continuing. Putting aside the admissibility of this testimony, it appears that both men were involved in the investigation of Mr. Epstein and are expected to testify about their investigations. Plaintiff's allegations were not a part of their investigation, which took place years after plaintiff left the country. Moreover, their investigation did not involve Miss Maxwell. Again, such duplicative and irrelevant deposition testimony speaks to the intended purpose of the 10 deposition limit. not a reason to exceed that limit. The same holds true for Nadia Marcinkova, Sarah Killen, aka Sarah Kensington or Sarah Vickers, and Jeffery Epstein, each of whom plaintiff anticipates will not respond to questions and invoke their Fifth Amendment right. As discussed above, such invocation has no bearing on the issues in this matter. Moreover, it is obviously cumulative and duplicative. Plaintiff also identifies Ronaldo Rizzo and John Brunel, but fails to provide any information from which Miss Maxwell or the court could identify the subject matter of their expected testimony. Thus, it is unclear how these individuals have information that differs from or would add to the other proposed opponents. It is the plaintiff's burden to explain to the court why these depositions should be permitted if they exceed the presumptive limit, why the information would not be cumulative, and its relevance to the important issues in the action, or the importance of the discovery in resolving those issues. She simply fails to provide any information by which the court can assess these factors, and thus should not be permitted to exceed the deposition limit based on her pro-offer. 3. The testimony sought is irrelevant to this single-count defamation case. This case is a simple defamation case. Plaintiff, through her counsel, filed a pleading making certain claims regarding Jane Doe No. 3, the plaintiff, and her alleged circumstances. See complaint. Ms. Maxwell denied the allegations made, stating they were untrue and obvious lies. Plaintiff claims these statements are defamatory because she has been called a liar. A public figure claiming defamation under New York law must establish that the statements complained of were 1. Of and concerning the plaintiff, 2. Likely to be understood as defamatory by the ordinary person, 3. False, and 4. Published with actual malice. Biro v. Cond. Nast. 963 F. Supt. 2nd D. 255 276 STNY 2013. Affert. 807 F. 3D. 541 2nd Sir 2015 and Aft. 622 F. Appendix 67, 2nd Sir, 2015. If Ms. Maxwell's statements are essentially true, plaintiff lied, plaintiff cannot establish her claim, and it is absolute defense. Further, if plaintiff cannot provide actual malice by Ms. Maxwell, her claim fails. See Contemporary Mission Inc. v. New York Times, Co. 842, F2D 612, 621, 2nd Sir, 1988. Limited purpose public figure must establish by clear and convincing evidence that the defendant published the alleged defamatory statement with actual malice. That is, with knowledge that it was false or with reckless disregard of whether it was false or not. Quoting New York Times, 376 U.S. 241 280 1964. That is, plaintiff must prove that Ms. Maxwell permitted the publication of the statement, knowing it to be untrue. None of the witnesses identified are listed as having discoverable information regarding any of the elements of this claim. Note: there is only one public statement that existed on January 2, 2015, to which Ms. Maxwell was responding in the statement by her press agent. The document is the joint motion filed in the Crime Victims' Rights Act case on behalf of plaintiff by her attorneys, Bradley Edwards and Paul Castle. Menninger de Cal X A Part 4. The very first line, describing Jane Doe No. 3, circumstances, is false, as plaintiff now concedes. It read, in 1999, Jane Doe No. 3 was approached by Ghislaine Maxwell. And continuing that, Maxwell persuaded Jane Doe No. 3, who was only 15 years old, to come to Epstein's mansion. Plaintiff now concedes that she did not meet Miss Maxwell or Mr. Epstein in 1999, and she was not 15 years old. Menninger de Cal XA, 26 to 29. No amount of circumstantial evidence can overcome the fact that Ms. Maxwell's statement was correct and that statements in the jointer motion were untrue. Continuing. None is claimed to have direct knowledge to confirm the truth of plaintiff's claims about what happened to her, that the acts she claims she participated in occurred, or that they occurred with the people she claims to have been involved. Rather, each witness identified as being able to provide their observations regarding other allegedly underage girls, their own experiences, or beliefs about plaintiff's credibility. None of this is relevant. This is not a case about Jeffrey Epstein, or the alleged modus operandi of the Epstein organization. This is a simple case of if Miss Maxwell's denial of the allegations made by plaintiff about plaintiff's own interactions with Maxwell was defamatory, and if Miss Maxwell acted with actual malice in issuing the denial. Plaintiff's attempt to amplify this proceeding into something broader should not be condoned. Because the evidence sought is nothing more than extraneous, inadmissible circumstantial evidence, irrelevant to proving the essential elements of the claim, the burden or expense of the proposed discovery outweighs its likely benefit, considering the needs of the case, the parties' resources, the importance of the issues at stake in the action, and the importance of the discovery in resolving the issues. Atkinson 2009 WL 890682 at 1. As such, the request for the additional depositions should be denied. Notes. The information sought is also inadmissible. Plaintiff seeks testimony from witness who she claims will testify to experience similar to her stories, and this will corroborate Miss Joffrey's account description of the motive, way in which Epstein and his co-conspirators created opportunity, intent, plan, knowledge, and to the specifics that make up the criminal signature of Epstein and his co-conspirators. Motion of 15 to 16. Such evidence is prohibited by FRE 404B, which states evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with the character. Furthermore, no other witness has claimed, as plaintiff does, that Ghislaine Maxwell sexually abused them, sexually trafficked them, or that she partook in daily sex with any underage girls. Plaintiff's claim stands in isolation because it is fictional. Additional note. This circumstantial evidence has no bearing on the truthfulness of the stories published by plaintiff. It is equally likely to show that plaintiff became aware of the allegations of others and decided to hop on the bandwagon. She then made up similar claims for the purpose of getting paid hundreds of thousands of dollars by the media for publicizing her allegations and identifying well-known public figures whose names she has seen documents that she reviewed or other stories she had read. Continuing on. Wherefore, Ms. Maxwell requests that the motion to permit in excess of the presumptive 10 deposition limit be denied. Alternatively, if in excess of 10 depositions are permitted, Ms. Maxwell requests that plaintiff be required to pay all costs and attorney fees associated with attending any deposition occurring outside 100 miles of the courthouse for the Southern District of New York pursuant to SDNY L Civ R31. Dated June 6, 2016, respectfully submitted, Laura A. Menninger. Attorneys for Ghislaine Maxwell. Certificate of Service. I certify that on June 6, 2016, I electronically served this defendant's response in opposition to motion to exceed presumptive 10 deposition limit via ECF on the following. Signed, Nicole Simmons.